Members, the Speaker.
I acknowledge the Ngunnawal and Ngambri peoples who are the traditional custodians of the Canberra area and pay respects to the elders past and present of all Australia's Indigenous peoples. Almighty God, we humbly beseech thee to vouchsafe thy blessing upon this Parliament. Direct and prosper our deliberations to the advancement of thy glory and the true welfare of the people of Australia. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done in earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive them that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory, for ever and ever. Amen. Pursuant to Section 22 of the Parliamentary Workplace Support Service Act 2023, I present the Commonwealth Parliamentary Workplace Report for 2025. I call the clerk.
Government business. Notice number 1. Statements on significant matters. David Malouf, AO.
I call to the Leader of the House and Minister for the Arts.
Thanks very much, Mr Speaker. I might say it's one of the more intimidating things I've been asked to do in this House, to pay tribute to one of Australia's greatest ever writers, because on the 20th of March of this year, David Malouf died. And even if David Malouf had stuck to just one branch of literature, we would have revered him. This Brisbane boy, this gentle giant of Australian letters who did so much to define for us the adventure of a new page. Yet he didn't stop at one branch, he became the whole forest. Whatever form David touched, he made it his own. He was a master of the poem, the novel, the short story, the memoir, the essay, the libretto. But there was a single unifying feature regardless of the form. If it was David Malouf, it was all poetry. I was introduced to his work when I studied An Imaginary Life for the HSC as a teenager. And learnt back then that whether the narrative was set in ancient Greece as it was later in Ransom, or in ancient Rome as it was in An Imaginary Life, whether it was set in the Brisbane suburbs in Jono, he was always drawing on the Australian experience. The Australian experience of an Australian with proud Lebanese heritage. His work's always been deeply personal to me. Nearly 20 years ago now, he put out one of his poetry collections, one called Typewriter Music. I bought it at the time. It sat in my shelf in my office for nearly 20 years. This is the first time it's actually left the office when I brought it down here this morning. His short story, The Empty Lunch Tin, was one I had multiple copies photocopied of, must be 30 years ago or more, it would be more actually, when I was President of Young Labor. And new members of the party would come through and I'd give them a copy of this short story, The Empty Lunch Tin, because I thought the story there of the young person who didn't have enough money for lunch but didn't want the friends to know, so turned up with the empty lunch tin every day, was one where it took people thinking about policy to the reality of people's lives. In the last election campaign, I was walking through Devonport, and it happened to be the 10 Days on the Island Festival. To see in a shop window there was actually a performance of An Imaginary Life, a novel I hadn't read for a very long time. I had time, so I bought a ticket. There was a tiny hall, there were about 20 other people. The numbers were inflated by me being there and the members of the AFP who were following me being there, but a very small group of people, and his prose poem about the power of language, with that character of the child where the power of language is brought forward by a character who has no words. It was performed in all of its fragile glory. Nearly 40 years after I'd first read the words of that novel, they were still fresh, they were still poignant, as his work will always be. David Malouf's work is illuminated by lyricism, by intelligence, curiosity, infinite heart, and an imagination that came to span the world and the ages. It really glows with this gentleness wrapped around a profound strength. It's elegant, but it's also an uncompromising humanity. He'd moved between worlds without ever losing touch with this one, and he found consequence, even in other things that you might find inconsequential. He gave us pages that would involve love and commemoration, innocence through to realisation. You can open any of his works at random and you might find him digging beneath an ancient myth or finding the heartbeat of a local suburb. All of this was powered by a mind that, even when he was roaming across the greatest of literature's epics, he worked on a scale that was intimate and human. David delivered us an Australia in all its complexity. It was deeply interconnected mosaic with generations shaped by our environment, coloured by the experience of war, resonating from the collision of Indigenous and non-Indigenous worlds. He believed passionately in reconciliation, and he believed in the power of language, passions that he united as a lifetime ambassador for the Indigenous Literacy Foundation. He showed us sometimes surprising places where freedom can be found, and as a member of PEN, Sydney, he worked for writers in parts of the world where freedom is more elusive. As he dealt with questions of memory and identity, he never flinched, he never recoiled, and he showed us the poetry that surrounds us, how to find ourselves, how to maybe let the universe in a little. Now, like his imagined version of the poet Ovid, where you get those scenes of the ocean of grass that welcomes him to the end of life's journey, David himself has taken his last step. In typewriter music, there's a reference where he describes someone else's final moments, where someone who he loves is clearly nearing the end, but not tonight, where he concludes the anthology with, "We are alone, no need between us for speech. Take your time, eat the last of the apple, finish your wine." That sort of gentle kindness and joy is what we all hope David himself saw for his final years. Similarly, in the closing lines of Parting, that's the poem that opens his final poetry collection. He uses these words: "We look back with no regret to where we lay lost in each other's gaze. Parting is where we began, where we begin." David Malouf, the man, has parted from us, but we'll never have to live in a world without him. He's left himself to us in so many ways: guide, teacher, a gentle, towering figure of humanity. And ultimately, for all the beauty that he saw in others, the greatest beauty he's left for Australia was his own words, was himself.
And I give the call to the member for Moncrieff to speak in response to the Minister's statement.
Thank you, Mr Speaker. I rise to pay tribute to a great Australian and a fabulous Queenslander, the great literary statesman David George Joseph Malouf, AO. What a great life David lived, a full 92 years, during which time David made a significant and enduring cultural contribution to our nation. David achieved this through his family, his literary works and his support of the literary community in Australia and around the world. And born in Brisbane in 1934 to first-generation migrants to Australia, his father, George, was a Lebanese Melkite Christian, and his mother, Welcome Wilhelmina, was English of Sephardi Jewish descent. They were hard-working small business owners running a corner shop. During this time, David was educated at Brisbane Grammar School, where he studied French and Latin and then began studying law as a scholarship student at the University of Queensland, before switching to study English, where he graduated with first-class honours, unsurprisingly, in 1955. After school, he worked as a teacher in Brisbane and London and lived for some time in Europe. And after his time abroad, he lived in Sydney and lectured at the University of Sydney. It was in 2017 when David continued to demonstrate his greatness by choosing to retire to the magnificent location of Surfers Paradise. During his life, he was a prolific writer of novels, poetry, essays, librettos, plays and short stories, working across genres with flair and with elegance. It has been said by many that David's writing was influenced by his multicultural origins, his upbringing in Brisbane during the Second World War, his mother's passion for her Englishness, and his intellect. With the Australian's culture critic Peter Craven describing David as arguably the most accomplished Australian writer of his generation, a modest man, a man of immense culture. And the Australian's literary editor Stephen Romai describing David as the understated grand statesman of Australian letters. David's writing is considered exceptional due to his selection of themes that have helped Australians rethink history, identity and connection to place, exploring complex themes of humanity, memory and understanding across cultures. His writing is often described as poetic because of its rich imagery, emotional depth, exploring the inner lives of his characters and the landscapes around them. There was hardly a literary prize for which David was not considered. One of his most famous novels is Remembering Babylon, published in 1993. The story follows a young man who was raised by Aboriginal Australians and later struggles to fit back into colonial society. Through this novel, David examines fear, prejudice and the divisions between cultures in Australia's colonial past. The book was internationally acclaimed and in doing so helped bring Australian literature to a global audience. And I'm going to read out the list of awards that it won. The inaugural International Dublin Literary Award, the Los Angeles Times Book Prize for Fiction, the Prix Femina Estranger, the Prix Baudelaire, the Commonwealth Writers' Prize, New South Wales Premier's Literary Awards, Christina Stead Prize for Fiction, and it was shortlisted for the Booker Prize. All for one book. Extraordinary. Most authors might be content for one of those awards in their career, or indeed just to write one book. Some of David's other distinguished honours and awards included an Order of Australia, the Neustadt International Prize for Literature in 2000, election as a Fellow of the Royal Society of Literature in 2008, and an Australia Council Award for a Lifetime Achievement in Australian Literature 2016. Throughout his entire life, he supported others in the literary world, including engaging with young authors. And Trent Dalton describes David as having given every Brisbane kid who ever owned a library card permission to dream beyond their bedroom, even beyond their front and backyard, and maybe even down the street a bit and up the creek and all the way around the bend and around the world. David was a passionate supporter of the arts, and specifically of Opera Australia, Adelaide Writers' Week and the Indigenous Literary Foundation. His literary agent, Jane Novak, said he was a kind, generous, wonderful man behind the masterpieces. She said everyone loved working with David. He was committed to reading and supporting new Australian writers. If a nation's soul is expanded by its literature, then it follows the body of work that David has left us with and has certainly become part of the fabric of our nation. In David's own words from his last novel, Ransom, that's part of some Year 12 curriculums. Words are powerful. They too can be the agents of what is new, of what is conceivable and can be thought and let loose upon the world. Australia has been enriched by David Malouf's life. And with his passing, Australia will continue to be enriched for years to come through his great works. And finally, in David's own words, this time from his novel An Imaginary Life, I now have a life that stretches beyond the limits of measurable time. How fitting. Vale David Malouf AO. Thank you, Mr Speaker.
We'll call to the Leader of the House.
Thanks, Speaker. I move that further statements on David Malouf AO be permitted in the Federation Chamber and thank the Shadow Minister for joining the remarks.
I'll put the question. Those opinions say aye. Against no. I think the ayes have it. I'll call the Leader of the House.
I declare that unless otherwise ordered, the Defence Force Discipline Amendment RCDVS, Implementation and Related Measures No. 1, Bill 2026, stands referred to the Federation Chamber for further consideration at the adjournment of the debate on the motion for the second reading of the bill.
I present report number 10 of the Selection Committee relating to the consideration of committee and delegation business and private members' business for Monday, 25th of May 2026. The report will be printed in the Hansard for today, and the committee's determinations will appear on tomorrow's notice paper. Copies of the report have been placed on the table. Call the clerk.
Government business, notice number 2, Regulatory Reform Omnibus Bill 2026.
Call to the Assistant Treasurer and Minister for Financial Services.
I present the Regulatory Reform Omnibus Bill 2026 and the explanatory memorandum.
Call the clerk.
First reading, a bill for an act to repeal certain acts and provisions of acts and to make various amendments of the statute law of the Commonwealth and for related purposes.
Call to the Minister.
I move that this bill be now read a second time. Australians have faced extraordinary economic challenges over the last few years, driven by events beyond our shores. This week's budget outlined the government's strategy to respond to these challenges through responsible savings, supporting intergenerational equality, and by building an economy that is more productive and more resilient. In particular, higher productivity is the key to boosting the real value of our wages and our standard of living. A more productive economy is a more resilient one, and reversing the decay to Australian productivity which set in during the 2010s is a key economic goal for the government. Better regulation is a key piece of this economic picture. Regulation touches on nearly every aspect of everyday life. From road rules to housing construction, regulation sets the ground rules which govern how individuals behave and how businesses and institutions operate. Last year's Economic Reform Roundtable highlighted the importance of getting regulatory settings right and the strong desire from businesses and community organisations for better regulation. The government is delivering an ambitious regulatory reform agenda to facilitate investment, protect Australians from harm, and reduce unnecessary regulatory costs across the economy. Through this agenda, we have been identifying and implementing continuous improvements to regulatory settings on a government-wide basis. When our agenda is fully implemented, the gains delivered for Australians will include a $10.2 billion reduction in the regulatory burden every year, a single national market to create clear and consistent rules for businesses, workers and consumers, no matter where they are in Australia, faster administrative processes to get more projects off the ground more quickly, modernised regulation that is fit for purpose for the digital economy and responsibly balances the challenges and opportunities brought to us by AI, and regulators being active stewards of regulation to embed productivity into how they work. The government will expect all our regulators to balance managing known and likely risks with supporting economic growth and dynamism. Regulatory reform omnibus bills will be instrumental in delivering needed legislative reforms under this agenda. Last October, the Treasurer introduced the Regulatory Reform Omnibus Bill 2025, which was about better regulation, cutting compliance costs and launching the ambitious transition to a tell us once approach to government service delivery. Today, I am proud to continue the government's regulatory reform agenda by introducing the Regulatory Reform Omnibus Bill 2026. This bill continues the work from last year's Omnibus Act by further simplifying regulation, particularly for businesses, progressing additional measures to support the government's Tell Us Once agenda, and making technical amendments to get regulation working better for Australians. In total, it amends 26 acts, repeals 2 acts, and will improve the operations of 19 government agencies. First, the bill will update Australia's intellectual property laws. It will provide the Registrar of Trademarks with more discretion over the amount of costs prescribed by the regulations to be awarded in a trademark opposition matter. Currently, the Registrar can only award scheduled amounts regardless of how much a party spent in legal fees. Giving the Registrar more flexibility to determine costs will further build integrity into the opposition's process for businesses and deter poor behaviour intended to run up the costs of the other party. It will also introduce a 6-month grace period for plant breeders to renew their plant breeder rights, where they are late in paying the annual renewal fee. Under the current settings, these rights are automatically lost if the fee is paid late, and the plant breeder must apply again to get them back. We know that life and business get hectic sometimes. This change means that plant breeders won't accidentally lose valuable rights just because they missed a renewal payment deadline. It will boost protections by allowing investigations and discipline of patent and trademark attorneys to continue, even if an attorney deregisters to try to avoid the process. It will also impose stricter requirements for re-registration where a patent and trademark attorney is found guilty of misconduct. Together, these changes will help businesses maintain confidence in the IP attorney profession. It will close an unintended loophole while still allowing easy re-registration for attorneys with a clear conduct record. Beyond intellectual property, the bill will remove the mandatory 30-day appeal period for importers who advise they don't intend to appeal a negative preliminary decision by the Anti-Dumping Commissioner for a partial refund as part of the duty assessment process. This change will allow importers to receive faster refunds when they advise that they don't intend to appeal the decision. The Commissioner's preliminary decision is subject to being finalised by the Minister. When the decision is finalised, the importer can be paid the refund they are entitled to. However, even when an importer has no intention of appealing the decision, the Commissioner must wait the full 30-day period before recommending that the Minister finalise the decision. This amendment will allow the Commissioner, on receiving confirmation from the importer that they don't intend to appeal, to immediately recommend that the decision be finalised. This change means faster cash flow for businesses by adding fit-for-purpose flexibility to an administrative process. The bill will also simplify business reporting requirements. It will simplify workplace gender equality reporting and target setting requirements by adding a 12-month window at the end of a target cycle. Right now, reporting at the end of a target cycle comes with additional regulatory burden for businesses. Not only must they finalise their data and reporting for the current cycle, they must also select new targets for the next cycle. This amendment will give employers more time to identify high-quality, meaningful targets by adding a 12-month window to identify and nominate them. This change means more time for employers to analyse and understand their performance in the previous cycle, leading to more considered targets and more sustainable progress towards gender equality in our workplaces. The amendment also reduces the administrative burden for employers that comes at the end of a target cycle. The bill will also align the reporting period for public and private sector employers to ensure comparable data on gender equality in the workplace is available for both Commonwealth and private sector employers. Another improvement to business reporting made by the bill is to move reporting under the new eligible drama expenditure scheme from a financial year to a calendar year basis. This aligns these reporting requirements for subscription television broadcast licensees and channel providers with other Australian content reporting schemes. This change will make it easier for businesses who are reporting under multiple schemes to prepare, compare and lodge the required information. A core part of the 2025 Omnibus Act was supporting a shift towards a tell us once approach to how government works for Australians. A realised tell us once approach across government means Australians and businesses won't have to enter the same information more than once when interacting with government. This bill will advance the government's efforts to embed a tell us once approach across a wider range of government activities and services. For importers, it will allow goods that are covered by a tariff concession order to be exempt from dumping and countervailing duties in certain circumstances without requiring a further administrative decision. This removes administrative delays in exempting some goods from dumping and countervailing duties and means importers can get on with business more quickly. The bill will make it easier for people who are nominees under the Social Security law to cancel their nominee arrangements by removing the requirement to cancel in writing. Nominees are appointed to assist Social Security, family assistance and paid parental leave recipients who need help interacting with Services Australia. Currently, when nominees want to cancel their nominee appointment, they must notify Services Australia in writing, even if they've already said they want to cancel their appointment over the phone. This adds administrative burden and can cause delays in the cancellation of arrangements that may no longer be appropriate or tenable, for example, due to the presence of family or domestic violence. This change will ensure that nominee arrangements are simple to cancel on a tell-us-once basis and can be actioned by Services Australia as soon as possible with minimal impost on the nominee. The bill will also make it easier for recipients of some Commonwealth pensions to comply with their proof of life obligations and reduce duplication of effort by Services Australia. These obligations apply to Australians aged 80 years or over who have been away from Australia for at least 2 continuous years. These amendments will allow Services Australia, in some cases, to rely instead on information it has already collected from other places. This is a significant change that will reduce the regulatory burden not just on elderly pensioners, but also on Australia's consular officials who often help prepare the certificates. The bill will also make changes that will get government working better for Australians. It will improve the Australian Human Rights Commission complaints process by removing excessive mandatory complaint notification requirements. These requirements were introduced in an attempt to increase procedural fairness. In practice, they have only applied to people who play no role in the resolution of complaints and aren't able to formally respond. Receiving a notification can be a confusing and stressful experience for these people, and they may contact the Commission for support even though there are no legal consequences for them. The notification process has also not helped complainants get better outcomes. This change will mean more time for the Commission to spend supporting complainants and less stress for people who would otherwise receive these notices. The bill will also allow eligible Defence Force Superannuation Scheme members to access an account-based pension from CSC when they retire. This will give former ADF members more choice to manage their money in retirement and has support from serving and former ADF members. Finally, the bill will also make various technical amendments to improve the operation of existing regulations. It will repeal acts that have become redundant. It will clarify and align legislative definitions and concepts to support more efficient and timely administrative decision-making. I am introducing this bill into the House on behalf of my colleague in the other place, Senator the Honourable Katie Gallagher, Minister for Finance, Women, the Public Service and Government Services. I want to acknowledge her and thank her for her work in bringing this bill together. It is a reflection on the commitment of this government to continued regulatory reform that we are able to introduce another regulatory reform omnibus bill so soon after the first. As the Treasurer said when he introduced the 2025 Omnibus Bill, regulation should be there to protect Australians and empower them, not weigh them down. This bill is about making sure regulation supports businesses to get the most out of their investment and their hard work. It is about sensible changes that simplify regulations while maintaining essential safeguards for the community. It takes further steps towards a wider tell-us-once approach across all of government. It will support the government's work to build an economy that is more dynamic, more resilient and more productive for all Australians. We understand that there is more work to do and expect to introduce further omnibus bills in the future. This bill is another step towards delivering the better regulation that Australians deserve. Full details of all the bill's measures are contained in the explanatory memorandum.
The debate must now be adjourned. To give the call to Member for Herbert.
I move that this debate now be adjourned.
The question is the resumption of the debate be made an order of the day for the next sitting. I'll put the question. Those opinions say aye. Against no. I think the ayes have it. Call the clerk.
Government business. Order of the day number 1. Defence Force Discipline Amendment, RCDVS Implementation and Related Measures, number 1, Bill 2026. Resumption of debate on second reading.
The question is that this bill be now read a second time. And I give the call to the honourable member for Herbert.
Thank you, Speaker. Can I start by acknowledging all those that continue to serve our nation uniform, our veterans and your families, and note that the freedoms that we enjoy today are on the back of hard-fought battles, wars and sacrifice that you have made through peacekeeping missions, natural disasters, humanitarian and combat operations. And in recognition to your service, it is incumbent upon us in this Parliament to ensure that Defence Force members, veterans and your families are treated with respect, dignity and get the appropriate support that you deserve. Today I rise to speak on the Defence Force Discipline Amendment, the Royal Commission into Defence and Veteran Suicide Implementation and Related Measures Bill. The Coalition will not oppose this bill. This legislation implements key recommendations of the Royal Commission into Defence and Veteran Suicide, a landmark inquiry that was established by the former Coalition government. It was in 2021 where I stood in government in the corner and I looked up and had families of those whose sons had died by suicide sitting in the gallery holding photos of their sons saying we must have a Royal Commission. The Coalition called it and the Labor government is implementing it. And I thank the Minister for his genuine bipartisanship through this process. When we established the Royal Commission, we said its aim was to shed a light on the critical steps needed so we can reduce the heartbreaking cases of suicide. The findings confirmed what service members of the Australian Defence Force, veterans and their families have been saying for years. They deserve truth, accountability and genuine reform. With more than 500,000 Australians serving or having served and currently serving, we have profound obligation to ensure that issues identified are acknowledged and that necessary action is taken. The Coalition believes we have a personal responsibility to care for the physical and mental wounds of our Australian Defence Force personnel, past, present and future. Our Defence Force and veteran community must always be recognised for their incredible sacrifices they have made and continue to make, and their unique health challenges are prioritised and addressed. We've seen far too many of our brave men and women succumb to their war within, their invisible wounds. That is why, at the last election, the Coalition committed to implementing and agreed response to the Royal Commission to deliver better outcomes for the Defence Force and veteran community. The Coalition remains committed to addressing the unacceptably high rates of suicide among Defence Force and veteran communities. This bill provides the necessary framework to implement recommendations 18, 20, 23, 34 and 63. It also introduces reform to the military justice system, which is an integral framework underpinning military discipline and command. The Coalition understands that delays in resolving discipline matters adversely affect morale, welfare and operational effectiveness. Prolonged uncertainty places a strain on personnel that can undermine unit cohesion and trust. A fair, effective and timely system is essential for protecting personnel and ensuring that the Australian Defence Force remains mission ready. Turning to the specifics of the bill, in Schedule 1 it directly implements several of the Royal Commission recommendations designed to protect victims and enhance accountability. Recommendation 18 called for enhanced safeguards to ensure alleged victims are not required to work alongside alleged perpetrators during investigations. This sounds like something that shouldn't have occurred, but it has occurred in many units over many, many years. Currently, a member suspected of a minor service offence can be suspended, but a member suspected of a serious civilian criminal offence, such as rape, sexual assault, or even murder, often cannot be suspended. This can create an inconsistent and unsuitable outcomes where serious criminal offences do not trigger the same protective actions as minor service matters. The bill resolves that inconsistency by introducing a new suspension power where a member is under investigation by civilian authorities. Furthermore, Schedule 1 implements Recommendation 20, requiring service tribunals to consider victim impact in sexual offences cases. It also addresses rank disparity in sentencing. We also see the implementation of Recommendation 21, establishing a framework to ensure serious service convictions are disclosed to the Australian Criminal Intelligence Commission for inclusion in the National Policing Records. Additionally, in line with Recommendation 63, the bill removes stigmatising language like malingering from the Defence Force Discipline Act, replacing it with descriptions that do not carry the same negative connotation for wounded, ill or injured members. Schedule 2 streamlines superior tribunal procedures. This gives effect to Recommendation 34, which required a review of provisions where court material panels were not required to give reasons for punishment. This legislation now requires that any conviction and sentencing decision by the superior tribunals or reviews to be accompanied by formal reasons. By requiring these reasons, this bill seeks to enhance transparency and accountability within the system. This schedule also makes changes to trial phase, where the complex task of sentencing becoming the responsibility of the judge advocate and not lay a panel. The government has stated that these measures are intended to align the practice of the superior tribunals more closely with those of civilian justice system. The bill also provides for matters to be prescribed by regulation, enabling the framework to remain responsive to future reforms and developments across civilian judicial jurisdictions. To strengthen procedural fairness, the schedule also introduces reforms allowing either the accused person or the prosecution prior to a plea being entered to apply for the election of the reform or mode of trial. This includes the ability to seek a trial by judge advocate alone, the escalation of proceedings from the restricted court material to general court material, or a referral of a matter from a Defence Force magistrate to court material. To reduce the likelihood of retrials and improve trial continuity, the Registrar of Military Justice is granted flexible powers to appoint and substitute judge advocates and panel members in response to illness or operational demands. This is reform seeks to ensure the wheels of justice do not halt due to the unique pressures of military service. We note measures to align court material proceedings to contemporary civilian practice may prove more difficult in practice owing to the unique nature of court material, where it could be argued that there is no direct equivalence between a court material and a civilian jury. Schedule 3 updates the provisions of the Defence Force Disciplinary Act concerning the management of mental impairment in service tribunal proceedings. Part 1 of this schedule updates the powers of service tribunals. We're dealing with those suffering from mental health impairment, with Part 2 establishing a Defence Mental Health Tribunal as a specialised decision-making body. The current framework lacks the mechanism to address mental health conditions that fall short of legal incapacity but still impact an accused person's well-being or the fairness of superior tribunal proceedings. This bill introduces new diversionary measures permitting a service tribunal to adjourn proceedings for up to 6 months. Under the proposed subsection 113E, a service tribunal must dismiss a charge entirely where reasonably satisfied that the accused person is suffering from a mental impairment. The judge advocate rules that continuing to try the charge is not in the interest of maintaining discipline in the defence force. The prosecution has had the opportunity to be heard. Factors that must be considered to dismiss the charge include the nature of severity and expected duration of the mental impairment and the nature of seriousness of the charge. Part 2 of the Schedule 3 establishes a Defence Mental Health Tribunal. This will allow for the provision of clinically informed alternative to be outdated custodial provisions, which are currently the Defence Force Disciplinary Act, allowing for orders related to treatment, care or appropriate detention. These orders will be reviewed every 6 months, ensuring that the restriction of liberty is always proportionate and subject to clinical oversight. This is a trauma-informed approach that supports well-being of the accused while also maintaining confidence in the discipline system. The commencement of this part is to commence or proclamation or on 1 January 2028 to allow for the negotiation of state and territory funding to access facilities, and we urge the government and will work with the government to expedite these discussions. Schedule 4 seeks to simplify the middle tier of the disciplinary framework, creating the summary contravention scheme. The current 3-tier system can be complex and a major source of delay and inefficiency. This bill replaces that system with a single streamlined summary scheme. The new scheme is administrative, not criminal, and uses the civil standard of proof. It allows defence to manage minor misconduct in a proportionate way while reducing escalation into the services of offence system. This balances the need for efficiency with the fundamental right for a fair trial. Schedule 5. This is the one I had a little bit of concern about. It contains 16 parts. It's very big, and it covers a broad range of amendments. In particular, the part that I had concern about, and I thank the Minister for allowing some defence members to go through the process with me, is to establish a clear statutory basis for Defence Force police members to carry, handle and use specified policing equipment. So that means MPs being able to hold tasers. Now, MPs, military police, can't use tasers on the civilian force. They would only be able to use it on still serving or those who have broken into a military base and they are defending the base. So as a former enlisted soldier, I get concerned because the most likelihood of where these tasers would be used or who they'd be used upon would be enlisted soldiers. So I have some concerns around this. I spoke with the 3 service people yesterday, including a warrant officer class 1, and in some jurisdictions they already carry the taser. I am sceptical of it. I am worried that it's going to be used on enlisted soldiers. Well, definitely would be more than officers, but I do think we just got to keep an eye on this. We just got to keep an eye on this. I know what I was like when I was a soldier. I'm glad there was no tasers then. So part 1, it does allow for specified military police to use specified policing equipment, tasers. Part 2 amends the DFDA to update prescribed quantities for drug offences by repealing definitions of controlled drug and controlled plant. Part 2 also repeals a new definition of prescribed quantity. This will align with DFDA definitions to other Commonwealth legislation. Part 3 amends DFDA to enable the disclosure and protection of certain information in proceedings before service tribunals or for law enforcement purposes. Part 4 amends DFDA service offences, removing outdated location-based elements and to modernise the scope of assault and harassment Related offences, these amendments seek to ensure that service offence provisions reflect contemporary expectations. Part 5 amends the maximum term of imprisonment that may be imposed by a restricted court material from 6 months to 2 years. Part 6 amends DFDA to ensure that reviewing authority can not consider a petition relating to proceedings that it has already reviewed under Section 152 as part of the automatic review process. This is seen as a fairness measure. Part 7 amends the DFDA to increase the maximum term of appointment of legal officers appointed under Section 154 from 3 years to 5 years. This part also clarifies that reviewing authority should not commence a review without obtaining a report on the proceedings, which can be provided by a legal officer appointed under Section 154 or under the Defence JAG. Part A makes amendments to vest all statutory discipline powers to the CDF rather than with the CDF and other service chiefs, allowing CDF to delegate those powers to service chiefs and other Defence Force officers at or above the rank of Commodore, Brigadier or Air Commodore. Part 9 amends the Defence Act and the DFDA to update the title Director of Defence Counsel Services to Director of Defence Legal Assistance. This is to reflect increased scope over the years of the Director. Part 10 amends the DFDA to expand the statutory functions of the DMP to include representing the CDF and other service chiefs in specified federal court and high court proceedings relating to DFDA. Part 11 amends DFDA, modernise and harmonise the termination provisions for the JAG and the DJAG, aligning with the contemporary judicial office termination standards. Part 12 amends Section 146 of the DFDA to enable regulations to apply, adopt and incorporate evidentiary rules that operate in the Jervis Bay Territory for use in the DFDA proceedings. Part 13 amends the DFDA to modernise and broaden the concept of the investigating officer. These amendments ensure that DFDA investigations are conducted appropriately by appropriately trained people, support the professionalism of the defence investigative practice. Part 4 amends Section 84A of the DFDA to expand the existing removal order power that it applies not only to cyberbullying offences under Section 48A, but also to any service offence involves the provision of intimate images of another person via social media or electronic services. This ensures service tribunals can order the removal of harmful intimate image material whenever it is posted or otherwise shared as a part of the DFDA offending, not only when it constitutes cyberbullying. Part 15 creates the power to extinguish historical homosexual service offences. Part 16 amends the DFDA to relocate all disciplinary infringement provisions from Part 1A into a standalone Schedule 1. The aim of this amendment is to improve readability and simplify the numbering of infringement provisions. Finally, Section 6 provides a transitional rulemaking power to the Minister. This will allow the Minister to make rules by a legislative instrument that the government sees this as a necessary measure to deal with unintended outcomes or unforeseen issues as we move from the old framework to the new. The Coalition expects the Minister to use the powers judiciously, ensuring that the rules made are in the interests of justice and accord fairness to all proceedings. Now, the highlight of the bill for me is around streamlining and marrying up the offences from when you're in defence or your DFDA. If the Defence Force are investigating you, you then get stood down, given appropriate support. It's up to the command element around your pay structure. But if you're investigated by Queensland Police or a state police service for a serious crime, then you may not, or at this stage, you would not be stood down. So We have seen in Townsville, Darwin, Brisbane, Tasmania, at different units where an alleged perpetrator of sexual assault was working with the alleged victim. That is not good enough, and this is a protection to make sure that that doesn't occur. Because when that alleged, in many cases where an alleged perpetrator does get convicted and becomes the perpetrator, this poor victim has been made to work with the person that has assaulted them, sexually assaulted them, or been convicted of raping them. I do think this is an appropriate change, and we do support this. It marries it up. It makes a lot of sense to me. We remain deeply committed to addressing the high rates of suicide among our defence and veteran community. I know that is a bipartisan statement in this parliament. And last year, the Coalition supported the legislation to establish the Defence and Veterans Service Commissioner, which was recommendation 122 of the Royal Commission. It is imperative that we work together to roll out these recommendations. We will continue to engage with key advocacy groups, ensure the unique challenges of defence personnel and veterans are prioritised. No good ideas come out of Canberra. No good ideas come from politicians. They come from the experts, and it's our job to listen, work and deliver for those ESOs and defence groups and veterans that come to us and say, hey, why aren't we rolling out this, or how do we move it quicker? We will not stand in the way of this bill. A strong, fair, effective military justice system is essential to maintain discipline, operational effectiveness and the confidence of the Australian people in our Defence Force. Our servicemen and women deserve a system that is transparent and timely. We must do better by those who defend us, our families and our way of life. The implementation of the Royal Commission recommendations is a critical step in that direction. Thank you.
The question is that the bill be now read a second time, and I give the call to the Minister.
I move that the debate be adjourned and the resumption of the debate be made in order of the day for a later hour this day.
The question is that the debate be adjourned and that the resumption of the debate be made in order of the day for a later hour of this day. I will put the question. All the opinions say aye. Contrary, no. I believe the ayes have it. Clerk.
Government business, order of the day number 2. Treasury Laws Amendment, the Survivors Law Bill 2026. Resumption of debate on second reading.
The question is that the bill be now read a second time, and I give the call to the member for Bullwinkle.
Thank you, Speaker. Speaker, I rise today to speak in support of the Treasury Laws Amendment, the Survivor Bill. This bill addresses a simple but fundamental principle of justice. Perpetrators of child sexual abuse should not be able to hide behind complex financial structures to avoid accountability. For too long, our legal and financial systems have contained an inadvertent and deeply unjust loophole, one that has allowed convicted offenders to shield their assets in superannuation accounts, while the victims and survivors of their crimes are left without the compensation that they are legally or morally owed. Today, we move to close that loophole. This is not just a technical correction to our Treasury laws, it is a moral alignment of our financial systems with the values of the Australian people. We are making a clear statement that the perpetrator's right to a comfortable retirement does not and will never outweigh a survivor's right to justice and redress. Speaker, it is essential that this House understands why this reform is so urgent. Child sexual abuse is not a crime that ends when the physical act stops. Its impacts are enduring, complex and profound. Survivors frequently carry the effects of their abuse into their adulthood, and the experience may ripple through every facet of their lives, affecting their mental health, physical well-being, the ability to form stable relationships and their educational outcomes. We often hear from survivors who have spent decades navigating the world in silence, carrying a burden that was never theirs to carry or to bear. For many, This trauma directly impacts their ability to participate fully in the workforce. When we talk about the harm caused by the abuse, we are not just talking about the emotional scars. We are talking about material disadvantage. Survivors may face lifelong barriers to stable employment and financial security. They may require ongoing medical care, psychological support, and specialised services that may come at a significant financial cost. The courage it takes for these individuals to come forward, often decades after the events, cannot be overstated. They choose to relive their most painful experiences in pursuit of justice, knowing full well that legal outcomes are never guaranteed. As a Parliament, our response must be equally serious, sustained, and above all, centred on those who have been harmed. But Speaker, for too many survivors, a court ruling in their favour has proven to be nothing more than a paper victory. They have endured the gruelling, often re-traumatising experience of legal proceedings, and they have stood in front of the law and asked for acknowledgement. And yet, even after being awarded compensation, they face the further distress of seeing those orders go unpaid. And this compounds the original harm. It sends a message to the survivor that even after the state acknowledges their suffering, the perpetrator can still win by playing the system, and it is a failure of our institutions to deliver on the promise of meaningful redress. I have met with constituents who have walked this path. They have won their cases only to be told by lawyers that the perpetrator's assets are untouchable because they have been funnelled into superannuation. This is a perversion of the intent of our retirement savings system. Superannuation was designed to provide security in old age and not to act as a safe haven for those seeking to dodge a debt of justice. Speaker, under these reforms, we are introducing a practical, targeted mechanism for enforcement that levels the playing fields. Point 1, direct access to contributions. Where a court-ordered compensation debt remains unpaid after 12 months, victims and survivors will be able to seek access through a court order to specific superannuation contributions. Point 2, in targeting voluntary shielding, we are specifically targeting additional personal and salary sacrifice contributions. These are the voluntary payments that have previously been used by offenders to park their wealth out of reach. We are not touching their basic employment contributions required for baseline retirement, but we are ensuring that any extra wealth accumulated by the criminal perpetrator is available to pay their victims first. And 3, ending the bankruptcy refuge. Crucially, this bill ensures that compensation debts do not simply disappear through bankruptcy. By allowing these debts to survive bankruptcy proceedings, we are reinforcing a clear and necessary message. Financial manoeuvring must not override moral and legal responsibility. Bankruptcy should not be a refuge for accountability for such serious harm. These changes will apply not only to future bankruptcies, but also to those that are currently in progress. And this recognises that justice delayed is justice denied, and we must act for those who are struggling with the system today. Speaker, we acknowledge that the superannuation and bankruptcy systems, although the bedrock of our financial stability, are highly technical, and changes to these systems must be carefully designed to be effective and enforceable while remaining consistent with broader legal principles. Getting the technical details right is how we ensure that justice is real. We have consulted extensively with legal experts, financial regulators and survivor advocates to ensure these mechanisms will work in practice and not just on paper. This bill should be understood as a significant and necessary foundation. It closes a clear, inadvertent loophole and sends a strong signal about the direction of reform. We have heard from the voices of survivors and advocates clearly. They are looking and they are looking to us to continue to build on these reforms following the passage of this bill. Their lived experience must remain at the centre of the conversation. When survivors tell us where the system falls short, it is our responsibility to listen and act. And that is why the review measure, which is included in this bill, is so critical. We are not just passing legislation and moving on to the next item of the agenda. We are committed to remaining engaged. We will assess whether victims are genuinely benefiting, and we will identify additional changes that are required to remove remaining barriers. Our policy must continue to be informed by those who use the system, the survivors, the legal practitioners, and the advocates. Speaker, ultimately, this measure is about restoring fairness and dignity. It is about ensuring that the law does not inadvertently protect those who have caused profound harm and are deemed criminals, while leaving their victims without recourse. When an offender retains substantial retirement savings, while their victim struggles financially, often as a direct consequence of abuse, it is unacceptable, amoral, and it undermines public confidence in our justice system. It risks perpetuating a cycle where the burden of the crime continues to fall on the shoulders of the person who has been harmed. This bill aligns with our laws and our values. It says that perpetrators must be held accountable. It says that survivors deserve not only recognition, but meaningful support and redress. By passing this bill, we are making it clear that this Parliament is committed to the long-term work of listening, improving, and building a foundation of justice that survivors can rely on. Speaker, just to surmise, this bill closes a loophole that has allowed perpetrators of child sexual abuse to shield assets in superannuation and avoid paying court-ordered compensation. Survivors can win in court and yet receive nothing because offenders can park their wealth in protected accounts or use bankruptcy to escape enforcement. These reforms in this Survivors Bill ensure that judgments can be enforced and that justice is meaningful and not merely symbolic. I commend the bill to the House.
The question is that the bill be read a second time, and I give the call to the member for Wentworth.
I rise today with honour to speak in support of the Treasury Laws Amendment, the Survivors Law Bill. Before I address the substance of the bill, I want to acknowledge those who have made this reform possible, advocates like Super for Survivors, Bravehearts, Grace Tame Foundation, Fighters Against Child Abuse, and the Carly Ryan Foundation. The many victim survivors and advocates who have shared their stories, often not just once, but over and over again, during consultation, media moments and closed-door discussions. We thank you, and we are deeply sorry for the pain you've been forced to carry. It takes an incredible amount of courage to speak up about what has happened to you, and even greater courage to do so on behalf of others, to ensure that it will not happen to them. This is, sadly, too often how important legislation like this can happen. Let's turn to the bill. This bill attempts to confront a unique injustice: perpetrators of child sexual abuse who use the superannuation system to shield assets from compensation claims. Currently, perpetrators can make large contributions to their superannuation, sometimes in the tune of millions of dollars, which are in most cases protected from creditors, and then declare bankruptcy to avoid paying compensation that their victims are owed. This is no longer just a loophole, but has been documented to be a deliberate way that perpetrators can continue their abuse by denying victim survivors the financial compensation and justice they are owed. I'm pleased that the government is finally denying perpetrators this opportunity to utilise this loophole. This bill creates a framework that enables victim survivors of child sexual abuse and similar offences to seek access to a perpetrator's superannuation to satisfy unpaid compensation orders arising from criminal or civil proceedings. The legislation includes important safeguards. The framework only applies where a compensation order has remained unpaid for 12 months or more, and where the perpetrator has been convicted of or found guilty of certain offences to a criminal standard. In this legislation, these offences relate to child sexual abuse offences. Victim survivors who meet the criteria must apply to the Commissioner, who can then facilitate the release of funds through the creation of a new type of release authority. Perpetrators retain the right to challenge any such order. This justice matters deeply. We know that victim survivors experience long-lasting impacts of their abuse beyond the abuse itself. This trauma can go on to impact their mental health, their relationships and their ability to work, study and trust others. We have a responsibility to ensure that the justice, including compensation, that victim survivors are owed is delivered in its fairest form. Compensation cannot undo harm, but it can recognise these impacts. When perpetrators are able to manipulate the legal system to avoid this justice, this injustice compounds. I have expressed my support for the bill and will vote for it. However, I want to flag an omission in this legislation which my amendment is seeking to address. The Minister himself acknowledged in his own second reading speech that mechanisms for review are necessary to ensure that legislation is functioning as intended. Despite this, there is no such provision in this bill. We cannot simply implement legislation and consider the job done. This is not just for the sake of trust and integrity, but for the very victim survivors this government and this Parliament are seeking to protect and empower through this bill. We have an obligation to monitor outcomes, identify gaps and act where a framework is falling short. The government has a responsibility to respond to these reviews as well. Accountability is what turns good intentions into lasting change. My amendment also invites the review to consider whether the framework should be extended beyond child sexual abuse offences. This bill has rightly been driven by high-profile cases involving child sexual abuse. The advocacy has been sustained, powerful and effective. But the question I ask, are there other victim survivors of sexual violence, of domestic and family violence, or other offences who might equally benefit from a framework that prevents perpetrators from using superannuation to evade their obligations? I want to be unambiguous. I'm not seeking to delay this legislation with this question. The reform that victim survivors of child sexual abuse have fought for deserves to be implemented without hesitation. I also recognise that different offence categories involve different complexities. Careful consultation with stakeholders and lived experience advocates would be required before any expansion could responsibly be undertaken. That is exactly why this is a question for a review after this legislation has been operating for some time, not a precondition for the bill's passage. My amendment requires the Minister to cause an independent review within 2 years of the legislation coming into effect. The reviewer will have 6 months to complete the review, and then the Minister must table the report in Parliament within 15 sitting days of receiving the final report. This review will be asked to consider whether the amendments are achieving their objective of enabling victim survivors of child sexual abuse offences to access compensation from a perpetrator's superannuation, the effectiveness of the safeguards established by the amendments, C, any barriers that have prevented victim survivors from accessing the framework, D, whether any further amendments are necessary or desirable, and E, whether the framework established by the amendments should be extended to victims and survivors of offences other than child sexual abuse offences, and if so, what offences and conditions ought to apply. This is a modest amendment which enforces a commitment that the Minister has already indicated the government would like to make. It is an obligation on us as elected representatives to ensure that the legislation we are writing and voting on is indeed working as intended. I understand that the government is intending to move a second reader amendment in the Senate to show their commitment to a review. Whilst I understand that the government wishes for this legislation to pass swiftly through both houses and as such has opted for a second reader, it is frustrating that this cannot be committed to formally through amending the bill itself rather than through a non-binding commitment. I trust the government's intention on committing to such a review. However, this commitment should be in the form of clear accountability mechanisms, not just words. This bill is long overdue. It seeks to correct continuing injustices which should never have occurred. It tells a powerful message to victim survivors that we will not allow the justice system to be manipulated to deny what you are rightly owed. I support this bill and commend it to the House.
The question is that the bill be now read a second time, and I give the call to the member for Chisholm.
Thank you so much, Deputy Speaker. Now, the Albanese Labor government is committed to standing with victim survivors, and I want to thank all victim survivors and advocates for their work in informing this bill. We are committed to ensuring our legal and financial systems work in the interests of justice, not in the interests of offenders seeking to evade responsibility. And that's exactly what this legislation does. It works in the interests of justice. This is an important and overdue reform. It is a reform grounded in justice, accountability and dignity for victim survivors of child sexual abuse. It is a reform that says clearly and unequivocally that perpetrators of these abhorrent crimes should never be able to hide behind financial loopholes to avoid paying compensation owed to those they have harmed. We will always stand with victim survivors, and I will always stand with victim survivors. For far too long, there has been a deeply unfair loophole in our system, a loophole that has allowed convicted child sexual abusers to shield assets in superannuation accounts while refusing or avoiding paying court-ordered compensation to victim survivors. That loophole has caused immense distress and frustration for survivors, because after enduring unimaginable, horrendous abuse, after having shown the incredible courage to come forward, after participating in deeply traumatic legal proceedings, and after securing a compensation order through the judicial system, too many survivors are then facing another devastating reality, which is that the offender still refuses to pay after all of that. They face the reality that their assets of the offender remain protected. And what this means is that justice is incomplete and that justice is not delivered. This can no longer be the case. This bill closes that loophole. It establishes a very clear principle that convicted perpetrators of child sexual abuse cannot use the superannuation system as a shield against accountability. Under these reforms, victim survivors will be able to apply for a court order to access additional personal or salary sacrifice superannuation contributions made by the offender, where a related compensation order remains unpaid after 12 months. Importantly, victim survivors will also be able to apply to the Australian Taxation Office with appropriate safeguards to identify whether eligible superannuation exists before seeking that court order. This is a really practical, targeted measure, and most importantly, it is a reform designed to deliver meaningful outcomes for survivors. We know child sexual abuse causes profound and lifelong harm. Its impacts extend across every aspect of a person's life. It affects mental health, physical well-being, relationships, educational outcomes, employment and financial security. And for many victim survivors, the trauma does not end when the abuse ends. We see that. It's carried on for years, often for decades. Too many people face ongoing barriers to stable work and economic security as a direct consequence of the abuse they suffered as children. And this issue before the House then is not simply about financial compensation. It's about recognition, it's about accountability. It's about ensuring victim survivors are not left carrying the burden alone while perpetrators continue to benefit from protected assets. Justice often means more than just securing a conviction. It's about ensuring meaningful redress. Because what message does it send when a perpetrator can accumulate significant savings while refusing to pay compensation ordered by a court? What message does that send to survivors who have already endured so much? By not closing this loophole, we undermine confidence in the justice system. What has happened before compounds trauma. It perpetuates unfairness. It's wrong and needs to change, and this bill seeks to restore balance. Our reforms say very clearly that our financial systems must align with our values, and our values demand justice and demand accountability. Deputy Speaker, this bill also introduces important amendments to the Bankruptcy Act of 1966. These amendments will ensure compensation debts owed to victim survivors survive bankruptcy. That's a really critical part of what we're putting before the House today, Deputy Speaker, because bankruptcy should never become a refuge from accountability for perpetrators of child sexual abuse. Financial manoeuvring must never override moral and legal responsibility. And these reforms ensure offenders cannot simply walk away from debts owed to survivors through bankruptcy processes. Another important feature of this legislation is that it applies not only prospectively, but also to historical compensation orders that remain legally enforceable. And that matters greatly because there are survivors right now who have been denied justice under the existing framework. There are survivors who have waited years for compensation that was lawfully ordered by the courts. And this legislation recognises their experiences and seeks to address those existing inequities. These reforms did not emerge in isolation. They are the product of years of incredible courageous advocacy from survivors, families and organisations determined to improve a system that has too often failed victim survivors. I want to acknowledge and deeply thank the extraordinary courage of survivors who have spoken publicly about their experiences. That bravery cannot be understated. Coming forward is never easy. Reliving trauma in public is never easy. Yet survivors and advocates continued to push for change because they believed future survivors deserved a better system. And because of their advocacy, because of their courage, our government is acting. I want to acknowledge too the organisations that have campaigned tirelessly for reform in this area. Organisations like Brave Hearts, the Grace Team Foundation, Fighters Against Child Abuse Australia, the Carly Ryan Foundation and Super for Survivors. These organisations, alongside survivors and advocates, have played a vital role in bringing these issues to national attention, and their advocacy has made a real difference. Our government has listened to what these organisations and survivors have had to say. We've listened to the many Australians who believe perpetrators should not be able to exploit legal and financial loopholes to escape accountability and to deny people justice. I want to thank those very deeply in my community of Chisholm who've taken the time to contact me and speak to me about this very important issue. Importantly too, Deputy Speaker, our government has also committed to reviewing the operation of these laws after full commencement to ensure that they are operating effectively for victim survivors. This is really important because this legislation should not be viewed as the end of the conversation. Instead, it is a significant step forward and establishes an important foundation. But we must continue listening to survivors and continue looking for opportunities to improve outcomes and strengthen justice at every juncture. Deputy Speaker, I believe this place is at its absolute best when we work together to deliver meaningful reform for those in our communities who need it most. And I do want to acknowledge the bipartisan and crossbench support that has been expressed for this legislation. Because protecting children and supporting victim survivors should never be a partisan issue. The reforms before us today are about basic fairness, about justice, about accountability, and ensuring the law reflects community expectations. At the heart of this bill is a very simple idea. If a court has ordered compensation for a survivor of child sexual abuse, convicted perpetrators should not be able to shield their wealth while refusing to pay. I think this is fair and long overdue. To any victim survivors watching this debate today, the message from the government and the Parliament is clear. We hear you, we believe you, and we're committed to ensuring our systems deliver accountability and justice. I commend the bill to the House.
Question is that the bill be now read a second time, and I give the call to the member for Moreton.
Thank you, Deputy Speaker. Deputy Speaker, behind every piece of legislation are real people whose lives have been profoundly impacted. And this bill is a stark reminder of that fact. At its core, this bill responds to a simple but fundamental principle. Perpetrators of child sexual abuse should not be able to use financial structures to avoid accountability. For too long, a deeply unjust loophole in our system has allowed convicted offenders to shield wealth held in superannuation, while survivors were left unpaid the compensation that courts had determined was owed to them. And as the Minister stated in his second reading, these reforms have not emerged in isolation. They are the result of a sustained advocacy from survivors, from families, from advocates who have worked for years to ensure that survivors were not left without justice or meaningful compensation. And it is because of them, and it is for them, that we are here today. This legislation takes an important step forward to addressing that injustice and to ensuring that our legal and financial systems better reflect basic principles. Principles of fairness, principles of accountability, and principles of dignity for those survivors. This bill closes a loophole that has undermined confidence in both our financial system and in our justice system. Under the current framework, survivors may successfully pursue a compensation order through the courts, endure lengthy legal processes, having to stand up and repeat their stories again and again and again, relive deeply traumatic experiences and still be left without meaningful compensation, without meaningful redress, because assets remain protected inside superannuation. This needs to change, and this needs to change now. The law should never be allowed to operate in a way that allows those who have caused profound harm to retain significant protected assets while survivors are left carrying the financial consequences of that harm, as well as the emotional and personal consequences of that harm. This bill changes that. It creates a framework that allows survivors of child sexual abuse offences to seek access through a court order to certain superannuation contributions made by a perpetrator where compensation debts remain unpaid. Importantly, this is not an unlimited or sweeping measure. The framework has been designed carefully and specifically. It applies in circumstances where there has been a criminal conviction and where compensation ordered by a court remains unpaid after a significant period of time. That matters because reforms in this area must balance the need for justice with the integrity and stability of our superannuation system. Super exists to provide dignity and security in retirement. It is a famous Labor reform. But that principle cannot be distorted into a shield against accountability for serious criminal harm. This legislation recognises that financial systems should reflect community values and basic fairness. And when this bill is passed, Deputy Speaker, they will. One of the most important ideas underpinning this bill is that justice cannot stop at conviction alone. Nothing can stop the horrific experiences of survivors. But what we can do is listen to their experiences, is understand what they need and take action. There is a growing recognition in our community that accountability is not only about securing a guilty verdict, it is also about ensuring meaningful redress for victim survivors. And for many survivors, the impacts of abuse do not end when criminal proceedings conclude. Child sexual abuse leaves deep and lifelong scars. Survivors often carry the effects of those scars into their adulthood, affecting their mental health, affecting their physical well-being, affecting their relationships, their education, their employment, and indeed their financial security. The trauma does not simply disappear with the passing of time. Many survivors continue navigating its impacts day in and day out, often quietly and without adequate support. And for some survivors, the harm is not only emotional and psychological, but deeply material as well. Some face barriers to stable employment and financial security directly connected to the abuse that they experienced. So when compensation orders remain unpaid, it compounds that harm. It sends a message, whether intended or not, that the burden continues to fall on those who were harmed rather than those who caused the harm. It flips the accountability switch, and this legislation is intended to put it right. This bill seeks to rebalance that inequity. It recognises that compensation orders are not symbolic. They need to mean something and they need to be real. They are intended to provide real acknowledgement, real accountability, and some measure of justice. Another important feature of this legislation is the amendment to bankruptcy laws to ensure compensation debts can survive bankruptcy proceedings. And this is a significant reform. Bankruptcy exists for important reasons within our legal and our economic systems. But bankruptcy should never become a mechanism through which perpetrators can escape responsibility for causing serious harm to others. This bill sends a clear and necessary message. Financial manoeuvring must not override moral and legal accountability in a fair system in this country. Where compensation has been ordered because of the devastating impacts of child sexual abuse, those debts should not simply disappear through bankruptcy while survivors continue living through the consequences. Again, this reform is about restoring balance, and it's about restoring fairness to the system. It is about ensuring that the law does not inadvertently protect perpetrators while leaving survivors without recourse. As I stated at the beginning of this speech, these reforms have not emerged in isolation. They are the result of sustained advocacy from survivors, from their families, from legal experts and organisations that have worked tirelessly to expose where the system has fallen short. Many survivors who advocate for reform do so while carrying extraordinary personal pain. And the courage it takes to come forward, often years after the abuse occurred, can never be overstated. Many victim survivors have spent years and in some cases decades seeking accountability and recognition through systems that too often compounded their trauma rather than eased it. They have had to repeatedly revisit traumatic experiences in pursuit of justice, knowing outcomes were never guaranteed. That takes enormous strength. It takes enormous tenacity. And this Parliament has a responsibility not only to listen to survivors, but to act when the system is failing them. And when survivors tell us that a loophole is allowing perpetrators to avoid accountability, we should take that seriously. This legislation reflects that listening, but it also reflects what happens and what must happen after that listening. which is action, to make sure that that listening is not in vain. It reflects that understanding that lived experience must be central to policy development in this area and to reform. These are technically complex reforms. Superannuation law and bankruptcy law are highly specialised areas. Any changes must be carefully designed to ensure that they are enforceable, workable and consistent with broader legal concepts. This bill adopts a targeted approach. It focuses specifically on circumstances involving criminal convictions for child sexual abuse offences and unpaid compensation orders. And that targeted design, that's important because it demonstrates that the government has sought to address a serious injustice while maintaining confidence in the broader superannuation framework. The bill also includes a review mechanism, once the reforms are in operation. And this is critical because legislation like this should not simply pass through Parliament and then be forgotten. It needs to have teeth and it needs to mean something. And we have an obligation to ensure these measures are working effectively for survivors in practice. Reviewing the operation of the reforms provides an opportunity to identify whether barriers remain and whether further changes may be necessary in the future. Listening to the experiences of survivors does not stop at the passing of this legislation. It has to continue. We need to ensure that these laws work for the people that they are intended to. Superannuation is one of Labor's proudest legacies. It reflects the long-term and responsible view that Labor took all those many years ago of Australians' future. That every Australian deserves the dignity and security of an independent retirement after a lifetime of hard work. And over more than 3 decades, our superannuation system has strengthened retirement incomes. It's reduced pressure on the age pension. It's helped deliver greater security and peace of mind for millions and millions of Australians. But the purpose of superannuation was never to shield predators from accountability. This bill ensures that those convicted of the most serious offences cannot exploit protections within that superannuation system to avoid paying compensation that courts have determined are owed to victim survivors. And in doing so, it protects both the integrity of the system and the principles of fairness and accountability that must always underpin it. This bill should also be understood as part of a broader journey of reform. It is a significant and necessary foundation. It closes a clear loophole. It sends a strong signal about the direction of reform, and it establishes a framework that can be built upon in the future if additional changes are required. Importantly, it also acknowledges something many survivors have told us for years, that justice systems and financial systems cannot operate separately from human consequences. When perpetrators retain substantial protected assets while survivors struggle financially, confidence in those systems is undermined. And confidence in those systems is important for every Australian, and particularly those who've experienced the hurt of those that we are talking about today. People rightly expect our laws to reflect fairness, to reflect accountability and to reflect community standards. And this legislation moves us closer to that. Deputy Speaker, at the beginning of my remarks, I spoke about the seriousness and sensitivity of this debate. I also spoke about the survivors and the advocates whose persistence has brought this issue to this place and before the Parliament. This bill will not undo the harm survivors have experienced. No legislation can, but it's an important step in the right direction.
I do thank the honourable member for the contribution, and the question before the House now is that this bill be read a second time. And with that, I give the call to the most honourable member for Cowper.
Thank you, Deputy Speaker. Can I start by firstly acknowledging all the victim survivors? We can stand in this place and speak to bills such as this one. We can work in the sectors that support victim survivors, but we can never understand what they have been through and the scars that they endure for the rest of their lives. So I'd just like to start by acknowledging them and their strength and their advocacy for those people who they support as well. Deputy Speaker, perpetrators of child sexual abuse should never be able to hide from justice or retribution. And our legal system should never provide those found guilty with loopholes to hide behind in plain sight. These heinous acts must be punished with the full force of the law and all the perpetrator freedoms. And I believe that these offenders have a special place reserved for them in hell. Deputy Speaker, I often speak about my time in the police as a country copper, then a detective and a prosecutor. And I saw some terrible things, countless fatalities, suicides, but nothing stuck with me like a child sexual assault or child exploitation material. That was the only thing that, when I left the police, continued to bother me. And as a result, I went into law and I made a decision there and then on day one that I would never take a brief for child sexual assault or child exploitation material. And I slept well every single night. Because, as I said, these people have a special place reserved for them in hell. And we can never know, never understand the true trauma that the victim survivors actually go through. We can watch it, we can observe it, we can walk with them, but we'll never understand it. And this is why this bill is so important. Victim survivors carry the scars inflicted upon them for life, through no fault of their own. They live with mental health challenges and stigma every single day, and in many cases, these ongoing impacts affect the survivor's ability to maintain healthy and positive relationships, including long-term employment opportunities and financial stability and security. And it is imperative that we as a government provide the framework to support those people. The bill we are discussing here today is a positive step and a necessary step, and I know will be a welcome relief for many of the contributors to the final iteration we see in the House today. It's been an excruciating wait over 8 years, Deputy Speaker, since the original coalition-led consultation that specifically dealt with the superannuation. And I'm sure that on both sides of the floor we agree with its swift and immediate passing in the best interest of all survivors of child sexual abuse and their families. These measures are entirely apolitical and bipartisan, so they should be. And I'd like to genuinely thank the Assistant Treasurer for his open and considered approach in relation to these issues to date. I'd also like to acknowledge the work of the former Coalition Minister for Financial Services, Kelly O'Dwyer, for making a start on these back in 2018. I do need to stress that this is the first step and that there is much more to be done when it comes to victims of crime more broadly. And I say that with the survivors and the advocates in mind. Please know that we have heard you and we know there are more considerations that must be captured as quickly as possible that this bill may not have directly addressed. To give credit where credit is due, I know that the Assistant Treasurer is committed to working through all the implications for the final steps. And with that, I'd like to run through the specific problem that this bill seeks to address and why it is critical that we do what we are doing. In the past, where an offender knows that they will be facing court, they have transferred assets into their superannuation in an attempt to avoid compensation to the victim survivor. That was a gaping loophole, Deputy Speaker, and one that was identified by victim survivors and advocates a long time ago. And you might ask, how could that possibly occur? And the answer is as simple as it is unethical. The perpetrators have hidden their assets in their superannuation, declared bankruptcy to having avoided to pay their victims the amounts they have legally been awarded through our justice system. Due to the historic protections around superannuation account, this evil loophole has been easily exploited. As I indicated, as a former prosecutor and later a defence lawyer, I'm well aware of the burden of proof in these cases lies squarely with the victim and prosecution. In order for a court to find an accused perpetrator guilty, the amount of evidence that needs to be supplied, retold and relived is as necessary as it is horrific. To know that a victim can be subjected to that torture, finally awarded with a guilty verdict and handed down compensation amount, only to have that compensation ripped away by a legal loophole that goes unchecked, is simply unthinkable. Well, this bill will now shut that loophole. By creating a court-supervised process for survivors of child sexual abuse to access certain superannuation amounts held by a perpetrator, this bill allows a court to order the release of the perpetrator's funds that were previously protected under superannuation law. It also allows a court to make an order to release superannuation information that was previously confidential. And this is important because transparency and strong deterrent will ensure that abuser can't hide their assets. Deputy Speaker, I would like to acknowledge and recognise the contributions of Carolyn Kelly. Carolyn is a solicitor, New South Wales solicitor in Port Macquarie. She's a grandmother to Eden Van Haren, a child who suffered horrific abuse at the hands of prominent CEO Maurice Van Ryn. Van Ryn was found guilty in July 2023 and ordered to pay compensation amounting to $1.4 million plus legal costs. To date, Eden has not received his court-directed amount, and that's due to Van Ryn's exploitation of the Bankruptcy Act. With Eden and his family in mind, we must pass this bill as swiftly as possible to immediately assist all victims currently left waiting and without their due compensation. I do want to note some of the concerns and suggestions from the Law Council of Australia and the Australian Lawyers Alliance and ask that we monitor cases closely once the changes begin. From the Law Council, it appears likely that once in place, the proposed framework will create a demand for legal assistance from victim survivors seeking to access the scheme. Consideration should be had to ensuring these reform measures are accompanied by adequate access to frontline legal services to ensure there is sufficient capacity to respond to the increase in legal needs. And from the Australian Lawyers Alliance, it would be possible for an offender to fund a contribution to the superannuation account of a third person, such as a family member or a friend, with an understanding that when that person becomes eligible for the benefit, they will remit a portion of their superannuation benefit to the offender. We have to ensure, Deputy Speaker, that closing this loophole does not open another one, and that victims are adequately supported to take advantage of the new legislation. But, Deputy Speaker, We will not let perfect be the enemy of good in this instance, and I fully agree with my colleagues around the floor. This legislation is critical, this legislation is just and considered, and this legislation must be passed immediately. Thank you.
I thank the honourable member for his contribution. The question before the House now is that this bill would be read a second time, and with that I give the call to the most honourable member for Griffith.
Thank you, Deputy Speaker. At the outset, I acknowledge victims and survivors of child sexual abuse, including those whose courage, persistence and advocacy have helped bring this bill before Parliament. Some survivors have spoken publicly, many have not. Some have shared their experiences in courtrooms, submissions, media conferences, meetings with members of Parliament, or quiet conversations with people they trust. Others have carried their story privately for many years, often without the recognition, support or justice they deserved. To every survivor who has contributed to this reform, whether publicly or privately, I say thank you. Your courage has helped change the law and your advocacy has helped secure this. Parliament sees a gap that should never have been allowed to remain. I also want to acknowledge the families, friends, advocates and supporters who have stood beside survivors through very difficult processes. I acknowledge the victims and survivors who spoke so powerfully before the introduction of this bill. Speaking publicly about trauma is never easy, and it can come at a real personal cost. When survivors choose to speak, this Parliament has a responsibility to listen with care, respect and with willingness to act. I acknowledge the organisations that have advocated for this reform over a long period, including Super for Survivors, Brave Hearts, the Grace Tame Foundation, Fighters Against Child Abuse Australia and the Carly Ryan Foundation. I also acknowledge members across this Parliament who have worked towards this reform, including the member for Boothby, the member for Eden Monaro, the member for Lyne, and members across the chamber, across parties and the crossbench who have supported this very important work. I thank the Assistant Treasurer and Minister for Financial Services and the Attorney-General for bringing forward this bill. Deputy Speaker, when we debate laws like this, we are speaking about people's lives. Children who were harmed, adults who have carried out that harm, and families who have stood beside the victims' survivors. We must approach this debate with care and avoid language that diminishes, sensationalises or turns a person's story into a political point. We should also recognise that survivors are not a single group with a single experience. Some seek public advocacy while others seek privacy. Some want court action while others do not, and some want to speak while some never will. All deserve respect and all deserve systems that are safe, fair and responsive. A survivor-centred response starts by recognising that the person who is harmed should not be forced to carry that cost alone. Justice can take many forms: being believed, a conviction, an apology, support to heal, or compensation that is actually paid. No single bill can meet every need, but this bill meets a real and serious gap. It gives survivors a new avenue for enforcement, makes it harder for perpetrators to use superannuation as a shield, and ensures bankruptcy cannot simply wipe away compensation debts owed to victims and survivors. Deputy Speaker, this bill goes to a fundamental principle. Perpetrators of child sexual abuse should not be able to hide behind financial structures to avoid accountability. For too long, a deeply unjust loophole has allowed convicted offenders to shield assets and superannuation while victims and survivors are left without the compensation that they are owed. That is not only a technical failure in the law, it is a failure of fairness, because when a court has recognised harm and ordered compensation, that order should mean something in the real world. A survivor should not be forced to endure the trauma of legal proceedings, secure a court order in their favour, and then find that the person responsible can avoid repayment by relying on protected financial structures. That compounds the harm and undermines confidence in the justice system. No law can undo the abuse that has occurred. No payment can erase the trauma or return the safety, peace or trust that may have been taken away. But compensation can still matter. It can help pay for counselling, healthcare, housing stability, education, work, care responsibilities, and the long process of recovery. It can also provide practical recognition that the person responsible must not be able to walk away from their obligations. Child sexual abuse can leave deep and lifelong impacts affecting mental health, physical well-being, relationships, education, employment, housing, trust, and a person's sense of safety in the world. And I do want to acknowledge all of the victim survivors who have come to me since I have been elected as the member for Griffith to talk to me about their personal experiences in our community with this. Some survivors experience financial insecurity, not because of any lack of effort or resilience, but because abuse can reach into every aspect of a person's life. That is why compensation should not be treated as an abstract legal debt. We are speaking about the cost of therapy, medical care, lost opportunity, instability, and years of navigating trauma without adequate support. We're speaking about dignity. Under these reforms, where a related court-ordered compensation debt remains unpaid after 12 months, victims and survivors of child sexual abuse will be able to seek access through a court order to certain superannuation contributions made by the offender. This includes additional personal contributions and salary sacrifice contributions, which have previously been able to operate as a vehicle for shielding assets from enforcement. Victims and survivors will also be able to apply to the Australian Taxation Office with appropriate safeguards to identify whether there may be eligible superannuation before deciding whether to seek a court order. Without visibility, a survivor may be left in the dark, facing cost, uncertainty and stress before they even know if a pathway exists. This bill improves transparency, gives survivors more information and makes it harder for perpetrators to wait out their obligations while their financial position remains protected. This is not an unlimited or automatic access regime. The bill is targeted and it is designed to address the misuse of particular superannuation contributions as a shield against lawful compensation. Superannuation and bankruptcy systems are highly technical and changes must be carefully designed so they are effective, enforceable and consistent with broader legal principles. But the technical nature of the system should never obscure the human reality. If a person has been convicted of child sexual abuse and a court has ordered compensation, they should not be able to use complex financial arrangements to avoid responsibility. Financial manoeuvring must not override moral and legal responsibility. The bill also amends the Bankruptcy Act to allow compensation debts to survive a perpetrator's bankruptcy. Bankruptcy should not become a refuge from accountability for such serious harm. A survivor should not finally receive a compensation order only to see that obligation disappear because the perpetrator enters bankruptcy. These are not ordinary debts. They arise from profound harm, from abuse, and from conduct that has damaged lives. Allowing those debts to survive bankruptcy sends a clear message that accountability does not end because a perpetrator's financial circumstances change. The bill also recognises historical injustice. Unfulfilled historical compensation orders brought into existence before commencement will be eligible if they remain largely enforceable and were awarded in relation to a criminal conviction or finding of guilt for child sexual abuse. This reform is also for survivors who have already fought for recognition, endured the legal process and still have not received what they are owed. Deputy Speaker, the bill also reflects a trauma-informed approach by protecting the identity of victims and survivors. Certain courts must not publish the name of the victim in relation to these proceedings or related appeals. For a survivor, privacy can mean safety, dignity and control. It can be the difference between being able to seek justice and being deterred from taking another step. A justice system that asks survivors to come forward must also take seriously the risk of re-traumatisation. It must not force people to give up their privacy in order to enforce their rights. Deputy Speaker, I come to this debate informed by my work on the Joint Standing Committee on Implementation of the National Redress Scheme. After joining this Parliament about a year ago now, I asked to be nominated to serve on this committee because I believe deeply in its work. Before coming to this place, I worked with children and young people for more than 2 decades, and I know how important it is that every child is safe, supported and protected by the adults and institutions around them. The Joint Standing Committee has a critical role in examining whether the National Redress Scheme is delivering what it was intended to deliver: acknowledgement, accountability, and a small measure of justice for people who experienced institutional child sex abuse. As a member of that committee, I have heard firsthand from people who have carried the trauma of childhood sexual abuse for years, often for decades. I have heard harrowing accounts of abuse, of institutions that failed to protect children, and the systems that too often required survivors to keep proving their pain before they could be heard. Those experiences stay with you. They reinforce why redress must be more than formal recognition. It must be practical, accessible, and grounded in the lived experience of survivors. Deputy Speaker, I also want to acknowledge the extraordinary work of Micah Projects and their Lotus Place program based in Stones Corner in my electorate of Griffith. Lotus Place provides a safe and trusted place for people living with lifelong impacts of institutional childhood abuse, including forgotten Australians, former child migrants, care leavers, and people seeking redress through the National Redress Scheme. They help people understand their options, navigate complex systems, seek redress, access support, and rebuild connection, dignity, and trust. For many survivors, that kind of support can make the difference between a system that feels impossible to face and a process where they are not left to walk alone. The team at Lotus understands that redress is not just paperwork. It is often tied to some of the most painful experiences in a person's life. It requires patience, care, trust, and an understanding of trauma. It requires listening without judgment, supporting people at their own pace, and recognising that every survivor's path is different. In our community, Micah Projects has long shown what survivor-centred support looks like in practice. I want to acknowledge their team leader, Mark Reimers, and their entire team. When I went to meet with the team at Lotus Place recently, I was expecting a meeting with one or two of their team, and their entire team showed up and sat around the table because of the importance of the work they're doing and how passionate they are about representing and supporting the victim survivors in our community. I thank Micah Projects, Lotus Place, and every worker across our country and every advocate who supports survivors through this difficult and important work. Deputy Speaker, when offenders retain substantial retirement savings while victims struggle financially, often as a direct consequence of the abuse they suffered, confidence in the justice system is undermined. It tells survivors that the system may recognise their harm in one breath and then protect the perpetrator's assets in the next. That's not fair. This bill helps shift that burden. It says that if the perpetrator owes compensation and if they have used certain superannuation contributions to protect assets, there must be a pathway for survivors to pursue what they are legally owed. It's a practical reform, but it's also a values statement. It says our financial system should not be misused to avoid accountability, and our legal system should not unintentionally protect those who have caused profound harm. Deputy Speaker, this bill is a significant and necessary foundation. It closes a clear loophole, sends a strong signal about the direction of reform, and creates a framework that can be built upon in the future. The bill also provides for a full review after commencement to assess whether the law is operating effectively for victims and survivors, and that review will be critical. We will need to know whether survivors can access the information they need, whether the court process is workable, and whether legal costs or delays remain barriers. In communities like Griffith and right across Australia, people expect the law to reflect basic fairness. They expect that when a court says compensation is owed, the law will not then make the compensation impossible to recover. This bill aligns our laws more closely with those expectations. Deputy Speaker, this bill has been shaped by the voices of people who know, far better than any of us, what it means when the justice system recognises harm but still does not deliver redress. To survivors who have advocated for this change, thank you. To the families and supporters who have stood beside them, thank you to you also. To the organisations who have kept this issue on the agenda, I say to them also thank you. And to the members of this Parliament from both sides of this chamber who have worked constructively across party lines, I thank all of you. Deputy Speaker, this bill is about restoring fairness and dignity. It's about ensuring that the law does not inadvertently protect those who have caused profound harm while leaving victims and survivors without recourse. It is about recognising that justice must be more than words on a page. It must be felt in people's lives. It is about making clear that this Parliament is committed to continuing this work, to listening, improving and building on this foundation.
I thank the honourable member for the contribution. The question before the House now is this bill be read a second time, and with that I give the call to the most honourable member for Lyons.
Thank you, Deputy Speaker. I rise today to speak on the Treasury Laws Amendment Survivors Law Bill. I came to this Parliament to help make Australia a better place, to stand up for people facing injustice, especially those who too often feel invisible, unheard or left behind by the system. This bill is one of those moments where I can play a very direct role in this Parliament to genuinely change lives for the better. Today we have a chance to fix a serious injustice that has hurt survivors of child sexual abuse for far too long. For years, convicted offenders have been able to avoid paying court-ordered compensation to their victims simply by declaring bankruptcy and shielding assets through superannuation laws. That is simply wrong. And for survivors, it can feel like being failed by the system all over again. Not just once through the abuse they suffered, but again by a legal system that allowed offenders to escape accountability. This issue was brought directly to me by one of my constituents, Carolyn Kelly, a strong, determined and deeply compassionate woman who refused to stay silent after seeing the injustice her grandson, Eden Van Haren, experienced. Carolyn did not come to me asking for sympathy. She came asking for justice. And she has fought tirelessly, not just for her grandson, but for survivors right across Australia who deserve fairness, dignity and recognition. After meeting with Carolyn in my office in Wauchope and hearing Eden's story, it became immediately clear to me that the law needed to change, particularly when it was obvious there were already many other legal precedents where certain debts survive bankruptcy. Child support debts survive bankruptcy. Certain fraud-related debts survive bankruptcy. Some debts owed to the government survive bankruptcy. So how could it possibly be the case that compensation owed by a convicted paedophile to their victim could simply disappear? That made no moral sense, and frankly, it made no common sense either. So I took the issue directly to the Minister. I advocated strongly for reform through parliamentary speeches and through a submission to the government's discussion paper on the exposure draft to this bill. And today, I want to sincerely acknowledge and thank the Assistant Treasurer and the government for listening, for engaging seriously with this issue and for acting. In this place, difficult reforms can sometimes take years to progress. So when governments are prepared to genuinely listen to survivors and to opposition members and respond constructively, that certainly deserves recognition. This legislation exists because brave people refuse to give up. Eden Van Haren is a survivor of horrific abuse. Following civil proceedings in the Supreme Court of New South Wales, he was awarded compensation by the court. But the offender later declared bankruptcy from prison, effectively avoiding responsibility for paying that judgment debt. That should never have been allowed to happen. And I want to acknowledge Eden's extraordinary courage in speaking publicly about his experience so that others may not have to endure the same injustice. Eden said something incredibly powerful in a speech that I wish he could deliver in this chamber. In it, he said, "This is not about vengeance, it's about the mechanics of healing." Those words go to the very heart of why this legislation matters, because this debate is not really about money. No amount of money can restore a stolen childhood. No amount of money can undo years of trauma. No court ruling can fully repair the damage caused by abuse. And as Eden so powerfully explained, how do you even begin to quantify trauma? How do you put a monetary value on not being able to hold down a job because of PTSD? How do you quantify the panic and fear triggered by ordinary daily tasks that most people take for granted? How do you measure lost confidence, lost opportunities, broken relationships, or the life someone should have had. The truth is you cannot. But compensation still matters, because compensation is about recognition. It's about accountability. It's society saying to survivors, we hear you and we believe you, and what happened to you was wrong. When the legal system allows offenders to use bankruptcy laws or protected superannuation to avoid those obligations, it sends exactly the opposite message. It tells survivors that the system still protects perpetrators more than victims. That is why this bill matters so much. The bill has two principal objectives. First, it creates a mechanism to allow certain amounts held in a perpetrator's superannuation to be accessed in order to satisfy unpaid compensation orders relating to child sexual abuse offences. Secondly, it amends the Bankruptcy Act so that these compensation debts survive bankruptcy and cannot simply be wiped out. These are significant reforms. Now, I acknowledge this bill is legally and technically complex. It intersects with criminal law, family law, bankruptcy law, taxation law and superannuation law. There are detailed provisions dealing with competing claims, court oversight and interactions with other legal processes. And I acknowledge the considerable work undertaken by officials, legal experts and ministers to bring the legislation to this point. But while the legislation itself is technically complex, its moral purpose is actually very simple. If a court has ordered compensation to be paid to a survivor of child sexual abuse, an offender should not be able to evade responsibility through legal loopholes. This legislation also recognises something important about the purpose of superannuation. Superannuation exists to provide dignity and security in retirement. It was never intended to become a shield that allows perpetrators to avoid accountability for horrific crimes. And as the bill itself makes clear, these powers are limited to exceptional circumstances and operate under court supervision. Put simply, you cannot commit a heinous crime and then expect to hide behind your superannuation or hide behind bankruptcy. Nor should human rights arguments be distorted in ways that deny justice to survivors. Importantly, this bill also sends a much broader message to victim survivors across Australia. Many survivors still suffer silently. Many still struggle to trust institutions. Many still feel shame for crimes committed against them. And too many still feel the system is not truly on their side. Eden spoke movingly about reaching a point in his life where, in his words, the pain of existing was heavier than the fear of dying. Those words should stop every one of us in our tracks, because behind every statistic is a human being carrying an unimaginable pain. But Eden also said something else that speaks to remarkable courage and resilience. He said, "In surviving that moment, I realised, why not stay alive for the other victims?" That courage deserves the respect of this Parliament and this nation. And this legislation matters because it tells survivors they are not alone. It tells them their suffering matters, it tells them their accountability matters, and it tells them that Parliament is prepared to act. Now, this bill may not resolve every issue. There may well be aspects that require refinement or strengthening in the future. But the most important thing we can do today is finally close these loopholes so offenders can no longer abuse the system to avoid paying court-ordered compensation to survivors. I want to again acknowledge Carolyn Kelly for her determination and advocacy. I want to acknowledge all survivors who've spoken publicly and relived unimaginable trauma in pursuit of this reform. And I want to acknowledge all those across government, departments, advocacy organisations and the legal profession who've worked to bring this legislation forward. Most importantly, I acknowledge survivors like Eden, whose bravery has helped drive meaningful change for others. As Eden said, it's time for Australia to heal. I commend this bill to the House.
I do thank the honourable member for that contribution. The question now is that this bill be read a second time, and with that I give the call to the most honourable member for Boothby.
Thank you, Deputy Speaker. Working in the homelessness sector brings you into contact with many people who have experienced trauma. It's a very common story to hear that someone who in later life becomes homeless turns out to have a trauma history. Trauma has a long tail. We would hear from people who turned up in the homelessness system about various forms of trauma at various stages of life, and perhaps the most heartbreaking stories were those whose experience of trauma was as a child. We're also hearing similar stories from those who are giving evidence at the inquiry into the link between family, domestic and sexual violence and suicide. They tell of lives riven by the inability to trust, the inability to form relationships, be they intimate partner relationships, collegial work relationships, family relationships or friendships, the inability to hold down a job, and the impact of triggers, seemingly minor things, a word, an aroma, a familiar environment, a song, that would catapult them back into their trauma, into panic, into helplessness, into fear and into distress, fight, flight or frozen, back into their childhood, back into their trauma. The damage done to the child in so many instances remains with them long after the abuse stops, chasing them into adulthood. For many years, just as their abusers had told them would happen, survivors were not believed, and so they kept it inside. The heavy silence, which for decades was a feature of our collective response, is unforgivable. For far too long, there's been a culture of secrecy and avoidance when it comes to confronting the realities of child sexual abuse. This culture extends not just to the abuse itself, but to the structures of justice and redress that should be supporting the most vulnerable individuals in our communities. And Deputy Speaker, I was shocked when I found out that in our existing legal framework, perpetrators can evade paying their victim survivors court-ordered compensation by hiding assets in superannuation and declaring bankruptcy. This is the experience of Eden Van Haren, who lives in my electorate of Boothby. Eden is a victim survivor of child abuse. He's very kindly given me permission to tell his story and use his name in my speech. Unusually, Eden has managed to get both criminal and civil convictions against his perpetrator. And I say unusually because we know that few cases are disclosed, few cases make it to court, and it's difficult to establish evidence and prosecute years, sometimes decades after the fact. In 2023, the New South Wales Supreme Court ordered that Eden's abuser pay out $1.4 million to him in compensation. And from his jail cell, Eden's abuser declared bankruptcy. This meant that the payments that Eden's abuser would ordinarily have had to have paid would become void while protecting his assets in superannuation. A deliberate and brazen exploitation of our laws that is nothing less than malicious, designed to inflict more pain, more hurt, more trauma. The perpetrator is reaching out from their jail cell and exerting power over their victims all over again. And thousands of other victim survivors today remain exposed to these underhanded and callous tactics. The Treasury Laws Amendment Survivors Law Bill 2026 seeks to rectify this shortcoming in our financial structures. It will close a loophole by which perpetrators who have been criminally convicted can avoid paying settlement to their victim survivors. It will ensure that superannuation is no longer a haven in which perpetrators can seek financial refuge. It will deny perpetrators the opportunities that exist in our current framework to evade accountability, and it will affirm the bravery and dignity of victim survivors who, having endured so much, continue to endure on their road towards justice. The bill seeks to do two things. It gives victim survivors access to additional contributions in their offender superannuation in order to satisfy unpaid compensation orders, and it ensures that compensation debts are not extinguished where the offender has declared bankruptcy. Where offenders fail to meet their legal obligations to satisfy a compensation claim within 12 months, victim survivors will be able to apply to the ATO for information about the perpetrator's superannuation in advance of applying for a court order. Victim survivors will then be able to apply for a court order to access certain superannuation contributions of their abuser. Perpetrators will have no recourse to wait out a court order while shielding their assets in their superannuation in order to defeat a compensation claim. Victim survivors will therefore have another tool to be able to enforce unpaid compensation. The bill will also amend the 1966 Bankruptcy Act to ensure that it continues to fulfil its intended purpose of allowing those in financial distress to make a fresh start, but it will no longer facilitate convicted child sex abuse criminals being able to avoid paying court-ordered compensation. Such debts will now survive a declaration of bankruptcy, applying to both current and future bankruptcies. This bill seeks to reset the scales in the victim survivors' favour by giving victim survivors real and substantive tools to pursue court-ordered compensation at the end of what is often a long and traumatic process of litigation, and by realigning our financial and legal structures with those values which are at the heart of victim survivor redress: justice, fairness and accountability. And by removing the barriers to victim survivor compensation, we avoid compounding survivors' harm, trauma and distress. Of course, this bill is not a magic bullet, it is a first step. Superannuation and bankruptcy are complex and technical legal terrains that require complex and technical legislative responses, and it is the government's intention to get this right. But this bill provides the foundation on which conversation can be had and maintained, the foundation on which future reforms are now conceivable. As I wrote in my submission to the 2023 consultation, I am particularly committed to seeing these changes in the future embrace civil, not just a criminal component. Where an abuser has been found liable in a civil proceeding, where a judge has looked at the evidence and decided on balance that abuse did occur, even though there may not be a criminal conviction, victim survivors should have the same ability to enforce compensation. But that is for another time, and this legislation now is a very welcome first step. And because the government wants to get these changes right, the changes will later be subject to review. And such a review will ensure that these new mechanisms are practical, enforceable and adhere to legal principles, that they are making a genuine difference in survivors' lives and that they are working for survivors and not against them. And the government will continue to consult with those voices that have been instrumental in the creation of this bill: victim survivors, advocates and legal experts. It is no small thing to have to relive childhood abuse. In fact, it takes a courage that most Australians will never in their lifetime have to muster, and hopefully will never have cause to need to muster, especially when it can feel like you are shouting into a void. Can I therefore thank victim survivors, their advocates and supporters for speaking out, for sharing their stories and for continuing to share their stories. Be in no doubt, your efforts have changed lives and will continue to change lives far into the future. For victim survivors, conviction, where it can be had, is not the end of it, and nor is compensation for that matter. There can be no monetary value on the trauma and pain that victim survivors experience, but compensation can assist in rebuilding a life. And beyond compensation, what this bill hopes to do is deliver justice, a justice that victim survivors have already had to fight long and hard for, or what Eden has termed mechanics of healing. Eden's advocacy is not necessarily about himself, although it goes without saying that his story is absolutely important. It is about fixing a fault in the system that enables perpetrators to not only evade the consequences of their actions, but to continue to victimise their victims through financial means. Eden has asked me to read his words to this House, and it is as follows. My name is Eden Van Haren. I am a survivor. For years now, I have fought to close legal loopholes that allow the architect of a child's trauma to hide behind bankruptcy laws and protected superannuation, laws that pedophiles use to further abuse their victim survivors. This is not about vengeance, it is about the mechanics of healing. Compensation payments attempt to quantify pain and suffering, but how do you quantify the pain caused by not being able to hold a job, or the pain you feel when someone asks you for something as simple as, "Can you do the dishes for me?" and suddenly you're right back there reliving everything? How do you put a monetary value on not being able to add a time schedule to your to-do list, because even telling yourself that something needs to be done triggers your PTSD and now you can't even get yourself out of bed? The answer? You can't. The legal system can't give me back the life and the potential I have lost, so it does the next best thing and puts a monetary value on it, because that's all we have. But for too many years, pedophiles have been able to hide assets, sequester funds in superannuation, and worst of all, declare bankruptcy to extinguish the compensation our courts have awarded them. This in particular added to the pain and suffering. At 20 years old, I tried to end my life. I reached a point where the pain of existing was heavier than the fear of dying. But in surviving that moment, I realised, why not stay alive for the other victim survivors? When you have already walked to the edge and looked over, you lose the ability to be intimidated. I am here because I have nothing left to fear and everything to fight for. That was Eden's words, and I'd like to thank him for his advocacy, for his bravery in pursuing his perpetrator and exposing his evil with both criminal and civil convictions. It takes guts to face your perpetrator in an adversarial legal process. Eden's advocacy and the advocacy of so many others, including lawyer Andrew Carpenter, is what has made a difference. It will change the law now, and it will help, sadly, the so many other victim survivors in the same situation. I'd also like to thank former Assistant Treasurer Stephen Jones, who started this process with a consultation in 2023, which I submitted to, and the Assistant Treasurer Daniel Molino, who picked up the baton and kept the journey to get this done. And to Eden and all the other survivors and advocates, I know for you this is only the start. There is much more you are fighting for. You want recognition of civil findings, not just criminal findings. You want all superannuation on the table, not just additional payments. After all, if somebody is going to be living in poverty as a result of this heinous criminal activity, it should be the perpetrator, not the survivor victim. This legislation is a really important step forward, and I know that you will keep pushing for the next steps, and I want you to know that this government hears you, I hear you, and I will keep working with you. Changing these laws is more than just providing access to financial compensation. It is recognition, it is support, it is the delivery of justice. It is saying to every victim survivor in Australia, we hear you, we stand by you. We are on your side. This bill needs to be passed for the silent pandemic, the hundreds of thousands of Australian victim survivors whose lives were irrevocably changed through no fault of their own and who are suffering. I commend the bill to the House.
I do thank the honourable member for the contribution. The question before the House now is this bill be read a second time. And with that, I give the call to the most honourable member for Warringah.
Speaker, and this is an incredibly important legislation because it does, I think, honour the incredible bravery of so many in coming forward to highlight this problem and people who have already been through so much to get to this point, victims of child sexual abuse. So this bill is built on a simple proposition. A compensation order made by a court should mean something. We would think that that goes without saying. It should not be possible for a convicted child sexual abuse perpetrator to hide assets in superannuation, declare bankruptcy or escape accountability, because this leaves a survivor holding a court order that is, in practice, worth less than the paper it's written on. Superannuation exists to provide dignity in retirement. It was never intended to become a legal bunker for people seeking to avoid accountability for serious crimes. The bill establishes a framework for survivors of specified child abuse offences to seek visibility of and access to certain superannuation amounts held by perpetrators where compensation remains unpaid. It also amends the Bankruptcy Act so that relevant compensation debts are not extinguished by bankruptcy. This is not about turning superannuation into a general compensation pool. It's targeted, it applies to victims and survivors of specified child abuse offences where there has been a conviction or a finding of guilt and where a court has made a compensation order and where that order remains unpaid. The bill does not create a compensation from scratch. It makes existing court order compensation enforceable by giving survivors a targeted pathway to recover unpaid debts from certain superannuation amounts, while sitting alongside proceeds of crime laws rather than replacing them. It's long overdue reform. Survivors have already had to endure the abuse, the trauma, the legal process and the indignity of chasing accountability through systems that too often exhaust them before they deliver justice. No community, including mine in Warringah, is immune from the curse and the scourge of child sexual exploitation. Warringah is comprised of communities built around families, schools, sporting clubs, surf clubs, multi-faith communities and small businesses. But there are also communities where survivors live, work, study, volunteer, raise families and rebuild their lives. Nationally, the data is really confronting. The Australian Child Maltreatment Study found that 28.5% of Australians aged 16 and over have experienced child sexual abuse. That's quite confronting, 28.5%. It also found that child sexual abuse is often repeated, with 78% of those experiencing it reporting that it happened more than once. And the Australian Bureau of Statistics has also reported that 7.5% of adults experience sexual abuse before the age of 15, and that the majority of women who experience childhood sexual abuse never told police. In New South Wales, police recorded sexual assaults has increased significantly over the past decade, with Boxar reporting that recorded child sexual assault incidents increased by around 10% per year over the decade to June 2025. So this is no small problem. These numbers remind us that this is not an abstract legal issue. This is real, impacting real lives, and the ongoing consequences are often long and really, really damaging. It's about people who have already had agency stolen from them, who should not then be forced into another grinding battle simply to enforce a lawful compensation order. So I do very much welcome this legislation. It's important to be clear again that this legislation is, it's not creating a right or a compensation from scratch. It's simply, courts can already make compensation orders requiring perpetrators to pay survivors. The problem is that when an order does not always mean payment, despite the pain and the difficulty of going through court processes and getting to a compensation order and a finding of guilt through the courts. If a perpetrator refuses to pay or hides money and assets in superannuation, relies on bankruptcy provisions, then survivors can be left without any practical redress, despite findings of guilt, despite compensation orders. So this bill is about enforcement. It helps ensure that a lawful compensation order is not just symbolic, but can actually lead to recovery of funds that will help those survivors. I've previously spoken in this place about child sexual abuse as one of the most serious violations a person can experience, and about the Royal Commission's finding that institutional child sexual abuse was a national tragedy. I've also supported reforms to make the justice system more victim-centred, while making clear that further reform would be needed. The survivors' law is one of those further reforms. The problem this bill addresses is painfully specific. Survivors may obtain a compensation order through criminal or civil proceedings, but if the perpetrator does not pay, the survivor is left to enforce that order. In some cases, perpetrators have been able to shift wealth into superannuation or rely on bankruptcy in ways that make compensation far harder to recover. And that's, I would argue, a grotesque outcome. The law recognises the harm, a court has ordered the compensation, yet the survivor in our system still enabled that avoidance of responsibility and payment, and it denied practical redress to survivors. Public reporting has shown why reform is needed. Survivors and advocates, including Grace Tame and others, have campaigned for years to close this loophole. In one reported case, survivor Eden Van Haren was awarded $1.4 million in damages, while the perpetrator declared bankruptcy and his superannuation remained protected. That's unacceptable. There are legitimate reasons why superannuation is protected, but in these instances, I welcome this legislation change. People should not generally be able to raid another. We need to protect retirement savings. I absolutely agree with that primary position, but we should not be able to have criminals use the superannuation system to hide and move assets around. And so again, I think this is very welcome legislation. The Supers Members Council has put that superannuation is a safe haven for most Australians' future, but should not be from justice. The bill strikes the right balance between caution and urgency. The key question is whether this bill responds proportionally to the problem. The bill creates the pathway for survivors to apply to the Commissioner of Taxation for information about a perpetrator's superannuation. That matters because survivors often don't know where a perpetrator's superannuation is held and whether there are amounts that may be available. The survivor may then apply to a court for an order releasing certain amounts from superannuation where compensation remains unpaid after 12 months. It's important to understand that this is distinct from proceeds of crime laws. Proceeds of crime laws are generally about the state confiscating assets linked to criminal offending. So this bill is very different. It's about ensuring unpaid compensation reaches survivors. It's targeted and practical, as I've said. Again, this bill is about accountability. It also addresses bankruptcy. Compensation debts owed to survivors of specified child abuse offences will not be extinguished by a perpetrator's bankruptcy where the relevant criteria is met. That is important. And I also welcome the fact that historical compensation orders may be eligible provided they are still legally enforceable. And I hope that results in finally payment to so many that hold compensation orders. Again, I commend this bill to the House. I thank everyone who has so actively campaigned and advocated for these changes. I can't begin to understand the trauma and the difficulty for so many, but if this plays a small part in helping gain redress, I welcome it.
I thank the honourable member for the contribution, and the question before the House now is this bill will be read a second time, and with that I give the call to the most honourable member for Bonner.
Thank you, Deputy Speaker. The Australian Child Maltreatment Study estimates that around 1 in 4 Australians aged 16 years and over have experienced child sexual abuse, with females twice as likely to have experienced child sexual abuse than males. These estimates are conservative because they do not include many online forms of child sexual abuse. The Australian Centre to Counter Child Exploitation has reported that online child sexual abuse and exploitation has grown exponentially in recent years. We must also acknowledge that child sexual abuse rarely occurs in isolation. 78% of victim survivors of child sexual abuse said the abuse occurred more than once. 42% said it occurred more than 6 times. 11% said it occurred more than 50 times. These numbers are confronting and very sobering. But behind every statistic is a person, and not just a person, a child whose trust was violated, a child whose safety was stolen, a child who was failed by adults and by systems that were supposed to protect them. Deputy Speaker, legislation like this is one of the reasons I came to this place, because legislation like this, supported in a bipartisan way, reminds us of the power of this Parliament to effect meaningful change for some of the most vulnerable in our society. This reform should remind us all in this chamber that some issues rise above politics. Protecting children, supporting survivors, ensuring accountability for perpetrators, these are not partisan values. They are national values. And for too long, perpetrators of child sexual abuse have been able to hide assets in their superannuation, shielding wealth, evading accountability, and denying survivors compensation they are owed. That is not simply a loophole, it is a profound failure of our system. Justice must be more than words on paper. Justice must be real, enforceable, and meaningful. It must be felt by those who have already endured the unimaginable. Survivors of child sexual abuse carry with them a burden that no person should have to bear. We've heard many accounts in this chamber over the last day and today about the trauma and the grief, and that they're carrying the lifelong impacts of crimes committed against them when they were at their most vulnerable. For too long, many survivors have carried something else as well. The knowledge that even after finding the courage to come forward, even after fighting through the courts, and even after securing a judgment in their favour, they could still be denied that compensation. Denied because perpetrators manipulated the system and offenders hid their assets in superannuation accounts. And denied because bankruptcy protection was used in calculated ways to avoid paying compensation owed to those survivors. That is not justice, it is injustice compounded, and survivors should never have to fight for justice twice. Deputy Speaker, we know from the Royal Commission into institutional responses to child sexual abuse that many survivors do not disclose abuse for years, sometimes decades, sometimes never. Not because they are unwilling to speak, but because trauma does change people, and because shame also silences people. Many survivors have been manipulated into believing that what happened to them was somehow their fault. And for many survivors, pursuing civil action is not about financial gain. It is about acknowledgement and accountability and having a court formally recognise the harm that was done to them. That process can take years. It can involve reliving trauma repeatedly through court proceedings, medical evidence and cross-examination. As a former lawyer, I have seen that happen over and over again through our court systems, not just in circumstances of child sexual abuse, but also in domestic violence and criminal cases. And after all of that, after finding the courage to come forward and after enduring the re-traumatisation that legal processes can involve, survivors should not have to discover that their entitlement to compensation can be defeated through financial engineering. That is why the Albanese Labor government has introduced this legislation known as the Survivors' Law, a reform that sends a clear and unequivocal message. There is no place in our system for perpetrators to exploit legal and financial structures to evade responsibility for the harm they have caused. This reform did not emerge in isolation. It is the product of years, indeed nearly a decade, of tireless advocacy under this government and the former government. It built on the voices of survivors, the determination of advocates, and the courage of individuals who refused to accept that the system should work against those it was meant to protect. I want to acknowledge those survivors who shared their stories publicly, often at enormous personal cost. Those who relived trauma in pursuit of reform. Those who persisted despite setbacks, delays and disappointment. Their courage has driven this legislation. Their advocacy helped shape it, and their voices will continue to guide future reform. The problem we are addressing is clear. Under existing arrangements, superannuation has in many cases been treated as an untouchable asset, effectively beyond the reach of civil compensation processes. Perpetrators have exploited this reality. They have structured their finances to minimise visible assets while transferring wealth into superannuation accounts. In some cases, millions of dollars have been shielded. Some offenders have even declared bankruptcy while significant funds remained in superannuation accounts and out of the reach of the very people they harmed. The law has not kept pace with the reality of how these individuals operate. That is the loophole, and we have a duty to close it. Through this legislation, we will be doing exactly that. This bill ensures that where there is a valid court order for compensation relating to child sexual abuse and where the compensation remains unpaid, victim survivors may seek access to certain superannuation contributions made by the perpetrator. Specifically, this includes additional contributions such as voluntary contributions and salary sacrifice amounts paid into superannuation accounts. This is a targeted reform. It does not dismantle Australia's superannuation system, nor does it undermine the broader principle of retirement saving protections. What it does do is ensure that superannuation can no longer be weaponised as a shield against accountability. Importantly, the bill also amends the Bankruptcy Act to deliver practical and enforceable change. Under existing settings, superannuation is largely protected during bankruptcy proceedings, even where an individual has substantial outstanding liabilities. This bill makes clear that such protections must not extend to circumstances where they are being used to avoid paying court-ordered compensation to victim survivors of child sexual abuse. Specifically, the amendments enable trustees and courts to identify and recover certain superannuation contributions that would otherwise remain shielded. These are funds that in many cases were deliberately channelled into superannuation to place them beyond reach. By bringing their contributions within scope, the bill ensures that the true financial position of a perpetrator can be considered and that bankruptcy cannot be strategically used to frustrate justice. Alongside these changes is a carefully designed mechanism involving the ATO. For many survivors, a key barrier has been the absence of information, whether superannuation assets exist and whether pursuing legal action is likely to result in any meaningful outcome. This bill also addresses that gap. Victim survivors will be able to apply to the ATO for limited information about a perpetrator's superannuation interests for the purpose of informing a decision about whether to seek a court order. Importantly, this is not an unrestricted disclosure regime. It is a tightly controlled, subject to strict eligibility and supported by safeguards. Requests will only be available where there is a relevant connection to the child sexual abuse claims, and the information released will be limited to what is necessary to indicate whether eligible superannuation contributions may exist. These technical measures matter. They ensure survivors are not forced to pursue costly and re-traumatising legal action without knowing whether assets are actually available. They provide transparency and they reinforce the principle that our legal and financial systems must not be capable of being manipulated to avoid accountability. Together, these amendments transform this reform from principle into practice, delivering a system that is fairer, more transparent and more firmly on the side of survivors. Deputy Speaker, there are complexities in this legislation, particularly regarding civil findings and broader retrospective application. These issues must be worked through carefully and responsibly. That is why this legislation includes mechanisms for review and ongoing assessment of how the law operates in practice. In developing this legislation, the Albanese Labor government listened closely to survivors and advocates. In January 2023, the government released a discussion paper exploring options to better support victims and survivors of child sexual abuse. The government listened to feedback and acted on it. As a result, the bill was strengthened. The scope of accessible contributions was expanded and certain defined benefit accounts were brought within scope in appropriate circumstances. Likewise, the look-back provision for contributions was extended because we know financial manipulation often occurs over a longer period of time. These changes matter because they reflect the lived experience of survivors and practical reality of how perpetrators act. They will help ensure this reform is not merely symbolic but actually effective. I also want to say clearly to victim survivors that this legislation is an important milestone, but it is not the final destination. There are further issues requiring consideration and there may be additional reforms needed in the future. Parliament must continue to listen to survivors, continue examining how systems can be weaponised against vulnerable people and continue identifying opportunities for reform. That is our job in this place. I want to again acknowledge the persistence of survivors, advocates, community leaders and organisations who brought this issue to national attention. Those whose stories again and again they were told in the hope that someone would finally listen. I particularly acknowledge those who stood alongside the Assistant Treasurer and Minister for Financial Services, Dan Molino, when this legislation was introduced. I was proud to stand there on that day and hear the words of Eden Van Haren, who said, "As a survivor of child abuse, I stand here not just for myself, but for every child who hasn't found their voice yet. This is not just a personal issue, this is a community responsibility. As a country, we need to do better. We need stronger laws and we need longer sentences for offenders. They must have real consequences for the lives that they destroy. It takes all of us, and it starts with these laws." I want to acknowledge advocates like Eden who transform deeply personal pain into a campaign for change that will benefit others. I also want to acknowledge organisations in Queensland like Brave Hearts and the Daniel Morcombe Foundation who do extraordinary work advocating for victim survivors for legislative change over not just years but decades, and continue to work every single day to keep our kids safe. Deputy Speaker, the Albanese Labor government will not stop until we are confident that our systems are delivering for survivors and protecting the most vulnerable members of our community. Child sexual abuse is one of the most abhorrent crimes imaginable. It leaves lifelong scars, physical, emotional and psychological, and it is committed against those who are least able to protect themselves. It demands a response that is compassionate, practical and strong. No law can undo the harm of child sexual abuse. No legislation can restore what has been taken. But this Parliament can decide whether our system protects perpetrators or it supports survivors. This bill makes that choice clear. It closes a loophole that never should have existed. It strengthens important accountability, and most importantly, it tells survivors that this Parliament has heard them and that their voices matter. I commend the bill to the House.
The question is that the bill be now read a second time, and I give the call to the member for Wide Bay.
Thanks, Deputy Speaker. I rise to speak in support of the Treasury Laws Amendment Survivors Law Bill 2026 because at its heart it's about a simple proposition. Perpetrators of sexual crimes against kids should not be able to manipulate the laws and to avoid financial compensation for their crimes. And survivors should not be forced to keep fighting for justice. Under the current laws, superannuation is generally protected from creditors. That protection is important for most Australians, but it has created a loophole that has been manipulated by criminals and in this case, the most evil people in our society. We have seen circumstances where offenders have moved assets into superannuation or declared bankruptcy, and in doing so sought to sidestep court-ordered compensation. This is just completely and utterly intolerable and something that I can't believe we haven't already fixed. But I'm so glad we are, and I commend the government for doing this. Survivors can do everything to bring about justice for the horror that's occurred to them. Making the complaint, coming forward, is hard enough. And then taking part in a process that is extremely difficult, the court process, to be found that the offender is found guilty, and then to have this happen must feel like they're being re-offended against again. The same type of deception and manipulation and vile behaviour that was perpetrated on them as a child is at play again, but being used to hide assets that should be going to the victim to help them recover or to live on and survive from the horror that's occurred. The bill addresses that injustice by enabling survivors of child sexual abuse where there is an existing court-ordered compensation to seek access to eligible superannuation amounts held by the perpetrator to satisfy that unpaid order. The bill allows a survivor to apply to the Australian Taxation Office for limited information about a perpetrator's superannuation so they can make an informed decision about whether a court application is worthwhile. And critically, the bill amends bankruptcy law so that compensation debts for child sexual abuse can survive bankruptcy action, which closes the loophole some offenders have used to defeat valid court orders. We should be clear about why this matters. Child sexual abuse causes lifelong harm, and for many survivors, the abuse does not end when the offending does. Survivors have gone through the court process, as I said before. Just coming forward is extraordinarily difficult. But to go through this and then, as I said, have these evil individuals who are just human garbage continue to perpetrate their deception just must be so difficult. The Coalition's position is clear. We support survivors and we'll support the bill. Survivors and their families have waited too long, while gaps in Australia's superannuation and bankruptcy framework have been exploited by the worst criminals. I acknowledge the work of the former Coalition government in bringing the legislation forward, and most importantly, I acknowledge those survivors, their families and advocates, many of whom have come to this place and shared their stories with extraordinary courage. This reform is a result of years of persistent advocacy. Of course, no single bill will capture every circumstance. There is more work that should be done in the future to give victims of other serious crimes similar pathways to compensation. But this bill is a major step forward. It restores a measure of fairness to a system that has too often compounded harm and reinforced the principle that court-ordered compensation means something in practice, but not just in theory. Convicted perpetrators must never be able to get away with their crimes. They must not be allowed to lose in. They must not be allowed to lose in court, declare bankruptcy, and expect to be able to preserve their retirement savings while the victim receives nothing. The Parliament has the opportunity today to close this loophole and strengthen justice for survivors, and I commend the bill to the House.
And I give the call to the Assistant Minister.
Thank you, Deputy Speaker. I move that the debate be adjourned.
The question is that the debate be adjourned and the resumption of the debate be made in order of the day for a later hour of this day. All of the opinions say aye. To the contrary, no. I think the ayes have it. Minister.
I ask leave of the House to make a ministerial statement relating to the regional budget statement.
Is leave granted?
Leave is granted.
Thank you. Minister.
Thank you, Deputy Speaker. As Minister for Regional Development, Local Government and Territories, I rise to outline the Albanese Government's vision for a more prosperous, resilient and sustainable regional Australia. This budget not only supports that vision, but also delivers the kind of investment that will keep our regional communities at the very centre of national economic development, as it should be. I'm a proud member of this place, a very proud regional member, and I know how fortunate I am to have spent my life in regional Australia. I'm lucky to call the Bega Valley home, and I wouldn't want to live, work or raise our family anywhere else. The people, the landscape, the lifestyle and the opportunities And at the risk of sounding like a new tourism ad for southeast New South Wales, it really is a special place. There is a deep sense of community spirit in regional and rural areas. It's something that at times is hard to describe. It's a rare mix of determination, respect, good humour, resilience, optimism, and a touch of sarcasm. And you can certainly feel it in the way that people come together quietly, with purpose, particularly in the hard times, and with great gusto to celebrate when times are good. Deputy Speaker, this budget is about looking out for regional Australians in good times and when times are tough. No one held back and no one left behind. It's about easing cost of living pressures. It's about access to housing. It's about better health care for regional Australians, with better access to services closer to home. And it's also about providing more opportunities to study closer to home or to undertake apprenticeships and training pathways that lead to real jobs at the end. And that's what keeps young people living in the regions, close to family and friends, to community supports, to work and to study. It's about more investment in better, safer roads for long-distance travel and for local trips, because regional Australians deserve nothing less. Deputy Speaker, every dollar matters, but never more with the rise in the cost of living. The past few years have been difficult for families, for people on low incomes, for small business owners, and for young people starting out. And it's been tough in regional communities, with longer distances to travel and higher costs due to freight charges. This government wants to make sure every hard-earned dollar goes further for regional Australia, and that's why we're introducing new tax cuts for every working Australian taxpayer. The Working Australians tax offset provides an additional tax cut of up to $250 for working Australians on top of the tax cuts in the 24-25 budget and the two upcoming rounds announced in the 25-26 budget. The Working Australians tax offset is a permanent annual tax offset of up to $250 from the 27-28 income year for all Australian workers. Our 5 different tax cuts will benefit the average worker by up to $2,816 in 2028 and add up to $54 back in the average worker's pocket each week. Deputy Speaker, our government also wants to make small businesses save thousands of dollars by making the instant asset write-off permanent. This means small businesses will be able to immediately deduct new equipment worth up to $20,000, from new tech to tools and machinery. The other immediate pressure we've worked hard to address is fuel. Cost of fuel and availability of fuel, especially diesel. Regional Australia has been hit hardest by the impact of the global fuel shortage. By acting quickly to secure more fuel for industries most exposed to the shortage, agriculture, transport and mining, we're protecting regional productivity. We've moved quickly to more than halve the fuel excise and reduced the heavy vehicle road user charge to 0 for 3 months to June. This has helped keep freight moving around the country and all Australians that have been feeling the pinch. The availability of fertiliser is also critical for our farmers. This government has secured a deal for 250,000 tonnes of additional agricultural grade urea to provide certainty for the upcoming planting season. And we've also underwritten the purchase of fertiliser by the private sector to support availability and streamlining broader processes, including reducing port clearance times. Farming and agriculture has always been the backbone of this country and of regional Australia, and we know how important it is to support this industry. That's why this budget is delivering a landmark $14.8 billion Australian fuel security and resilience package to safeguard the nation's energy sovereignty. The package will help secure the fuel and fertiliser supplies that Australia needs by targeting financial support and also establishing a government-owned reserve. The Albanese government will protect Australia's energy interests, support essential industries and help secure reliable fuel access during future supply issues. Deputy Speaker, one of the great privileges of my portfolio is not only traversing so much of my own electorate, but also visiting so many communities from across this incredible country of ours. From Colac to Cloncurry, to Katherine, to Dolphin Sands, to Orange, and communities like yours in Bendigo. It's when you're visiting the local Chamber of Commerce or the SES, talking to parents and staff at the childcare centre, catching up with locals at a bakery, that you start to understand the challenges and the hopes of each region. And while every town and community is unique, there are compelling themes that are raised all the time. So I turn now to the health and well-being of regional Australians. Last August, I spent time with my colleague, the member for Hunter and Special Envoy for Men's Health, Dan Repicoli. We visited the Goulburn Railway Bowling Club to talk about all the topics that can sometimes be difficult for men to talk about. And what we heard was no surprise. Health and well-being in regional Australia is top of mind, even if it's not always spoken about. Access to care is top of mind. Affordable care is top of mind. And quality of care is top of mind. And it always remains top of mind for our government, which is why this government's $579.6 million a year investment to keep Medicare urgent care clinics open and free matters so much to Australians who are living in regional and rural communities. Our Medicare urgent care clinics will be embedded as a permanent feature of Australia's health system. That's 137 clinics providing accessible and affordable urgent care services across the country, and 47 support communities in regional, rural and remote Australia. Now, I know what a difference the urgent care clinic made in Bega, in my local community. It opened in February. Glenn from Bega took the time to contact me to express his gratitude, and he used the clinic because he'd had an altercation with a Stanley knife. He said it was an excellent service and that he was very happy and grateful for this initiative. And Gordon from Bega also called my office to let us know he was impressed with the service and he's been telling everyone about it. Having access to this bulk billed urgent care clinic is also taking pressure off the emergency department at the South East Regional Hospital. We know Medicare urgent care clinics are a game changer, particularly if you live outside a major city. Free urgent care close to home, removing another cost of living pressure and supporting better health outcomes for regional Australians. In the 26-27, we're also investing a further $25 million to establish up to 6 new fully bulk billed general practices in the Central Coast, Newcastle, Lake Macquarie and Hunter regions. These measures mean Australians in regional, rural and remote areas will have options to access healthcare closer to home. And we're also investing in the next generation of doctors through higher education measures. This includes 20 new medical Commonwealth support places for the University of Tasmania to help address rural and regional workforce shortages and to strengthen primary care outcomes, particularly in northern Tassie. On the point of education, I want to highlight the work we've done to support learning in regional Australia. I went to a great regional public school, and it set me up for a great career in the law and now in public service. My kids go to a great regional public school, and I want them to have that same quality education experience that others might get. One that doesn't just see them through the grades, but sets them up for life, to shine, and to succeed at whatever they wish to do. Great educational outcomes need great teachers, and this government has invested $160 million in the Commonwealth Teaching Scholarships program to encourage more people to enter the teaching profession, especially in regional communities. We've also seen the incredible success of the regional university study hubs to help country students access higher education without moving. And in April, I was delighted to open the new Country University Centre, Snowy Valleys, which is in Tumut, not far from here. Talking to young people, to parents, staff and local employers, this model is so welcome in our communities, where in the past it had been an accepted practice to wave school leavers off to the major cities for a higher education. We say not anymore. Looking out for the youngest members of our community is also a priority for me. This government recognises that support for the early years, the under fives, is also investing in Australia's future. That's why we are supporting early childhood programs such as the National Voice for Our Children Early Years Support Program, supporting culturally safe and holistic early learning while strengthening families and communities. There is also $5.8 million to extend higher parliament and civics education rebate levels for schools in regional and disadvantaged areas for a further 2 years. This program supports those educational visits and school camps to the national, democratic, historical and cultural institutions in Canberra. Deputy Speaker, as Minister for Regional Development, I'm acutely aware that housing supply, affordability and enabling infrastructure in our regions are key drivers of whether families and workers can move to or to stay in the place that they are needed most. Our government is addressing the unique housing challenge in regional Australia to ensure our regions remain strong, connected and well positioned to provide opportunity to those who live and work there. Responding to concerns about housing security, particularly in regional Australia, this government has an over $47 billion Homes for Australia plan to build more homes, to help more first home buyers and to support renters. Underpinning this plan is a shared commitment to deliver 1.2 million new, well-located homes by 30 June 2029 under the National Housing Accord. Regional Australians are a priority across our major housing initiatives, with significant programs underway that are already delivering better outcomes in our regions. Programs such as the expanded 5% deposit scheme and the Help to Buy scheme are helping more Australians get the keys to their own home. We've already helped over 81,000 regional Australians into home ownership through the 5% deposit scheme since May 2022. The Albanese government has committed to deliver 55,000 social and affordable homes across the country, including through the Housing Australia Future Fund. Under the Housing Australia Future Fund, $200 million is being allocated for the repair, maintenance and improvement of housing in remote Indigenous communities in Queensland, WA, South Australia and the NT. Rounds 1 and 2 of the Housing Australia Future Fund are also supporting the development of more than 2,800 social and affordable homes in regional and remote areas, with more expected in round 3. Down in the Snowy Mountains, we've recognised the need for more housing. So we're providing $12.4 million to the Cooma Housing Project through the Housing Australia Critical Infrastructure Program, which will develop 12.6 hectares of unused land into a new community with 140 new residential land lots, with a mix of social, affordable and private housing options tailored to the local community. The $2 billion Social Housing Accelerator payment is on track to deliver over 1,350 homes in regional Australia. Deputy Speaker, I've seen firsthand how safe, secure housing can change lives, and I've heard loud and clear from local councils all over the country that they stand ready to help us deliver more housing. They need help with more enabling and community infrastructure, and in this budget we are delivering both. To increase housing supply in the regions, the government has created a new $2 billion local infrastructure fund under the Housing Support Program, with $500 million of that dedicated to local enabling infrastructure in regional Australia. We are responding to the demand for housing enabling infrastructure demonstrated through the Community Enabling Infrastructure stream under that Housing Support Program. It's funded projects like the $112.3 million Morong Sewer Infrastructure Upgrade, which is a project in growing the Morong Township of the Bendigo region. This project is well underway, delivering upgrades to 3 sewer pump stations in Morong and constructing 6 kilometres of rising mains along the Calder Highway to enable the development of over 2,300 much-needed new residential lots. The new stream of the Housing Support Program will help local governments and state utility providers build the critical last-mile infrastructure needed to support new housing developments. It will be available where a state or territory commits to undertake further reforms to build more homes. An ambitious set of reforms has the potential to support tens of thousands of additional homes. Deputy Speaker, this budget also supports priority transport and community infrastructure projects that improve safety, freight efficiency and connectivity for our regional communities. It delivers safer and more reliable transport networks, it strengthens connections between the cities and the regions, and it supports economic growth. We're continuing to invest in transport infrastructure through the over $120 billion 10-year infrastructure investment pipeline. This budget will see a total of $12.1 billion in new investments across the transport and infrastructure portfolio, with $10.3 billion for transport infrastructure projects, $976 million for transport and $803 million for community infrastructure. This included record investment in regional Australia, from the Pilbara to the Limestone Coast to the Bruce Highway. We're also supporting our local councils, doubling the level of funding they are provided to maintain and improve local roads through the Roads to Recovery program. Since July 2024, the government has committed $4.4 billion nationally over 5 years. This is $1.8 billion more than the previous 5 years. Funding is allocated to each local council, with almost $850 million allocated nationally this financial year. In this budget, we're also bringing forward payment of $2.9 billion for local councils, being 80% of the 2026-27 estimate, which will be paid to states and territories before June 26, to be passed on to every council in Australia. This will be important funding to assist councils to continue to deliver essential services in our regional and remote communities. The $200 million per year Safer Local Roads and Infrastructure program also funds targeted freight efficiency. It improves road safety and productivity. It renews bridges and delivers heavy vehicle rest areas on our regional highways. Projects like the replacement of the bridge over the Growan Creek on Guida Highway near Collarenebri is a perfect example of how this government is improving freight movements to and from our regions. We also have the Remote Roads Upgrade Pilot Program, committing $150 million to 33 road improvement projects in regional communities. Locally, that includes Mansfield Shire Council's recently completed $12.3 million upgrade to Highton Lane, Rifle Butts Road and Chapel Hill Road, improving safety, traffic flow and heavy vehicle access. Following our support throughout the Rex Voluntary Administration process, this government continues to put in place measures that will help preserve regional aviation connectivity. This year's budget will provide $38.1 million over 4 years and $7.3 million ongoing each year to strengthen protections for aviation consumers, and $4.5 million over 4 years for the Australian Competition and Consumer Commission to continue aviation price monitoring. These are important measures that help support people in the regions who rely on accessible and affordable air services. Deputy Speaker, this government is committed to improving road safety outcomes across the country, and that matters to me and every regional member of this place. We want to make sure that everyone travelling our regional roads makes it to their destination safely and makes it home safely. That's why we're investing more in national road safety research to ensure our future funding decisions are targeted to where it will have the greatest impact. This work will draw on the expert advice and leverage the extensive national data set through our National Road Safety Data Hub. In 2024, Minister King successfully negotiated data sharing provisions through the new Infrastructure Federation Funding Agreement with the states and territories. These provisions are delivering an uplift in the quality and the utility of road safety data available to the Australian Government. This further research will explore the incidence of road accidents in greater depth, and it will consider emerging opportunities and risks as vehicle technologies evolve. To this end, we will continue our important Black Spot program, increased from $110 to $150 million per year by this government. In every state and territory, we are funding essential improvements like traffic signals, roundabouts and safety barriers. Turning from road to rail, we are supporting high-speed rail through funding for the Newcastle to Sydney development phase, providing $659.6 million over 3 years to the High-Speed Rail Authority. Better connection between Newcastle and Sydney will support regional livability and growth, not to mention workforce participation as we keep up the momentum towards the delivery of high-speed rail in Australia.
Deputy Speaker, we're also investing a further $1.75 billion in the Australian Rail Track Corporation to strengthen the existing rail track network, taking our total commitment to upgrade that network to nearly $2.8 billion. This work will involve upgrades to improve the efficiency of the north-south rail line, supporting longer trains and enhance service reliability and safety. Works will also include resilience upgrades in high-risk, flood-prone sections, particularly along the east-west corridor, which has faced many multi-week closures over the last decade following downpours in Central Australia. We'll also continue to focus on delivering the Inland Rail project between Beveridge in Victoria and Parkes in New South Wales by the end of 2027. This will enable double-stacked freight trains to travel between Melbourne and Perth via Parkes. These transformative rail projects are helping to reduce emissions and to make our roads safer. Deputy Speaker, I also want to highlight our commitment of an additional $750 million for a further round of our flagship programs, Growing Regions and Thriving Suburbs, bringing total investment since 2022 to over $1.7 billion. The Growing Regions program supports community infrastructure development across regional, rural and remote communities. And we've already seen some amazing projects being delivered under this program. I was delighted to visit Roma in Queensland and see how our $15 million investment under this program will help revitalise the local swimming pool. It only took a Labor government to get that. And I also want to mention our $5.9 million Growing Regions program support for the revitalisation of the CBD in the Cloncurry, one of the most friendly and growing communities in northwest Queensland. The upgrade of Scar Street will deliver improved amenities, accessibility, connectivity and safety for residents and visitors alike, and is particularly welcome given the recent floods in that area. Round 3 of Growing Regions will provide between $250,000 to $15 million per project for construction-ready, broad-use, community-focused infrastructure that strengthens connection and social cohesion and supports local governing bodies to deliver infrastructure aligned to local, regional and national priorities. This budget also includes $22.5 million to deliver Round 10 of the Stronger Communities program, building on the more than 18,000 projects already delivered to benefit local communities. Deputy Speaker, this budget also delivers on our Closing the Gap commitments. It delivers more support for Aboriginal and Torres Strait Islander people, especially in regional and remote communities. And we know firsthand that economic empowerment in Central Australia is improving outcomes for First Nations people. That's why we are investing an additional $299 million in the Remote Jobs and Economic Development program to double new jobs from 3,000 to 6,000 by 2030. These are jobs with decent wages and conditions like sick leave and superannuation. And this is about the dignity of work for people in remote areas. And I want to thank the member for Lingiari for her continued commitment in this space. The government has committed an additional $27.4 million for the expansion of the low-cost essential subsidy scheme. Families in remote communities are seeing savings of up to 50% on items like canned fruit, tinned vegetables, pasta, nappies, soap and toilet paper. By addressing the higher cost of essential goods in remote areas, this initiative also supports improved food security and contributes to better health and wellbeing for individuals and for families. We're also committing $32.7 million over 3 years from 26-27 to expand the store's efficiency and resilience package. This will enable an additional 75 remote stores to increase stock levels and be prepared when communities are cut off. This budget includes measures to improve digital inclusion, including free Wi-Fi for 53 remote communities through the First Nations Community Wi-Fi program, and this has proved to be an absolute game changer. We're delivering more health services with further investments in health infrastructure, in culturally safe maternity services and in 1-3 Yarn to support First Nations people when they need it most. We are delivering the first standalone national plan to end violence against First Nations women and children. Our ways, strong ways, our voices. And we are backing it with a $218.3 million injection of funds for immediate action. It supports community-led responses to family, domestic and sexual violence by establishing a national Aboriginal community-controlled organisation network and continuing funding for the peak body, Our Ways Strong Together. We're also continuing our early years support through SNAKE, National Voice for Our Children, helping First Nations community-controlled organisations deliver early childhood services in New South Wales, Victoria and Western Australia. It also supports learning and jobs, investment to lift First Nations education outcomes, expanding the TAFE Technology Fund so training can be delivered through mobile services, particularly in remote First Nations communities. These measures sit alongside investments that help First Nations people take part in new economic and environmental opportunities in the regions. Deputy Speaker, over the course of this high-risk weather season, I've seen firsthand the devastating impacts of natural disasters across many regional and rural communities. Communities like yours, communities like Julia Creek in Queensland, Catherine in the NT, Ruffy in Victoria, Dolphin Sands in Tassie, and of course on the Central Coast. In just the last high-risk weather season, we saw 60 severe weather events impacting more than 190 local government areas, with some communities impacted back to back. And resilience is a word we talk a lot about in emergency management, and it unfortunately has been sorely tested across significant parts of our country by extreme weather events. A recovery journey doesn't end when the high-risk weather season does. It takes years, which is why this government is investing in disaster recovery and emergency management to back regional communities every step of the way. Deputy Speaker, reliable and timely public warnings are essential for local preparedness, for early action and for community safety. Our new national messaging system, AusAlert, is a national emergency and public safety capability designed to deliver fast, secure and geo-targeted messaging. AusAlert will empower Australians to make timely, informed decisions to keep themselves safe and their loved ones too. The AusAlert project continues to progress with community-based trials in June and a national test on the 27th of July this year. Following these tests, the AusAlert system will be operational by October 2026. 2026 obviously was a summer where we saw fires impact a lot of Victorian communities. Once again, they are reeling from catastrophic damage. Longwood, Dargo, Carlisle River, Walwa, Toowong, Alexandra, Harcourt and many, many more. Having lived through the horrific Black Summer bushfires in my own community, the sound, the smell and the taste of bushfire is something that you don't get used to, but it has become a reality of living in regional and rural Australia. Today, the National Aerial Firefighting Capability is a coordinated, high-tech fleet of over 160 contracted aircraft managed by the National Aerial Firefighting Centre on behalf of states and territories, and we are continuing to invest in it through this budget. When I first became a member of this parliament, having proudly served my community as a local mayor, I said that a postcode should never be a barrier to opportunity in regional Australia. Where you live should not define your opportunities in life, and I mean that just as much today as I did then. Perhaps even more so, as I meet more of the extraordinary people who call regional Australia home. Deputy Speaker, this budget is for them, it's for their children and for their grandchildren to follow. This budget is a blueprint for a stronger and more resilient regional Australia, a regional Australia that is more optimistic for its future, is confident that the government is going to be there in good times and in bad. It's about supporting a vision for growth and development while preserving the unique identity and fierce sense of community that sets our regional communities apart, so that every Australian, no matter where they live, can share in our national prosperity today and for the decades to come. Thank you.
I call the member for Gippsland to speak in response to the minister's statement. Okay. Thank you, Minister. The member for Gippsland.
Well, thank you, Deputy Speaker. And I must say from the outset, regional Australians want their country back. And I do actually feel sorry for the minister, because I like the minister. I don't doubt for a second her passion for regional Australia. She's a good Traralgon girl. She grew up in the Latrobe Valley and has worked hard in her shire, or Bega Shire, and then in local government, and gone on to become a Member of Parliament. And I think she is passionate about the future of regional Australia. And in that same vein, when I've seen her work with our communities impacted by natural disasters, she has been honest in her exchanges and determined to get a good outcome for our communities. And we all know in rural and regional communities we live with natural disasters, and we need support from government from time to time. But having said that, I feel she is constantly let down by her colleagues in the ministry in her own party. Yep. And what we saw last night was not a blueprint for the future of Australia, it was a red print for the future of the Labor Party. This was a ruthless political document designed to inflict pain on certain members of our community and divide our community in ways that only this Prime Minister would think was appropriate. So I say to the Minister, the majority of her speech was simply rehashing previous announcements, putting the word regional in front of general government programs, and didn't provide any actual new insights into the way this government is going to support regional Australians as they strive to get ahead in difficult times. But if the Minister really believes, if the government really believes that they have so much to offer regional Australia, you'd think they'd want to go and contest a by-election on the weekend in the regional community.
Where were they?
Couldn't find them. Couldn't find them. And I've heard members opposite laugh about the result for the coalition, and they've had great joy in pointing out our primary vote. And I accept that there are quite a few voters who didn't like us in Farrer. But you should have heard what they said about you. They hated you. Boy, oh boy. They mightn't have liked us, but they hated you. And so what we saw, Deputy Speaker, instead of a plan for the future of regional Australia in last night's budget, we saw more Labor lies and broken promises from a Prime Minister who simply can't tell the truth. He's just incapable of telling the truth. This is a budget which is full of broken promises: higher taxes, more debt, lower living standards for all Australians, and fewer homes for Australians. In its own budget papers, the Treasury acknowledges 35,000 less homes as a result of the tax changes being implemented by this government. And we've got to this point, Deputy Speaker, for the age-old reason. Labor can't manage money. And when they run out of money, they come looking for more from the Australian people. And we're facing now a decade of deficits worth $150 billion, and every Australian will be forced to foot the bill. Australians will pay an extra $50 billion in taxes over the next 4 years, in the highest taxing budget in our nation's history. And still, there wasn't much in this budget for regional Australia. In fact, nothing in terms of new regional initiatives to help our communities prosper. During the Farrer by-election, Deputy Speaker, I had the opportunity to spend some time in a paddock at Holbrook with about a dozen farmers, and I asked them a question. Just over the last 4 years under the Albanese government, put your hand up if you think you're better off. No one put their hand up. I asked a second question. No, these farmers are aged between 20 and 75. I asked another question. Put your hand up if you think our country's heading in the right direction. Not one put their hand up. And then one bloke said to me in front of the group, he said, "Mate, it just feels like they hate us." And that was a horrible thing to hear from an Australian farmer. Yeah. It just feels like they hate us. He's a successful farmer, he's worked on the land, he's built his family up, family farming enterprise up, his daughter's working on the farm, and he said, it just feels like they hate us. And when you look at the compliance burden, the red tape, the green tape, all of the punishments inflicted on our farming communities by Labor green ideology, you can see why they feel that way. When you think about the Labor Party and its obsession with banning the timber industry, cutting jobs in regional communities, you can see why they feel like they hate us. When you look at the live sheep export sector, a decision made with no consultation, a complete debacle, you can see why farmers feel like the Labor Greens hate them. And our commercial fishermen, constantly facing cuts from the Labor Green ideology, constantly cutting jobs away from our communities. And then all those occasions, Deputy Speaker, it's not like we're not using timber anymore. It's not like we're not using fish anymore. We're just importing from other countries with poorer environmental credentials and protocols than our own country. So, Deputy Speaker, the only plan in the budget last night from the Labor Party was to tax regional Australians more. Their own budget papers forecast the cost of living crisis is far from over for all Australians. And then the Prime Minister says, he said this in question time yesterday, in the few times he actually tried to finish a question off, the Prime Minister says he's doing the right thing. So you have to ask, is lying to Australians doing the right thing? Because you simply can't believe a word this Prime Minister says. He told Australians many times in the lead up to the 2025 election, my word is my bond. Very solemn. My word is my bond. The Prime Minister was repeatedly asked about his plan for new taxes. I don't know how many times he was asked, but he told us, he's answered it 50 times, no negative gearing changes, no capital gains changes. So in the lead up to the 2025 election, the months afterward, he ruled out any changes. It's abundantly clear this Prime Minister lied to get elected. We've now seen Labor's true colours. It's a reheated version of the Bill Shorten manifesto. I mean, at least the former member of Maribyrnong, the former leader of the Labor Party, Bill Shorten, had the decency to take it to the election, had the guts to face the Australian people and say, this is my bold new plan for the future of our nation. And then we had, I think that was the right election, we had that genius from McMahon. If you don't like it, don't vote for it. 2019, that's right. The genius of member McMahon, if you don't like it, don't vote for it, and Australians didn't need to be invited twice. But at least the member for Maribyrnong had the guts, the former member for Maribyrnong, Bill Shorten, had the guts to take his plan to the Australian people, to take his plan out in front of the voters and give them a chance to decide what direction they want to take their country in, and thankfully the Australian people rejected it. But did you know it was Bill Shorten's birthday yesterday? It was actually Bill's birthday. You couldn't make this up. Happy birthday, Bill. You got the budget you always wanted. At the end, I thought, oh, the Treasurer's finished 5 minutes early. Do we sing happy birthday to Bill? What do we do now? We're filling a bit of time. Happy birthday to Bill. Oh. Anyway, it actually was Bill Shorten's birthday yesterday, and all his birthday wishes come true with his hit job on aspirational Australians being stamped, endorsed by the Treasurer and the Prime Minister. Because we know, Deputy Speaker, we know on this side, and I reckon the Prime Minister knows this too, if Labor had taken that plan, that budget he announced last night to the election in 2025, it would have been rejected by the Australian people. Yep. And the Prime Minister wouldn't be living in the lodge anymore. And the Prime Minister knows that, so he said, I'll just keep that a little bit quiet. Hey, Jim, hey, Treasurer, hey, member for Rankin, the lad from Logan who wants to go to the lodge as soon as he can. Hey, we'll just keep it quiet, you and me, we'll work this one out, and at some point in the future we'll get the chance, we'll find a crisis somewhere and pretend everything's changed and we need to introduce the most regressive taxes that Australians have seen in a generation. There is no amount of spin. The fortunate thing about this for us is there's no amount of spin that can change this story. Labor and every member opposite told lies to their electorates to get them elected. Yep. But funnily enough, they actually think they can spin their way out of this because through the blessings of this parliament, someone left the talking points behind in an office yesterday, and we all got the chance to see how they're going to try and spin their way through all this. So the Coalition and everyone, the press got a copy of Labor's talking points to their morning note. Now, for those joining us at home, those 5 people who are listening, the morning note is our way to deal with those tricky questions that any journalist might ask during the day. And Labor's morning note yesterday, their message to the members and senators, is said, if asked, have you broken a promise, the MPs are told to say, the right decision is to do the right thing with the right policies at the right time. That could have been ChatGPT, I think. I mean, the right decision is to do the right thing with the right policies at the right time. It's almost, maybe Dr. Seuss wrote that one for them, but anyway. No, the right decision, if you ask the Australian people, is just tell the truth. Hey, lash out. Just tell the truth. The right decision was not to lie to the Australian people to get elected in the first place. The right decision is to develop policies which actually unite Australians rather than always seeking to divide our nation, as this Prime Minister inevitably does. Because what we see, Deputy Speaker, is whenever the Labor Party gets in a bit of trouble, the tactic is always the same. How do we divide Australians here for some sort of political advantage? How do we divide Australians to make sure we get some more votes out of this and keep our place in this building? The career of the most left-wing Prime Minister in Australian history is summed up in one line from his own mouth. I like fighting Tories, that's what I do. I like fighting Tories, that's what I do. He is like the great dividing range of Australian politics. The Prime Minister is the great divider. He has no interest in building a consensus, and he views every issue through a political lens and political opportunism. I like fighting Tories, that's what I do. That's the boast of the most institutionalised Member of Parliament in this place. 30 years in this place, the ultimate Canberra bubble boy. It's the boast of our Prime Minister and explains everything about his divisive approach to his parliamentary career and his failure to govern for all Australians. And we saw it last night, Deputy Speaker. There are many examples of this Prime Minister being the great divider of Australian politics. Remember how he tried to divide Australians with the voice. Went out of his way to try and divide Australians on the basis of race and forced a referendum on the issue, and he lost. He's dividing Australians right now with this reckless renewables rollout, which is tearing families apart, tearing communities apart in regional Australia. None of these transmission lines and these industrial-scale use of farming lands occurring in their electorates. He's dividing communities with his approach. The Prime Minister also widened the city-country divide in this nation by cutting regional programs from the day he started in the role. And now, look, I didn't actually think we'd ever get to this point. I never thought we'd get to this point. He's dividing Australians based on the year they were born. He's dividing Australians on their birth dates with a suite of broken promises in last night's budget. Now, they're trying to claim this is some sort of intergenerational equity issue. This is intergenerational fraud. It is fraud what they're trying to commit onto the Australian people right now, because many of us, in fact a lot of people in this parliament, have had the opportunity to work hard, save money, use the property investment system to provide for their own futures, aim to be a self-funded retiree one day, have no burden on the tax system as a pensioner at that point, and pass on something to their kids when they pass away. But what this Prime Minister did last night, and Treasurer in supporting him, was pull up that ladder of opportunity and say, no more. You can't do that. You can't work hard and invest in property and have that opportunity to get ahead and prepare for your own retirement. You're not going to have that opportunity, but it's okay because the Prime Minister had it. He's still got it. I've still got it. But the next generation, in this gross intergenerational fraud, has been told it's good for them. How's it good for them? Rents are going to go up. There's going to be 35,000 less dwellings built. You are killing aspiration in this country, all on the basis of political division and opportunism to try to get some sort of political advantage, and it won't work because Australians are awake to this mob. Instead of helping young Australians into homes, the Treasury itself acknowledged in the budget papers 35,000 less homes being built, rents will increase, and young Australians have been robbed of the same opportunities that I've enjoyed, the Prime Minister's enjoyed, and I'm staggered that those opposite, any of them, just one of them, maybe two if we're on a good day, doesn't realise what an outrageous fraud they're committing on young Australians by breaking their promise and then pretending it's okay because we'll be looking after you. Now, Deputy Speaker, all this is being done while the Prime Minister is happily bringing 1.2 million more people into the country without the housing supply to support it. In regional Australia, Deputy Speaker, in regional Australia, we're very proud of our communities and our contribution. In regional Australia, we grow great food, we grow great fibre, and we grow great kids. And those kids want a future in those regions, and part of their future is dependent on having governments willing to invest in the infrastructure and the services that make it possible to thrive in regional areas. On this side of the House, we make no apology for always standing up and fighting for the interests of people who don't choose to live in our capital cities and see a future for them and their families in our regional areas. Now, regional Australians have had a gutful of being punished by this government because they didn't vote Labor. We've seen it with the water buybacks in the Murray-Darling Basin. They're stripping water out of productive use. You go out to those communities in the Murray-Darling Basin, you look those farmers in the eyes, you look the shopkeepers in the eyes and ask them what they think about these water buybacks, and it is traumatic, Deputy Speaker, because they're having their livelihoods, their futures stripped away from them by Labor green ideology driven out of metropolitan areas. We've seen it with Labor's attempts to make farmers pay for the biosecurity screening, which is a national responsibility and a cost that should be borne by all Australians who benefit when pests and diseases are kept from our shores. We've also seen it in this budget, Deputy Speaker, with funding cuts to control invasive species, which have an enormous economic impact on our farmers and devastate our biosecurity. And we've seen it, remarkably, we've seen it in the budget with cuts to the Future Drought Fund. I mean, I don't know why anyone opposite thinks we won't need that funding at some point in the future while farmers are preparing for El Nino, but cuts to the Future Drought Fund at a time when we're already seeing farmers struggling with dry seasonal conditions in large parts of our nation. Now, Deputy Speaker, we've also seen it with cuts to productive infrastructure investment, like the Inland Rail project. Now, the Minister did mention Inland Rail. She did mention that the original plan was to take it from Melbourne to Brisbane, now it's going to stop at Parkes. But instead of providing for what is widely regarded as a corridor of commerce through Victoria and New South Wales into Queensland, instead of providing funding for that Inland Rail project, which would take 200,000 truck movements off the road per year, instead of providing funding for that and continuing that program, the government has bailed out Premier Jacinta Allen. The Jacinta Allen vanity project, the suburban rail loop. Now, maybe if we had got the common chair-os to build the Inland Rail, it would have been safe. Instead of backing the banditos, the bikies, the thugs and the big build projects in Melbourne, maybe we had them on the Inland Rail project, it would have been safe. But this mob has cut funding to a project which, funnily enough, Deputy Speaker, they used to support. The Prime Minister himself, you find plenty of press releases, the Prime Minister advocated for it, championed the project. The Minister Catherine King also supported it. He took credit. That's right. I'm reminded the member for Grain actually took credit for the Inland Rail at one point, just as he took credit for building the pyramids and the Sphinx. But the fact is, the Prime Minister was fully on board with the Inland Rail until he wasn't. Until it was okay, it wasn't convenient anymore, and he'll just break another promise. So we have another broken promise, Deputy Speaker, in this budget, which is going to have real consequences, social and economic and environmental consequences in regional Australia. And I say this with great earnesty, Deputy Speaker, that the New Highway is regarded as one of the most dangerous sections of road in our country for good reason. There are some tragic crashes on that road over a long period of time. In Australia today, 1,300 people are killed on our roads on an annual basis, and a disproportionate number of those people live and work in regional communities. One of the really key reasons for the Inland Rail project was to reduce that heavy vehicle movement on the New Highway and to make it safer for people. Because when someone is killed and someone is injured on a regional road, the ripple effect of that accident, that crash, goes right throughout, particularly regional communities. Because more often than not, the first responders, the SES volunteers, the CFA volunteers, the police, the AMBOs, more often than not, they might know one of the victims because they live in those communities. So it ripples through the community where they're attending a crash site where someone they know, or played footy with, or went to school with, has been killed. And the Inland Rail project wasn't just about moving freight efficiently between two great cities in Brisbane and Melbourne, and also linking, obviously, the regional communities with opportunities along that route. It was also about saving lives. And what value do you put on that? What price do you put on that? And at a time when road trauma costs the Australian economy $30 billion per year, that's the economic cost of road trauma, the social cost of so many Australians being killed and injured on our roads, particularly our regional roads, has to be factored into any decision to abandon the Inland Rail project, and I'm sure it wasn't. I'm sure it wasn't, Deputy Speaker, because if they thought about that, there is no way they would pull the rug out underneath the feet of regional Australians and abandon that project. Deputy Speaker, the Labor Party claims to care for the environment. They're spending an additional $18 billion on the net zero dream, but at the same time, they are actually cutting sustainable land management and our pest control programs. Right now, it's our farmers, our landholders in rural and regional areas who are doing the majority of the heavy lifting when it comes to pest animal control. Now, every environmentalist actually agrees with this fundamental point. The greatest threat to biodiversity and extinction of native species in our country is not climate change, it's invasive species. It is the feral animals and the weeds which are preying on native species, which are causing the extinctions and reducing biodiversity in our nation. And this government has cut sustainable land management and pest control programs in this budget. And I argue, Deputy Speaker, we need more boots and less suits. That is, more boots on the ground doing practical environmental work and less suits in Canberra, Sydney and Melbourne making excuses for why that work can't be done. Now, the Minister mentioned disaster resilience. One of the keys to disaster resilience is more boots and less suits. That's more people on the ground doing the hazard reduction work, clearing the fire breaks, maintaining roads, and I accept these are largely state government responsibilities. But at the same time, the federal government has a role as an active partner in ensuring that sustainable land management, practical land management and pest control programs continue to have an impact on these invasive species because, as we're all well aware, the pigs, the dogs, the foxes, the deer, they don't respect state borders, the rabbits, the cats. These are all invasive species which require a national response in partnership with our state governments. And when it comes to healthcare, Deputy Speaker, we also saw Labor's true colours again in last night's budget. There was no standalone regional health package and not a single regional workforce measure in the budget. So the member for Lyne has been an active campaigner on behalf of her community, and Labor's much vaunted urgent care clinics, which, funnily enough, closely match the Labor-held seats around Australia, but that's purely coincidence. But despite that need in other communities like Lyne and like Gippsland, the Labor Party continues to target the urgent care clinics strategically for political advantage. The Minister knows it, Press Gallery knows it, and communities like mine miss out. Do you know, Deputy Speaker, despite the obvious need in my electorate of Gippsland, and the Minister opposite knows Gippsland well, she, as I said, was born in Traralgon, there's not a single urgent care clinic delivered or promised from Warragul to the New South Wales border. In fact, no, beyond the New South Wales border, all the way to Bega, the lovely clinic the Minister spoke about in her statement. The Minister spoke about the Bega clinic and the poor fellow with the Stanley knife accident, and I'm sure it's a very welcome initiative, and I'm sure it's working well in Bega. But it's 505 kilometres from Warragul to Bega. If the poor fellow had his Stanley knife incident in my electorate, he'd be driving for 3 hours in either direction to try and find an urgent care clinic provided by this government. And what about Taree? What about Taree? The member has campaigned actively, and surely at some point the Minister will just show 1 ounce of compassion and look after the people of Lyne, the people of Taree, and provide them with an urgent care clinic, particularly when you talk about the region heavily impacted by natural disasters in recent times. So the Nationals, as part of a strong coalition, believe that regional Australians shouldn't have to put up with second-class access to healthcare just because of where they live or just because of the way they voted. Families across regional Australia are facing GP shortages, they've got long wait times for specialists, and there's a shortage of mental health and allied health providers, and there is a worsening workforce shortage, and this government is not listening to the people in our communities. Speaker, in a time of crisis, the one thing I did expect to see last night in the agricultural portfolio budget statement was funding to implement the National Food Security Strategy. Not a single dollar. Not a single dollar for implementation of that strategy. It's time for this government to stop having roundtables, to stop having dialogues, to stop having strategies and waffling. Let's get serious about food security, and no new funding means no action for yet another year on this issue. In the middle of this fuel and fertiliser crisis, we've urged the government to fast-track the National Food Security Strategy and make sure it remains targeted at the key issues, not wander off into fluffy topics which are best addressed through other mechanisms in the health sector. And I urge the government and ministers just to occasionally listen to members on this side of the House. When we come forward with ideas from our regions, it's because the people in our communities are telling us that is what they need. Right. We are well connected to the people in our communities. We hear from them every day. And when we come here seeking some support for things like an urgent care clinic in Taree or other projects in our community, don't always approach it from a direction of political advantage. But sadly, that is what we're seeing from this government. The neglect and the division goes on day after day. The Prime Minister divides Australians into Labor and non-Labor voters. In just 4 years, he went out of his way to cut a long list of regional programs which were designed to actually boost productivity and livability in our regions. And last night's budget did nothing to reverse those cuts. We've seen Building Better Regions disappear. Roads of strategic importance, cut completely. Local roads and community infrastructure program, all cut, no new rounds by this government. Most regional Australians didn't vote for this Prime Minister, so he goes out of his way to cut the programs they needed. But it even goes worse, Deputy Speaker, because they actually did create one program called the Growing Regions program, and then they cut that as well. They brought it back to life last night for one more round by the sound of it, but it's been rolled into, would you believe, a thriving suburbs program. There's no clarity or transparency now how much that means going to regions, how much is going to suburbs. I'm going to take a bet that we'll get shortchanged. I'm going to take a bet that under the Growing Regions program, thrown into the Thriving Suburbs program, regional Australia will get done over again. So, Deputy Speaker, instead of a plan for regional Australia, Labor has shown us their plan to try and spin their way out of trouble. Now, I say that this Prime Minister probably doesn't know how much trouble he's actually in. When I was out in the booths in Farrer, it was pretty obvious they were voting for change. And the Prime Minister can't hide from the voters of Australia forever. On that weekend in Farrer, yes, they voted for change. They're angry, they're frustrated. They don't want business as usual. They've been left behind by a Prime Minister who promised to govern for all Australians. But the problem with business as usual for this Prime Minister is more broken promises. That's right. And the first chance he had after the Farrer by-election was to break more promises, break more trust with the Australian people. It's tough out there, Deputy Speaker, for our farmers, for our small business people and Australian families. And what does the Australian Prime Minister do when the going gets tough? He goes missing. And then he goes out and announces more broken promises in the budget. This is a Prime Minister who was too gutless to face the voters in Farrer, and now he's breaking more promises with taxes he ruled out dozens of times. Now, Deputy Speaker, I say those opposite with all sincerity. If you'd bothered to go out to Albury or Griffith or Moama, Leeton, and listen to the voters and hear what they had to say, you would have heard just how much the voters in those communities have had a gutful of Labor's approach to regional Australia. Yep. You would have heard from them directly their message that they want a fair go. Yep. They want a government which is actually on their side. They don't look for handouts. They just want a government which is on their side and helping them through tough times and giving them the freedom to invest in their businesses, invest in their farms, invest in their family's future and have a great opportunity to enjoy life in the greatest country in the world. We on this side will continue to fight for a fair go for regional Australians because, Speaker, regional Australians want their country back and we're going to give it to them.
Yeah.
Can I just, before I call the Minister, just say to the Leader of the Nationals in the House of Representatives, and I want to remind all members that the House of Representatives practice, page 516, an accusation that a member has lied is clearly an imputation and an improper motive and is therefore ruled disorderly. Leader of the Nationals, I just need to point that out. And we will withdraw those comments that you made in your speech.
To assist the House, I withdraw.
Thank you. And I call the Minister.
I move that the House take note of the Minister's statement on the regional budget statement.
The question is that the House take note of the document. All those opinions say aye. Contrary, no. The question is that the debate be adjourned and the resumption of the debate be made in order of the day for the next sitting. The question, the debate be adjourned.
The debate can be adjourned. I move the debate be adjourned.
And I call the Minister.
I ask the Leader of the House to refer the order of the day to the Federation Chamber for debate.
Is leave granted?
Leave is granted.
Minister.
I move that resumption of debate on the motion to take note of the Minister's statement on the regional budget statement be referred to the Federation Chamber.
I put the question that the regional budget statement be referred to the Federation Chamber. All those opinions say aye. No. The ayes have it. And I call the clerk.
Government business, order of the day number 2. Treasury Laws Amendment, the Survivors Law Bill 2026. Resumption of debate on second reading.
And I'll call the Minister for Regional Development.
Thank you, Deputy Speaker. In rising to support this bill, I want to acknowledge the deep pain and hurt of members of my own community. This legislation seeks to right an historic wrong that affected people and communities across Australia, including in my own. These are people who have already suffered too much. Victims, survivors of child sexual abuse. This legislation follows a fundamental principle that perpetrators of child sexual abuse should not be able to hide from accountability. Trauma does not end when the abuse ends. For many survivors, it is something that they must navigate every day, too often in silence and without adequate support. Some survivors face barriers to stable employment and financial security, meaning the harm they experience is not only emotional and psychological, but also material. Our compensation legislation should support victims and victim survivors. Under these reforms, where a court-ordered compensation debt remains unpaid after 12 months, victims and survivors will be able to seek access through a court order to certain superannuation contributions made by the offender. This includes additional personal and salary sacrifice contributions, which have previously been used as a vehicle to shield assets from enforcement. An important component of this schedule ensures that compensation debts do not disappear through bankruptcy. By allowing these debts to survive bankruptcy proceedings, we are reinforcing a clear and necessary message. Financial manoeuvring must not override moral and legal responsibility. Bankruptcy should not be a refuge from accountability for serious harm. A 2019 Deloitte study estimated that violence against children and young people cost $11.2 billion in New South Wales alone. This legislation is deeply personal to many people in my electorate. I have heard their stories and have been moved by their courage. The passage of this bill is the culmination of a sustained and honourable campaign by a dedicated collection of people in my electorate of Eden Monaro. Everyone in the Bega Valley was shaken by the crimes committed by Maurice Van Ryan, who was convicted of abusing 9 children between 2003 and 2014. Van Ryan was also later convicted of abusing a 10th child in 2019. In 2023, the Supreme Court of New South Wales awarded the 10th victim Eden Van Haren $1.4 million in damages for the abuse he endured. Van Ryn then declared bankruptcy in December 2023. Under the existing laws, this would extinguish his debt and deny victim survivors justice. This legal escape clause allowed Van Ryn's abuse of Eden to continue by hiding his superannuation against the compensation he owed to his victims. When I was first elected as the member for Eden Monaro in 2020, the campaigners for this change in my community came to me and explained the work that had already been done. I was moved enough to use my privileged position to take up this cause. I want to thank Attorney General Michelle Rowland and Assistant Treasurer Dan Molino, who have worked tirelessly to deliver this life-changing reform for victim survivors. These new laws will close a deeply unjust loophole and give victim survivors access to compensation they are owed. I want to extend my genuine gratitude and admiration to victim survivors like Eden Van Haren for their bravery to sustain this campaign and push the government to make our laws fairer for victims. For Eden, this took countless meetings with the Assistant Treasurer and the Attorney General to iron out the specific ways this reform could be implemented that could stand against challenge and pass through the Parliament as quickly as possible after introduction. Other campaigners that I would like to thank for their sustained efforts include Nicholas Kavanagh, who was another victim of Maurice Van Ryn, Eden's grandmother, Carolyn Kelly, who is a solicitor on the mid-north coast of New South Wales, David Neal, a Super for Survivors campaigner and local community advocate from the Bega Valley, Andrew Carpenter, partner at Webster's Lawyers, Fighters Against Child Abuse Australia founder Adam Washbourne, abuse survivor, actor and advocate Madeline West, and all the campaigners from the Super for Survivors campaign. In preparation for delivering this speech, Eden asked me to say this. I know there is a lot of anger around this topic of survivors, and everyone wants to get revenge on these monsters and make them pay. And I've been angry, so bloody angry, wishing I could just start life over again, wishing I could make this insidious pain and struggle I deal with every day just disappear. But that's not what this is about. This is about all of us. This is about Australia. This is about the absolutely monumental effect the cause of child sexual abuse has on every aspect of Australian life. The sheer number of people who contact me to share their story every day, my heart tearing just a little bit more. We should not have had to spend our lives suffering because of a decision adults made towards us as innocent children. We need a change. We need to heal. Australia needs to heal. So I beg you, please help us heal. Please help us heal at the expense of the responsible party, not at the expense of the rest of Australia. No more hiding money in super, and absolutely no more to allowing bankruptcy to be used to clear the pain caused by this disgusting behaviour. Super for Survivors campaigner and local Bega community advocate David Neal also asked me to relay his words. I started this campaign in 2017 after recognising that perpetrators of child sex offences were able to weaponise the existing legal system and use it against victims who dared to seek civil compensation for the harm done to them. With the passing of this bill, we can bring this abhorrent practice to an end. As one victim survivor of Maurice Van Ryn said after witnessing this bill presented to Parliament in March 2026, we have taken back the power from this monster. I also would like to thank local media, with particular reference to Bega District News, Power FM, ABC Southeast, A Current Affair and Region Media, for continuing to shine a light on this issue and ensuring it did not leave the agenda of government. As a Parliament, we must recognise that the impacts of child sexual abuse are enduring, complex and profound, and that our response must be equally serious, sustained and centred on those who have been harmed. For too many survivors, a court ruling in their favour has not translated into real-world outcomes. They have endured the trauma of legal proceedings, only to face further distress when compensation orders go unpaid, compounding the harm. When survivors tell us that the system still falls short, it is our responsibility to listen. It is important to remember the voices that we do not hear. According to the Australian Institute of Health and Welfare, only a third of sexual assaults are reported to police. Making sure our legislation remains fit for purpose and meets the expectations of community is critical, which is why reviewing this measure after its implementation is also essential. This will ensure that Parliament does not simply pass legislation and move on, but remains engaged with how those reforms are working in practice. It provides an opportunity to assess whether victims and survivors are benefiting and whether additional changes are required. This reform is about righting wrongs, restoring fairness and ensuring accountability in our legal system. I am proud to be part of a government that has delivered this reform. I'll continue to support victim survivors and advocate on behalf of our community, and I am really proud that this Parliament will come together over this bill, and I proudly commend the legislation to the House.
The question is that the bill be now read a second time, and before I would like to I understand that the member for Pearce would like to present a copy of her speech for incorporation into Hansard in accordance with the resolution agreed to on the 6th of November 2025.
Thank you, Deputy Speaker.
Thank you, member for Pearce. The question is the bill be now read a second time, and I call the member for Menzies.
Thank you, Deputy Speaker. I rise today in support of the Treasury Laws Amendment, the Survivors Bill 2026. I'd like to acknowledge the contribution of the Minister for Regional Development, Territories and Local Government that preceded this, for her moving contribution and for giving voice to some of the victim survivors that she spoke about earlier. For all members of Parliament, for parents like me and for anyone with children in their lives, there are few crimes more horrifying and more devastating than child sexual abuse. Of course, there is the sickening cruelty, the betrayal of the act or acts itself, often perpetrated by someone in a position of trust or authority. But the impacts for victim survivors can be lifelong. Many may not be aware of or acknowledge, let alone disclose, abuse until much later in life. For survivors, the harm does not end when the abuse stops. In many cases, it follows people for years and decades afterwards. It affects mental health, relationships, education, employment, financial security, and the ability to feel safe in everyday life. Victim survivors may experience post-traumatic stress disorder, anxiety, depression, substance abuse, self-harm, and suicidality. And the reality is this issue touches far more people and families than many Australians realise. According to the Australian Child Maltreatment Study, more than 1 in 4 Australians have experienced child sexual abuse. Research shows more than 1 in 3 girls and almost 1 in 5 boys have experienced child sexual abuse in Australia. These are confronting figures. National data tells us that more than half of recorded sexual assault victims in Australia are children and teenagers under the age of 18. They are people we know. They are our neighbours, friends, colleagues and family members. Across communities like ours, there are survivors quietly carrying trauma, raising children, working, moving forward while dealing with experiences that never fully leave them. Years can pass before somebody feels able to speak about what happened to them. Many fear they will not be believed. Many fear reliving the trauma through police investigations and court proceedings. Others carry shame and silence that was imposed on them as children by people who abuse trust, power and authority. And even when survivors do everything the system asks of them, justice can still be incomplete. That is the problem this bill seeks to address. Because too often, survivors have gone through lengthy court processes, secured compensation orders, and still been unable to access the compensation they are legally owed. But in reality, some offenders have been able to shield assets and avoid responsibility, including through the use of superannuation arrangements and bankruptcy processes. When I worked at the County Court of Victoria as a judge's associate, we had a case that had been in the court for years through different legal proceedings where the victim survivor had successfully obtained compensation, and then, in exactly the circumstances that this bill seeks to address, the perpetrator had filed for bankruptcy, and so the victim survivor had had to follow them through a number of federal court proceedings and then back to the county court in a way that can only be described as systems abuse. Perpetrators causing further harm, causing further trauma by using the justice system and by frustrating justice. There is a saying that justice delayed is justice denied. This only talks about half the picture, because often legal processes themselves can be traumatic and gruelling. They are, of course, expensive. Sometimes victim survivors are required to give evidence in civil proceedings in ways that they would usually be shielded from in criminal proceedings. They can consume weeks and sometimes years of people's lives, especially where proceedings are drawn out in the way that people who engage in systems abuse often do. And after years of trauma and after the stress of legal proceedings, after finally hearing a court acknowledge the harm that has been done to them, victim survivors are still forced into further exhausting battles simply to enforce what the justice system has already recognised. And that is why this reform matters. This reform has been in discussion for years. In 2018, the Turnbull government announced it would legislate to allow victims of serious crimes to access a perpetrator's superannuation to satisfy compensation orders. But the legislation was never introduced and survivors were left waiting. The Albanese Labor government is now delivering the reform survivors and advocates have been calling for years. This bill closes a loophole that should have been closed long ago, and it helps ensure accountability and has real meaning in practice, not just in principle. This debate is about more than just financial enforcement alone. It is about whether the justice system can be weaponised by perpetrators to cause further harm to people who have already experienced immense trauma. This is in circumstances where the court has already recognised harm, a judge has awarded compensation, but if survivors cannot access what is owed to them, the justice that compensation can represent is never fully realised. This reform exists because survivors and advocates refuse to let this issue disappear. It is incredible that some people can bring the hardest experiences of their life and channel it into advocacy in this space and in so many other spaces where we have the privilege to meet victim survivors who advocate around issues in this place. I want to acknowledge the extraordinary advocacy of survivors, families, lawyers and child protection organisations over many years, including organisations such as Bravehearts, Fighters Against Child Abuse Australia and the Carly Ryan Foundation, alongside so many others who continued to push this issue into the national spotlight and refused to let it be ignored. I've come into contact with some of these advocates, some of these victim survivors through our work in the Social Policy and Legal Affairs Committee inquiry into domestic, family and sexual violence and suicide. And of course the terms of that include victim survivors of child abuse, and the fact that this inquiry seeks to investigate and reduce the risk of suicide that results from domestic, family and sexual violence reflects the real ongoing consequences of childhood sexual abuse. I'd particularly like to acknowledge a couple of victim survivors who gave evidence before the inquiry, Connor and Camille, who spoke very powerfully and affectingly about their experiences and will certainly inform the final outcomes of that inquiry. It is a very brave but also a generous thing that advocates do, using their time and their energy to help us in this place better understand how we can legislate to ensure that the harms that are caused to them are less likely to happen to others in the future, and how we can close loopholes like this to make sure that the law is delivering justice. Child sexual abuse often exists alongside family violence and coercive control, emotional abuse and financial manipulation. This bill closes a very serious loophole. It means offenders who owe court-ordered compensation to survivors of child sexual abuse will no longer be able to shield certain superannuation contributions while leaving survivors unpaid. If compensation remains unpaid for more than 12 months, survivors will be able to access certain contributions made into the offender's superannuation account in order to satisfy that debt. The bill also ensures that debts cannot simply disappear through bankruptcy. That matters because bankruptcy should never become a mechanism for avoiding responsibility for serious criminal harm. At its core, this bill says something very simple. If somebody commits profound harm against a child, they should not be able to protect their finances while survivors continue to carry the lifelong consequences of abuse. It's not about undermining the purpose of superannuation. Australians rightly value the superannuation system, but it was never intended to operate as a shield against reparations for such serious criminal conduct. It's about basic justice. People know the difference between protecting retirement savings and protecting offenders from responsibility, and this bill draws that line clearly. What becomes very clear quickly is that abuse affects every part of somebody's life. I've met with survivors of abuse in my office, and they talk about how it can affect their confidence, and it can affect health, and it can affect stability, economic and housing. It can affect a person's sense of safety and self-worth in everyday life. And that is why this reform matters. And frontline workers see the impacts of this every day. In my electorate of Menzies, in Manningham, in Melbourne's East, organisations like Doncare Community Services and Eastern Community Legal Centre work every day with families facing trauma, financial stress and family violence. They understand that the effects of abuse do not simply disappear once court proceedings end. Trauma can shape a person's mental health, financial stability, relationships, employment. Recovery is often long, uneven and deeply difficult. The workers at these organisations like Doncare focus on recovery because they recognise that it is often a long road and that support is needed, expert support, often from people who have been through the same experiences. And survivors need more than recognition of harm. They need systems that deliver practical accountability and real support. This is also why broader investment matters. Last year, the government announced $12 million in grants to support specialist and community organisations responding to child sexual abuse and harmful sexual behaviours in children. That funding means more trauma-informed counselling, earlier support for vulnerable children and families, and stronger frontline services in communities dealing with the long-term impacts of abuse. And as part of the broader $80 million National Cabinet commitment to strengthen responses to family, domestic and sexual violence, it means more support reaching communities earlier. That matters because early intervention can change the course of somebody's life. It can mean a child receives support before trauma deepens further. It can mean families receive help sooner. And it can mean cycles of violence interrupted before they continue into another generation. These investments are important because no single reform on its own can fully address the lifelong impacts of abuse. But legislation like this still matters enormously because it addresses a clear injustice that survivors have identified themselves. For too long, survivors have done the hard part and carried the burden of advocacy. They have come forward, they have relived trauma, they have participated in difficult legal processes and advocacy. They have secured compensation orders through the justice system, and then those orders for compensation have been delayed or denied. Some offenders, some perpetrators, have been able to protect assets while survivors remain unpaid. People expect accountability to mean something real, and this bill helps restore that principle. It strengthens accountability in a targeted and measured way. Importantly, it reflects the voices of advocacy of survivors themselves. Many survivors have spent years pushing for changes like this because they understand better than anyone where the system has failed. Their advocacy has helped expose gaps in the law that allows offenders to avoid responsibility even after criminal convictions and court-ordered compensation. Their advocacy matters. It has helped move this parliament towards a fairer outcome, and it's important that this parliament continues listening to those voices. At its heart, this bill is about dignity, fairness and responsibility. It is about making sure our legal and financial systems do not leave survivors carrying the burden while offenders continue to enjoy their assets. When a court says compensation is owed to survivors of childhood sexual abuse, that compensation should be paid as soon as possible. It should not be out of reach because of financial loopholes. Survivors deserve better than that. This legislation will not erase trauma, and it will not undo the harm caused. No amount of compensation can ever truly do that. But this reform does move us closer to a system where justice is real, enforceable and meaningful. And for that reason, I commend the bill to the House.
Thank you. I now call the Assistant Minister for Defence.
Thank you, Deputy Speaker. The Albanese Labor government understands that it's a truism, I guess, that when you get the best policy outcomes when you meaningfully engage with the people that the policy is actually for. And that's why we have and we continue to listen to survivors of child sexual abuse and advocates who have long called for stronger accountability for perpetrators and improved justice outcomes. So many people might not know, but convicted perpetrators of child sexual abuse in Australia can be ordered to pay a financial compensation to their victims, and there's multiple ways that that is done through court orders and so on at state level as well. And I'll run through those. But what people might not know is that a loophole actually exists in existing legislation that has meant that the perpetrators have been able to shield their assets in their superannuation, which effectively leaves victims and survivors without the compensation that they are owed and have been determined that they should be paid. So this bill, which will become law, the survivors' law, closes that loophole for good. It allows victims and survivors to seek access to a perpetrator's superannuation to satisfy unpaid compensation orders where a criminal conviction has been made. And the bill really goes to a very simple but fundamental principle, that perpetrators of child sexual abuse should not be able to hide behind financial structures to avoid accountability for their crimes. Justice is not only about conviction, it is also about meaningful redress. And the survivors' law will provide meaningful redress for victims. There are three avenues, as I mentioned earlier, in the manner in which victims are paid compensation. It includes state and territory compensation schemes, where the state or territory, rather than the offender, pays the compensation to the victim. There's compensation or reparation orders handed down as part of the sentencing process in a criminal proceeding, or there is a civil action pursued by the victim against the offender for damages. None of these options, however, allow the victim to access any financial compensation through the perpetrator's superannuation. According to the Department of Treasury, there have been many such cases where offenders who are either subject to or anticipating criminal proceedings have made large voluntary personal contributions to their superannuation to avoid having to pay the compensation. And this has allowed the offender to shield their assets from those compensation claims. Obviously, this cannot continue. And the Albanese Labor government has introduced this bill to shut this loophole for good, as I said, Deputy Speaker, ensuring that those who have suffered so horribly from abuse are no longer blocked from the compensation they deserve. Deputy Speaker, this bill seeks to amend the Taxation Administration Act of 1955 and other relevant Commonwealth acts to allow victims and survivors of child sexual abuse to apply for a court order for the release of certain amounts from a perpetrator's superannuation interests. Under these reforms, where a court-ordered compensation debt remains unpaid after 12 months, victims and survivors will be able to seek access through a court order to certain superannuation contributions made by the offender. This includes additional personal and salary sacrifice contributions which have previously been used as a vehicle to shield assets from enforcement. So this is a very practical and targeted step. It also introduces a mechanism to ensure that perpetrators cannot simply wait out their obligations while their financial position remains protected. Importantly, this schedule ensures that compensation debts do not simply disappear through bankruptcy. Now, by allowing these debts to survive bankruptcy proceedings, we are reinforcing a clear and necessary message. Financial manoeuvring must not override the legal and the moral responsibility. Bankruptcy should not be a refuge from accountability for such serious harm. These changes will apply not only to future bankruptcies, but also to those currently in progress. That's significant, Deputy Speaker, because it recognises that there are survivors right now, today, who are being denied justice under the existing framework. When offenders retain substantial retirement savings while victims struggle financially, often as a direct consequence of the abuse they've suffered, it really undermines confidence in the justice system. It risks perpetuating a cycle where the burden continues to fall on those who were harmed, rather than those who caused the harm. Child sexual abuse crimes often leave deep and lifelong impacts that extend far beyond the period of abuse itself. And that trauma does not end when the abuse ends. For many victims and survivors, it is something they must navigate every single day, too often in silence and without the adequate support that they need. Some survivors face barriers to stable employment and financial security, meaning the harm they experience is not only emotional and psychological, deeply emotional, but it's very material as well. And for those who seek the pursuit of justice, they must then relive the painful experiences they went through from their abuser as part of that process. This bill, Deputy Speaker, is our government's way of recognising the deep and lasting pain that victims do endure and trying in just an important way to redress some of that pain. But because under our government, no victim of child sexual abuse should have to endure the risk of financial insecurity due to the lasting effects of the abuse that they suffered. Our government, Deputy Speaker, is committed to protecting our most innocent and vulnerable citizens and holding those who seek to do them harm accountable. As a parliament, we must recognise that the impacts of child sexual abuse are enduring, they're complex, they're profound, and our response must be equally serious, sustained, and centred on those who have been harmed. We will continue to listen, importantly, Deputy Speaker, improve and build upon these laws. That is why this bill should be understood as a significant and necessary foundation to more work that needs to be done. It lays the groundwork for potential future reforms, because enclosed within these reforms, Deputy Speaker, is a framework that can be built upon in the future. This ensures a critical measure of being able to review these reforms after their implementation, and we should and will remain engaged in our policies to ensure that they are making a tangible impact on those that they affect. That's why the review mechanisms enclosed in this bill allow our government the opportunity to assess whether victims and survivors are genuinely benefiting and whether additional changes are required. The legislation will continue to be informed by voices of survivors, advocates, legal experts and practitioners. And engaging with these stakeholders is critical to ensure it is delivering on its intent and whether barriers remain that need to be removed. Deputy Speaker, the reforms enclosed within this bill will make a real difference in the lives of victims and survivors. It cannot wipe away the pain and the trauma, but it will make a difference. And the ability to provide new avenues for enforcement and financial compensation will allow for a greater chance of achieving some measure of justice for the survivors. Our government can't, no government can reverse the harm that has been experienced by victims, these survivors. No one can do that. Survivors of child sexual abuse have gone through a horrific experience. We can't reverse that. We can, however, legislate here in this place reforms to ensure that the perpetrators of these crimes feel the full enforcement of the law. Because those who seek to harm children should know that this government and this parliament will not stop until survivors get the justice they deserve. So this bill is about aligning our financial and legal systems with, I think, in effect, our values in many respects. Values that say perpetrators must be held accountable, that the victims and the survivors deserve not only recognition and acknowledgement of their pain and understanding, but also meaningful support and redress. So we stand in this parliament today, and I think both sides of the House, to demonstrate that recognition of the courage shown by so many survivors who've spoken out about the abuse that they have endured as children. No easy task to go through that experience and then to speak about it many, many years later. Their lives have been shaped by pain, by injustice, and all that occurred to them at such a young age. So difficult to cope with at any age, but for them to go through this experience as children is horrific. I don't think many of us here are parents. I don't think any of us, or any of us who are not parents, all of us would probably agree very clearly that no children should ever have to experience the suffering that so many victims and survivors have had to face. So this parliament, I think, is doing a good thing in reaffirming our responsibility to ensure that those voices are heard, that the injustices that they experienced at some level are addressed with some measure of justice, and that the failures that have occurred in the past are never repeated. I commend this bill to the House.
Thank you. And the debate is interrupted now in accordance with Standing Order 43, and the debate may be resumed at a later hour. And if any members require a continuation of speaking when the debate is resumed, the permission will be granted. Are there any statements by honourable members? I give the call to the member for New England.
Thank you very much, Madam Deputy Speaker. Yet again, I have a meeting with people who have had their money stolen. Lion Property Group has their 400 victims, $250 million has gone, and the Albanese government, under Assistant Treasurer Stephen Jones, had said the system had to prevent collapses, malfeasance, mis-selling and catastrophic consumer losses. We haven't done that. And on the back of that, that's on the back of me representing First Guardian and Shield Master Funds. What is going on? Who is looking after it? What is ASIC up to? I'm going to give some tips as an old auditor of what they should look at. In some of these authorising bodies, who authorised MWL to have a licence? Who audited MWL? When was the last audit of MWL? What type of audit was undertaken? Qualified, unqualified? What fees did MWL receive for placing the business? What security did the directors of MWL receive? What fees did equity trustees receive for handling the money of MWL? What fees did the directors of equity trustees receive to manage the funds? Who are the audit partners of equity trustees? What are the auditors' fees? What report did the auditor deliver on where equity trustees were investing? What working papers can the auditor present to describe diligence in their job? How much did they charge in equity trustees? Madam Deputy Speaker, no answers have been given. And if they can't do the job, hand it over to me, I'll do it for them.
Member for Werriwa.
Thank you, Deputy Speaker. On Saturday the 18th of April, the voters of Liverpool Council South Ward went to the polls after the resignation of a councillor. Setting aside the unnecessary costs of this election, quoted by the media at least $800,000, the election was because the CEO did not organise for a countback procedure at the beginning of the council term. Congratulations go to Labor's Zeli Munjaza, whose positive-focused campaign meant that she won every booth in South Ward. This amazing result sends a clear message that the lack of services and broken promises should be addressed by Council and the Mayor, as the ratepayers have had enough of the grandiose ideas and want back to basic delivery. I'd love to see Council use the grants that have been received from the federal government to fix many roads in the electorate of Werriwa, or deliver on the parks in Austral as promised and funded by the federal government. When the Council is slow to act, it's always the residents who are inconvenienced or worse, put at risk. Speaking of which, I also want to add my concern about the proposed job losses that went to an extraordinary meeting of Council last night. These job cuts, should they go ahead, will no doubt result in the cancellation of further basic services and see workers sacked when we need to be hiring workers to make sure that our normal services like parks are mowed properly. Ratepayers are again paying the price for Council's poor administration.
Member for Wright.
Thank you, Madam Speaker. My phone is ringing hot during the morning of constituents in the electorate of Wright, letting me know their disappointment with the broken promises, the trail of broken promises from Labor as a result of the budget last night. And I said, where's the broken promises? And they said, well, we would promise $275 to reduce our electricity some time back, and that never happened because we were told that electricity prices were going to go down, and they've actually increased 43%. And we were told that if Labor spent $43 billion on housing, that it would supercharge the economy and more houses would be built and it would be easier for young Australians to get access to the market. Well, the reality is when we left government, we were building 220,000 homes a year. Under these guys, 40,000 left. Recent data from Housing Industry Australia, 183,000 homes built in the reporting period last year. Broken promises after broken promises after broken promise, and of course we remember the clanger. What was that one? My word is my bond on the stage 3 tax cuts, where we got a 2.2% reduction. Broken promises time and time again. You just can't trust Labor. We got the highest spending Labor government for 40 years outside the pandemic, and interestingly, we don't have a spending problem. We don't have a taxing problem. These guys have got a spending problem.
Member for Leichhardt.
Thank you, Speaker. One of the great privileges of representing a seat such as Leichhardt is the unmatched natural beauty, and recently I had the good fortune of being able to share that with Assistant Minister to the Prime Minister, Patrick Gorman. He came up to speak to businesses and locals across the river at Cape Tribulation about some of the issues they'd been having post-floods. As many of you would already know, the ferry washed away, which cuts off the Daintree and Cape Tribulation from the rest of the world. We had to helicopter in fuel, food and other supplies, but the Daintree ferry is back. And the Douglas Shire Council has waived all fees for anyone in Far North Queensland, or Far North Queensland locals can now head across the river for free and enjoy one of the world's great natural wonders. And I would encourage absolutely everybody to do so. From the views out at Cape Tribulation across the mighty Daintree River to some of the most beautiful and pristine beaches on the planet, you may even see a cassowary. Now, the beaches are not necessarily for swimming, Speaker. There are bitey things in there, but there are some fantastic swimming holes that are crocodile-free. Just head up to Mason's, stop at Flora Villa and grab yourself an ice cream. A really special day. Not a single person ever in the history of the world has regretted a moment they've spent in the mighty, mighty Daintree. I recommend everybody in the far north get in the car, head across the river, support local businesses. They've been doing it tough, but they're going to show you one of the best places on the planet.
Member for Kennedy.
Madam Speaker, I have been agonising over whether to raise this issue on the national agenda or not, and I just can't really put it off any longer. Life expectancy for first Australians has slipped from 54 to 49, whilst the rest of us, our life expectancy is 82. Now, you know, I hope no one will call this genocide, but if you know this is going on and you do nothing about it, and I have repeatedly raised the issue, and not only myself but other people as well, and you do absolutely nothing about it, they can't grow their own fruit and vegetables because you abolished their right to have backyard fruit and vegetable gardens in the Torres Straits, and because they are not allowed to own land anywhere in the Aboriginal communities in Northern Australia. I can't speak the rest of Australia, probably the same. Now, you know, there are 2 million hectares in above 24-inch rainfall area, supposedly owned by the First Australians. But you mob over there and you mob over here have said it has to be owned by the tribe. Well, why don't we put that on you? Why don't we say, oh no, you can't own any land here, you're Scottish, go back to Scotland.
Time has expired. I'll just remind people, direct your comments through the chair. We don't want a personalised debate. Member for Banks has the call.
Thank you, Deputy Speaker. Parliament and Canberra can sometimes feel like something that is very far away. While we all get the pleasure of welcoming school groups to Parliament when they visit, it is also important that sometimes this place comes to them. That is why it is my pleasure, and it was my pleasure, to welcome the Speaker of the House to Panania North Public School in my electorate of Banks a few weeks ago for the Parliament in Schools program and the Australian Parliament National Flag Roadshow. The students at Panania North got a great lesson about how both our Parliament and our democracy functions and how their voices can be heard. They also got to unfurl one of the flags that fly on top of this building in their very own playground. It was fantastic to see the leaders of tomorrow so engaged and interested in learning about how our country works, how decisions are made, and how they can have an impact. I wanted to say a big thank you to the teachers, staff and students at Panania North Public School for helping to facilitate an amazing visit, as well, of course, to the Speaker himself and his office for making the time to visit us in the electorate of Banks and Panania in particular. Since the visit, I've had countless families tell me how enjoyable that visit was.
Member for Groom.
Thank you very much, Speaker, and I don't need to tell you or any other member of this place just how tough things are out there in the economy at the moment, whether it's talking to businesses, watching cash dry up in their businesses, or charities finding it harder to raise the money they need to do the good things in our community. But the two areas I think most on are young people struggling to get on the property ladder and renting pensioners. You want to see two parts of the community that are really struggling. Renting pensioners, costs are going up everywhere on fixed incomes, and they are hurting. They are hurting, Speaker. And in this context, Australia turned its hopeful eyes to the government that they would deliver a budget that would provide some relief, some hope, a light at the end of the tunnel in this budget that would help them out. Instead, Speaker, we got the highest taxing budget ever delivered by a government since records have begun, the highest taxing budget. And what has it done? It's done what all taxes do. It has taken away hope and ambition. And I'll give you just one example. Page 158 of budget paper number 1 reveals 35,000 less homes will be built in Australia over the next 10 years because of these tax measures. That is a direct quote from their own budget papers. Tax high and you kill off investment. And that is what is happening. And for young people who are hoping that opportunities will grow for them on the housing ladder, no. Labor have just taken them away.
Member for Bean.
Deputy Speaker, sudden cardiac arrest can impact people of all ages, genders and lifestyles. It does not discriminate. Approximately 10% of people who experience a cardiac arrest outside of hospitals survive. However, if good quality and timely CPR and AED are utilised, survival rates can increase to 70%. That is where the work of organisations such as St John's Ambulance comes in. St John's asks governments, partners, funders and communities to get behind public access to defibrillators. Working together with Street Beat, an initiative led by Goodloop Mutual in partnership with St John's Ambulance ACT, I have sponsored the installation of one of these life-saving devices in my community. I was also able to run community training on how to use this AED last week in recognition of Heart Week. This program has so far installed 47 publicly accessible AEDs across Canberra. Last week it was announced that due to the generosity of people such as Matt Franklin and Capital Chemist Group, we will see an AED installed in every residential suburb in Canberra, making our city one of the first in the world to achieve this. Every Australian should have access to this life-saving equipment. Any Australian can learn first aid and how to use one. I commend St John's and Goodloop Mutual for working to make this a reality.
Member for Parkes.
Well, Deputy Speaker, after last night's budget debacle, hard-working Australians are waking up to the realisation that the harder they work, the more this Albanese Labor government takes from them. In this misguided attempt to address intergenerational equity, they have achieved the complete opposite. And they have managed to do this while delivering another kick to the older generations who've worked hard, done without, saved, paid off their homes under high interest rates and then been able to invest. This generation have been taxed on their wages, taxed on their savings, taxed on their super, and now absolutely gouged on their investments. This might have been the legacy that they left for the next generation. Now, this has all become more difficult, more expensive and less possible. Speaker, this budget is kicking Australians when they're down, and no one knows more or better than the people who represent Australians in local government. Some of my mayors are here today in the gallery, and I'd like to acknowledge Darryl from Narrabri, Marg from Parkes, Catherine from Warrnambool Shire and Doug from Gilgandra. They are here to try and move past the chaos that is the axing of the inland rail north of Parkes in this budget. Another day, another blow, another absolutely devastating budget from a Labor government.
Member for Reid.
Last Sunday, I participated in the Mother's Day Classic with my son, alongside 100,000 Australians walking and running to support life-saving breast and ovarian cancer research. I was inspired by my constituent, Melanie Warman. She is the chair of the Sydney Organising Committee for this incredible national event. She's also the founder of Boobs on the Run, an incredible women's-only running group. Her drive to raise funds and improve women's health is deeply personal. She lost her mother to breast cancer almost 20 years ago, and she's turned that loss into action that's helping thousands of women feel supported, informed and empowered. It was a privilege to walk alongside her and other participants who showed up with love, courage and solidarity for this deeply emotional but also hopeful event. The Classic was founded by Louise Davidson AM and the late Mavis Robertson AM, with the support of Women in Super, as a small event in Sydney and Melbourne in 1998. Today, it's grown to be so much more than a fun run. It's a national message of hope, with 1.9 million Australians taking part, raising over $50 million, and a reminder that research saves lives.
Member for Mallee.
Thank you, Deputy Speaker. Numbers matter. And when the government brings down a budget, the numbers matter even more. $50 billion in more taxes on the Australian people. The disgrace in the budget last night is who the government is deciding to tax more. And it is our elderly. Surprisingly, the government has decided to go after our elderly. And that is while the aged care system is failing them dreadfully. At the moment, as I said, numbers matter. 200,000 elderly Australians are waiting to get assessed or to receive home care support, support at home, Commonwealth home care support. I really don't care what the name is. The fact is our elderly are being ignored and their dignity is at stake under this government. And last time we checked, 5,000 people have died waiting to get on to aged care support. This is an absolute shame on this government. And rather than talking about those things and making sure that more funding is available, guess what? They're coming after over 65-year-olds to take private health insurance, so they theoretically can pay for the aged care debacle.
Member for Melbourne.
Thank you, Speaker. At the launch for the National Plan for the Push here in Parliament House, there was a different kind of buzz in the air. Young people were talking about music, what they were building and where they were taking to it next. That is what the push does. For more than 30 years, it has backed in young people to jump in, try new things and turn their love of music into something real. Not just for the artists on stage, but for the people behind the scenes as well. The ones running the gigs, mixing the tracks and building the sets from the ground up. In Melbourne, young people are right at the heart of the live music scene, which is alive, loud and constantly changing. They are filling our venues, starting bands, running shows and moulding the sounds of our city. That energy was right here in Parliament House, because when you back in young people in music, we back their confidence, their creativity and the culture we all get to be part of. So I want to thank the Push for the work they do, for bringing young music and young people together, for bringing the spark back into this place and for backing a generation that is ready to take the stage. Thank you.
Member for Cowper.
Thank you very much, Deputy Speaker. The budget rhetoric we heard last night from Labor is taking the Australian people for mugs. While proclaiming to take pressure off Aussie families and lift living standards, in reality, Labor is taxing aspiration and lifting the ladder from young would-be investors and pouring an irresponsible level of migrants into our already overstretched networks, from housing to health and everywhere in between. And for the regions, well, it appears that any savings made in this budget are at our expense. $4.7 billion cut from infrastructure, $103 million cut from the national water grid, $191 million cut from pest and disease, regional trade and drought funding for farmers, and $21 million cut from regional communications funding. Money being ripped away from nation building and redistributed to Labor's metro-centric pet projects and a tax cut of $4.80 a week. Not enough to even buy you a coffee. Infrastructure and communication funding are literally lifelines for my communities, and seeing them brutalised by this Labor government shows the true lack of care they hold for my electorate of Cowper. The irony is that solutions to so many of our nation's problems lie in the regions. Housing, resources, food and sovereignty, that's what the regions have to offer in this country, but Labor continues to ignore us.
Time. Member for Solomon.
Last night's budget provided $24 million to upgrade major safety hotspots on Bagot Road in my electorate in Darwin. This issue is very close to my heart as someone who's very well aware that a road user in the Northern Territory is 4 times more likely to die in a road incident than in other parts of Australia. And I'm also the chair of our local Black Spots Committee. It's a very important issue. We all know the physical, mental and social impacts from road injuries and deaths, not only on the individual themselves but on their families and the whole community. So improving road safety is a challenging issue, but particularly when it comes to pedestrians as well. For example, as is the case on this road in question, Bagot Road, there's Aboriginal communities are located close to that road and with little public transport and safety infrastructure. So it's both the pedestrians and the drivers that become vulnerable. And I met with Menzies School of Health research team last week to hear about their road maps for the NT project, which is funded by our government, that talks to the Aboriginal community members in Darwin, to service providers, policymakers and researchers to get more effective local road strategies, and I thank them for that work.
Member for Flinders.
Thank you, Deputy Speaker. Last night's budget told you everything you need to know about this Labor government's priorities. In the macro, punish ambition, tax wealth, make it harder for everyday Australians to get ahead, lift rents, keep pressure on interest rates, and in doing so, crush the construction industry's willingness to build the homes we so desperately need. By Labor's own data, 35,000 fewer homes will be built over the next decade. But the true believer bias, pro-union, anti-employer, is in the micro detail of the budget too. Last night, the Albanese government set aside $5.3 million to prop up the CFMEU's administration, a union mired in allegations of corruption, criminal infiltration, intimidation and bikie links. And how much money for small business trying to navigate Labor's ever more complicated Fair Work system, this impossible morass? $1.3 million. Labor is spending 5 times as much shielding the CFMEU as it is helping small business find its way through the Fair Work quagmire it has created. Every day I meet small businesses being crushed by it: the cafe owner in Rosebud, the tradie in Hastings, the restaurant owner in Sorrento, the family business struggling in Somerville, all expected to keep pace with Labor's endless industrial relations changes with next to no support. Australians are now literally paying more to keep a dysfunctional, corrupt union afloat than to help small business create jobs and opportunity.
Member for Bonner.
Thank you, Deputy Speaker. Last night, Labor announced we are investing almost $183 million to make the child support system safer and fairer. There is currently $2 billion in unpaid child support debt in Australia, and women make up around 83% of recipient parents. These historic reforms will help prevent the weaponisation of child support and protect parents and children from financial abuse. These are the most significant changes to the child support system in nearly 20 years. It includes $3.6 million to ensure that when Services Australia identifies systems abuse, they have the power to stop it. From 1 July next year, the Child Support Registrar will be able to refuse certain applications when made for the purposes of harassing the other parent. $6.1 million from July this year to support the ATO to prosecute parents who repeatedly fail to submit their tax returns. $12.4 million to improve income data checking so that it can be flagged when income changes. About half of the 70,000 income estimates each year are incorrect. And there is more to come, Deputy Speaker. Labor is making the child support system safer and more effective, delivering accountability and justice for those who need it most.
Member for Canning.
Thank you, Deputy Speaker. The Treasurer stood up last night and hit us with hard news that housing prices have increased more than 400% since 1999. For many Australians, the dream of home ownership is dead, and every week people line up at home opens only to have their dreams crushed. And I hear these stories in my community of Mandurah all the time. Now, what's Labor's plan to fix this? New taxes on housing. Taxes they ruled out before the last election. But the Treasurer failed to mention immigration. He didn't mention that under Labor, Australia's population has grown by 1.8 million people, and that growth has been driven by 1.4 million migrants, at a time when our fertility rate has hit a low of 1.4 births per woman. We're not having enough children to replace ourselves, and Labor is running the fastest immigration program in our history. The Treasurer also failed to mention that we've only built around 500,000 homes under Labor. No wonder young Aussies are locked out of the housing market. Now we learn that Labor will welcome another 750,000 migrants over the next 3 years. Labor is on target for 2 million migrants before the next election. Yet we can't build fast enough to house these people. Prime Minister, here's a tip. Why don't you tie immigration to housing builds? Look after Australians, get our people into a home before you open our borders to everyone else.
Member for Bendigo.
Thank you, Deputy Speaker. Well, one of the line items in last night's budget, I'm proud to stand here and say, was our government's commitment to building more Bushmasters in Bendigo. An extra $750 million to deliver extra Bushmasters to the Australian Defence Forces, 268 in total, which will secure work at the site for the next 7 years, securing the jobs of 300 locals and encouraging Tallis to bring on that next generation of tradies. They are already talking to local schools about the opportunities that could exist at Tallis once they leave school. This is an exciting moment for Bendigo, locking in these jobs and securing the site. I just want to remind the House where the site was at prior to the 2022 election. Tallis had reached out to say that they had no work secured by those opposite. The site would close if Labor did not win the election. The good news is we did win the election, and with the dedication of this government, we've secured the jobs and secured contracts now and into the future. I want to pay tribute to the workers and their union for hanging in there, for committing to the site, and to this government for backing in these workers, this future manufacturing that will continue at the site, locked into our budget now and into the future.
Member for Goldstein.
Thank you, Deputy Speaker. And Deputy Speaker, now we know the truth. Australians went to the ballot box taking the Prime Minister on his word. 50 times over, red hot with rage, he said he wouldn't tax houses, he wouldn't tax rents and he wouldn't hit small businesses. And entrusted with a supermajority in this parliament, that power has all gone to the Prime Minister's head. This government has ignored cost of living continuously, and Australians are looking at this budget and saying, what has that got to do with us? It's doing nothing to lower our costs, but it is hitting us with higher taxes. And last night, the government handed down a bad faith budget. Bad faith because it was built on broken promises 50 times over. Bad faith because it increases taxes, the highest on record for a government. Bad faith because by its own admission it will increase in rents. Bad faith because it will lower living standards, 3% over the life of this government as a share of real wages. And bad faith because it will build fewer homes. I have never seen a budget document like this where they go out and boast so strongly, Deputy Speaker, that they're going to address intergenerational incomes and fairness, and then goes on and builds 35,000 new homes. If you've got a story of how this budget judges you, go to www.notthetaks.com.au.
Call to the member for Patterson. Member for Patterson has the call.
With a world in a state of flux, marred by conflict, by global disruption, by rising pressures beyond our shores, we could have used last night's budget to really retreat from these challenges as an excuse for hesitation. We could have curled up into a Conservative ball and rolled along with the status quo, using the events of the world as a cover to keep doing the same thing and expecting different results. Instead, we as a government have chosen something different. We've chosen to strengthen our sovereignty, to invest in our capacity to make, to build, to care for and house ourselves, and to secure our place in a rapidly changing global economy, not as passengers on the journey, but as active shapers of it. Because at its core, this budget understands something simple but powerful. Every person is driven by the same basic needs: shelter, health, connection and bettering ourselves. A safe and affordable home, access to quality health care when you need it, and the opportunity to stay connected to family, to community, to work, to purpose. Nimbleness, fairness and bravery in government are essential if we are to meet the demands of a rapidly changing world. This government is answering those challenges, and I am proud to be part of it.
In accordance with order, in accordance with Standing Order 43, the time for members' statements has concluded. If members can take their seats quickly and quietly, we shall move to questions without notice. Are there any questions? And I give the call to the Honourable the Leader of the Opposition.
My question is to the Prime Minister. Why did Labor lie to Australians about your plan to tax them more?
Order. I just want to deal with the word lie, and I have a number of order. We just want to make sure that it is not directed to a person. Former speakers have directed it to parties, political governments. So I'm just going to be careful with that word today to make sure it's not directed to an individual. Just putting everyone on notice. I've got a list of examples here where we can have that withdrawn. So as long as everyone knows the rules, we'll be fine. Give the call to the Prime Minister.
Thanks very much, Mr Speaker, and I thank the Leader of the Opposition for his question. We are changing the tax system to give young people a fair crack at their first home. That is what we are doing. That is what we are doing.
Order. Order.
And
Order.
indeed,
The member for Forest. Order. Members on my left will cease interjecting. Prime Minister. Order. There is far too much noise. We are not. Order. We are not. If the member for Herbert has a prop, he'll not use that. Great. Just putting him on notice as well, so everyone's crystal clear. No props today as well. If any props are used, you won't be here for the remainder of question time. When the House comes to order, we'll hear from the Prime Minister.
thanks very much, Mr Speaker. This is a change in our policy, and I'm upfront about that. But unless we act now, we're looking at a generation missing out. And indeed, someone who was appointed by the Leader of the Opposition
Order. The member for
had this
Fisher.
to say when reflecting about how their political party was going. I quote, "We were timid. We weren't prepared to lean into the challenges and the lived experience of the next generation of Australians. I'm quite happy to put things up that will robustly challenge the status quo if it means we're going to build a better future."
Oh no, the member for Herbert will leave the chamber. He's holding up a prop. I've asked him not to do that. He'll leave. We're not having props today. I can be crystal clear on this. Nice try, but we're not having them today or any other day, OK?
I can see you there anyway, Phil.
It's far too much noise. The House is going to come to order and the Prime Minister is going to be heard in silence.
That was the Shadow Treasurer talking in February. Words of wisdom and reflection from the Shadow Treasurer. Words of wisdom and reflection, Mr Speaker. When reflecting on how well they were going in replacing the former member for Farrer as leader by this bloke here.
Has the Prime Minister concluded his answer? The Leader of the Opposition on the point of order.
Relevance, Mr Speaker. The question was about Labor's lies.
Order. Order. Well, if you're going to ask a question like that, you're going to get quite the answer. Order. There's just far too much noise. I know everyone seems exercised today, but we are going to show restraint and respect. We just cannot have this continue. I ask the Prime Minister to be directly relevant to the question.
Thanks, Mr Speaker. Well, when I talk to young Australians who are this close to giving up any opportunity to aspire to own their own home, when I speak to their parents and grandparents who say that they are worried that their children and grandchildren will never be able to own their own home, what we are not prepared to do is just sit back and kick the can further down the road. What we are doing is acting in support of aspiration, acting in support of growing the economy, acting in support of housing supply. Because the difference between investing in an existing home with negative gearing is it benefits the investor, but if you invest in a new home, it benefits the investor and it benefits the nation.
Far too much noise from the member for Barker, the member for Casey and the member for Goldstein, who is also the author of the MPI today. So I'm sure he'll want that to proceed. Give the call to the member for Bass.
Thank you, Speaker. My question is to the Prime Minister. How will the Albanese Labor government's budget help ease cost of living pressures, help younger Australians get into their own home and make our economy more resilient for future generations?
Call to the Prime Minister.
I thank the fantastic member for Bass for her question. someone who came into this place as a former school teacher and understands that the kids that she used to teach in those classrooms need to be able to aspire to their own home. Our budget helps Australians with the cost of living.
No, the
Our
Prime
budget backs
Minister, Prime Minister's going to pause. The member for Gippsland is not going to interject anymore. You've been yelling non-stop through yesterday's question time and today. You're on a warning. One more word, you're not going to be here for the remainder of question time. Prime Minister, the member for Bass has asked her question. The Prime Minister is entitled to answer it.
Importantly as well, Mr Speaker, it builds Australia's resilience. At a time of global instability and turbulence, we have managed today to have more fuel in Australia than we had on February 28th. And the package in this budget on fuel security will further help that. Those opposite said, why are they bothering to talk in Southeast Asia? They took the same principle that they did in government, where they ignored our neighbourhood where we live. They've taken that principle into their ever-diminishing opposition, Mr Speaker. Now, we've also...
The manager on a point of order.
Relevance. The question was very clear.
Resume your seat. Resume your seat. Resume your seat. Resume your seat. Because under the standing orders, you're entitled to raise a point of relevance, which you did. You don't need to explain what that is. And I've got plenty of examples we can go through about what former speakers have handled this exactly the same way, and I'm happy to list them to the member if he requires it. Prime Minister in continuation.
Thanks, Mr Speaker. We have cut taxes for 13 million Australians. Five times. The first one, the one that they said they'd reverse. Then, of course, our second tax cut our top-up that begins on July 1. The further top-up that begins on July 1 next year. Then the $1,000 automatic tax deduction. And then, of course, our working Australians tax offset. If you add all that up, for average workers, it's around $2,800, of which they will be better off. We've not only done that, we've put in place measures such as cheaper medicines. They're making permanent their urgent care clinics as part of Medicare. Something opposed by those opposite, but now they all want one on their corner. We have made free take permanent. We are making a difference with cheaper batteries, benefiting hundreds of thousands of Australians as well. But importantly as well, we are giving Australians a fair crack at buying their first home, backing aspiration. Now, the Coalition have already told us what they are against. In interview after interview, asked about helping young Australians into their own home, they've said they're against it. They'll repeal it now. They'll repeal it. It's a repeat of what happened. A repeat of what happened 1 year ago, and we know how that ended. These geniuses are going to go to an election saying that they will repeal young Australians getting a fair go.
The member for Forrest will leave the chamber under 94A for that continual interjection and yelling during the Prime Minister's answer. And plenty of people will follow him today if that continues. We'll hear from the Leader of the Opposition.
My question is to the Prime Minister. Can the Prime Minister confirm that 35,000 fewer homes will be built as a result of Labor's new taxes?
Order. Give the call to the Prime Minister. Order.
What I can confirm is, as a direct result, and it's there in the budget papers, increase housing supply by at least 30,000. 30,000 as a direct result.
Order.
The $2 billion local infrastructure fund will support up to 65,000 new homes over the decade.
Order. Member
Budget
for
paper number 1.
Order. The member for Cook and the member for
Statement
Goldstein
4,
will just
page
read his book.
158. Page 158. Quote, the measures in this budget are expected to improve home ownership and increase the overall supply of housing. That is what we are doing. This $2 billion additional takes our Homes for Australia plan to $47 billion.
Member for Cowper.
So whether it's increased public housing through our Housing Australia Future Fund, opposed so strongly by those opposite, whether it is private rentals through our build-to-rent scheme, whether it be our shared equity scheme, whether it be our support for local infrastructure, or whether it be the changes that we are proposing, which will ensure that people who want to negatively gear an investment property in the future will invest in new supply, therefore benefiting not just themselves but benefiting the nation as well. All of those measures, every single one of them, is about boosting supply as we go forward. But we're doing more than that as well, because we're reserving a whole range of those houses for first home buyers alone, making sure that we deliver on successful programs that are underway right around the country. But in addition to that, of course, we're making sure that the workforce is there to build those houses. That's why we have free TAFE. That's why we have a $10,000 incentive for construction apprentices or for electrical apprentices as well. All of it opposed by those opposite. Those opposite who didn't even bother to have a housing minister during most of their time in office. Now, we want to make sure that we continue to give Australians a fair crack going forward. Those opposite have blocked every single housing measure that we've put forward. They delayed a whole range of them along with their friends in the Senate. What we're doing
Order. Members on my left.
is moving forward. Labor is the party of aspiration, and this budget last night shows that.
Order. When the House comes to order, we'll hear from the member for Banks.
Thank you, Mr Speaker. My question is to the Treasurer. How will the Albanese Labor government's budget help to reform our economy and make Australia more resilient to economic shocks, and how does that compare to other approaches?
Call to the Treasurer.
Thank you, Mr Speaker, and a big thank you to the member for Banks as well, an absolutely outstanding and valued member of our team on this side of the House. He knows, Mr Speaker, that this is a responsible budget which is all about resilience and reform at the same time. Not resilience or reform, but resilience and reform. It's all about getting Australians through this global oil shock and building an economy that works for more people, Mr Speaker. This budget helps Australians today and it lifts living standards into the future by responding to the global oil shock, by taking pressure off Australians with cost of living and housing, by making our economy more productive over time, by delivering tax reform for workers, businesses, home buyers and future generations, and by making sensible and responsible savings to make sure that the deficits are smaller every year of the forward estimates. Now, Mr Speaker, in this budget, when it comes to fuel, in addition to all of the good work done by the PM, the Minister for Energy and others, we've got a fuel security package which is investing in more fuel for more motorists and more industries to keep our country moving. We're also more than halving the fuel excise and reducing the heavy vehicle road user charge, as well as the fuel and fertiliser security facility, Mr Speaker. On housing, we're reforming the tax system to support more first home buyers, and we're investing an extra $2 billion to build up to 65,000 more homes in our plan, which now goes to $47 billion, as the Prime Minister said. We're rolling out tax cuts for every working Australian, in addition to the 3 tax cuts already on the way, plus the instant tax deduction. Mr Speaker, this is a government cutting income taxes for working Australians 5 times, 5 different ways in just 4 years, Mr Speaker. We've got a comprehensive package to boost productivity, to save business more than $10 billion a year in compliance costs and to boost long-run GDP, Mr Speaker. We've got big investments in innovation and investment to make sure that we support all kinds of businesses, the dynamic part of our economy which will create wealth and opportunity into the future. And we're doing all of this while finding an historically high amount of savings in the budget, $63.8 billion of savings, a net improvement to the budget of $25.1 billion. For the first time in the history of this country, we are in 2 consecutive budget updates banking every extra dollar of revenue when it comes to revenue upgrades. So this is an ambitious budget. It provides immediate support to Australians. It delivers urgent economic reforms. And it also, very importantly, Mr Speaker, doesn't forget our obligations to future generations.
Before I call the member for Kennedy, I'll just welcome a few people to the gallery and he will get the call as soon as I am done. I'm pleased to inform that the House that present at the gallery today are participants of the Disability Trust Next Step program, an initiative for young people focusing on employment pathways, skill building and workplace experience, as guests of the member for Whitlam. I'm also pleased to advise the House that we have representatives from Wattle Nest, a non-profit organisation that provides support for emerging athletes and aspiring Olympians who may be experiencing financial stress and resulting mental health issues. With the group is the Wattle Nest founder Rachel Conders-Fields, as well as Wattle Nest athlete Jess Lloyd and an Australian representative Archer from the sunny coast chasing her Olympic dream. And we've got the mayors from the Parks electorate, including the Deputy Mayor of Park Shire, Councillor Darryl Timms, the Mayor of Narrabri Shire, and Councillor Catherine Rhinefish, the Mayor of Warrnambool Shire Council, as guests of the member for Parks. And give the call to the honourable member for Kennedy.
Prime Minister, you cannot have agriculture without fertiliser. Diammonium phosphate is the most common fertiliser. The only plant in Australia is in Mount Isa, supplying almost half of Australia's needs. It is being choked to death by a monopolistic Woolworths and Coles type gas supply. Prime Minister, congratulations on the reserve resource policy, but it has no teeth. Without price controls, we will still be left in a monopolistic situation. Prime Minister, will you save Australia's phosphate plant, 17,000 jobs, or will your government continue with this free market teacher's pet mentality and import 100% of our fertiliser?
Call to the Prime Minister.
I thank the member for Kennedy for his question. I'll ask the Minister for Resources to supplement my answer, but can I say that my government has been very focused on this. As the member for Kennedy knows, I visited the great town of Mount Isa on many occasions, including with him. And we have intervened together with the Crisafulli government in a bipartisan way across the Commonwealth and the Queensland government to defend industry there, particularly because we know the phosphate industry is critical for Australia. Had we not intervened last year, if we'd had the free market, let it rip approach, then we would have been in a really dire situation right now. That's the truth. And I say that the Minister for Industry, Tim Ayres, has worked very closely as well with his counterparts to make sure that we weren't in that position. I'll ask the Minister for Resources to add as well, but I thank the member for the way, that diligent way, that he represents that community in such a passionate way to make sure that jobs and industry are protected, not just in the interests of the people of Kennedy, but of course in the interests of the national interests, because those industries are so important for our national economy.
Call to the Minister for Resources, the Minister for Northern Australia.
Thanks, Speaker. Thanks, Prime Minister. Thanks, of course, to the member for Kennedy. Is quite, of course, right to say that agriculture depends on fertiliser. In this budget, and I congratulate the Treasurer and the Minister for Agriculture for the Fuel Security and Resilience package, and part of that is a $7.5 billion fuel and fertiliser security package. We have, and I'll turn to the way forward in a moment, but we have secured through the new powers given to Export Finance Australia 90,000 tonnes of urea to Australia. We're supporting Incitec, Pivot and CSBP, and 250,000 tonnes of urea from Indonesia through that new mechanism. You're right to identify the supply chain challenge, but moving to the future, this government has invested, as many will be aware, over $475 million through the Northern Australia Infrastructure Facility for the Perdaman Urea Facility in Karratha. This government and me, as a Minister for Northern Australia, has supported a $220 million loan to Perdaman to build the largest urea plant, a $160 million loan to the Pilbara Ports Authority and a $95 million loan to the Water Corporation. This total $475 million federal commitment to the project and supporting infrastructure will see over $8 billion as investment. And I know those opposite want to take credit, but the thing is they didn't secure the approvals for the project. That is the truth. They talk a big game, they don't do anything. They failed to invest more in that. But Member for Kennedy, as you know, we will make this country urea independent, and by the middle of next year is when production will commence, and I think we can look forward to that.
We'll hear from the member for Kennedy has had his question, and he can have another question a bit later on if he's lucky. Give the call to the honourable member for Deakin.
Thank you, Mr Speaker. My question is to the Minister for Housing. How is the Albanese Labor government helping first home buyers get into a home of their own, and is the minister aware of any risks to this work?
Call to the Minister for Housing, the Minister for Homelessness and the Minister for Cities.
Speaker, the member for Deakin is a fantastic champion for aspiring homeowners in his electorate, and I want to thank him for this question. Speaker, too many Australians today feel that the housing system is stacked against them, and especially younger Australians. And Speaker, they're not imagining it. Right across our community, home ownership rates are declining. They're declining across all age brackets, Speaker, but the effects are particularly pronounced when we look at what's going on for younger Australians. Now, Speaker, as Housing Minister, I often get asked what are the things that keep me up at night, and here's one of them. Since the year I was born, a low-income young couple in this country are half as likely to own their own home than they were in 1980. Half as likely, Speaker. Now, we know those opposite are obsessed with division and conflict, and they're talking about these important changes as though this is some kind of fight between the generations. But they know, and I know, Speaker, that as people representing the Australian community, we are just as likely to get stopped in the street by grandparents who are worried about their grandchildren and parents who are worried about their kids, Speaker. Our housing challenge is affecting the whole country, and that's why our government has built the boldest and most ambitious agenda to tackle this that a Commonwealth government has had in 70 years. Speaker, we're building more homes because we know the main game is building, 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 because more housing means more affordable housing for Australians. But, Speaker, it's really important that we address the playing field and levelling that playing field for first home buyers. Now, Speaker, our 5% deposit program helps you get to the auction sooner, from 11 years to save a deposit down to 2 or 3. And, Speaker, that's already changed the lives of 240,000 Australians around the country. So we help you get to the auction faster, Speaker. Now we're giving you a fair shot when you get here. Speaker, our home ownership package will help an additional 75,000 Australians go from renting into home ownership. Now, Speaker, I'm asked about risks, and we've already got one on the table. We've heard that the Liberal Party plan to oppose these reforms and unwind them at the next election. Now, Speaker, this is a political party for which one of their foundation beliefs was a belief in home ownership. They have completely lost their way, Speaker. And, Speaker, they speak of aspiration. There is no greater aspiration in this country than young people wanting to get the keys to their first home, Speaker. Well, why is it that Liberals have come in consistently over the last 4 years, and voted against every initiative that we have put forward to help first home buyers? Speaker, first home buyers have a hell of a challenge out there, but I want them to know that they have a Labor government and 93 Labor members behind me that are with them and fighting for them every single day.
Call to the Shadow Treasurer.
Thanks, Speaker. My question is to the Treasurer. Since Labor came to office, 1.4 million people have arrived in Australia. This year alone, the government is also building 77,000 homes behind its housing target. Treasurer, where will all these new migrants live?
The member for Kennedy. The Treasurer has the call.
Mr Speaker, I hope the Shadow Treasurer is aware that when he blows on the dog whistle, they can hear it in Goldstein too. They can hear it in Goldstein too. And when the Shadow Treasurer said he was prepared to be in a government with One Nation, I think they heard it in Goldstein. I think they heard that in Goldstein too, Mr Speaker. Now, when it comes to the migration numbers in the budget and the housing numbers in the budget, it's very inconvenient to those opposite that when we came to office, the net overseas migration number was surging. And what we've been able to do in the 4 years that we've been in office is to see net overseas migration come down 45% off its peak. And there are additional steps in the budget to put more downward pressure on net overseas migration, Mr Speaker. So 45% down from the peak after the surge that we inherited from those opposite, Mr Speaker. That's on the net overseas migration numbers, down 45% from their peak. In the last full year, they came in 30,000 fewer than the Treasury forecast in the budget. So we've been managing that down, Mr Speaker. Obviously, there are calculations around departures and the like which are altering the forecast this year and next year. But overall, net overseas migration has come down. I didn't see you mentioning that when you're traipsing from disappointed door to disappointed door in Farrer, Mr Speaker. That's the first point. The second point, Mr Speaker, is this. The second point is this, and the Housing Minister just made this point, I think, in a very compelling way. Our budgets, not just the budget on Tuesday night, but all of our budgets.
The Treasurer will pause. We're not going to have that sort of language. We'll just ask for that to be withdrawn.
I withdraw.
I thank the member for Maranoa.
Hello,
Order. The Treasurer will continue.
So the point that the Housing Minister was making is that our big investments in the budget on Tuesday night in housing supply were not the first time that we had come to the table with very substantial investments. An extra $2 billion in the budget means an extra 65,000 homes because it invests in the small-scale infrastructure, the drains, the power infrastructure, the local road infrastructure to get more projects over the line. So that's just the latest instalment. That's just the latest instalment in this government's enthusiastic investment in trying to make up the lost ground from the decade of those opposite doing almost nothing when it comes to housing supply. Now, Mr Speaker, if I'm asked about housing and I'm asked about progress that this government has made, let me give you a few sets of numbers. Dwelling commencements are up 26%. They were falling 28% under those opposite. Dwelling building approvals up 13%. They were falling 21% under those opposite. Dwelling investment up 5.5%, falling 3.6% under those opposite. We know that there's more work to do to build more homes in local communities, and that's why there's extra investment in the budget.
Hear from the honourable member for Braddon.
My question is to the Minister for Health. How is the Albanese Labor government continuing the work of strengthening Medicare after a decade of cuts and neglect?
Call to the Minister for Health and Ageing, the Minister for Disability and the National Disability Insurance Scheme.
Yeah, thank you, Speaker. Well, last night the Treasurer delivered his and the government's fifth budget, and in every single one of those budgets, a priority of this government has been strengthening Medicare. And I struggle to think of a community that has benefited more from our Medicare investments than North West Tasmania. And I struggle to think of a candidate who more energetically has campaigned for those investments, the member for Braddon. It may be part of the reason why she got the biggest swing to her at the last election of any one of the 150 members in this House, Mr Speaker. Other, of course, than her endless charm and energy as a candidate, Mr Speaker. Last night we provisioned $25 billion in additional hospital funding, Mr Speaker. $25 billion more than they would have got, the states and territories, if the agreement negotiated under the Morrison government had been continued. And I'm really pleased to say that the biggest beneficiaries of that additional investment are the smaller states, because they had been getting a raw deal for far too long. Tasmania will get an additional almost $1 billion, really lifting them up to the level they should have been for years and years. And I know that's going to make a difference not just to Braddon but to all of the communities in Tasmania, Mr Speaker. We also locked in that investment for Medicare urgent care clinics, making them a permanent feature of our Medicare system. The Devonport urgent care clinic's already seen more than 40,000 people all bulk billed. The Burnie urgent care clinic, which was recently opened in the soon-to-be-open Burnie Health Hub, has already seen thousands of patients from that part of Devonport as well, Mr Speaker. And can I also say Braddon has had one of the best responses to our bulk billing investments of any community. One of the best to the first investment we made for 2023, targeted at pensioners and concession card holders, and since our additional record investment in November, the number of bulk billing practices in Braddon has more than doubled. Now 7 out of 10 general practices in Braddon bulk bill all of their patients all of the time, Mr Speaker. And that's not to mention the cheaper medicines benefits, 2.5 million cheaper scripts just in the member for Braddon's community, hundreds of millions across the broader nation. Mental health investments to open a new Medicare mental health centre in Devonport late last year, with another one to come in Burnie in the future. Uplifting the headspace at Burnie, which will be now a full service as well, Mr Speaker. We know the difference that these strengthening Medicare investments make, not just in the member for Braddon's electorates, but in electorates right across the country, those represented by those opposite the crossbench and Labor electorates as well, because Medicare is just the core social program for our country.
Has concluded. Before I call the member for Goldstein, I'm pleased to inform the House that we've been joined in the gallery today of a large parliamentary delegation from the National Assembly of Kenya, led by the Honourable Jeremiah Milibena, the CBS MP, the Member of Parliament and the Speaker's panel. Accompanied by the delegation is His Excellency Dr Wilson Kogo, the High Commissioner of Kenya to Australia. I see we've got a group of Melbourne University political activists joining us today, a large delegation as guests of the member for Moncrief, and students from the Catholic College from Wodonga, Year 11 and 12, from the electorate of Indi. Give the call to the member for Goldstein.
Thank you, Speaker. My question is to the Prime Minister. Jack earns $25,000 income and realises a capital gain of $10,000. The tax on Jack's capital gain is $1,400, equal to his marginal tax rate of 14%. As Jack's marginal tax rate is lower than Labor's new 30% investment tax, Jack needs to pay an additional $1,600 in tax. Prime Minister, why is this government stealing $1,600 of Jack's future home deposit and taxing lower-income earners and undermining the tax-free threshold?
We're just going to withdraw that part of the question of accusing someone of that term. Thank you. So we'll just withdraw that.
I'll withdraw that.
Thank you.
Tax.
Yeah. Just remember all parliamentary language. Order. Members on my left, members on my right. The member for Moncrief, we're not going to have anything until the House comes to order. Treasurer has the call.
Thank you very much, Mr Speaker. I appreciate the question being flicked to me from the Prime Minister from the Shadow Treasurer. The question is about the examples provided in the budget to help people understand the very important, very ambitious tax reforms which are in the budget that we released last night. And an important part of that is about dealing with the big distortion that exists in our tax system, which makes it harder and harder for young people to buy their first home, particularly young people. And so what we're doing with this tax package, is better aligning the tax levied on people who work versus people who earn their income in other legitimate ways, and we're levelling the playing field in the housing market. I think any objective observer of our housing market, how it interacts with our tax system, would conclude that the combination of those two things is making it too hard for Australians, particularly younger Australians, to get a toehold in the housing market, Mr Speaker. And so that's why we are making these changes. We understand that those opposite are heading towards making the same mistake that they made at the last election in repealing, saying that they will repeal our tax package. Our tax package gives tax cuts to 13.3 million workers, Mr Speaker. For anyone who's looking for evidence that they haven't learned a thing and they haven't changed a bit, they're coming back to the well, Mr Speaker, and saying that they will repeal our tax package. Now, Mr Speaker, the question from the Shadow Treasurer is about capital gains. Now, I want to tell the House what the Shadow Treasurer wrote in his own book about capital gains. This is what he said. I'm quoting, Mr Speaker. Capital...
Order. The member for Lingiari, the Minister for Social Services, will hear from the Manager of Opposition Business.
Speaker, it goes to relevance. The question wasn't about the Shadow Treasurer's book. It was about... No, let me finish. It was about Jack and the impact on Jack from your budget. You're cutting 1,600...
If the Treasurer's got a quote and he's going to use a quote to talk about Jack or the order, but if he's going to talk about the person that he was asking, I need to make sure the quote is directly relevant to what he was asked about. I don't know what the quote's going to be. I haven't read the book, but I'll hear what the... Order. No, I haven't read the book yet. Treasurer.
Thank you, Mr Speaker. The member for Wannon might not think the Shadow Treasurer's views are relevant, but I do, Mr Speaker. And they're very relevant to Jack and the example that we provided in the budget papers, because this is what the Shadow Treasurer said, quoting, "Capital gains from appreciation of holding assets is taxed at half the applied rate, effectively entrenching the benefit of having and holding assets which can only exist if you're established. There's no intergenerational justice in such preferential arrangements." That's the Shadow Treasurer. Now, Mr Speaker, also relevant to Jack is what the Shadow Treasurer said in the Parliament, Mr Speaker. This is what he said. "Today it's time to be honest. The tax system is screwing over young Australians. Instead, it favours well-off established interests against those trying to get ahead. People who can predominantly live off income from their assets can pay very little tax and get discounts on capital gains from increase in asset values." This is what he said, Mr Speaker. I'm quoting, "Young Australians need to demand a fairer tax system where they aren't the only ones carrying the burden to cover the cost of Australia." Well said, Mr Speaker.
Order. When the House comes to order, we'll hear from the honourable member for Bean.
Speaker, my question is to the Treasurer. How will the Albanese Labor government's tax reforms benefit Australian workers, first home buyers and businesses? How does this compare to other approaches?
The call to the Treasurer.
Thank you, Mr Speaker. Thanks to the absolutely terrific member for Bean for his question and for all of the work that he does in our team as well. A big part of the ambitious budget that we handed down last night from this dispatch box was tax reform, Mr Speaker, and in that tax reform package we took on a number of difficult issues, recognising that the tax system is part of the problem often rather than part of the solution when it comes to ensuring that our economy can work for more Australians. And so our tax reform package was really all about three objectives. The first one was about better aligning the tax treatment of people who work and people who get their income from other legitimate sources. The second motivation was to try and level the playing field to help more Australians, particularly younger Australians, get a toehold in a really difficult housing market. And the third objective is to improve productivity by encouraging more investment and more innovation in our economy. And so each of the elements of the tax package that we released last night is about satisfying one or more of those objectives that we have. And so there were tax cuts for more than 13 million workers. There were big incentives for innovation and investment, supporting small business. I shout out the wonderful Small Business Minister for her work on the small business part of this package. And also, of course, some of those admittedly politically contentious changes to capital gains and negative gearing. And again, that's about recognising that when the Howard Costello government changed the arrangements for capital gains, they introduced a big distortion into the tax system, which made it harder for Australians to buy their first home, particularly to buy their first home. And so we are acting in the budget to try and address those legitimate concerns that people have about the opportunity to own their first home, Mr Speaker. Now, I notice that the word aspiration is being used by those opposite to explain locking more and more Australians out of the housing market. And, Mr Speaker, this side of the House knows about aspiration from our local communities. That side of the House learns about aspiration from focus groups, Mr Speaker. And the reason we know that is because there is nothing aspirational about stacking the deck against young Australians. I say to the young Australians in the gallery today, this side of the House is on your side when it comes to getting a toehold in the housing market, Mr Speaker. There is nothing aspirational about a status quo that turbocharges the issues in the housing market and makes it harder and harder for more people to get ahead. This side of the House is about aspiration for more people. That side of the House sees aspiration as the exclusive preserve of a very few Australians.
Call to the member for Cook.
My question is to the Prime Minister. The Prime Minister has confirmed he has used negative gearing and the CGT discount. And the Prime Minister, I note, has bought a $4 million property in Copacabana. So why is the Prime Minister stopping the next generation of Australians from using the very opportunities he has personally benefited from?
Order. Members on my right. Member for Bennelong. The Prime Minister.
For his question.
Order.
And I remind him and others that when people in the front here hand you a question, you don't have to ask it. You don't have to ask it. But so be it. What we are doing is precisely the opposite of the suggestion which he puts forward. I have had access to home ownership, and I had it in my 20s. And I had it because my mother, who lived in the one public housing her whole life,
member for Cook will cease interjecting.
used to say to me, when you get a chance in life, own your own home. It was drilled into me. It's the aspiration that's drilled into working class people. Working class people who want the next generation to be better off than they are. And that is precisely what we are doing here. Precisely what we are doing.
Members on my left, the Leader of the Opposition and the member for Groom. This is completely unacceptable. Members on my right aren't helping the situation either. I want there to be some respect and dignity back in the House. Prime Minister.
Thank you, Mr Speaker. And I'm proud that I wasn't born to rule. I'm proud that I worked hard. I'm proud of what I've achieved. And that is why I want other young...
The Leader of the Opposition and the Minister for Infrastructure and the Minister for Environment, if the three of you continue in such way, I'll be left with no other choice but to take action. That is the last thing I wish to do. Show some restraint. The Prime Minister.
Thanks, Mr Speaker. And that is why in last night's budget we made sure that we do not want to leave a generation behind. That we are not prepared to sit here and know that increasingly young people are being priced out of the market, and we will say it's too hard to make this change. Too hard to make this change. We'll just occupy the space. But the other thing that we are doing, Mr Speaker, is making sure that people can still negatively gear properties and that they can as well apply the 50% capital gains discount if they wish. The difference is they will buy a new home rather than an existing one, which means that not only are they helping their aspiration, they're helping the aspiration of the country as well going forward. Our idea of helping young people is to do something practical that will help them get ahead. Their idea of the future in young people is having a ballot between Tony Abbott and Alexander Downer over who will be the next leader of the Liberal Party. They are reduced to a farce, Mr Speaker.
Order. Prime Minister's concluded his answer. Prime Minister's concluded his answer. Order. The members on my right can begin silent. Order. I'd like to hear from the honourable member for Bendigo.
Thank you, Speaker. My question is to the Minister for Climate Change and Energy. How does the budget strengthen Australia's fuel security and resilience and protect Australians from future energy shocks? What policies would weaken resilience?
Call to the Minister for Climate Change and Energy.
Well, thanks very much, Mr Speaker. The member for Bendigo is a champion for rural and regional Australia, Mr Speaker. Thank you for the question. The member for Bendigo knows the importance of fuel security for her constituents, and that's why this government has worked so hard over the last 2.5 months to ensure that we now have more fuel in Australia today than we did on the day the Iran war broke out, Mr Speaker. But this government also knows we need to build for the future. That's why there was a $14.8 billion package for fuel security and cost of living relief in last night's budget. And that package has many elements. One of them of importance to rural and regional Australia is the $1.1 billion fund that the Minister for Transport and the Treasurer and I have announced to support cleaner fuels, i.e. biofuels, so that the farmers of Australia can take products like canola and tallow and turn them into fuel, Mr Speaker, which improves our fuel resilience and is great for Australia's farming sector. But we also know that there's even more to do, and that's why another element is a $3.2 billion commitment for a strategic fuel reserve owned by the government for the people. That's a key initiative, and that's been welcomed across regional Australia. Grain growers, Australia said, establishing a domestic government-owned Australian fuel security reserve demonstrates significant progress. National Farmers Federation have said today's announcement of a $10 billion Australian fuel security and resilience package is a welcome step towards building sovereign capability that we need to protect our fuel system. The Australian Livestock and Rural Transporters Association have said the government has made the right call. A strategic national reserve is long overdue, and we commend the government for getting it done. So these are all rural and regional peak groups have welcomed a government-owned strategic reserve. I'll tell you who hasn't welcomed a government-owned strategic reserve: the Leader of the Opposition, who said they're going to compete in the market with the private sector. That's what this government always thinks, that the government is always the entire answer. So the opposition, or at least the Liberal Party, not sure about their coalition partners, the Nationals and One Nation, would oppose a government-owned strategic fuel reserve and take us backwards. But it's even worse than that, because we believe a government-owned fuel reserve is an important complement to increasing the minimum stock obligations of the private sector. You need to do both. The opposition's announced opposition leader announced he would increase the minimum stock obligation to 60 days and said it was 1 billion litres. Well, 1 billion litres gets you to 37 days, Mr Speaker. They couldn't even get the maths right, Mr Speaker. Not only would they not have a government-owned reserve, their private reserve doesn't add up. It doesn't matter whether it's 800 million or 80 billion, Mr Speaker. The fact of the matter is, whatever figure they choose, they haven't done the homework. Their maths don't work. They would weaken Australia's fuel security, they would weaken Australia's resilience, and the Albanese government will strengthen it.
Call to the honourable member for Fowler.
Thank you, Speaker. My question is to the Minister for Health. Minister, up to 160 Australians with disability will be worse off under your government's NDIS cuts. You plan to slash 7,000 per participant from social and community supports, the very thing that connects people in multicultural communities like Fowler to culturally and linguistically appropriate care. With your $200 million Inclusive Communities Fund, how much of that money is actually quarantined for cold community?
Call to the Minister for Health and the Minister for Disability and the National Disability Insurance Scheme.
Thank you, Speaker, and thank you to the member for Fowler for her question. And can I take the opportunity just to say a couple of things about investments for her community? In the budget last night, she will have seen $80 million provisioned for the upgrade of the emergency department at the Fairfield Hospital, part of a $630 million total upgrade. The Minister for Energy talks to me a lot about the importance of that to that community. The Liverpool Urgent Care Clinic is working well. And can I say to the member, there is no electorate that has done better from our bulk billing investments than the electorate of Fowler. Now, 97% of general practices in Fowler are bulk billing 100% of their patients. And I know how often the member acknowledges the benefit of our investments in strengthening Medicare, and I thank her for those frequent acknowledgements. But she asks about the NDIS, and I thank her for that question and her interest particularly around cold communities. We've had a discussion already about that. First of all, can I say how determined we are to get this scheme back on track? It's growing too fast, it's got too big, there's frankly too much money going to shonks and fraudsters, and we see it as a very deep responsibility of a government, particularly a Labor government, that put this scheme in place in the first place to secure its future for the long term. A series of those changes are about essentially urgent financial controls, and I will be introducing legislation this week to put those controls in place and to get that cost growth under control. But there are other reforms. There are other reforms that will need more work in close consultation with the disability community that will take place over coming months, and that must include called members of the disability community. And given that our recognition of called participants in the NDIS relies on voluntary identification, frankly, we're currently underdoing that engagement. Only 9% of NDIS participants are registered as cold. Obviously, in a country with 30% of the population identifying as cold, that is obviously an underrepresentation. And we've been working very hard to improve that engagement. Our cold strategy was co-designed with more than 800 people working with us, called NDIS participants. Over the last few months of last year, we had 68 sessions with more than 3,000 called participants and other stakeholders to inform that work. We've got an expert advisory group that is advising us about the implementation on things like better data, on making sure that markets and services are attuned to the cultural needs of participants. And I've made the decision to expand the remit of that group's work to include the reforms that the member asked me about.
Give the call to the honourable member for Sturt.
Thank you, Speaker. My question is to the Deputy Prime Minister. How is Australia engaging with other countries in relation to the Strait of Hormuz? How will last night's budget improve capability for the Australian Defence Force, and how does this compare to other approaches?
Call to the Deputy Prime Minister and the Minister for Defence.
Well, can I thank the member for her question and acknowledge her extensive experience in Australia's defence industry. Last night, along with 40 defence ministers from around the world, I participated in a meeting of the multinational military mission in respect of the Strait of Hormuz. And we were all resolute that the Strait of Hormuz be open, that freedom of navigation apply, and that when conditions allow, a defensive military mission underpin this. Australia has made a commitment to this mission. Indeed, we've committed an E7 wedge tail, and we will have further talks with the UK, with France and with our other partners about how else we can contribute. But the conflict in the Middle East has highlighted the volatile nature of the world in which we live, the acute pressure which is being placed upon the global rules-based order, and the impact on Australia, our region and the world of disrupted sea lines of communication. And looking forward, this is really our most consequential strategic risk, that a future adversary would seek to coerce Australia by disrupting those sea lanes. And so in last night's budget, we had a significant increase to defence spending. $14.5 billion over the forward estimates, $53 billion over the decade. So since coming to government, we have increased defence spending over the next 4 years by $30 billion relative to what we inherited, $117 billion over the decade. Now, to try and put that in some kind of context, during the entire period of the former coalition government, they increased defence spending by just $10 billion over the planning decade, which is to say that in the last 4 years we have done 12 times as much in respect to increasing defence spending as what the Liberals did in their entire 9 years in office. I mean, they were very big about awarding the Defence Ministry as a trophy to those on the front bench. 6 different people won that prize, and since going into opposition, another 3 have won the prize, including the Leader of the Opposition. But while they've been completely focused on the defence trophy, they have utterly ignored defence policy and, with that, the nation. Now, the Albanese government is changing all of that. Since 2023, we have increased defence spending each and every year, and what we did last night was the biggest step, and the result is to provide a much more capable defence force which, in a challenging world, can keep Australians safe.
Call to the honourable member for Riverina.
Thank you, Deputy Speaker. My question is to the Prime Minister. Labor's budget of broken promises and higher taxes contains a budget bomb with more than $18 billion in new net zero spending. At the same time, Labor has ripped more than $600 million from essential health services for our veterans. Why has the Prime Minister decided to prioritise breaking promises, raising taxes and spending big on net zero while cutting vital support and services for our veterans, including funding for the Invictus Games?
Call to the Prime Minister.
I thank the member for his question. I'll ask both the Energy Minister and the Veterans Minister might want to supplement my answer. But can I say this when it comes to veterans? We have significant additional investment in this budget as a result of the Royal Commission and the response into veteran suicide. That comes on top of something like $800 million as the package in this budget. And in addition to that, of course, one of the big expenditures that we have had upon coming to government was addressing the backlog that was there. People waiting forever and ever. Now, the member for Calare knows something about this because he stood up, to his great credit, to the former government, of which he was a part as a minister, and said he's just not going to cop the cuts that were there in the budget. So we put significant investment in the budget to make sure.
When I say cease interjecting, that means cease interjecting. You leave the chamber under 94A.
We put significant investment in our budgets to make sure that that delay, where people literally were leaving this earth while they were waiting for payments to come through, it was a complete outrage. It is one of the things that led us to a significant increase in public servants so that we could clear that backlog. But I might see if either of the ministers want to supplement.
Minister for Veterans Affairs.
Well, I thank the Prime Minister for the opportunity to address something that the member has raised, which is actually a great success of this year's budget for veterans, because what we have been able to do here is to make sure that as we've improved the system, as the Prime Minister said, more people have been able to get their claims processed and get access to the health care they need. But what that has also seen is a degree of over-servicing coming into the system where practitioners are taking advantage of veterans. And so what we have done is introduced an annual monetary cap for allied health services, which is well above what the vast majority of veterans ever actually access, but for a small proportion will mean that we remove over-servicing, restoring integrity to the system. But importantly, by doing this, we are increasing the fees that will be paid to allied health professionals by $169 million over the forwards. That means it's easier for veterans to access health care. Veterans and health professionals have been saying to us for a long time, you need to increase fees. The Royal Commission said to us, increase the fees. And that is what this budget is delivering, so that our veterans get better access to health care. That is what you're seeing reflected in the budget, and the additional funding that is going into implementing Royal Commission recommendations as well.
Call to the honourable member for Petrie.
Thank you, Mr Speaker. My question is to the Minister for Aged Care and Seniors. How is the Albanese Labor government's budget building Australia's future through historic investment into aged care?
Call to the Minister for Aged Care and the Minister for Seniors.
Thank you, Mr Speaker. I thank the member for Petrie. She's an extraordinary representative for her community and she stands up for older people every single day. Mr Speaker, last night the Treasurer delivered a budget that is responsible, that's ambitious and that is squarely focused on building Australia's future. It's a budget that backs workers and strengthens Medicare, that builds the homes, the workforce and the skills that this country needs for the decades ahead. And for older Australians in need of care, it builds more aged care beds and improves home care so that more older Australians can access the high-quality aged care they deserve.
Order.
Mr Speaker, we cannot build the Australia of tomorrow without delivering on our promise to the people who built the Australia of today. And that's why at the centre of our aged care agenda in this budget is a significant boost to residential aged care. Labor has already invested more than $1 billion through the Aged Care Capital Assistance Program since 2022, and we're not stopping there. In response to the accommodation pricing review, we're building on our record investments to deliver more beds in the places that need them most, built in partnership with a sector that we're determined to keep strong and sustainable in the interests of every older Australian. These are 5,000 real beds every year for the parents and the grandparents that raised each of us. It'll mean real jobs in care and in construction. It'll mean older Australians getting the care they need closer to home sooner. And it'll have a particular focus on ensuring those who need financial support to get into appropriate aged care are never left behind. Mr Speaker, this is a budget that lives Labor's values. First Nations elders who have received stolen generations redress payments will no longer have those payments counted against them in residential aged care means assessments. That's the right thing to do. And this budget will continue our work to make sure that more Australians can age at home with dignity, purpose and quality care. No older Australian with a place in the Support at Home program will be out of pocket for help with showering, dressing or continence care. And we'll extend care for older Australians in the final weeks of their lives, giving them continuity and certainty so they can focus on precious moments with their loved ones. Mr Speaker, this is what a responsible, ambitious budget looks like. It builds on our generational reforms and record-breaking investments in aged care. It shows we've listened to older Australians, their families, workers and providers, and it delivers on our promise to build a fairer and more compassionate aged care system that every Australian can trust. And Mr Speaker, it is one more step in this Labor government's careful, considered work of building an aged care system worthy of the Australians who rely on it every single day.
Call to the honourable member for Curtin.
My question is to the Treasurer.
I support the capital gains tax reform for housing, but my community and I are concerned about its impact on the start-up sector, which contributes significantly to productivity. The reforms announced could undermine investment in innovative, high-risk early-stage businesses. I acknowledge your commitment to consult with stakeholders on this issue. Could you outline the consultation process and whether the government is considering a carve-out for early-stage businesses?
Call to the Treasurer.
Thanks very much, Mr Speaker, and to the member for Curtin for her important question. I do acknowledge that in parts of our economy, a very important part of our economy, the start-up and VC sector, that there is more work to do, more consultation to do to make sure that we get the right set of arrangements. And I wanted to acknowledge other members on this side of the House, including the member for Chifley and other members who I've been engaging with. The member for Parramatta is obviously across these issues, and a bunch of other issues, and other colleagues as well. The budget is very supportive of venture capital and VC. There's a number of tax changes in there which are about supporting, assisting, encouraging, incentivising more of this really important part of the economy. But I do acknowledge that even before last night, this sector had raised some issues with us. We had been consulting privately with the sector already before last night to make sure that we can get the right arrangements in place. I say to this part of the economy, we think that you are a really important part of the economy, in lots of ways the hope of the side when it comes to dynamism and productivity, and we will reflect and recognise that in our policy. There are particular circumstances in this part of the economy when it comes to the calculation of the cost base for CGT, which is the concern that the member and other members is reflecting. My commitment to the sector, publicly and privately, has been to continue to work on these issues to get the best landing that we can. It's a very, very small part of our economy, and so it's not a big part of the changes that we are announcing, but it's an important part of the economy, and our work will reflect that.
Call to the honourable member for Whitlam.
My question is to the Minister for Disability and the National Disability Insurance Scheme. How is the Albanese Labor government working to secure the NDIS for future generations?
The call to the Minister for Health and Ageing, the Minister for Disability and the National Disability Insurance Scheme.
Thank you, Speaker, and thank you to the member for Whitlam. I don't think there's anyone in this chamber who knows more about the NDIS and disability services than the member for Whitlam. She has worked with it and in it for the entirety of the scheme's life, including before coming here last year as the Chief Executive of one of the country's largest disability institutions. So I value her advice very deeply, Mr Speaker. Mr Speaker, the NDIS is unarguably one of Australia's great modern reforms. It's gone from the dream of generations of activists through the 70s, 80s and 90s to become a truly cherished institution. It's changed the lives, as all of us know, of literally hundreds of thousands of people with disability and their families as well. But the truth is it currently costs too much, it's growing too fast, and it's become a soft target for too many fraudsters and shonks, as well as, frankly, serious organised crime. And we simply can't go on like this. We can't afford for the NDIS to continue to fail. The steps we've taken over the last few years to get it back on track simply aren't delivering the results that we need to see in the scheme. Since just last December, the mid-year budget review at MyEFO, Mr Speaker, costs have blown out already by more than $13 billion. And these blowouts simply can't continue. And that's why later this week I'll introduce legislation to get a grip on that scheme inflation and on plan inflation as well, and to set the clearest possible path, Mr Speaker, to a secure, sustainable future for the NDIS. And that path rests on 4 pillars: fighting fraud and stopping rorts, which everyone wants to do; slowing rapid cost increases of the type we've seen in the latest cost blowout since just December, Mr Speaker; clearer eligibility requirements to get the scheme back to its original intent; and most importantly, delivering quality supports and services to people living with a disability. I want to stress, Mr Speaker, even with these changes, the NDIS will continue to grow every single year. But by the end of the decade, we project it will cost $55 billion rather than the current projection of $70 billion, Mr Speaker. It will still be the largest social program that we have in this country outside the age pension, and still the centrepiece of the most comprehensive framework of supports for people with disability you will find anywhere in the planet, Mr Speaker. The bill I'll present later this week is simply good financial management, good financial control. The deeper reform that we've telegraphed in my speech to the Press Club will obviously be conducted in close consultation with the disability community and with states and territories as well.
Time has concluded. Give the call to the member for Page.
Thank you, Speaker. Speaker, my question is to the Treasurer. Treasurer, why is the Albanese Labor government introducing a 50% capital gains tax discount for foreign multinationals investing in renewable energy projects, saving them $450 million, while taxing hard-working Australian mum and dad investors with more?
Call to the Treasurer.
Thank you, Mr Speaker. The member is referring to the transitional arrangements in the renewable energy sector, where we're moving from a more generous treatment to a less generous treatment over time, and so he's not quite accurately representing the situation, Mr Speaker. What we're doing in capital gains for foreign investors is equalising the arrangement because it was too generous to foreign investors. We're making it more consistent with the tax paid by Australians, and that means, in some important areas of the economy, a transition from the existing arrangements to the new arrangements. Just like in the capital gains tax changes we announced last night, there are transitional arrangements there too.
The call to the honourable member for Brisbane.
Thank you, Speaker. My question is to the Minister for Small Business. How is the Albanese government easing pressure on small businesses and ensuring they can plan for the future?
Give the call to the Minister for International Development, the Minister for Small Business and the Minister for Multicultural Affairs.
Thank you very much, Mr Speaker, and I do want to thank the member for Brisbane for her question. It was an absolute pleasure to visit some of the really inspiring small businesses in her electorate, I think around 2 weeks ago, and I thank her for that. Since we came to government, Mr Speaker, I'm pleased to inform the House that Australians have established an additional 180,000 small businesses. Visionary individuals who are strengthening our workforce, they're strengthening our supply chains and, of course, strengthening our communities. And yesterday's budget delivers for them, ensuring that they have the settings that they need to thrive. As one masthead put it, gee whiz, it's a win for small biz. Clever. Declaring that Aussies running small businesses are a surprise winner in this year's budget, even going so far as to call it a cash flow hug from our great Treasurer here. We're backing small businesses as part of our $3.5 billion of new business tax relief to boost investment, to increase cash flow and to support growth. Now, the $20,000 instant asset write-off has been a lifeline for small businesses seeking to upgrade or purchase assets to grow their businesses and to keep their cash flowing. But for many years, they've had to navigate whether or not the instant asset write-off would be available for them in future years. They've had to navigate that uncertainty. That's now a permanent feature of this government's small business assistance, making it a permanent feature for small businesses and, importantly, Mr Speaker, saving small businesses around $32 million per year in compliance costs. The budget also contains a permanent 2-year loss carryback so that small businesses can return to profitability faster and they can have the confidence to invest earlier. Big one is that we are slashing red tape, simplifying the tax system, harmonising national systems with a tell-us-once approach, cutting regulatory costs by over $10 billion right across the economy. And we're improving, along with free TAFE
and incentives for apprenticeships, we're improving skills recognition and skilled migration systems so that small businesses can have access to the skilled workforce they need. Now, red tape, cash flow and access to skilled workers are the three big things that small businesses raise with me every time I see them. And this budget sends a clear message to them that the Albanese government has listened. We're delivering the kinds of changes that they need to thrive and grow because they have an Australian story, a story of nation building, of aspiration and of giving back.
Call to the honourable member for Kooyong.
Thank you, Speaker. My question is to the Minister for Health and Ageing. After months of sustained advocacy and almost 8,000 campaign emails, I am thrilled that the budget includes an additional $508 million for medical research. This means that disbursements from the Medical Research Future Fund will increase to $1 billion a year from 2030. It's a huge win for the medical research community, but it is contingent on your government releasing the long overdue National Health and Medical Research Strategy. Minister, when are we going to see the strategy?
Call to the Minister for Health, the Minister for Disability and the Minister for the National Disability Insurance Scheme.
Thank you, Speaker. Thanks to the member for Kooyong for that question. As she knows, Australia punches way above its weight in health and medical research. About number 7 in the world, although we don't even rate in the top 50 by way of population. And that was the objective, the mission of Billy Hughes 80 years ago this year when he established the NHMRC, and we've achieved it. We have year upon year added great potential for healthcare, not just for people here in Australia, but right across the world. But I acknowledge people have wanted us to do more, including the member herself, but the member for Melbourne, who has the great honour of representing one of the most important biomedical precincts on the planet at Parkville. She's been a strong advocate. The member for Chisholm and the Minister for Housing, who have that rival precinct down in Clayton, has also been a strong advocate, many others besides. And I want to acknowledge the Treasurer, with a very busy workload, has thought about this very carefully after the 10-year review of the MRFF, lobbying for many in the community, which is why I was so very pleased in a very challenging budget to be able to find around $500 million in new funding to start to see those disbursements ramp up from $650 million a year to $1 billion a year by the end of this decade. As well, as the member probably knows, we've found $15 million to do the next stage of the one-stop shop for clinical trials to improve the clinical trials and research environment in Australia as well. Once we hit that $1 billion mark, when you put it alongside the NHMRC funding, we'll be investing $2 billion or more every single year in our world-class health and medical research workforce. And this is going to be a terrific thing when we get to that. To the national strategy, as the member knows, and many members on our side have engaged in this as well, we asked Rosemary Huxtable, a very esteemed former public servant who was Secretary of Finance, Deputy Secretary of Health, as well as holding many other positions, to do a unified strategy rather than having an NHMRC strategy and an MRFF strategy. That has been delivered to government. I wanted to wait until a budget outcome around MRFF disbursements as well as the one-stop shop before we look at releasing that, but I'll have more to say about that in the coming days.
Call to the honourable member for Paterson.
Thanks, Mr Speaker. My question is to the Minister for Regional Development, Local Government and Territories. How will the Albanese Labor government's budget deliver for regional Australia, and how does this compare to other approaches, Minister?
Give a call to the Minister for Emergency Management, the Minister for Regional Development, Local Government and Territories.
Thank you so much, Mr Speaker, and I want to thank the member for Paterson for her passionate representation of her community in Paterson. I'm thrilled to once again rise and speak in this place about how the Albanese government is delivering for regional Australians, because that is what we're continuing to do, Mr Speaker. We are delivering. We're delivering on cost of living, we're delivering on health and in housing, because your postcode should never be a barrier to opportunity, particularly in regional Australia. And when it comes to cost of living in regional Australia, Mr Speaker, not much bites us harder than the cost of fuel. And there's no doubt regional Australia has been hit hardest by the impact of the global fuel shortage. And that's why our comprehensive $14.8 billion plan to secure more fuel, to strengthen our supply chains, to build resilience and to take the sting out of prices is so incredibly important to regional communities. And speaking of stings and bites, Mr Speaker, our Medicare urgent care clinics are the place to be if you need treatment, which is why this government's nearly $580 million investment to keep them open and free matters most, particularly for Australians living in regional and rural communities. 137 clinics providing accessible urgent care services across the country, and 47 of those are supporting communities in regional, rural and remote Australia, Mr Speaker. And then there's our $25 million investment to establish 6 new bulk billing clinics across the Central Coast, Newcastle, Lake Macquarie and the Hunter. That's right, Mr Speaker, we're supporting more GP practices bulk billing, unlike those opposite who stood by as GP practices closed in regional Australia under their watch. And Mr Speaker, this government is committed to addressing the housing challenges faced by regional Australians. That's why $500 million has been dedicated to local enabling infrastructure in regional Australia. The power, the roads, the drains that are needed for new housing. And on top of that, our tax changes make sure that 75,000 Australians achieve the dream of home ownership. And Mr Speaker, I want to highlight our commitment of an additional $750 million for further rounds of our flagship programs, Growing Regions and Thriving Suburbs, bringing our total investment since 2022 to $1.7 billion. Mr Speaker, our government is getting on with the job of delivering for regional Australia, which is in stark contrast to those opposite who paid to hold our fuel reserves in Texas. Last time I checked, that wasn't in the country. And it reminds me of a saying, Mr Speaker, all sizzle and no steak, and that's what they have opposite. All statement, no substance, and that's why regional Australia relies on this side of the House, the Labor government.
Call to the Prime Minister.
On that fine note, Mr Speaker, I ask that further questions be placed on the notice paper.
Order. If members can take their seats or leave quickly and quietly, we will just go to papers, and I call the Leader of the House.
Speaker, these documents are tabled in accordance with the list circulated to the honourable members earlier today. Full details of the documents will be recorded in the votes and proceedings.
Okay, if members can leave the chamber quickly and quietly, we shall move to the matter of public importance. I've received a letter from the Honourable Member for Goldstein proposing that a definite matter of public importance be submitted to the House for discussion, namely the failure of the government's 2026-27 budget to deliver on its promises to Australian families, leaving them worse off through higher taxes, higher costs and broken commitments and a budget of breaking the Australian dream. I call upon those honourable members who approve of the proposed discussion to rise in their places and give the call to the Shadow Treasurer.
Thank you, Deputy Speaker. Thank you, Speaker. Australians voted at the last election and went into a ballot box thinking that they could trust their government, that the policy pronouncements that were put forward before the Australian people would be honoured on the other side. The Prime Minister said 50 times over he was red hot with rage, indignant, as the member for Riverina said, about journalists having the hubris and the arrogance to keep asking the same question. Will you change the taxes on capital gains? Will you change the taxes on trust? Will you abolish negative gearing? And the response for the 50th time, no, and consistently demanded that journalists stop asking the questions because it was so impertinent and rude to do so. Well, Deputy Speaker, we now know why. Last night, the government provided its bad faith budget that broke so many promises to the Australian people. It broke the fundamental promise from the Prime Minister himself and has shredded any integrity or trust that the Australian people will have in him into the future. Broken promises so many times over, promising they wouldn't change tax rules around homes, saying they wouldn't change tax rules around rentals, saying they wouldn't change tax rules around family savings, but instead they simply got the knife and slit each one left, right and centre. And what's the story we now know? This budget, a bad faith budget, is built on a house of broken promises but won't build any new homes. We're seeing this in their approach where they explicitly state, despite the denials from the Prime Minister in question time, that they are going to build 35,000 fewer homes. It's extraordinary, Deputy Speaker, to think you come into the publicly and in this House and in this budget and say to the Australian people, this is all about intergenerational fairness because as a government we want young Australians to buy their own home. But instead what they do in this budget is they go through measure by measure, step by step, and undermine the chance for young Australians to be able to afford their first home. The budget papers explicitly, Deputy Speaker, and I know you're looking at me almost with a state of surprise, the budget speakers explicitly state that rents will go up under the government's tax changes. I don't know about you, Deputy Speaker, but I'm pretty sure that before people own their own home, they tend to rent. So you're going to take with one hand and increase the rents on young Australians saving for their house deposit. But then the government is turning around and applying an increase in capital gains tax on the savings of first home buyers trying to get ahead to save their deposit, and almost in some cases doubling the tax on first home deposits when they're invested. So you're increasing rents, you're taxing people's first home deposits when they invest them so they can bring the future forward, and now they are building fewer homes, 35,000 fewer homes, while by the government's own projections they are going to continue to bring more people into Australia beyond their targets. They're pumping in people to prop up their budget numbers. Australians will simply live under this budget with broken promises, higher taxes, lower living standards, fewer houses and higher rents. We've had a 3% decline in real wages under this government, and their solution now is to kneecap young Australians through measures that will make it harder for them to save to buy their first home. And we've heard story after story that's been in contact with us of young Australians who buy shares, who buy ETFs, who buy crypto, and they use that as their home deposit. And 43% of Australians, according to the Australian Stock Exchange's own research, own their own shares at the age of 21. And now the government is coming with their tax agenda and going after their first home deposits. This is where this government is kneecapping Australians, and they're constantly doing it on the basis that they somehow think they're helping young Australians get ahead. And they can see through it. We are seeing more and more stories come through our Not the Tax website, which is Not the Tax Australians Voted For, or www.notthethax.com.au. And if you have a story, I encourage you to submit them because some of them are truly shocking. Here's one. My brother and I are millennials. We both rent, yet we have worked hard over the past 3 years investing all our savings in a tech startup. The business is an electronics/edge AI space with onshore manufacturing. We have scaled the business quickly. We now employ people locally, and our devices are sold to 12 countries across Europe and New Zealand. A true made in Australia, sold to the world story we are proud of. This is a high-tech product that we've invested a Sydney-sized house deposit multiple times over in our business without taking a salary because we see a problem we wanted to solve and we expected to see some upside. This is productive economic activity that helps Australia build skills and competition. I'm all for changes to certain taxes, as we should be directing capital to things that boost productivity. However, the Treasurer's changes kill younger people who try to start a business to get ahead. Other stories, like my wife and I started with nothing and have worked so hard to try to get ahead. We have worked full-time whilst raising a family, stretching ourselves and taking on risk. Hassle and huge stress to buy and renovate investment properties, and to have Labor then change the goalposts on CGT and negative gearing is heartbreaking, and a huge impact on our plans for the comfortable retirement that we deserve. The Prime Minister and the Treasurer are breaking an election promise in a cynical tax grab whilst turning a blind eye to the billions lost to the CFMEU and NDIS corruption, and giving handouts to others who haven't had a crack like we have. And finally, just as another example, less than 18 months ago, since this person left PAYG to set up a business, the business has been structured in a way that will enable them to pay themselves a salary, the dignity of a salary. But profit they'll be made will be earned by a family trust as the shareholders of the business. I'm subject to strict professional services rules, and so I can't push all income into the trust to the benefit only becomes large when income for the business grows substantially above what is reasonable for a similarly qualified employed professional. So if a tax trust is 30% minimum, the incentive is gone. This government has overseen record small business insolvencies. And now their solution to all those small businesses who are struggling to get ahead, Deputy Speaker, all those small businesses that are suffering under the crippling regulation and taxation of this government, is there is a point. There is one thing they're proposing, which is, why don't you go into more debt? Or the other one is increase taxes on small business. And remember, small business is the place not just where people can get ahead, support themselves and their families. So often it is the first place that a young Australian in a community gets their first job. And their answer is, the Labor government's answer is, let them eat taxes. This is the problem with this government, is they simply have no understanding of the consequences of their measures. And the Treasurer has the temerity to come into this parliament and quote my own book of me. I'm reminded of that old quote, what's the difference between a capitalist and a communist? Both have read Marx, one understands it. Well, the difference between a shadow treasurer and a treasurer is the shadow treasurer wrote the book, the Treasurer clearly doesn't understand it. He has, no, I did an actual search because I have an electronic copy on my phone, and the number of times I typed in higher taxes, higher GGT, higher capital gains, and each time it came back with search completed, no matches found. That's the difference between writing a book and understanding it, but I don't expect the Treasurer to ever understand that. When it comes down to it, this government does not understand the consequences of their measures, but Australians do, because they're living the pain and the punishment of the Albanese government. And if Australians have a story about how this betrayed trust is impacting them, please submit your stories at www.notthethax.com.au, because we want those stories where you can shine a bright light on what this government is actually doing. Because we know that tomorrow night the Leader of the Opposition is going to come into this chamber and offer Australians hope. This government will end. It will end when their taxing agenda is finally over. It will end, and this government will end because Australians see through their deception and their deceit, and we are going to offer a better future where young Australians look to the horizon with confidence.
Enough of the interjections, and yes, point of order.
The member for Isaacs used inappropriate terms and didn't refer to the member by his title.
I would remind all members of this House to be referring to people in this chamber by their correct titles always. Yes. What is your point of order?
The member for Isaacs should withdraw the mark and refer to the members by the proper title.
Is there a comment you need to withdraw, member for Isaacs?
I withdraw.
Thank you. And it would please me if you all talk to each other in a respectful way and use correct titles. That would be really helpful. So I'm going to give the call now to the Assistant Minister for Competition, Charities and Treasury.
Thank you, Deputy Speaker. My maternal grandfather, Rolly Stebbins, was born in a tent in 1922. His dad was a veteran who'd fought in World War I, and his dad could never afford a home of his own, never owned a home. During the Great Depression, my grandfather left school at age 14 to support the family and then worked as a boilermaker. And it was only after World War II that he was able to afford to buy a home of his own. Got a block of land in Seaholme near Williamstown, and he and mates worked to fire the bricks together. And he and my grandmother, Jean Stebbins, raised 4 kids in a home they built themselves. My grandparents' story was the story of Australia in that period. In the interwar era, about half of Australians owned a home. But by the time you got to 1966, thanks to the Curtin, Chifley and, yes, the Menzies government, the home ownership rate had gone up to 2/3. And yet, what we've seen over recent years is the reversal of that great Australian dream. We've seen the Australian home ownership rate falling now to a 60-year low. We've seen the abandonment of what used to be a great principle of the Liberal Party, just as the Liberal Party members in this House have abandoned so many principles of their party. I've had street stalls and town hall meetings in which teachers, tradies, nurses will talk to me about their sense that it's just become too hard to buy a home in Australia, that the statistics out there in the community are what they're feeling in their own lives. As home ownership soars out of reach, they keep on saving for a deposit, but the rates of house prices are soaring out of reach. And it's not just those young Australians, it's their parents and their grandparents that are repeatedly getting in touch with me and so many members on this side of the House, saying we need to do something to boost home ownership. We have the most ambitious plan on housing supply of any government in recent decades. But we're also, through this budget, tackling the challenges in the tax system. How did we get here? Well, it's the combination of 2 policies. In 1936, Australia moved to allow taxpayers to deduct interest losses against salary. You can't do that in Britain. You can't do that in the United States. And then, in 1999, the Ralph Review was handed to the Howard government. Not a word on real estate, a report that suggested that putting in place a 50% capital gains tax discount would turbocharge investment in innovative firms. And we immediately saw the result of that. The impact was principally felt in the housing investment sector. Previous to that, net tax paid by landlords was positive, but it very quickly turned negative. And in most of the period since those changes, we've seen landlords lose on net some $4 to $10 billion a year. Landlords in Australia have become among the biggest recipients of tax handouts. It's distorted investment decisions. The incentive now is to overinvest in loss-making assets, and it's to invest largely in existing properties. 4 out of 5 investor loans are for existing homes. This budget changes that. It responds to calls that experts have been making for decades for reform on capital gains and negative gearing. You will still be able to negatively gear a new home, but you won't be able to negatively gear an existing home if you buy it after these measures take effect. Now, that approach, of course, is the approach that we take with foreign investors. Those on the other side of the House support it when it comes to foreign investors. They will happily argue why foreign investors should only be able to buy new-built homes, because we're asking them to add to housing supply. But somehow they walk away from that principle when it comes to negative gearing. But the idea is exactly the same. If you want to benefit from negative gearing, we want you to benefit the whole community by adding to the housing supply. And we're seeing very clearly this week who the coalition is fighting for. We know that when it comes to analysis from the Parliamentary Budget Office, that the top 10% get 3/4 of the benefits of the capital gains tax discount and about 40% of the benefits of negative gearing. The Grattan Institute has crunched the numbers to ask the question, what has been the benefit to the typical income earner of these policies since the year 2000. And they estimate that the typical income earner has benefited to the tune of about $12,000 cumulatively over the last quarter century. What about the top 1% though, those now earning over $800,000? Well, the benefit to the top 1% cumulatively has been around $700,000. So these are policies whose benefits are more than 50 times larger to the top 1% than they are to the median income earner. What these tax reforms do is they fund a working Australian tax offset for everyone, not for the fortunate few, but for every working Australian who earns a salary. And that's why the Grattan Institute has referred to this as the budget we've been waiting for. It's a set of reforms which respond to the Economic Reform Roundtable last year. And it's a set of reforms that respond to calls that have been issued across the political spectrum. I remember sitting here in this House when Joe Hockey gave his valedictory speech. And he said in that valedictory speech, quote, "Negative gearing should be skewed toward new housing so that there is an incentive to add to the housing stock rather than an incentive to speculate on existing property." Well, Joe, we're doing exactly that. We've heard calls from the member for Canning, who has said, in response to a question, "Is this why you're also open to negative gearing, capital gains tax changes?" Quote, "This is a new era. I think we need to overhaul the whole system." And we've heard from the member for Goldstein, who has said, quote, "The tax system is screwing over young Australians. Instead, it favours well-off established interests against those trying to get ahead." He goes on to say, in short, if you work hard to get ahead, you get hit hard. If you live off assets, you don't. Senator Kovacic has said we should not be afraid to consider tax changes, whether they be capping the number of properties that can be negatively geared. We've heard from the member for Groom. I think there are some real issues we need to address. I'm open to a discussion on CGT. The former member for Menzies, when Menzies was a seat, who held it when Menzies was a seat held by the Liberal Party, has said this year, quote, "Current tax settings tilt incentives towards investors, particularly in existing stock. They reward bidding rather than building. The Liberal Party should lead with this. Cap negative gearing for established dwellings at one property per investor, while allowing the deduction for up to 5 newly constructed homes." We even had Scott Morrison, former Liberal Treasurer, when asked, "Does negative gearing need to be reformed?" replying, "There are excesses." Dom Perrottet, Rob Stokes, sensible Liberals from New South Wales have made exactly the same case. What we are doing is responding to a huge run-up in house prices relative to incomes. Unlike the Shadow Treasurer, I'm not afraid to have written a book or two and to be able to quote from those books. In Battlers and Billionaires, I crunched the numbers looking at how house prices have moved relative to the earnings of the average worker. If you go back to the 1980s, the typical house cost 4 years of average earnings. It then ran up to 5, 6 during the 90s, to 7 in the 2010s, and in the 2020s, buying the typical house took the typical worker 11 years of earnings. We've had more than a doubling in the house price to income ratio. No wonder young Australians are mad that they can't break into the property market. And it has taken a Labor government to act on boosting supply, working with states and territories to overcome unnecessary regulation on an abundance agenda, but also working to ensure that we have the right tax settings, fair tax settings, that fund a tax cut for every working Australian, and that ensure that our tax system is fairer and the incentives are there for people who want to take advantage of negative gearing to invest in new-built homes. This is a budget for all Australians and a budget that tackles the central issue of housing affordability in Australia.
Yeah. Member for Casey.
Thank you, Deputy Speaker. Well, that was quite the lecture, the economic lecture from the Minister opposite. It was excellent, but it begs the question, where was that lecture in May last year?
Yes.
Where was that lecture to the Prime Minister in May last year when the Prime Minister said he would not change negative gearing and he would not change the capital gains tax? Got quite upset. 50 times the Prime Minister said. So it is amazing that the Minister will give that economic lecture today. He obviously didn't have the ability to give that lecture last year. Just thought of it now. Suddenly, 12 months later, the world has changed. And this is the reality. Every backbencher over there has broken their word with their communities. Every backbencher has broken their word with their community. They all went to their communities and said we wouldn't change the tax settings. They made a promise and a commitment. Those first-termers have lasted about 12 months before they've broken faith with their communities. But it is not that surprising that they've had to break faith with their communities. They've had to betray their communities and mislead their communities because we understand what it's like to be a backbencher in the Labor government. One of them had the courage to background the Saturday paper this week. How did they describe the PMO? And I quote, "The PMO is like North Korea. They are Pyongyang," which I guess would make the Prime Minister Kim Jong-un. It means the backbenchers know that they have to follow orders. They have to break faith with their communities. They have to break their own word to their community, and that's something they'll have to live with. Because the worst part about this broken promise is it was a clear, deliberate decision 12 months ago to mislead their communities. And what makes it even worse is that it's actually not going to work.
That's right. That's the worst.
Supply is so important to getting housing down and affordable for everyone in Australia, including first home buyers. The Prime Minister himself, in a moment of honesty, said that supply was the most important way to make housing sustainable. Now, the problem with the tax changes and the broken promise of this government is their own budget papers, their own word confirms that these measures will decrease supply. So their own measures will make it harder for young people to get into a home. And I ask, it does say that, I can give you the page. Learn to read your... Stop taking the talking points, learn to read the budget papers yourself. The budget papers confirm... Member for Banks, the budget papers...
Order. You need to direct your comments through me as the chair, and I'd like the member for Hunter to stop the interjections. You have the call, member for Casey.
And the member for Banks should read the budget papers himself, because the budget papers confirm that 35,000 houses less will be supplied because of these tax changes. The budget papers also confirm that rents will go up because of these tax changes. So maybe don't follow orders from Kim Jong-un and do your own work, and don't break your own word to the Australian people. And this is the reality. They follow their talking points without understanding the detail, and they're actually going to make it harder for the Australian people. And while we're on the budget paper, let's have a look at what is happening.
Excuse me a moment. Is this on a point of order?
Yes, a point of order. I would ask the member to withdraw his comments around Kim Jong-un.
He's not a member of Parliament.
You can't say things like that. That's harsh.
It is a matter of taking offence. A lot of things are said in this House for an offence, and as long as you are not referring to a particular person, you're not ascribing that person to another, then I will allow it.
Looking at the budget papers, we should also think about what comes next. So, page 137 of the budget papers, and I quote, "Access to home ownership increasingly depends higher the wealth of the previous generation, the bank of mum and dad. This entrenches higher levels of wealth inequality across generations." The budget, what's that? Bank of mum and dad. Sounds a lot like an inheritance tax. Yep. Sounds a lot like a tax on the primary place of residence. It's the logical next step. It's in their own budget papers. Guess what? When the Prime Minister gets asked about it, he already has, he'll deny it. Gee, we've heard that one before. Broken his word once, broken his word twice. Come the next election, he's coming after your money and he's going to break his word again.
Yeah.
Member for Moreton has the call.
Thank you, Deputy Speaker. And Deputy Speaker, I'd remind the member for Casey that only one side of this chamber voted against a tax cut for every tax-paying Australian last year. I think that when we talk about this MPI in this debate today, I want to give you this quote again because we heard it earlier in the day. It's time to be honest. The tax system is screwing over young Australians. It favours well-off, established interests against those trying to get ahead. In short, if you work hard to get ahead, you get hit hard. If you live off assets, you don't. And you might think that that is a quote from the Treasurer. You might think that that is a quote from the Prime Minister. You might think that that is a quote from Minister Gallagher. But it's not. It's a quote from the person who moved this MPI. It's a quote from the member for Goldstein. It's a quote from the Shadow Treasurer. And, Deputy Speaker, I think it proves that conviction politics for the Liberal Party of Australia is not just dead, it is buried and cremated. Because when you think about that quote, it isn't just the first Cirque du Soleil-worthy backflip that the member for Goldstein has made today, because he made another one just the other day. And that was that he's opened the door up to a potential Liberal, national and one nation marriage. A terrifying prospect, but potentially not as terrifying as what the Leader of the Opposition has said just yesterday. And what the Leader of the Opposition has said should have every Australian, everyday Australian shaking in their boots. Because he said this: whatever it takes to unwind this budget, whatever it takes. So if you're a young person yearning to get into your first home, the Leader of the Opposition doesn't want you to have an even playing field. In fact, he'll do whatever it takes to unwind the reforms of this budget. If you're a working person, a working Australian who's looking forward to getting a $250 tax offset, the Leader of the Opposition is gunning for you. If you are a taxpayer looking forward to another tax cut, the Leader of the Opposition still doesn't want you to have that. And when we talk about the economy, when we talk about economics, we talk about it being a function of two things. It's a function of choices and of scarcity. And I think two things are really clear when it comes to those who sit opposite. The first is that they have made a choice in their response to this budget so far, and that choice is not for everyday Australians. That choice is not for young people. That choice is not for everyday taxpayers. And when it comes to scarcity, if you consider the result in the Farrer by-election and you also consider the member for Flynn's potential defection to One Nation, people from the LNP in this place are getting scarce. The intergenerational vandalism of those sitting opposite puts a target on the back of thousands of people in my community and puts a target on the back of millions of Australians across our country. Because when it comes to housing, this is a budget that has a reform of tax systems to support 75,000 more Australians into the housing market. It's creating homes for Australians, and that investment is now over $47 billion. That's on top of Help to Buy, that's on top of 5%. It's limiting negative gearing for residential property so it can only be used for new builds. And the dream of home ownership can be back again because we are making significant reform that will address intergenerational equality. On cost of living, the budget bottom line is nearly $45 billion better compared to my EFO, and this is more than $1 trillion better than what the coalition left us with. On cost of living, we know that the Labor government is investing in things that ease pressure for everyday Australians. So when we talk about an aspirational budget, a budget that is based on resilience and on reform, the Labor government is focused on driving the opportunities for the next generation, not leaving them behind.
Member for Herbert.
This budget is un-Australian. It treats aspiration like a problem to be managed, not a value to be rewarded. And you know the system's wrong when Queensland got a tokenistic acknowledgement of country mention, but not a single mention of infrastructure in this budget. This Labor's budget's message is simple. Lower your expectations, clap politely for crumbs. The Labor Treasurer really should have included that in his talking points on how to mislead the Australian people. You can't claim to back housing while punishing the people who actually provide it. Mum and dad investors, they're not monopoly men. They're nurses, tradies and retirees just trying to get ahead. And the Treasurer said war more times than he said Queensland. We have to be real here. This is 4 years of poor decisions by a Labor government, not a 4-month-old war. Last night's budget was presented as a plan for relief, but for many in Townsville, small businesses and investors, it will feel more like pressure with better gimmicks and branding. People are working harder than ever, but they don't feel like they're getting ahead. In Townsville, mum and dad investors, they're not the big end of town. They're just teachers with one investment property, tradies trying to build some security for retirement. They're small business owners who have backed themselves and have taken risks. And many of them are now feeling like aspiration is being punished instead of rewarded. This budget adds billions in new taxes over the coming years, including higher taxes that will ultimately affect investors, small businesses, superannuation and housing. Because when investors pull back, fewer homes get built. When small businesses lose confidence, fewer people get hired. And when businesses are hit with high operating costs, families end up paying more at the checkout. Families are already dealing with rising grocery costs, power bills, insurance premiums and mortgage repayments. And despite all the announcements and spending, inflation is still expected to remain high. That means interest rates could stay high for longer, and for many households, that's the difference between coping or falling behind. Small business owners are carrying wage pressure, energy costs and supply costs, while customers themselves are cutting back. And despite all the government spending, we're still left asking, why doesn't life feel easier? Because the reality is this: if inflation stays higher for longer, interest rates stay higher for longer. And that hits regional communities like Townsville particularly hard. Townsville's growing, and growth is a good thing. But growth without enough housing, infrastructure and planning puts enormous pressure on everyday Australians trying to buy, rent or build. And in this budget, many papers have now reported that there's been significant cuts to veteran services. $5,000 cap on allied health that veterans can get starting next year, which is not enough for those that have been injured, wounded or ill from their service. People need more physio, occupational therapy, more time in front of the GP, in front of the doctors. But with this cap, they will be out of pocket or living with chronic pain. This is a bad cut. This shouldn't have happened. Another part of this budget that I think is quite concerning is the lack of and defunding of Invictus Games, Invictus Australia. Invictus Games is a sporting event, a Tier 1 level that supports people that have been wounded, injured or ill from their service. Prince Harry was the founding father of it. I've been on Invictus Games events, the inaugural one, and then went back as a coach. I've seen it change lives and I've seen it save lives. Because sport is a healing power. To cut veteran services, to cut supports to veterans is absolutely shameful. This government needs to have a long, hard look at itself when it comes to what their priorities should be. Because I know that in Invictus, I've heard testimony from families who have said, without this sporting event, without this coming together as veterans, my son, my daughter, my husband
wouldn't be here anymore. This needs to be overturned and Invictus Australia should be funded.
Member for Canberra.
Thank you, Deputy Speaker. What a farce this MPI is. An MPI criticising the budget from a shadow treasurer whose great economic idea was a thought bubble to force young people to make an absurd Faustian bargain to either raid their retirement savings or accept never to be able to buy their own home. The shadow treasurer, who, as the chair of the Economics Committee, went round the country with a scare campaign telling pensioners that they would be made worse off by our policies, which was completely incorrect. It's little wonder that the Liberal Party is currently polling so low they're on the verge of becoming non-existent come the next election. They have zero vision. They have zero capacity to put forward a positive agenda for Australia, and they have absolutely zero credibility. And we saw the results of that just over a year ago at the federal election, and we saw the results last weekend in Farrer. Voters have made up their mind on those opposite. And contrary to the proposition in this MPI, this budget delivers much-needed hope and a real plan to increase housing affordability for first home buyers. Our changes will open the door to 75,000 new home buyers. We're making the tax system fairer by reforming negative gearing and the capital gains tax to ensure that every Australian has a chance at home ownership. And I know that everyone in this place, including those opposite, will be hearing this from their communities, as I do, about the difficulty of breaking into that housing market, particularly for young people. And the changes to negative gearing are grandfathered so that those who currently negatively gear will not be affected. They can continue to do so. The capital gains that people have made to July 1 next year will be unaffected. Gains procured on existing investments prior to the start date will retain the 50% discount. And most importantly, investors can still use negative gearing on new homes. So it's building into the tax system the incentive to invest in new houses, more homes, which is about addressing the supply issue as well. For Australian workers, this budget is cutting taxes for 13 million people. In the ACT, that includes 260,000 workers who will receive a tax cut of up to $250 through the Working Australians tax offset. And 140,000 Canberran workers will benefit from a new $1,000 instant tax deduction. This is money going back into people's pockets. Deputy Speaker, Labor governments always deliver. We said we'd cut income taxes, done. We said we'd invest in housing, done, to the tune of $47 billion since we've come to government. And we've said that we would take the pressure off working families, and that's exactly what this budget delivers and what the previous 4 Albanese Labor government budgets have delivered. The Shadow Treasurer wants to talk about broken promises. Where was the Shadow Treasurer when his government promised to fix housing and then proceeded to oversee a decade of doing absolutely nothing? We don't need a lecture on promises from a party that spent a decade in government and left Australians with nothing to show for it. This budget is about who this government is fighting for the hard workers doing double shifts who will keep more of what they earn, for the young couple in any electorate, mine or anyone's here, who thought home ownership was out of their reach, for the small business owner who now has a permanent $20,000 instant asset write-off. This budget is about fighting for hard-working Australians, all of them, right across this country. And that is what Labor does and what this budget does. It also invests in my own community here in Canberra, which is something we didn't see much of at all under the previous government. Yet since coming to office, our government has committed more than $4 billion to the ACT. And this is what it looks like when we are recognised as a community like the communities all around this country. Our government's investing $50 million matched by the ACT and New South Wales governments to upgrade the Canberra to Sydney rail link. This is something people have talked about for so long, and it is finally happening under our government.
Absolutely.
We're investing in our national institutions, which were falling into rack and ruin under the previous government, and we're ensuring that the CSIRO's groundbreaking research will continue with an additional $387 million funding boost. This is a budget that is delivering for Australians all around this country, helping them to earn more and keep more of what they earn and find a stable housing, whether it's buying a new home or getting into homelessness support.
Member for Fisher has the call.
For today, apart from all those mums and dads that are out there that are really struggling under this government, you know who I feel sorry for? I feel sorry for Bill Shorten. Because Bill Shorten would be sitting in his office, in his Vice-Chancellor's office at the University of Canberra, and he'd be thinking, why? Why? I tried to do the right thing. I took these policies to an election. I took these policies to the people, and they knocked me back. But under this government, under this Prime Minister, they learnt their lesson. You've got to give them that much. They learnt their lesson. They know this lot. This government knows that if you take unpopular policies to the people, to an election, then the people will figure you out and they'll let you know about it. But under the cover of darkness, and not just the cover of darkness, the Prime Minister, the Treasurer, consistently said, no, there'll be no new taxes on housing. It's not going to happen. How many times have I got to tell you? 50 times I've got to tell you. It's not going to happen. Yep, guess what? It's happened. And when you break that trust, that there is a solemn, believe it or not, we cop a lot of, you know what, with the members of the public as politicians. Is there any reason why, when you have people like the Prime Minister make those solemn promises, look squarely down the line of the camera and says, it's not going to happen under my leadership, and then there's a change of heart, and it's sold as some kind of a, well, we've had a change of heart because things have changed, there's this intergenerational equity issue. What a load of rubbish. This is socialism. This is socialism. That lot, the government over there, this is the biggest form of redistribution of wealth in this country since the Whitlam government. If you thought these policies were so good, why didn't you take them to an election? You didn't take them to an election because you knew you would lose.
I'll ask
just in the
comments
same
to be directed through me and stop this personal attack.
Just in the same way that the government knew it would lose, so it didn't take them to an election. And that's why the Australian public is so upset. You know, Madam Deputy Speaker, it's not just about the negative gearing, it's not just about the CGT, it's not just about discretionary trusts. I've got an older electorate, and my older electorate, people in my electorate are white hot with rage. They are white hot with rage. You know why? Because they've worked all their lives. You know, they're a bit older than you and me. They've worked all their lives for 40 years. When they were in their 20s, they listened to the government and they were encouraged to go out and get private health insurance. And they were even told, if you don't get private health insurance before you turn 30, then we're going to actually penalise you the older you get. So they, on good faith, they've gone out and taken out private health insurance. I've received an email from a member of my constituency this morning. She's a pensioner on a fixed income. And so many of my pensioners, I don't know how they do it, but they still pay their private health insurance. And now, under this health minister, who unfortunately has just walked out of the chamber, is going to rip those concessions away from you when you turn 65. Now, for the life of me, I cannot understand why this government wants to rip those rebates away. What's the magical figure? When do you most need private health insurance? It's when you're getting to yours and my age, Madam Deputy Speaker. When you're getting to that age, when you need that help, when you need that medical assistance, and now this government is going to make it $1,600 a year extra that my people, that Australians around this country over 65 are going to have to pay. Shame on this government.
Give the call to the member for Leichhardt.
Thank you, Speaker.
Sorry, just a moment. Is there a point of order?
There is a point of order. It's in relation to the member for Reid, who, as you pointed out, was continually interjecting.
I've already dealt with that.
She's a long way out of her seat, Madam Deputy
I've
Speaker.
dealt with the issue of interjections already.
I believe her
Thank
seat
you.
is somewhere
Please
down
resume
there.
your seat. I've already asked the member for Reid to stop interjections, and I'd ask all of the people not to be reflecting on the chair in future discussions either. But I will give the call to the member for Leichhardt.
Thank you again, Speaker. I grew up in towns of timber, agriculture, defence and mining, and I represent the most Australian place in Australia. I know the Australian dream. And unlike the member for Goldstein, who, when he's not desecrating Billy Joel, the temerity to attack the piano man in such a way, downloading his own book, which we discovered today during the MPI, which I guess is akin to the member for Hunter wearing his Commonwealth medals into the place, he's put together a website so he can speak to working people. Fantastic. I don't need a website. I grew up with them. I know them. It's my friends, my family. So I'm going to talk about a guy who I went to high school with. His name was Niz. This is an abbreviation of his last name. First one of us to shave, sprinter, played basketball with us, built like a bowling ball. Niz wanted nothing more in life than to be a mechanic. He was a good mechanic. And he went and worked for Holden, the great Australian car Holden. And he climbed the ranks to the point where his job was to take the new car out into the bush and do your level best to break it. Come back, fix it up, and start again. And we'd have beers when we got to catch up every now and then, and he would take us through the new car with sound effects. My favourite would be when it dropped from 5th to 3rd. He loved that job. He loved everything about it. That was his dream. The member for Goldstein is an economic rationalist. He called the Australian car manufacturing industry terminal, celebrated its demise. What about Niz's dream? That was all he wanted. And it was snatched away. Because most people's dreams aren't like the member for Hunter here, 5-time Olympian. They're modest. They're easy. They want to go camping with the kids. They want to have a nice family. Security. These are the things my children speak to me about. But more than anything else, they want their own home. Home ownership. That part of Australia that belongs to you. Where you'll bring your babies home. Where the grandparents will meet grandchildren for the first time. Where memories are forged. My parents live in the house I grew up in. They've owned it now for 46-ish years. The stickers that I put on the door are still there because they own that home. Renting cannot give you that. And that is why we have to address this. To give young people the opportunity, to let them back into that property market because they don't have hope. They look at it and they go, well, this is ridiculous. $1.2 million for a house, it's a number that you can't even think about when you're working, slinging boost juice for $42,000 a year, working at the local council for $85,000 to $90,000 a year. You're never going to get there. Changes have to be made. And to make changes, you have to be courageous. This government is courageous. It saw the problem, identified a problem that has been brewing since I was a child. House prices up, up, up. Looks fantastic on paper, but as the economic rationalists do not see, there is a living cost, a real cost, and that is taking and snatching the hopes and dreams of young Australians. This change will boost supply. We're not saying don't negatively gear, we're saying negatively gear, but build the house. Get more housing. Get more people into the housing. Let them rent to start their lives at a reasonable rate, and so then they can enter the housing market for themselves. So that in 40 years' time, the stickers from their child are still going to be on the door, so that they can have their holidays and return to their home with their dog or their cat, that they're not living under the rules of someone else, that they're not paying off the mortgage of someone else. Home ownership used to be something that everyone could aspire to. It was taken away. But this Labor government is giving it back. We are looking young people in the eye and saying, yes, we have heard you, we are acting, and Australia is as much yours as it was the previous generations. I'm proud of this budget. I'm proud to be a member of this government, and I'm proud that young Australians will have their own homes.
Member for Grey.
Speaker, this budget fails to deliver on a list of key promises made to Australians, leaving them worse off through higher taxes, exorbitant costs and a string of broken commitments. Before the election, the Prime Minister looked the Australian people in the eye and proudly declared, "My word is my bond." Well, Speaker, we now see exactly what kind of bond he meant. We thought we were getting James Bond, courageous, reliable, admirable. Instead, his economic management looks more like Alan Bond, leaving a trail of catastrophic debt for the next coalition government to clean up. Perhaps the Prime Minister meant a pair of old Bond's underwear, because his promises are full of holes and leave Australians completely exposed. Or maybe, Speaker, his word is just like cheap bonding glue from the bargain bin, completely falling apart the second you apply pressure. His word is not a bond at all. His word is entirely worthless. Speaker, this budget confirms that the Prime Minister now oversees the highest taxing government in our history, because Labor cannot manage money. They also can't manage spending, racking up an astonishing debt of $1.25 trillion. The yearly interest alone on this debt will hit $42 billion, or $80,000 each and every minute. And while this government burns money, everyday Australians and regional Australians cannot afford to live. This budget itself reveals the buying power of wages has declined by 3%. Homegrown inflation is forecast to hit 5%, higher than in France, Japan, the US and the UK. We also see Labor completely blowing their immigration targets. By the end of their first 2 terms, they will have brought in more than 2 million migrants, including overshooting their own targets by 90,000 people over the next 2 years. That puts even more pressure on infrastructure. But instead of offering relief, Labor introduces new taxes. It is pure intergenerational fraud. Labor are pulling the ladder up on younger Australians who are trying to get ahead. With their new housing taxes, Labor's own budget confirms 35,000 fewer homes will be built over the next decade. Speaker, you cannot make this up. But Speaker, it's not just families who are being attacked in this budget. It's farmers, it's fishers, it's family-owned businesses and critical industries that keep towns alive, like in Port Pirie. And on Port Pirie, this budget contains no new funding package to ensure the long-term viability of the lead smelter in Port Pirie. While an earlier transitional package of $57.5 million is included in the budget papers, that package expired on 1 May 2026, and negotiations for further support are still unresolved. This leaves the future of Port Pirie hanging in the balance, and that is not good enough. Everyone is feeling the pinch in this budget. Take the wine industry. With one hand, grabs money via higher taxes on trusts. With the other hand, they take away the wine tourism and sell-it-all grant program. It's a king hit. When it comes to agriculture, Speaker, Labor's raid on family trusts will hinder the ability for farms to manage income and transition ownership. Combined with changes to CGT, these policies will deplete finances and potentially force unintended asset sales just to stay afloat. We also see Labor cutting $52 million from the Future Drought Fund, plus totally ill-timed cuts to pest and disease preparedness and response grant fund. This is a cheap shot to all farmers who are only ever one bad year away from disaster. Speaker, this government, this Prime Minister and this Treasurer gave their word to regional Australia, but Labor's word is now worthless, and this Prime Minister's bond with Australians is now officially broken.
Give the call to member for McNamara.
Well, Deputy Speaker, it is just an honour to hear that insightful reflection from the Liberal Party about how important someone's word is. And I thought I'd reflect on someone's word in this chamber when they said the tax system is screwing over young Australians. Instead, it favours well-off established interests against those trying to get ahead. In short, if you work hard to get ahead, you get hit hard. And if you live off assets, you don't. Now, that wasn't anyone on this side of the House that said that, Deputy Speaker. It wasn't anyone on the crossbench either. It was the young Shadow Treasurer, Pauline Hansard's best friend. She's found a gold mine in Goldstein over there, and the Shadow Treasurer said those exact words. Because once upon a time, there were Liberal Party members who used to actually listen to the needs of the constituents that they represent. But long since those days are over. And the Liberal Party has shown itself that no matter what electoral punishments they continuously get, they are happy to go back to the well and ignore the interests of Australians, and then they get surprised when Australians ignore them at the ballot box. But on this side of the House, since coming into government in 2022, we have completely changed and transformed the way in which our housing sector is operating, and it's all been around giving more Australians the opportunity to either purchase a safe and secure home or to be able to access a safe and secure home when they need it. We've made sure that renters have a better deal with long-term tenants via working with the states and better conditions on those tenancies as well. But let me remind this place of the journey that the Liberal Party has opposed each and every single opportunity in order to improve access for Australians into the housing market. Our 5% deposit scheme, which over 200,000 Australians have accessed to be able to get into the housing market and purchase their own home, the Liberal Party and the then Shadow Minister for Housing said that that was subsidies for billionaires. Senator Bragg from the other place, I'm not sure what billionaire he was talking to and why they were using 5% deposits, but certainly the 200,000 Australians who have accessed this, I think, would have a very different opinion, that these Australians are hard-working Australians who struggled to get the deposit to get into the housing market, but once they had the opportunity to get a mortgage of their own, they could pay down that loan. There's also the Help to Buy scheme, a shared equity scheme that at every opportunity those opposite decided to come up with the most ludicrous ways of criticising it, saying that, you know, will be in your kitchen and all sorts of other absurd things, when actually the vast majority of people who are using that scheme are people who are either on low or middle income earners who are getting into the housing market for the first time, or people who have either separated. A lot of women who are single have used that scheme and have done so in order to give themselves safety and security and stability in their lives. And we couldn't be prouder to help every single Australian be able to get into the housing market and to find that stability and security of paying down their own mortgage instead of paying down someone else's. But of course, that is not all. Since coming into government, we have made the largest investment in social housing in decades. Now, those opposite didn't even have a housing or homelessness minister for most of the time in which they were in government, which showed just how low a priority it was for those opposite. I remember the former housing minister Mr Sukkar, the former member for Deakin, who has been replaced by an outstanding member for Deakin, may I say, who said that social housing is just a matter for the states and refused to invest a single dollar in social housing. Well, we are building 55,000 social and affordable homes that are going to Australians who really need them, whether they be key workers, whether they be people who have escaping family violence or domestic violence, or whether they are just people who, for no fault of their own, for a period of time need a safe place to go. And we are investing in making sure that there are those homes available, and we are. I've been touring the country looking at all of those sites, and it is so exciting, and the quality of those housing is something that we can all be very proud of. And finally, Deputy Speaker, I want to mention the youth housing incentive that we have funded in this budget, because what that will do is that will make sure that young people who are in those difficult circumstances will be on an equal playing field and will be able to access those incredible social housing homes that we're building and the others around Australia instead of being locked out. We care about housing, we're delivering housing, and we're helping Australians buy their own home as well.
And the time for this discussion has now concluded. I have to report that the Public and Educational Lending Rights Better Income for Authors Bill of 2026 has been fully considered by the Federation Chamber. A Governor-General's message recommending an appropriation for the purposes of the bill has been reported, and the bill has been agreed to without amendment. I present a certified copy of the bill. So the question is that the bill be agreed to. That's the question I'll put to the House. All those of that opinion say aye. Contrary, no. I think the ayes have it. This bill has been agreed to. Minister.
Thank you, Deputy Speaker. I seek leave of the House to move the third reading immediately.
Is leave granted?
Leave is granted.
Thanks. Member for Fadden. Minister.
Thanks, Deputy Speaker. I move the bill now be read a third time.
I will put the question to the House that this bill be now read a third time. All those of that opinion say aye. To the contrary, no. I think the ayes have it. I have another message. Oh, my pardon. I'll call on the clerk.
Third reading, a bill for an act to provide support for Australian creators and publishers of books available in Australian public and educational lending libraries and for related purposes.
Thank you. I have to report that the Public and Educational Lending Rights Better Income for Authors consequential bill, is this not the one we just... So there's the consequential amendments and transitional provisions bill of 2026 has been fully considered by the Federation Chamber and has been agreed to without amendment. I present a certified copy of the bill. And the question is that this bill be agreed to. All those of that opinion say aye. To contrary, no. I think the ayes have it. This bill has been agreed to. Minister.
Thanks, Deputy Speaker. I seek leave of the House to move the third reading immediately.
Is leave granted?
Leave is granted.
Thank you, Member for Fadden. Minister.
Thank you. I move that this bill now be read a third time.
I'll put the question to the House that this bill be now read a third time. All those of that opinion say aye. Contrary, no. I think the ayes have it, and I call on the clerk.
Third reading, a bill for an act to deal with consequential and transitional matters arising from the enactment of the Public and Educational Lending Rights Better Income for Authors Act 2026 and for related purposes.
Thank you, and I ask the clerk to call the next item of business.
Government business, order of the day number 2, Treasury Laws Amendment, the Survivors Law Bill 2026, resumption of debate in the second reading.
Thank you. The question is that this bill be now read a second time, and I'm giving the call to the Minister for Social Services. You have the call, Minister.
Thank you so much, Deputy Speaker. I want to start by thanking the brave victims and survivors that have lent their voice to this campaign. After unspeakable trauma and unimaginable grief, you've showed courage, strength and determination, making sure that no other victim will continue to suffer at the hands of their perpetrator long after a judgment is handed down. We owe you a great deal. I say this unequivocally. Our government is absolutely committed to holding perpetrators of child sexual abuse to account. The crimes they have committed are abhorrent. They should not have the opportunity to further add to someone's trauma by denying them the compensation that is rightfully owed. They should not be able to hide or avoid accountability, and that's what this bill will fix. It will close an unjust, unfair, cruel loophole that has been exploited by convicted sex offenders to hide their assets in superannuation. Meanwhile, victims and survivors have been left without the compensation that the courts have decided that they are owed. It will make sure that a court ruling in a victim or survivor's favour translates into real outcomes. Where a court-ordered compensation debt remains unpaid after 12 months, victim survivors will be able to seek access through a court order to certain superannuation contributions that have been made by the perpetrator of the abuse. This includes additional personal and salary sacrifice contributions, often used as a way to shield assets from enforcement. This is practical and it's targeted. It removes the ability for any perpetrator to wait out their obligations, protecting their financial position at the expense of a victim survivor. Importantly, this bill ensures that compensation debts don't disappear through bankruptcy, not just for future bankruptcies, but also for those currently in progress. I think, Madam Deputy Speaker, it is beyond imagining how absolutely, completely unprincipled the people are who have taken advantage of these provisions in the past. First of all, to sexually abuse a child, to have that proved, to have compensation awarded against you, and then to deliberately shelter your assets from paying the compensation that has been justly awarded. It really does add the most incredible insult to a lifelong injury. We know that this is just one area where reform is badly needed. We are working across family, domestic and sexual violence to make sure that we are ending violence against women and children as a priority, and every single one of us in this place has a role to play. Deputy Speaker, child sexual abuse, of course, is a crime that doesn't just affect girls, it affects boys in too large numbers, and it is important to understand that many grown women and men have a history that has followed them throughout their lives of child sexual abuse and impacted them throughout their lives. So far, our government has worked with victims of child sexual abuse on measures like the memorial that will be opened in Canberra in coming years, and in the Orphanage Museum in Victoria as well. But across sexual, family and domestic violence, we have invested more than any previous government, more than $4.4 billion in frontline services, in preventative programs and in behaviour change programs right across government. We've made the Leaving Violence payment permanent. We've launched Australia's first ever standalone plan on family, domestic and sexual violence for First Nations women and children, backed by $218 million in the budget last night. We've boosted funding for the 500 Workers program by more than 70%. We've boosted funding for 1800 Respect by 40%. We've legislated to make sure that our social security system can't be weaponised by perpetrators of abuse. We've supported the recovery of children who've experienced violence, investing $81 million for services including child-specific counselling. We've invested a record $3.9 billion in services, with an extra $800 million for family violence legal services. We've reformed the family law system so that it's safer, simpler and more accessible. Mr Deputy Speaker, you would know that last night in the budget we announced significant reforms to the child support system as well to better protect children. We are doing so much in this area because it is such an enormous need in our community. I do want to finish by repeating my thanks to the brave victim survivors who've come forward to demand this change, for sharing their stories, for seeking justice, for fighting to fix something that at its heart is absolutely demonstratively cruel and deeply unfair. So I say to you again, thank you. I want you to know that this bill is a significant and necessary foundation, but we won't stop here. This lays the groundwork for future reforms, and we will keep working with you to keep future generations of children safe.
The question is that the bill be now read a second time. The Assistant Treasurer.
Thank you, Deputy Speaker. Firstly, I would like to thank the many members from across this chamber who have contributed to this debate, and I acknowledge the conviction and the compassion with which this important policy has been advocated for within the Parliament. This bill represents the best of this place, and I hope that our demonstration of unity and solidarity sends a powerful message to victim survivors that the Parliament is listening and that we are acting. In particular, I want to thank the member for Boothby and the member for Eden Monero, who have advocated for this measure over a very long period of time. I would also like to acknowledge the member for Sydney, the Minister for Social Services, who's just spoken powerfully on this issue, the Assistant Minister for Social Services, the member for Cooper, and also the Attorney General. I would also like to thank the Shadow Assistant Treasurer, the member for Page, and the former Shadow Assistant Treasurer, the member for Cowper, for their engagement on this issue, and the member for Fisher. Members across this chamber and senators in the other place from all political parties have contributed to the strength of this measure. This is truly a bill which the Parliament has united behind. I note the amendment of the member for Wentworth and thank her for her positive engagement on this issue. As the member rightly indicated in her speech, the government has committed to reviewing the legislation following its implementation. Deputy, while we cannot support the member's substantive amendment to the bill, we remain committed to reviewing this legislation and to affirming that commitment in a way that can ensure confidence for survivors. I look forward to continuing to engage with the member on this measure and looking for all possible opportunities to strengthen it in the future. Deputy Speaker, this bill establishes a framework for victims and survivors of child sexual abuse and other similar offences to seek visibility and release of certain amounts from a perpetrator's superannuation to satisfy unpaid compensation orders. It is directed at preventing superannuation being used to shield a perpetrator's assets from compensation, which can delay or deny compensation and add further distress to victims and survivors. This bill closes that loophole and affirms that financial systems must not operate in a way that undermines justice, and its passage is a testament to the strength and hope of survivors of child sexual abuse and their families. At its core, this bill is guided by a simple but fundamental principle: perpetrators of child sexual abuse should not be able to hide behind financial structures to avoid accountability. I commend this bill to the House.
Being no further speakers, I'll now put the question. The question is that this bill be now read a second time. All those of that opinion say aye. To the contrary, no. The ayes have it. Clerk.
Second reading, a bill for an act to amend the law relating to taxation, superannuation and bankruptcy and for related purposes.
I've received a message from Her Excellency the Governor-General recommending, in accordance with Section 56 of the Constitution an appropriation for the purpose of this bill. Is leave granted? Sorry, you seek leave.
Leave.
Is leave granted?
I ask leave of the House to move the third reading immediately.
Leave is granted.
Leave is granted.
I move that this bill be now read a third time.
I'll now put that question, that this bill be now read a third time. All those that in opinion say aye. To the contrary, no. The ayes have it. Clerk.
Third reading, a bill for an act to amend the law relating to taxation, superannuation and bankruptcy and for related purposes.
Clerk.
Government business, order of the day number 3, Competition and Consumer Amendment Unfair Trading Practices Bill 2026, resumption of debate on the second reading and on the amendment moved by the member for Page.
The original question was that this bill be now read a second time. To this, the honourable member for Page has moved as an amendment that all words after that be omitted with a view to submitting other words. The question is that the amendment be agreed to. The member for Moreton has the call.
Thank you, Deputy Speaker. Deputy Speaker, the Aussie idea of a fair go may be one of those phrases that you hear all the time, but it really does capture something important about who we are as Australians. At its core, it's about making sure that everyone is treated fairly and gets a decent shot. It applies on an individual level and also on a societal level. You can see it in how we value fair access to healthcare and to education. And right now, when so many Aussies are doing it tough, we also need a fair go at the checkout. And I don't just mean on price. I'm talking about the need for consumers to be treated fairly and the need for business to play by the same transparent rules. In a time when commerce is rapidly changing and a time of global economic uncertainty, this is more important than ever. Deputy Speaker, a generation ago, shopping looked very different from what it looks like today. For a start, you had to physically go to the shops, drive into the park, you had to get your trolley, walk it down the aisles, pick out what you want, go to the checkout, pay in cash, and once there, transactions were pretty simple. You checked out those goods, you paid the price once, and you walked away with an item. These days, though, it's of course possible to never set foot in a store or a shop. Shopping online offers us convenience and accessibility, and we can shop from anywhere at any time. The landscape, the technology have changed. That's just one difference with how we shop, though. Another is in the price, because often the true cost of your purchase is only revealed at that last click, and the payment might never actually stop. Drip pricing is the name given to additional fees, things like booking charges and service costs, which are added as the transaction progresses. And consumers, lured by what might at first seem like a good deal, can find that the product is significantly more expensive than originally advertised by the time the actual purchase is made. Drip pricing also makes it harder to compare prices, where once you'd go from shop to find the best deal, it's now much harder to make an informed comparison on price when not all the costs are advertised up front. You don't know all the costs when you choose to buy. And, Deputy Speaker, I spoke to a local, a young bloke named Tim in my local area. He'd just finished high school last year, and we met at the lounge in the suburb of Runcorn on Brisbane's south side. And Tim told me a story about a long-awaited holiday. It was a holiday he was going on with his friends, and it was his first real time buying something that he wouldn't be going on a trip with his parents for. The tickets seemed cheap, but as he went to pay, those extra charges added up. And another major change is the popularity of subscriptions. And this is something that impacted on Tim as well. Consumers are increasingly signing up to ongoing services such as streaming platforms, apps and software which automatically renew. And for Tim's generation, these things should not be the norm. Tim needs to know, particularly at one of the most financially vulnerable points in his life, that as a consumer, he is protected and he isn't taken advantage of. And all you need to do is scroll through your phone, whether you've got Spotify, Netflix, Disney+, Stan, and so many others, to know that this is a challenging problem and it's getting bigger and bigger every day. It's easier for the number of subscriptions you have to accumulate over time, and over time you might not even notice the payments leaving your bank account. When you do want to cancel, in many cases, it's a complicated process. And Deputy Speaker, it shouldn't be a complicated process. Despite the entire subscription process being online, you might have to make a phone call to realise your cancellation. There can be multiple steps which can be deliberately confusing. And what the Assistant Minister described as a labyrinth of cancellation paths is real. And it's affecting everyday Australians every day. And that's why the Albanese Labor government has introduced the Competition and Consumer Amendment Unfair Trading Practices Bill of 2026. It brings consumer law in line with how Australians now buy, compare and subscribe. Because as technology changes, as norms for payments change, we must change with them. We have to keep up to date, lest everyday Australians cop the brunt of not having regulatory frameworks that address the real way in which Australians pay for things and in which they shop. This bill squarely targets unfair trading practices and is part of the government's commitment to improve protections for consumers. And it has three key areas of focus. Firstly, the bill introduced a ban on unfair trading practices by establishing a broad, principles-based rule that targets conduct which manipulates consumers. This includes mechanisms that distort the environment in which consumers make decisions, leading to harm. This measure will capture a wide range of behaviours designed to influence choices in ways that are misleading and in ways that are exploitative to everyday consumers. It's intended to set a clear and consistent standard of fair conduct across all sectors, enhancing fair competition and indeed boosting consumer confidence in the system itself. The bill sets out practical guidance by including a non-exhaustive list of illustrative examples of conduct that could breach these new laws. This includes preventing or hindering customers from exercising their legal rights or accessing remedies, failing to provide important information and presenting key details in ways that are confusing, in ways that are unclear, overly complex, ambiguous, poorly timed, or just plain overwhelming. It also covers situations where the overall environment, such as the design of digital interfaces, places undue pressure on consumers or makes it difficult for them to make or act on decisions. You know what this looks like. It's the countdown timer that increases the urgency to click the buy button. And we watch it on our computers. Tick, tick, tick. Better press buy right now. Or the pop-up that tells you that there's only one item left to purchase. And you better hurry up because your time is running out to click that button and pay. These aren't helpful. These are deliberately designed to swindle consumers. The bill's intention is not to limit genuine promotion or standard advertising. Instead, the focus is on addressing mechanisms that cross that line from persuasion into manipulation, harming consumers and negatively affecting fair competition. And when you cross that line, you need to know that the law in this country is coming for you. The second focus of the bill is banning drip pricing practices. Businesses will have to present the total cost upfront, including any unavoidable fees or charges. Now, Tim, in my local community, learnt that the hard way, and others shouldn't have to. By ensuring that any additional costs are clearly and transparently disclosed upfront, consumers will have a better understanding of the real price, allowing them to make more informed decisions from the outset. Because after all, transparent pricing is essential for markets to function effectively. When costs are hidden or revealed incrementally, genuine competition is weakened. And we know how important competition is for markets and for our economy, because competition is a core driver of quality. Competition is a core driver of getting prices down. These reforms help restore a level playing field, ensuring that businesses that are open and transparent are not placed at a disadvantage compared to those that conceal true price until that very final step. Finally, the bill will add transparency to subscription purchases by requiring businesses to clearly provide essential information before customers sign up, not after, not in the tiny print, not locked away behind 7 screens, before they make the purchase. And customers will also receive reminders and notifications at key points during that subscription. This means that you'll be notified when your free trial is ending or when your renewal is coming up, giving you the time to decide if you want to continue or if you want to opt out. And in the case of opting out, businesses will have to ensure that it's easier to cancel a subscription. That means it will be easier to find cancellation information on the website or the app. It will be simpler to complete, and it will only require steps that are reasonably necessary for the consumer. These obligations will apply both to consumer subscriptions and to standard form subscription contracts used by small businesses. At its core, Deputy Speaker, the reform recognises one very basic principle. If a contract can be entered into quickly, it should be just as easy to exit it. That is what makes sense, that is what is fair, and that is the obligation that businesses should have to their customers and to consumers more broadly. The amendments will come into effect from the 1st of July 2027, giving businesses sufficient time to understand their new responsibilities and to update their practices. And to support this transition, the Australian Competition and Consumer Commission will provide detailed guidance on how the new laws will operate in practice. In addition, the first 2 years of the subscription provisions will be reviewed to ensure the reforms are protecting consumers in the intended way. And I mentioned small businesses just now. And while this bill is focused on strengthening consumer safeguards, unfair trading practices are not limited to individuals. Small businesses, franchises often face similar challenges when dealing with their larger counterparts, and they deserve fairness as well. The government has started consultation on extending these unfair trading practice protections to small businesses, including those operating with franchising arrangements. The government will also work closely with the Assistant Treasurer and the Australian Securities and Investment Commission to explore potential alignment within the financial services sector. And Deputy Speaker, I'm lucky enough to have my office in the heart of the Brisbane seat of Moreton in a place called Sunnybank. And if you took a rock and you threw it as far as you could and you drew a circle around that, you'd find so many of these small businesses vulnerable to big players. And some of them are in hospitality, some in retail, some in manufacturing, all sorts of different sectors. But just like consumers, they deserve protections when it comes to the changing technological landscape. Deputy Speaker, this bill is part of the Albanese Labor government's drive to support consumers, to increase transparency in the marketplace and to boost competition. And it's all part of this government's #1 priority area, supporting Australians with the cost of living. And stronger competition plays a critical role in this and helps to deliver better outcomes for households. Labor has already seen some of the most significant overhaul of Australia's merger laws in 50 years, ensuring major mergers are properly assessed and anti-competitive acquisitions do not proceed without scrutiny. We've provided an additional $30 million in funding for the Australian Competition and Consumer Commission, strengthening its ability to take action on misleading pricing practices, particularly in sectors such as supermarkets. And further reforms are improving fairness and accountability across the market. The government has outlawed unfair contract terms, with regulators now empowered to seek penalties for breaches. And work is also underway to strengthen the unit pricing code. These amendments have a myriad of benefits for consumers, especially at a time when cost of living is at its toughest.
The question is that the amendment be agreed to. The member for Malouf.
Thank you, Deputy Speaker. Small businesses are struggling under Labor's homegrown inflation crisis. Their energy crisis, where $275 in energy savings never materialised. And now add to that the fuel supply crisis, which isn't just hitting direct fuel purchases, but also small businesses and farmers who struggle with a knock-on effect on fuel as part of their business inputs. We are also seeing eye-watering increases in the cost of trade goods like PVC pipe, which is up 35% in the last month alone. Even copper, up 7% in the last month, and up 37% over the last year. We have record insolvencies in small business, 40,000 on Labor's watch since taking office, and 15,000 in the last 12 months alone. About 27% of insolvencies are in the construction sector, the largest single sector for insolvencies. Little wonder we are struggling to build more homes. So in this witch's brew of Labor's homegrown crises for small business, what is the Albanese government's solution? You guessed it, more red tape in more consumer laws. And let's be upfront about what this will cost small business. Treasury estimates the bill will impose $123.2 million a year on regulatory costs. The general prohibition measure, I will talk about in a moment, that measure alone accounts for $93.82 million a year in extra compliant costs. More than 1.5 million small businesses are expected to be affected by the general prohibition alone. This bill creates a broad new general prohibition I referred to earlier, $93 million extra cost on small business, Treasury estimates, from this single provision on unfair trading. So what is it? Proposed section 28B, which provides that, and I quote, a person must not in trade or commerce engage in conduct in connection with the supply or possible supply of goods or services to a consumer that, and I emphasise, manipulates the consumer or unreasonably distorts the environment in which the consumer makes or is likely to make a decision, and causes or is likely to cause detriment, whether financial or otherwise, to the consumer. On face value, Deputy Speaker, this government's salesman-in-chief, Treasurer Jim Chalmers, and gaslighter-in-chief, the Prime Minister, would fail that test alone. Manipulating Australians, tick. Unreasonably distorting the environment in which they make decisions, tick. causing detriment, financial or otherwise. Tick. But it gets worse. Supposedly, according to the explanatory memorandum, detriment could include wasted time, frustration, or diminished consumer choice. Does Labor waste our time? Do they cause frustration? Have they diminished consumer choice? This Labor government is imposing on small business thresholds on manipulation, distortion, and adverse impacts that they themselves cannot uphold. This Labor government can go out into the marketplace 97 times saying you will get a $275 energy bill discount and not deliver. And that's okay, apparently. This is a Prime Minister who says nobody worse off, nobody held back. Yet last night's budget picked winners, and some Australians will be worse off, particularly those in the regions and those with savings or older Australians. How would the nobody worse off, nobody held back slogan stand up on the unfair trade practices test? This is a government that cannot practice what it preaches. Courts have held that detriment can include feelings of distress or embarrassment. So a business acting in a way that in the eye of the beholder, the consumer, causes them distress or embarrassment could breach these laws. Seriously? So if your spicy McChicken burger is a little spicier than you expected, is that a detriment? Well, not for some, but really? This will be a lawyer's picnic. It will play through the courts for decades to come and create great uncertainty for business and consumers alike. A clear winner of the uncertainty this general provision creates will be the biggest businesses that can afford the biggest legal and compliance teams or advice from big law firms. I get the Treasury would want a broadly drafted law, but forgive me for not accepting the Labor government position to just trust them, to apply a broadly drafted law narrowly and responsibly. A question a Senate inquiry might ask stakeholders is whether they specifically wanted a broad general prohibition, as this government has put forward. Consumer stakeholders may have wanted action taken, but did they want a government sledgehammer to smash small businesses with? Make no mistake, small business will suffer under this bill. Small business owners who, at last check, 75% of them were taking home less than the average wage. That's $1,000 a week, $52,000 a year, Deputy Speaker. That's according to the Australian Small Business and Family Enterprise Ombudsman in 2023. At that time, incidentally, 43% of small businesses were failing to make a profit. Now, these same small business owners will lose more sleep at night wondering if they will be taken to the ACCC or to court for causing an emotional detriment to their customers. More small businesses will fold, and big business will muscle in, and maybe that's Labor's agenda, collapse small business, and the big boys will move in. Well, that's how it plays out usually in the cities, franchises and the like. But in regional Australia, what happens is the small business closes, landlords can't rent out the commercial premises, and the town becomes a ghost town. That's the real impact of adding yet another straw of regulation during terrible business conditions. Small business owners will throw up their hands and simply give up. We can't afford to lose more small businesses in regional Australia. Huge numbers, over half in one recent survey, were already considering closing their doors. The big businesses that can afford to pay for the big law firms to advise them on this new law, will they wear it? I don't think so. Red tape costs are passed down to customers. In an attempt to protect consumers, compliant costs will be fed down and increase prices for consumers during Labor's homegrown cost of living crisis. Will small businesses be able to use this general prohibition in their dealings with larger businesses, as the Australian Small Business and Family Enterprise Ombudsman called for in the consultation phase back in December 2024? I am just trying to get a sense of how wide and hard-hitting this general prohibition actually will be. Another piece from the Labor playbook here is the very thin veneer of public consultation on this draft of a bill. The exposure draft of this bill only went out for consultation for 2 weeks. 2 weeks, Deputy Speaker. That's why, in the Senate, this bill should go to the Senate Economics Legislation Committee. A Senate inquiry should test whether the general prohibition is too broad, whether the definition of detriment is too wide, and whether small businesses should be exempted or given more time. It should give stakeholders more than 2 weeks to make their views on this law known. Nobody has a problem with protecting consumers, but the pathway there isn't a lawyer's picnic, unless, like Labor, you have some business mates you want to look after by obliterating small business. Where are the exemptions or delayed phase-ins for small businesses? This is a bill that needs a lot more work and a lot of scrutiny in the Senate, and I commend the Shadow Minister, the member for Page, and the Coalition Ministry team for the important work they have done on holding this government accountable for a badly drafted law that imposes crippling costs on businesses, particularly small business, when they can least afford it.
The question is that the amendment be agreed to. The member for Bennelong.
Thank you, Deputy Speaker. I support this bill, this Competition and Consumer Amendment Unfair Trading Practices Bill of 2026, because it's an important piece of legislation to make transacting out there in the real world better for consumers and fairer, because we have this simple unwritten rule here in Australia that underpins our entire society, and that's the fair go. And it's a concept that says if you work hard, you get ahead, and if you spend your hard-earned money, you get what you paid for. And we know that's under pressure right now, Deputy Speaker, and it's important for every government to make sure they take steps to enshrine that fair go into everything that we do, because no matter what you're buying, whether it be a coffee, petrol at a Bowser, or electricity from an EV charger, we'll need to update that saying now, I think, Deputy Speaker. If it's a room in a hotel, you deserve to be treated with basic honesty. But for too long, there's been a great gaping hole in our laws, a gap that's allowed some businesses to exploit, manipulate and trap Australians when they transact in basic everyday transaction. Today, this legislation seeks to plug that hole. Our laws right now are very good at catching a bold-faced lie, right? So if a business says you're buying a table and you buy it online and you get shipped a photo of a table, that's misleading and deceptive conduct, and businesses will rightly pull that up. But what this bill does is tackle two big problems that currently exist in our competition and consumer laws. It tackles two big problems of subscription traps and drip pricing, and I'll go into those a little bit later. And these things happen to exist because of deliberate and manipulative practices of some of these online businesses in particular. The subtle user interface and user experience design that's meant to mislead customers into paying more for an item than it's initially advertised for. The overly complicated menus when trying to unsubscribe from a subscription service, or even the discrepancy in how easy it is to sign up to a service versus how hard it is to unsubscribe from that same service. This is something that's unfair and something that we believe needs to be addressed with good, targeted regulation. We need to move from this whack-a-mole approach where we're fixing things case by case. We need to prevent this from occurring in the first place. And that's what this bill does, Deputy Speaker. It tells businesses in no uncertain terms that if your profit margins rely on trickery, if your revenue relies on nuisance, then your business model will no longer stack up. The reform sets a clear and consistent standard of fair conduct across all sectors, improving consumer confidence and protections, whilst also encouraging healthy competition. And Deputy Speaker, we've all been there. We've subscribed to that 7-day free trial, which is meant to be free, but they still ask you for your credit card details, even though it's meant to be free. So you've got to put them in. Then life happens. You forget. You're dealing with emergency. You know, your kids need help with their schoolwork, or you have to drive them around town to take them to sport. And then suddenly, money's taken from your account. Then comes the real nightmare, you know, going through that same process to try and cancel, which is a lot harder than you think. Signing up is easy, Deputy Speaker. One click here, one click there. You know, Apple Pay, your credit card details go straight through, even though it's a free trial. But trying to cancel, that's an entirely different story. Sometimes you try calling, but it's an international number that's only open in small hours. You try to cancel online, and then you have to navigate through a maze of menus and screens with different variations of "Are you sure?" And then they try and upsell you staying for longer. This bill says to everyone, including small businesses, enough. We deserve to be treated fairly here, and if it takes seconds to enter a subscription, it shouldn't take a diary appointment and an hour to cancel. Australians deserve transparency. For cost, duration and renewal, they all must be upfront and prominent. We deserve reminders. We live in a very technologically advanced world. It's not hard for a company to send a free trial is ending prompt, or just not to grab credit card details in the first place. The good news is there are some businesses doing great work here. They're already doing this. What this bill seeks to do is bring everyone else up to that standard that Australians expect, that fair go that I mentioned at the start of my speech, Deputy Speaker. This bill also outlaws drip pricing. There's nothing more frustrating than booking a hotel room or a concert ticket or a movie ticket for $100 advertised price, only to find that it's $130 by the time you reach the checkout. And where do these extra costs come from? Booking fees, admin fees, service fees, fees on fees. This is what drip pricing is, Deputy Speaker, where mandatory transaction or service fees are excluded from the price Australians see, and they only become evident right at the end of the purchase process, when you're already hooked in. When prices aren't up front, competition fails. The businesses that are doing the right thing and showing the all-in price look more expensive than the ones hiding the fees and hiding those extra costs till later in the checkout process. This bill will mandate that all mandatory fees must be shown alongside the base price from the very beginning. What you see should be what you pay. No surprise hidden fees, no admin fees, no gotchas right at the final click. This bill is clear. This does not stop advertising for small business. It doesn't stop legitimate persuasion or upselling. It stops manipulation and deception. And for a long time, some big corporations viewed Australian consumer law fines as just the cost of doing business, a small tax on their path to more profits each and every year. Penalties matter, so we need to incentivise these dodgy practices from engaging in this behaviour fully, and not of them to think it's just a cost of business. So within this bill, maximum penalties under the Competition and Consumer Act will increase as well, from $10 million to $100 million. So they ensure that businesses of all sizes face meaningful consequences for unfair and deceptive conduct. This bill sends a message, Deputy Speaker. If you choose to manipulate Australians, if you choose to trap them in subscriptions they don't want, you'll face tougher penalties that'll hit the business's bottom line. Some of you may know, Deputy Speaker, that I used to run a small business. And from that, I know that these unfair practices don't just hurt individuals. They hurt small business owners, particularly franchises, who are often hit with massive fees as part of their franchise. And it's like a David and Goliath. I'm pleased to announce I'm pleased to say that the government will be consulting this month on extending unfair trading protections to small businesses as well. A level playing field is what we're after here. That will help local mum and dad shops compete with global giants, because that's what they deserve, a fair go. In Bennelong, as it is across the country, Deputy Speaker, people are feeling the pinch of cost of living. This bill is one piece of a much larger puzzle to protect consumers from unfair business practices and dodgy fees. And it's part of a lot of reforms we've done since coming to government. We've done merger reform, Deputy Speaker, the biggest overhaul in 50 years to stop anti-competitive takeovers. We've had a supermarket price gouging crackdown, increasing ACCC funding by $30 million to target price gouging. We've attacked shrinkflation by strengthening the unit pricing code so you know if you're getting less for more. And we've made the food and grocery code mandatory to protect our farmers from the big squeeze by the big supermarket duopoly. Every dollar saved from a zombie subscription made outlawed by this bill, and every hidden fee that we outlaw as well, is a dollar that stays in a family's budget to save or to spend on their loved ones, to spend on themselves or to invest in their future. These changes have been carefully considered, they're pragmatic and they're methodical. We want to get this right, Deputy Speaker, because progressive reform like this is hard to come by. The digital economy has fast outpaced our laws, and this bill is the government's signal to say we're catching up. These changes, if this bill is passed, due to commence on the 1st of July 2027, giving businesses the time to adjust their systems, their coding, rewrite their websites. This bill seeks to protect Australians at the checkout. It rewards honest businesses and puts power back in the hands of Australian people, restoring that fair go at the supermarket and at the checkout. It ensures that Australians don't fall into subscription traps and get charged random amounts just before they forgot to cancel that subscription at the end of the 7-day trial. And it ensures that when an Australian clicks buy, they don't get landed with an extra $10, $20 in additional fees. It's time to end these traps. It's time to end these tricks. I commend the bill to the House.
The question is that the amendment be agreed to. The member for Whitlam.
Thank you, Speaker. Last month, I joined the Assistant Minister for Productivity, Competition, Charities and Treasury, Andrew Lee, in the Mural Hall, where he announced that the Albanese Labor government would introduce new laws to ban unfair trading practices. I wanted to attend that media conference and to speak on this bill today because I know these practices can cause frustration and even harm to consumers across the country, including in my electorate of Whitlam. Australians are fortunate to have many options when they decide to make purchases or subscribe to services. They can do this in person, in a shop, or online through their laptop. Most businesses do the right thing. However, too many use practices that can pressure, trick, confuse, or trap consumers. Australians increasingly make purchases or sign up for subscriptions online. And while online transactions can make consumers' lives easier, there are also serious downsides. Consumers may be pressured into purchasing because a countdown timer warns them that only a few of their chosen items are left in stock, when actually there are still plenty available. They find that what looks like a bargain, when they got to the checkout, they discover a fee or a charge that has been added to their purchase at the last minute, and it's no longer of such good value. Or they find that although they were able to subscribe to a service online, they are unable to unsubscribe without making a phone call to a person who is then very difficult to connect with. Many aspects of an online purchase may seem benign, but this is not always the case. Smart businesses understand the significance of every button, prompt, colour, timer, and default setting. And each of these is adjustable, and every click is measurable. The online world is optimised for engagement, retention and revenue. Speaker, more than half of reported consumer problems now occur in relation to online purchases. 1 in 10 people say that an online provider has manipulated their choices, while more than a quarter encountered unexpected charges added late in the transaction. And that is why this bill is needed. It amends the Competition and Consumer Act to reflect the realities of how Australians buy, compare and subscribe in today's world. It responds to concerns that certain harmful business practices, particularly in digital and subscription-based markets, may not be adequately addressed by Australia's existing consumer law prohibitions on misleading or deceptive conduct, unconscionable conduct and unfair contract terms. And it explicitly targets conduct that manipulates consumers or distorts the conditions under which transactional decisions are made, including through what is known as dark patterns. Dark patterns is a term used to describe design techniques that are crafted to influence behaviour in ways that benefit businesses at the expense of consumer understanding. These techniques exploit well-known cognitive biases, including loss aversion, optimism bias, inattention and fatigue. Speaker, the Competition and Consumer Amendment Unfair Trading Practices Bill delivers 3 important reforms. It introduces an economy-wide prohibition on unfair trading practices, it stops drip pricing, and it ends subscription traps. Its key features include ensuring that businesses disclose key terms upfront, give reminders before free trials end, make cancellation simple, and show all mandatory fees clearly before consumers buy. The first major reform in this bill is the introduction of an economy-wide prohibition on unfair trading practices. Remarkably, this prohibition does not currently exist in Australia. The bill stipulates that businesses must not manipulate consumers or unreasonably distort the environment in which consumers make or are likely to make decisions in circumstances that cause or are likely to cause detriment. This principles-based test captures conduct that does not neatly fall within the existing prohibitions on misleading conduct or unconscionability, but which nevertheless exploits behavioural biases, overwhelms consumers with complexity, or structures choices in a way that leads people towards decisions they would not otherwise make. The bill helpfully includes a non-exhaustive list of examples of practices that may contravene this new prohibition. These include impeding a consumer's ability to engage legal rights or seek legal remedies, failing to disclose material information to the consumer, disclosing material information to the consumer in a way that is complex, ineffective, unclear, unintelligible, ambiguous, untimely or overwhelming, and creating an environment, including by using design elements in digital interfaces that places unreasonable pressure on a consumer or that obstructs the consumer from making or fulfilling their decision. These examples are provided to help businesses understand where the line is drawn without restricting ordinary, legitimate commercial behaviour. It's important to note that this general prohibition is not about stopping businesses from promoting their products, nor is it about stopping advertising. It's about dealing with conduct that crosses the line from persuasion into manipulation, conduct that harms consumers and undermines fair competition. Speaker, another major focus of this bill is drip pricing. This term describes the practice of displaying a low upfront price and then, after the consumer has progressed through several steps of the online process and often not until they've reached the final checkout stage, mandatory transaction or service charges are suddenly added. By that stage, many consumers have invested a significant amount of time comparing options and they are mentally committed to the purchase. When the final price appears, they are reluctant to walk away from the transaction. Drip pricing is intensely frustrating. The price originally seemed reasonable, even a great deal, but then new fees appear at the very last step. This technique is used by businesses because it taps into well-understood behavioural tendencies. People anchor on the first price they see, and once they've invested effort in reaching the final stage of the transaction, they are less inclined to abandon it, even when new information would have changed their initial decision. Speaker, this bill requires businesses to disclose mandatory transaction-based charges at the same time that they display the base price. There should be no artificially low headline prices and no last-minute surprises. By ensuring any per transaction fees and charges are clearly displayed, the new laws will make consumers aware of the real price of a product or service, enabling them to make more informed purchasing decisions. It's important to note that the bill does not prohibit transaction fees, it just prohibits hiding them. It will also ensure that businesses that do the right thing are not disadvantaged by competitors that conceal the true cost until the final step. The third major area of reform in this bill addresses another great source of consumer frustration, subscription traps. Subscription services have become an increasingly common way for Australians to pay for products and services, and this model often works well for both businesses and consumers. However, problems arise when the subscription is structured so that joining is swift and effortless, while leaving involves added frictions or becomes confusing or is emotionally loaded. That imbalance is what turns an ordinary subscription into a subscription trap. Too often, subscriptions are designed to capitalise on the assumption that consumers will forget to cancel free trials, will not notice renewals, or will struggle to find the cancellation pathway. The Consumer Policy Research Centre found that 3 in 4 Australians have had a negative experience when trying to cancel a subscription. 1 in 3 felt pressured to continue their subscription, and 1 in 10 gave up trying to cancel and kept paying for a service they no longer wanted or needed. Some even resorted to cancelling their credit card or a bank account just to get rid of the recurring subscriptions. The estimated detriment from spending on unwanted subscriptions by Australian consumers is an extraordinary $971 million per year. Speaker, this bill directly addresses these problems with subscriptions. It stipulates that businesses must clearly disclose that a consumer is entering a subscription, what it costs, how long it runs, how it renews, and how it can be ended. This information must be provided prominently and in a way that is easy to understand. The bill also establishes a framework for reminder notices, ensuring that consumers receive timely, sensible prompts when a trial period is ending or a renewal is approaching. And cancellation must be straightforward. It must be easy to find, and it must require only the steps that are reasonably necessary. I note the amendments in this bill will not commence until the 1st of July 2027, which is just over a year away. This will allow businesses time to understand their new obligations and adjust their practices accordingly. The Australian Competition and Consumer Commission will develop guidance materials on the operation of the new laws, and the government will undertake a review of the first 2 years of operation of the subscription provisions to ensure the protections are working as intended. Speaker, the Albanese Labor government is committed to ensuring strong protections for Australian consumers, and this bill forms a part of a wider agenda to strengthen competition, improve transparency, and support consumers across the economy. Strong consumer laws ensure Australians are treated fairly and protected against misleading conduct, unsafe products, and unfair practices. Stronger competition is also essential to easing cost of living pressures. The Albanese government has legislated the most significant overhaul of Australia's merger laws in 50 years, ensuring that large mergers are properly assessed before proceeding and that anti-competitive acquisitions do not escape scrutiny. We've increased funding for the Australian Competition and Consumer Commission by more than $30 million, enabling stronger action against misleading pricing tactics, particularly in supermarkets and other consumer-facing markets. We have outlawed unfair contract terms and for the first time gave the Australian Competition and Consumer Commission and the Australian Securities and Investments Commission the power to seek penalties against companies that breach these laws. We are strengthening the unit pricing code and cracking down on shrinkflation. Australians will be able to see clearly when the contents of a product have been reduced, even if the sticker price remains the same. We've made the Food and Grocery Code of Conduct mandatory, backed by strong penalties that prevent supermarkets from using their market power to unfairly squeeze suppliers and farmers. Penalties matter, and that is why we have increased the maximum penalties under the Competition and Consumer Act from $10 million to $100 million. Stronger sanctions ensure that businesses of all sizes face meaningful consequences for conduct that undermines fairness, and that breaches of consumer law cannot be dismissed as a mere cost of doing business. Across the labour market, Labor's reforms to non-compete clauses and other restrictive practices will help improve job mobility and productivity. And the right to repair is being extended to agricultural machinery, ensuring that farmers have a genuine choice in how they service their equipment. Through a revitalised national competition policy, supported by a $900 million national productivity fund, the federal government is working with states and territories to remove planning and zoning barriers that make it difficult for new entrants to compete. Together, the Albanese government's range of reforms is strengthening competition, enhancing productivity and contributing to a fairer marketplace. It's important to note that unfair trading practices don't only affect individuals. Small businesses and franchisees often face the same vulnerabilities when dealing with larger suppliers. That is why this government is consulting on extending unfair trading protections to small businesses, including those in franchising. In conclusion, Speaker, I support this bill because banning unfair trading practices, cracking down on drip pricing and cleaning up subscriptions will strengthen protections for Australian consumers and support better functioning markets. These reforms will help make Australia a market where good businesses thrive by doing the right thing. They will also restore confidence that online markets can work on straightforward terms where prices are what they seem and leaving a service is as simple as joining it. They will protect consumers not only from the outright deception, but also from the kinds of subtle, cumulative influences that can undermine genuine choice. For all these reasons, I commend this bill to the House.
Thank you. The question is that the amendment be agreed to, and I call the member for Sturt.
Thank you, Deputy Speaker. I rise today to speak in support of the Competition and Consumer Amendment Unfair Trading Practices Bill 2026. This bill is designed to complement existing Australian consumer law legislation, increase consumer trust in the marketplace and encourage fairer trading amongst businesses. The bill operates to amend the Competition and Consumer Act, including the Australian Consumer Law, which is set out in Schedule 2 to that Act, with a lens on improving protections against current unfair trading practices and emerging unfair trading practices. It does so by introducing a general prohibition on unfair trading practices towards consumers, strengthening protections against drip pricing by requiring transparency of transaction-based charges, and introducing protections against subscription practices that are detrimental to consumers and small business. So, what do unfair trading practices actually look like? They relate to how businesses promote, sell and deliver products and services, how contract terms operate and how businesses take payments from consumers. It's things like accepting payments for products and services that a business does not intend to supply, or like using coercion or undue harassment against consumers, or exploiting known facts, circumstances or statements made by a consumer to coerce them into buying something or signing up to something or to enforce a debt. It's also unfair contract terms, it's making false or misleading statements about a product or service, it's a pyramid scheme, It's a referral scheme which does not result in discounts or other benefits to consumers despite a promise to do so, and it's unconscionable conduct, which is hard to define but which may involve behaviour so harsh that it goes against good conscience. Under consumer law, businesses are prohibited from acting unconscionably towards consumers or other businesses. And this is something that is more than just unfairness. It is something that makes the circumstances especially harsh. For example, if a business knowingly targets consumers who are experiencing a vulnerability, like people who are going through something difficult, like a death of a loved one, domestic or family violence, homelessness or the impact of a natural disaster, or who are sick and have disabilities, who are too young to make informed decisions, who have difficulties reading and writing, or live in remote areas, do not speak English as their first language, or are uncomfortable with using what is now considered very basic technology, such as the internet or smartphones, and this includes people who clearly have difficulties understanding and using basic financial skills. By and large, Australian businesses would never dream of engaging in unconscionable conduct or any of the other unfair trading practices I have described. Australian private enterprise is the engine room of our economy, providing investment capital, innovation, secure employment and opportunities for thousands of people, and most importantly, providing the products, goods and services that we all need. We can't afford to paralyse business. Private enterprise must be provided with the right settings to grow, to increase revenue and to make money. If they can't do that consistently, then they can't supply products and services. The private sector in this country is an indispensable force for sustainable development because it operates to spark the innovation we need, to improve productivity and improve the economic efficiency we need. And as I said, this is worth repeating. It creates the jobs and growth needed to end extreme poverty and boost shared prosperity. All of that being said, business must operate in a way that is fair to the consumer. And I'm confident there'll be very few businesses that would argue against that proposition. I suggested earlier that most Australian businesses would never dream of participating in unfair trading practices like unconscionable conduct or misleading and deceptive conduct. But there is some conduct that falls far, far short of these thresholds, but that may take place, sometimes inadvertently, that is unfair to the consumer. Just as we need private enterprise to prosper, to produce the products and services we need, we also need a fair marketplace that encourages consumer participation. If consumers are not getting a fair go or are being taken advantage of, then they either won't participate in certain marketplaces or they will make choices that they otherwise wouldn't if the trading and market conditions were fair. This is particularly important given the rapid and significant shift to the online marketplace, where now, almost on autopilot, people enter their credit card details into online platforms to purchase goods or sign up to services because they are there and it is easy. The ease of access to the consumer marketplace that the online world provides and the online world's prolific reach means it's more important than ever to act to ensure fairness for the consumer. So this bill does three things to make the marketplace fairer to the average consumer. Firstly, the general prohibition on unfair trading practices. The bill does this by introducing a new Part 2.4 with new subsection 28B1, prohibiting a person from engaging in unfair trading practices, a defined term, in trade or commerce. In practical terms, this provides that a person engages in unfair trading practices if and only if, in connection with the supply of goods or services to a consumer or an offer to supply goods or services to a consumer, the person engages in conduct that does or is likely to do either both of the following. Firstly, manipulate the consumer, or secondly, unreasonably distort the environment in which the consumer makes or is likely to make a decision, and that this is causing or likely to cause detriment, whether financial or otherwise, to the consumer. In this context, a supply or offer to supply may occur in an online setting, such as on an app or a website, or an offline setting, which means your traditional in-store retail setting. The prohibition is intended to be flexible and capable of adapting with evolving commercial practices and rapid technological advances. And offers of supply are intended to include the promotion, advertising or marketing of a relevant good and service. A non-exhaustive list of unfair trading practices in the context of this general prohibition is included in the bill. So this includes frustrating a consumer's ability to exercise legal rights or seek legal remedies, failing to disclose material information to the consumer, disclosing material information to the consumer but in a way that is complex, ineffective, unclear, unintelligible, ambiguous, untimely or overwhelming, and creating an environment including by using design elements in online platforms that places unreasonable pressure on a consumer or that obstructs the consumer from making or fulfilling their decision. This list is designed to assist businesses to understand the parameters of what may qualify as a contravention. The list can't be absolutely exhaustive because of the unique nature of businesses, the uniqueness of consumers, and the incredible breadth of product and services available in the marketplace, particularly online. So each matter will necessarily need to be considered on its own facts, but the non-exhaustive examples in the bill are intended to help businesses understand where the line in the sand is without impeding legitimate commercial action like promotion and advertising, which every business is entitled to do. The second feature of this bill relates to drip pricing, which is a practice where a consumer buys a service at what appears to be a fair and reasonable price and then experiences price creep, where new fees, previously unexpected, start to come in. So we've all bought a ticket to a concert, to a show, to live sport, to a movie, and then experienced an inexplicable and proportionally large booking fee being tacked on at the very end of the transaction. You still want the ticket, so you pay the booking fee. The proposal in this bill is simply that businesses disclose these mandatory transaction-based charges, like a booking fee, at the same time they display the base price. The consumer can then decide earlier in the process whether they wish to proceed with the transaction, knowing they will be paying a booking fee and what that amount of the booking fee is. So this reform does not prohibit business from charging a booking fee, recognising that there are legitimate reasons to do so. All it does is ask businesses to be upfront about these costs. This is entirely reasonable and allows consumers to make informed decisions early on in the transaction. Thirdly, this bill addresses subscription traps. Subscriptions to streaming services, newspapers, gyms, style guides, blogs, software services are often designed on the assumption the consumer will forget to cancel free trials, will simply shrug off renewals, or will find it so difficult to do so, so difficult to find out how to cancel, that they just roll on. Now, Deputy Speaker, I recently had an experience like this. I consider myself to be a reasonably unfashionable person, and having recently had a birthday, taking me firmly into mid-40s territory, I decided to sign up to a style app to promise to help me find the right colours, the right styles for my body shape, which is inverted triangle for those playing along, and transform me into a modern, youthful style fashionista. Fantastic. But, predictably, the app was not a revelation, presenting me with suggestions like jeans and white t-shirts, So it turns out I was actually stylish. There was no further room for improvement. So I rolled my eyes and chastised myself for actually signing up to this thing, and then proceeded to try and cancel before I got trapped in the endless renewal cycle. Cancelling was quite the exercise. I just wanted out, but I kept being presented with offers, promises, alternatives on a web page that was clearly designed to make it hard for me to find and activate the cancel button. I had to trawl through the app, I had to go to the settings on my phone, I had to get a couple of codes, and then I had to click on a link in an email that was eventually sent to me. So I'm all for businesses promoting their products, but why couldn't I just press a button and cancel? It took me longer to cancel than it did to be told that I look good in white t-shirts. This bill addresses these issues by requiring businesses to clearly disclose that a customer is entering a subscription, what it costs, how long it runs, how it renews, and how it can be cancelled, with cancellations required to be straightforward, easy to find, and comprised of only reasonably necessary steps. Reminder notices reminding consumers that a renewal is approaching or that a payment is coming up will also be required. Deputy Speaker, this bill is a principled, proportionate and timely response to real harms and frustrations being experienced by the Australian consumer. It does not paralyse business. To the contrary, it recognises the right of a business to grow, to innovate, to make money and increase productivity, but within a marketplace that is fair to the Australian consumer in what is a rapidly changing way we do business. And I commend the bill to the House.
Thank you. The question is that the amendment be agreed to. I call the member for Holt.
Thank you, Deputy Speaker. I rise today in support of the Competition and Consumer Amendment Unfair Trading Practices Bill. This legislation is an important milestone in our nation's journey towards a fairer and a more transparent market. And at its core, this is a bill about the basic integrity of the daily interactions between Australians and the businesses they rely on. It is about the fundamental principle of fairness in the everyday decisions Australians make. When they buy a ticket online, compare prices, start a free trial, sign up to a service, or try to cancel something they no longer use. In all of those moments, Australians should be able to rely on a basic standard of honesty and clarity. They should not have to navigate a maze of fine print. They should not need to reach the final step of a digital checkout only to be hit with extra compulsory fees that they were never disclosed at the start. And they should not have to battle a deliberately confusing website just to stop paying for a service they no longer want. Deputy Speaker, these experiences are familiar to too many Australians. A person sees one price advertised, but by the time they reach the checkout, the final amount is higher. Someone signs up to a free trial and later realises they have been rolled into an ongoing payment. Someone tries to cancel a subscription, but instead of a clear and simple process, they are sent through page after page of hurdles, offers, and endless questions. For many people, this is not just frustrating. It costs money, it wastes precious time, and it fundamentally damages trust. In my electorate of Holt, families are already watching every single dollar. They are comparing grocery prices, managing rent or mortgage payments, checking bills and doing everything possible to make the household budget stretch until the next payday. When budgets are tight, a few dollars in a hidden fee, another monthly charge for a service they try to cancel, or an automatic renewal, they were not properly reminded of it isn't just an annoyance, it's a financial hit. And those costs add up for students, for families, for pensioners, and for our small businesses. Deputy Speaker, this is why this bill is so necessary. The Albanese Labor government is amending the Australian consumer law to introduce an economic-wide prohibition of unfair trading practices. In simple terms, businesses will not be allowed to manipulate customers or unreasonably distort the environment in which they make decisions. We are not saying businesses shouldn't be successful. On the contrary, we want Australian businesses to thrive. We want them to advertise freely, promote their products, and compete fiercely. But that competition must be based on the things that actually matter: price, quality, service, and value. Not on who's the best at tricking a customer, who can hide their fees the longest, or who can make their cancellation button the hardest to find. This bill draws a firm line between clever marketing and predatory manipulation. The Australian consumer law has served us well, but the world has changed. The way we shop, compare, and subscribe today is vastly different from 20 years ago. This bill modernises our legal framework so it can respond to the harmful conduct of today and remain flexible enough to deal with the emerging tactics of tomorrow. Let's look specifically at the subscription economy. Deputy Speaker, subscriptions are now a staple of modern life. We subscribe to news, music, fitness apps, meal kits, and software. When these models are clear and fair, they provide great convenience. Many businesses already do the right thing. They send reminders, they make the price obvious, and they make it easy to leave. Those businesses have nothing to fear from this bill. In fact, they will benefit from a marketplace where their honest practices aren't being undercut by dishonest competitors. However, the Consumer Policy Research Centre has provided us with some sobering statistics. 3 in 4 Australians with subscriptions have had a negative cancellation experience. 1 in 10 has literally given up on trying to cancel a service because it was too difficult continuing to pay for something they don't want. Deputy Speaker, this is not the market working. This is a subscription trap. This bill breaks those traps. It mandates that businesses clearly disclose the total cost, the renewal frequency, and the cancellation process right at the start. It also introduced a click-to-cancel expectation. If you can sign up with 1 click, you should be able to leave with equal ease. The bill also addresses the deceptive practice of drip pricing. This occurs when a consumer sees an attractive price at the start of the transaction, but mandatory charges appear later in the process. It might be a service fee, a booking fee, a processing fee, or a transaction fee. The problem is not that a business charges a fee. The problem is when that fee is compulsory but not shown clearly upfront. By the time the consumer sees the real total, they may have already spent time choosing a product, entering details, selecting a seat, or organising the booking. Many people then go ahead because they feel they have already invested the time. This is not a fair way to compare prices. This bill requires mandatory transaction-based charges to be displayed alongside side the base price from the very beginning. This ensures that the price you see in the search results is the price you actually pay. It allows for genuine price comparison, which is the engine of a competitive economy. Deputy Speaker, I want to address those who might claim this is an interventionist or anti-business measure. In reality, this bill is pro-good business. In my community of Holt, I see local cafe owners, family-run trades and small retailers who work incredibly hard to build a reputation. They know that trust is their most valuable asset. They are upfront with their prices. They stand by their service and they work hard for every single customer. Those businesses should not be undercut by companies that rely on tricks, pressure, or confusion. A strong marketplace should be rewarded honesty, value, and service. This is why consumer protection and competition policy go together. When people trust the market, they are more confident to compare, switch, and try new providers. When people feel trapped or misled, they become cautious. They become less likely to switch, less likely to engage, and good businesses miss out. This bill does not stand alone. It is a critical piece of the Albanese Labor government's broader agenda to ease cost of living pressures and make the Australian economy work for people, not the other way around. We already have strengthened penalties for anti-competitive conduct, ensuring that breaking the law is no longer just a cost of doing business. We have acted on unfair contract terms, protecting small businesses and consumers from take it or leave it contracts that are already heavily weighted against them. We have tackled shrinkflation and unit pricing, ensuring that when the packet gets smaller, the consumer knows exactly what they are paying for. And we have made the Food and Grocery Code of Conduct mandatory, ensuring our farmers and suppliers get a fair deal from the major supermarkets. This bill is the next logical step in that journey. Deputy Speaker, the bill also takes a practical approach to implementation. The reforms will commence from 1 July 2027, giving businesses time to understand their obligations and adjust to their practices. The ACCC will provide guidance on how the new laws will operate. The government will review the subscription provisions after the first 2 years to make sure the protections are working as intended. That is the right approach. It gives consumers stronger protection and gives businesses time and certainty. Deputy Speaker, we are also looking into the future. We know that small businesses and franchisees often find themselves on the receiving end of unfair trading practices from larger entities. That is why the government will consult on extending unfair trading protections to small businesses, including those in franchising. We will also consider possible alignment in the financial services sector carefully and properly so the consumers do not fall through the regulatory gaps. Deputy Speaker, this bill reflects a very Australian expectation. Be upfront, be fair, and do not make life harder than it needs to be. Australians are not asking for special treatment. They're asking for the basics. They want prices they can trust. They want subscription terms they can understand. They want the freedom to leave a service when it no longer serves them. And they want to know when a business makes a promise, they will keep it. This bill gives that expectation the force of law. It gives people of Holt and people right across our country back their time, more clarity and better protection for their hard-earned money. It is fair. It is practical and it is absolutely needed. I acknowledge the work of the Assistant Minister for Productivity, Competition, Charities and Treasury, Dr. Andrew Lee, in bringing this bill before the House. This is practical, considerate reform shaped by the evidence and the real experiences of Australian consumers, and I commend this bill to the House.
Thank you very much. And I call the member for Ford.
Thank you, Deputy Speaker. I rise in support of the Competition and Consumer Amendment Unfair Trading Practices Bill 2026. And in doing so, I too commend the work of the Assistant Minister in the lead up to the bill, the preparation of this bill, and also the way that he has handled this bill through the Parliament and through the Labor Party processes as well. I don't think the community really could ask for a better minister, assistant minister at this time than this assistant minister that we have. Somebody who lives and breathes this sort of work, and it's a privilege to be able to serve in this Parliament alongside of him. Also to pay, I think, the due credit to the leader of our economic team and my neighbour, the Treasurer, who is really leading an economic policy focused on the cost of living, and it is very much the competition policy sits within that general approach to tackle the cost of living, and it is that these measures in this bill are about improving competition for our economy, and of course it is. I think that it sits within not only this government's mission, but also the Labor Party's historic mission as well. That we're now, I think, 52 years from the introduction of the Trade Practices Act, introduced by another great reforming government, the Labor government, the Whitlam government, and by another great reforming Attorney General, Lionel Murphy. And it sits just... the Trade Practices Act in 1974, of which this work builds on, sat squarely then in the government's approach to tackling inflation and cost of living, just as ours does today. And in fact, it gave me an opportunity while preparing for this speech to have a look at what Lionel Murphy said at the time. It's interesting that history rhymes, as the saying goes. He said that this bill is especially important because of its relevance to inflation. The purpose of many restrictive practices is to maintain prices at levels higher than would otherwise prevail. This contributes to the inflationary trend. He said consumer protection also assists in the fight against inflation because it is the consumer who has to bear the burden of higher prices and of unfair methods of dealing. And so, as I half quoted there, Mark Twain's quote that history may not repeat, but it certainly rhymes. Just as it is with the Trade Practices Bill in 1974, so it is that we hear mutterings from the opposition that are they supporting this bill? Are they not supporting this bill? I'm not 100% clear on what their position is. That's because I don't think they're 100% clear on what their position is, and so there is a rhyme from history here as well, because Lionel Murphy said in introducing this bill, he said, back in 1973, the year before, regrettably opposition senators refused to debate the bill because there had been insufficient time to consider its provisions. Some things just are hard to get out of your DNA, I think, when you're a political party that ultimately tries to parade itself these days is looking after the battler, but actually has always been the party for the big corporation, has always been the party for big businesses. And it is only the Labor Party that has stood up for small businesses and stood up for consumers and stood up for farmers as well. And I think when you look at the result they got in Farrer, I'm not sure they're drawing the right lessons, but they certainly would do to do a little bit of private introspection, rather than trying to rather than trying to litigate that in public. I think that because in the DNA of those opposite is that they were defending an act in 1974, just as they're equivocating about supporting this one, that Lionel Murphy described as that proved to be one of the most ineffectual pieces of legislation ever passed by that parliament, and even by this parliament, and even in 1974, that would have had some stiff competition. It said, in consumer transactions, unfair practices are widespread. The existing law is still founded on the principle known as caveat emptor, meaning let the buyer beware. And he said that principle may have been appropriate for transactions conducted in village markets, but it has ceased to be appropriate as a general rule. Now the marketing of goods and services is conducted on an organised basis and by trained business executives. And as insightful and prescient as Lionel Murphy was, I don't think even he could have been quite. I don't think even he could have been quite as. He couldn't have been. Deputy Speaker,
No.
I think the is making aspersions on former members that are outrageous, and I would ask that they be withdrawn.
You refuse to withdraw?
Okay.
Will you withdraw? Will you withdraw? Will you withdraw?
Okay. Well, I understand.
The question is, will you withdraw?
Deputy Speaker, I'll continue. I understand there's no standing order to deal with that sort of outrageous personal attack on somebody who is deceased, mind you. But
Excuse me, I'm sorry, Member for Ford, will you just pause there for a moment? I would like to request that when I call the House to order, that is respected by members in this chamber. Thank you very much. You may proceed.
And so I think that as insightful and prescient as Lionel Murphy was, and as somebody that really had at heart such a passion for defending the individual rights that Australians are entitled to, even he couldn't work out when he talked about marketing of goods and services being conducted on an organised basis by trained business executives. Even he couldn't have thought about what those trained business executives are like today, with the way they manipulate not only vulnerable consumers. I mean, at the best of us, we've all struggled to find that greyed out unsubscribe button, or we've all been attracted by the light and the colour. We've all had our hesitation measured. There are an infinite number of permutations and combinations that the latest market shysters are able to use to manipulate our behaviour. That I think in 1974 they could not have conceived of quite what it would be like. And so the work that we are no longer in a village market, we are no longer even in just in a sophisticated street market. We are well and truly in a new world, and this bill goes some of the way to addressing that inequity that exists between consumers and between those that are effectively wielding that power and have that responsibility. Of course, though, it sits within that general approach that this government has taken to fixing many of the problems that we were left with by the previous inaction of the previous government. The Australian Competition and Consumer Commission actually was funded. We kicked in an extra $30 million to enable stronger action against misleading and pricing tactics in the supermarket and other retail sectors. And again, the ACCC cops a fair bit of criticism, perhaps some of it's justified, but a lot of it because it was completely underfunded by the previous government. And the ACCC, I think, has done some amazing things when it comes to protecting consumers, and one of them has to be hitting Optus for six. When Optus copped a $100 million fine for selling expensive and really unwanted plans to people that it didn't even bother to check vulnerable people that it didn't even bother to check whether or not Optus was actually covering them in the regions area that they lived. And so Optus copped a $100 million fine for selling these plans to people with learning disabilities, people that were obviously disabled. One person who had been talked into it in a shop, an obviously disabled and vulnerable person who had been talked into it by the shop staff, and he was too embarrassed to say no at the time. But even when his representative, and he was lucky to have a representative, mind you, but even when his representative went into the store to try and get a refund, that guy was refused, and so the ACCC did some fantastic work on that, getting that $100 million fine, and I think that the government, this government, is the only party which really takes the enforcement actions of the ACCC seriously by funding it. We've also outlawed unfair contract terms. For the first time, we've given the ACCC and ASIC the power to not only to, I guess, help people have those terms voided in contracts, but to take action and have serious penalties imposed for inflicting those sorts of unfair terms. Going back to 1974, it was actually a practice of some people in contracts to have as a term that this contract will not operate under Australian law. That actually needed to be outlawed. But there are plenty of unfair contract terms in there today, things such as the supplier can adjust the terms whenever it likes. How can that possibly be fair? And I'm just reminded of one young woman who had a gym membership. She moved 90 minutes away from the gym. She rang, it was easy for her to sign up and online, but when she tried to unsign online, she was told she couldn't. She rang up, she was told she would need to come in. And so she needed to make a 3-hour round trip in order to have the contract terminated. And it was only because she was persistent and she was knowledgeable to the extent she was able to actually show them the law that the gym backed down. We're strengthening the unit pricing code and cracking down on shrinkflation. Even now, even while the supermarkets know that this is on the government's agenda, they are just outrageously still, they're asking for it, really. Their outrageous behaviour. There was an example there in February where they're selling a packet of bananas, 5 bananas as a unit, but actually when you're right next to the bananas which you bought them by weight, the packet costs twice as much. And Woolworths say it's for the convenience of the consumer because they can just grab it. So for the privilege of being able to take it off, Woolies think they can just charge them twice and get away with it without displaying clearly that they're paying twice as much as they would be if they picked up 5 bananas by themselves. We've made the Food and Grocery Code of Conduct mandatory, backed by strong penalties. And again, the other side talk about representing farmers. I mean, I used to be a station hand. I worked for these people. I know the heart and soul that these people put into their farms. And they're not Gordon Gekko dealing with international companies or huge companies like Woolworths. These people have no bargaining power. And so it is that through this code, which used to be voluntary, it took this government to make it mandatory. We've allowed for things such as people to be anonymous when making their complaints, to encourage whistleblowers to come forward, to try and put some balance, to restore some balance back into this, what is an otherwise thoroughly unequal situation. Across the labour market, this government has introduced reforms to non-compete clauses. Believe it or not, there are employment contracts out there now where a laundromat worker is not able to work in another laundromat in the town, where a young engineer straight out of university has to sign a non-compete clause in order to get the job, to say that he can't work as an engineer in another firm. These are not only things which are unfair on the individual, and ultimately courts generally, from what I understand, strike out those ridiculous terms, but sometimes you have to go to court And sometimes it's possible for the employer to actually put an injunction on you going to somewhere else that you then have to fight that. So even though these terms are basically completely unfair anyway, it puts the onus on the worker to do it. And so it is, I think, that, again, this sits within the history of the Labor Party. From 1974 to now, it has taken Labor governments to try and level the field for consumers, to try and level the field for small businesses, and try to level the field for farmers. And that's why the history of the Labor Party, I think, is going to continue into the future, while the history of the Liberal and National parties is somewhat in doubt.
Thank you. The question is that the amendment be agreed to, and I call the member for Barton.
Thank you, Deputy Speaker. I rise to speak on the Competition and Consumer Amendment Unfair Trading Practices Bill 2026. And at the core of this particular bill, it's about making our payment systems and our marketplaces fairer for everyday Australians. It's about making sure people can buy what they need without being misled, trapped, pressured or ripped off. And in Barton, when I think about trust in the marketplace, Deputy Speaker, I think about our grandparents. We all have stereotypes of our grandparents. Maybe it's Nonna and her insistence of stuffing you with fuller plates of pasta and homemade salami, or Papu, who's insisting for you to go check the lamb on the spit that's been there since 6 in the morning, or maybe it's Nai, who's using tiger balm to treat everything, or maybe it's your amapa, who might actually warn you for eating too much durian because it's a heaty food. But one thing that unites these grandparents, even if they live in different suburbs, speak different languages, or adhere to different religions or cultures, they all insist on paying on cash. Cash is king. Cash is something people understand. It's simple, it's physical, you hand it over in person, you look someone in the eye before you part with your money, and if someone is ripping you off, Nonna knows. More than that, our grandparents often knew the person they were buying from. They shopped on their local high street, where stores were owned and run by the person who sat next to at church, the person who coached your kids' soccer team, or the person who lived across the road. If someone was going to rip you off, chances are you knew about it already. The gossip mill had already armed you well to take on the local grifter. But now I know this might sound a little bit of a nostalgic trip here, but the local marketplace built on closeness and trust is becoming less common. Modern families are not always engaging with their high streets in the same way. Life is busy, shopping online is often quicker, easier and more efficient. And when we move from the local high street to the virtual high street, we lose some of those old protections. We lose the closeness, we lose the personal relationship, we lose the ability to judge a business by the way it treats people in our community. Now, these new virtual high streets are often not grounded in trust or community. Sometimes they are faceless, shady storefronts that just happen to be selling the exact product or service you need. Sometimes they're a huge multinational company whose face is a logo. Either way, it's much harder for an everyday consumer to know who they are dealing with when the whole interaction happens behind a screen. And when you are trying to buy something quickly, when you're rushing between work, school pickup, dinner, everything else, how are you meant to actually know whether the site is trustworthy? Many of these virtual storefronts build their business models around the absence of trust. They use traps, they use algorithms, they design systems to extract as much money from a buyer as possible. They do not care about the quality of service, they do not care about the product, they do not care about the person on the other end of the transaction. It is a profit model. But that's not the whole story, Deputy Speaker, because there are so many small businesses on our local high streets that have built an online presence. And there's so many of them in my electorate of Barton. I think of Self-Raise in Carlton and Bexley North, Greek Cargo in Earlwood, and LA Donuts operating in Beverly Hills. Frida, you're a genius. And I can say that these businesses are not engaging in traps used by nameless, faceless online businesses. They're using online tools to reach more customers, support their staff, and keep their bricks and mortar stores alive. They're still trying to provide the best quality local service they can. They're still part of our neighbourhoods. They still know their customers. They still care about their reputation because their reputation is built right here in our community. And without them, our local jobs and our local character will suffer. It would not be the Barton our grandparents grew up in and would not be the Barton we want to pass on. So yes, this bill is about stronger consumer protections, but it's also something much more bigger. It's about rewarding the good local businesses that do the right thing. It's about standing up to the unfair practices that punish consumers and undercut honest businesses. And it's about keeping alive the neighbourhoods our grandparents built and the neighbourhoods we still want to live in today. One of the central features of this legislation is the creation of a new economy-wide safeguard against unfair business conduct. And at its heart, this reform recognises a very simple principle, that Australians should be able to make purchasing decisions freely, transparently, and without being manipulated through unfair tactics. And this bill introduces a flexible, overarching standard that prevents businesses from engaging in conduct that unfairly influences or pressures consumers in ways that are likely to result in harm. It acknowledges that while businesses are entitled to market their products and compete strongly, there must be clear limits on practices that intentionally exploit confusion, vulnerability, or imbalance in information. This legislation is not designed to stop ordinary advertising or legitimate sales strategies. Businesses will continue to innovate, compete, and promote their services. Healthy competition remains a critical part of a strong economy. However, there's a clear distinction between persuasive marketing and conduct that deliberately steers consumers into decisions they may not otherwise make through pressure, obstruction, or deception. And increasingly, Deputy Speaker, consumers interact with businesses through digital platforms and online interfaces that are carefully designed to shape behaviour. While many businesses use these tools responsibly, some practices are specifically engineered to frustrate cancellation process, overwhelm consumers with excessive information, conceal important details, or create urgency that pressures individuals into rushed decisions. And this bill seeks to address those harmful behaviours. This bill also addresses the growing use of digital design features that create unreasonable pressure or deliberately obstruct consumers from making informed choices. These tactics can include complicated cancellation pathways, repeated prompts designed to completely wear consumers down, or interfaces structured to discourage people from changing their minds. Importantly, this reform has been designed with the future in mind. Markets, technology, and consumer behaviour continue to evolve rapidly, particularly in the digital economy. A principles-based framework allows the law to remain relevant as new forms of unfair conduct emerge, rather than relying on Parliament to constantly and continuously amend legislation in response to every new tactic or technology. And this approach creates a stronger and more adaptable consumer protection system, while also giving businesses greater clarity about the standards expected of them. Ultimately, these changes are about strengthening confidence in the marketplace, supporting fair competition, and ensuring Australians can engage in the economy knowing that they are being treated honestly and fairly. Deputy Speaker, Australians are increasingly relying on subscription-based services in their daily lives, from streaming platforms and fitness apps to software services and delivery memberships. Subscription models have become deeply embedded in the modern economy, and many of these services provide genuine convenience and value to customers. However, there is a growing concern about the way some businesses structure their arrangements to make cancellation very difficult and ongoing charges easy to overlook. Too often, consumers are drawn into arrangements through free trials or heavily promoted introductory offers, only to later discover that ending the subscription is unnecessarily complicated. In some cases, businesses rely on consumers forgetting renewal dates, missing important notices, or becoming frustrated by confusing cancellation processes. And while signing up may only take moments, cancelling can involve navigating multiple web pages, repeated prompts, hidden settings, or lengthy customer service interactions. And that imbalance is precisely what this legislation seeks to address. This bill introduces stronger safeguards to ensure subscription agreements are fair, transparent and easy for consumers to understand from the outset. Businesses will be required to provide clear and accessible information before a consumer enters a subscription arrangement. And this includes details about pricing, billing frequency, renewal terms, the duration of any trial period, and the steps required to cancel the service. The reforms also place significant emphasis on the cancellation process itself. And consumers should not face unreasonable barriers when trying to end a service they no longer wish to use. Businesses will need to ensure cancellation pathways are visible, practical, and proportionate. If a person can subscribe online quickly and easily, there should be a similarly straightforward process to discontinue the arrangement. In addition to these measurements, further regulations approaching on 1 July 2027 will introduce a reminder requirements for businesses. Consumers will receive a clearer notification before free trials expire or before automatic renewals occur. And these reminders are intended to give individuals fair opportunity to reassess whether they still wish to continue with the service before getting the additional charge. And these protections will extend beyond individual consumers to also cover small businesses, Deputy Speaker, who are entering into standard form subscription contracts. This is an important inclusion because small businesses can face many of the same challenges as ordinary consumers, particularly when dealing with larger corporations and complex contractual systems. They too deserve transparency and fair treatment. Importantly, these reforms also support businesses that are already doing the right thing. Many companies already communicate clearly with customers, provide fair notice of renewals, and make cancellations simple and accessible. Those businesses should not be placed at a disadvantage against competitors using confusing or restrictive practices to retain customers unfairly. This legislation also takes important steps to address the issue of hidden fees and misleading pricing practices that have become increasingly common in today's marketplace, particularly on online transactions. And Australians deserve to know the true cost of a product or service before they commit to making a purchase. Yet too often consumers are presented with an advertised price that appears attractive at first instance, only to discover additional compulsory charges later at the checkout process. By the time these extra costs are revealed, consumers may have already invested considerable amount of time entering personal details, comparing options, or progressing through multiple stages of transactions. And this practice is commonly referred to as drip pricing, which undermines transparency and weakens confidence in the market. It creates a situation where the initial advertised price does not accurately reflect what a consumer would actually pay. Instead, mandatory booking fees, processing charges, service costs, or other unavoidable additions are gradually introduced throughout the purchasing process, making that final substantial amount much higher than originally expected. Clear and accurate pricing is fundamental to a fair and competitive economy. Consumers can only make informed decisions when they have access to genuine and complete information. If important costs are concealed or delayed, it becomes far more difficult for individuals to properly compare products and services across the market. And the reforms in this bill will require businesses to present all mandatory transactions related to charges at the same time the advertised price is displayed. In other words, consumers will see the true price up front rather than being confronted with unexpected additions at the end of the process. This does not prevent businesses from charging illegitimate fees, nor does it interfere with their ability to structure prices appropriately. What it does is require is honesty and transparency about the total unavoidable cost a consumer can expect to pay. Deputy Speaker, like I said earlier, it is about keeping alive the neighbourhoods our grandparents built and the neighbourhoods we still want to live in today. Australians should not need to navigate hidden traps, confusing interfaces, or concealed fees simply to participate in everyday economy and commerce. Consumers deserve transparency, they deserve fairness, and businesses that do the right thing deserves a marketplace where integrity is rewarded rather than undermined. And that is why this bill is about restoring and reinforcing trust in fair competition and trust that Australians will be treated honestly when they spend their hard-earned money. That is good for consumers, that is good for businesses, and that is good for the Australian economy. Thank you.
The original question was that this bill be now read a second time. To this, the honourable member for Page has moved as an amendment that all words after that be admitted with the view to substituting other words, and the question is that that amendment be agreed to. And I call the member for Griffith.
Thank you, Deputy Speaker. Most Australians know what it feels like to keep a close eye on the household budget and make careful choices about where every dollar goes. We know today in Griffith there is a parent comparing the cost of school shoes, groceries and sports fees before payday, a student looking for a cheaper phone plan between shifts, an older Australian checking direct debits on a fixed income, and a small business owner reviewing every subscription, service charge and renewal notice. People in my community and across Australia are doing the sensible thing, comparing prices, reading the details, considering their choices and trying to make good decisions for themselves, their families and their companies. But all too often the companies and systems they're dealing with aren't as equally fair. A price that seems okay at first becomes more expensive at the final stage of the payment. A free trial unexpectedly turns into a paid subscription, and cancelling something that should be easy becomes complicated with runaround tactics, repeated prompts and pointless difficulties. These aren't just annoying, they are costing people money, time, effort and faith. And when people are already dealing with work, family, bills, appointments and everything else, they shouldn't have to spend their free time battling systems that are deliberately designed to try and exhaust them. That is why this bill is important. It restores fairness to everyday purchases by ensuring people know the true price before committing, understand the conditions of something before they agree to it, and can leave a service without being endlessly redirected. It also supports the many businesses that already are honest and respectful to customers. Australians shouldn't have to be experts in the small print to be able to be treated well. By amending the Competition and Consumer Act 2010, this bill strengthens our Australian consumer law by banning unfair trading practices generally, with specific changes for unfair subscriptions and improved protections against drip pricing and similar charges that appear during a transaction. Fundamentally, this bill is about stopping unfair things that manipulate people's choices, distort what they decide, and really where it harms them. This harm isn't only financial, it also includes wasted time, frustration and lost confidence from being forced through systems that aren't meant to be fair for consumers. This is an overdue and necessary update to our consumer protection laws. For a long time, the Australian consumer law has correctly protected us from misleading information and unfair contracts. Those protections are important, but in today's digital age, consumers face a different environment. Sometimes it's about what isn't said upfront on a website. Sometimes it's a fee that only shows up at the very end of a purchasing process. Sometimes a website's design that subtly pushes, pressures or prevents people in ways they don't even realise. And sometimes it's where a cancellation option technically exists, but is so difficult to find, people often find they just give up trying. I've actually had constituents mention to me in passing that they have found it easier to cancel their credit card and get a new one reissued than to actually work out how to unsubscribe from some services. This bill acknowledges that a consumer's choice can be undermined even without a direct lie. It acknowledges that people can be pushed into decisions that aren't in their favour by difficulties, confusion, being overloaded with information, pressure, and let's be frank, tiredness. These changes will stop business methods that depend on confusion, tricks in the design, unnecessary difficulties, or people just being exhausted. They establish a standard that is both clear and fair, and one that good businesses should be able to meet. One of the clearest examples of why this reform is needed is subscription traps. Subscriptions are now a huge part of life for both families and small businesses. Streaming, music, meal boxes, fitness, kids learning, software, cloud storage, news, and so much more. Small businesses use them daily for accounting, wages, booking, point of sale, website hosting, email, rosters, and delivery. They're useful and flexible and can be good value, but all too often these subscriptions depend on people forgetting, missing a renewal date, or finding it hard to cancel. Someone might start a free trial intending to cancel if it's not suitable, but then forget the reminder, the trial finishes, and the money is taken. For some households, this might be a small, annoying charge. For others, it could be the difference between being okay financially and going over budget. For a small business, it could mean paying for software, booking, delivery, wages, or marketing they're not using at a time when every expense is important. Then comes the second frustration, trying to cancel. And I know every single member in this chamber here this evening has had this frustration. Something that may have taken seconds to sign up for shouldn't take half an afternoon to stop. People shouldn't have to search through many account pages, be shown lots of warnings and offers to stay, or have to phone during work hours when they signed up quite simply online. If you can join with a few clicks, you should be able to leave with a few clicks too. You should be told exactly when a free trial ends, when you'll be charged, how your subscription will automatically renew, and crucially, how to cancel it without being endlessly passed around different departments. The Consumer Policy Research Centre, the CPRC, has been looking closely at the problems caused by these subscription traps, and their research shows that 3 in 4 Australians who have subscriptions have had a bad experience trying to get rid of one. Half of those people spent longer than they intended simply cancelling. 1 in 3 felt pressured to keep it, and 1 in 10 just gave up and continued paying for something they didn't even want. Latest estimates are that these traps are costing Australians around $46 million each year, which is a national price tag for the little, sneaky and irritating unexpected charges many of us see on our bills. And these numbers, of course, represent real people. Think of the parent up late after the kids are in bed, hunting for the cancel button, or the student who signed up for a trial during an exam period and missed the renewal date. Consider the older Australian, unsure if a pop-up is actually telling them something or attempting to frighten them into remaining in being a subscriber. People who are busy, careful with their money and tired are being made to deal with deliberately confusing systems. The CPRC's research also shows us that 90% of Australians would use the same company again if cancelling was fast and simple. That's a key point in this discussion, as treating people decently isn't against what businesses should do, it's simply good for business. People remember how they're treated when they finish with a company, whether their time was valued, their details were clear, and the processes were honest. This bill makes companies reveal all the important details of a subscription at the time of signing up and sends reminders at specific points during the subscription and makes sure there's really easy, obvious way to cancel. This bill also tackles drip pricing, which is a familiar frustration for many Australians. You find a price online, it looks okay. You begin to buy and you fill in your details, choose your date, your seat, room, delivery method or ticket. Then right at the end of the payment process, hidden additional costs are added to the cart. Transaction fees, booking fees, service fees, and processing fees. The final cost is now significantly different to the price you were initially shown. At this stage, you might feel you've come too far to stop. You've spent time comparing and filling in your details. You may be buying something with a deadline, tickets for your children, travel for a family event, or making plans around work and childcare. The true price should have been stated at the very beginning. Transparent pricing is vital for proper competition. If prices aren't clear to begin with, people can't compare them properly. And if people can't compare them properly, the market doesn't function as it should. This bill makes it harder to use drip pricing and other charges added at the transaction stage by requiring all transaction-based charges to be shown with the original price if they can be calculated at that point, or explaining how the charge will be worked out if it can't be worked out in advance. Because of this, Australians will be in a better position to see the full cost earlier on, make a proper comparison, decide if they want to go ahead, and make a choice with more confidence on all of the information. Deputy Speaker, this change is also about helping good businesses. Small businesses in our communities work hard for every customer. They understand how people see them matters, and that trust is built up over time through being fair with prices, communicating clearly and offering respectful service. They don't want to be forced into using underhanded tactics simply because others are. Being upfront shouldn't mean they lose out to competitors who use hidden fees, confusing websites or extra steps to make things difficult. This bill creates a more equal playing field. It says that businesses should win customers by offering better products, better service and better value, not by making it harder for people to work out what they're actually buying. This is good for customers, good for businesses, good for competition and good for how much we achieve as a country. When people are confident in the marketplace, they're more willing to be involved. When they can compare easily, the best businesses can get customers on their own merits. And when unfair practices are discouraged, businesses have a greater reason to come up with new ideas to improve and to compete fairly. This bill is not about stopping businesses from advertising, promoting their products or competing strongly. Businesses should absolutely be able to explain why their product is good value, why their service is useful and why a customer might choose them. But there is a difference between persuasion and manipulation. There is a difference between encouraging a customer and trapping a customer. There is a difference between making a sale and designing a process that makes it harder for someone to make a free and informed choice. This bill deals with conduct that crosses that line. These new rules are backed by real consequences because a right is only meaningful if it can be enforced. This bill aligns penalties for contraventions of this new unfair trading, subscription and drip pricing provisions with the existing civil penalty settings under the Australian consumer law. That sends a clear message. Consumer harm cannot be treated as a cost of doing business, and fairness cannot be optional. We have also taken a sensible approach to implementation, with these changes coming to effect on the 1st of July next year, giving businesses the appropriate time to understand their obligations and to adjust their practices. This bill also provides for a review of the new measures within 2 years of commencement, which will help ensure the protections are operating as intended. That is a balanced approach and gives businesses time to prepare while making the direction clear. While this bill focuses mainly on consumer protections, unfair trading practices can affect small businesses and franchisees too. Many small businesses deal with larger suppliers, platforms, landlords and franchisors. They can face information imbalances, bargaining pressures and systems that are difficult to challenge. That is why consultation on extending protections to small businesses is important. We have already commenced targeted consultations on extending protection from unfair trading practices to small businesses and franchisees, and are considering whether further steps are appropriate in the financial services sector. Small businesses are integral to my community of Griffith. They sponsor our local sports teams, they support our school raffles, they employ locals and they know their customers by name. They deserve fair treatment too, and the principles should remain at the centre of these ongoing consultations. Deputy Speaker, 17 leading consumer groups welcome the introduction of this bill. The Consumer Policy Research Centre has described a ban on unfair business practices as the missing part of Australian consumer law. Choice has put the competition point clearly. Businesses should compete on price and quality, not by manipulating or distorting the choices that people make. The Consumer Action Law Centre has said these reforms have the potential to transform the consumer experience away from harm and towards real fairness. That support is important because these organisations see the real-world consequences of unfair practices. They hear from people who are dealing with financial stress, confusing contracts, hidden fees, high-pressure sales tactics and systems that make it harder to act in their own interests. Deputy Speaker, these reforms are about treating people fairly in the ordinary decisions they make every day. They recognise the time people spend comparing prices, checking terms and managing household budgets, especially when the cost of living is already stretching families and small businesses. When someone compares prices, they should be able to trust that the first price they see is not hiding mandatory fees. When they sign up for a trial, they should be clearly told when it ends, what it will cost and how they can cancel. And when they decide a service is no longer right for them, they should be able to leave without being sent in circles. That standard is good for customers, but it is also good for the many businesses that are already doing the right thing. A business that's upfront about its practices, its prices, it's clear about its terms and respectful of its customers should not be disadvantaged by competitors who rely on confusion and on hidden costs. Most people are simply trying to make good decisions for themselves and for their families. They are trying to manage their money, support their children, keep their small businesses running and get through the week with a little less stress and a little more certainty. Our consumer laws should support them in that. This bill introduces an economy-wide prohibition on unfair trading practices. It tackles those subscription traps, it tackles drip pricing, and it strengthens consumer protections for the way Australians buy, compare and subscribe today. People in our community are working hard, they are budgeting carefully and they're making thoughtful choices every day. Our consumer laws should meet them with the same honesty and the same fairness.
Thank you. The original question was that this bill be now read a second time. To this, the honourable member for Page has moved as an amendment that all words after that be omitted with a view to substituting other words. And the question is that that amendment be agreed to, and I call the member for Hasluck.
Thank you, Deputy Speaker. At its core, this bill is about something simple: honesty. Honest treatment for consumers, honest prices presented up front, and honest processes that allow Australians to organise their lives and their buying decisions easily and without tearing their hair out. Because in today's digital economy, the issue is not just about what things cost. It's whether people are being dealt with honestly during the process. And in communities like mine in Hasluck, that matters deeply. In Hasluck, people are not making abstract economic decisions. They're making real decisions under real time and money pressures. When I'm out in my community in Midland, in Ellenbrook, in Bassendean, people consistently raise the same issues: cost of living, housing affordability, health, education and jobs. And the reality is many households are doing it tough. The great majority of residents in Hasluck are managing mortgages or rent, and those pressures do continue to rise. So what does this mean in practice? It means families are sitting at the kitchen table going through every expense. It means people are carefully checking their bank statements. It means people are making deliberate choices about what they can and what they can't afford. And in that environment, every dollar matters and every decision matters. People in Ellenbrook and Midland and Bassendean want to know honestly and upfront what something will cost. And they don't want to be led up the digital garden path for an hour to find out what something will really cost, or to cancel a subscription. So this legislation deals with the hidden costs and drip pricing. Australians expect something very simple. The price they should see should be the price they pay. But too often that's not what is happening. The ACCC has warned that customers can be lured into purchases they would not otherwise have made when businesses display only part of the price up front and reveal the total cost only towards the end of the purchasing process. And we've all been annoyed by this. It is the opposite of honesty and transparency. It is confusion. People in the Swan Valley, in Guildford, in Aranda, right now, booking flights or event tickets online or making purchases, will often be finding that additional fees only appear at the very final stage, after they've already invested considerable time and effort in the process. And we often feel locked up in that time, having invested so much energy and time in the process already, that there are only so many minutes in the day. So as Minister Lee said, it's often at the very last click. And Consumer Advocate Choice notes that having new charges thrown in right before you're prompted to pay has become an everyday annoyance in the consumer marketplace. And of course, it is online, so it's not just happening here. In the United Kingdom and the United States, regulators are already taking action against these practices, requiring businesses to show the full price up front and penalising those who hide their fees until the final step. This bill ensures that Australian consumers are given that same clarity. The same problem exists with subscription services. And here, the issue is not just pricing, it is control. It's about whether consumers can leave and leave easily when they choose to. When people in Ellenbrook, Dayton or Hazelmere sign up to services online, they expect the process to be simple. And it often is, but cancelling is too often a completely different story. Multiple steps, unclear pathways, and sometimes no obvious exit at all. Sometimes payments continue after cancellation should have been acknowledged and processed. And it can be hard to chase up those small amounts of money. So a lot of the time people just don't bother. A contract that can be entered in seconds should not take hours of effort to exit. And again, we are seeing action internationally. In the United Kingdom, new laws will require clear information, reminder notices and simple cancellation processes. The UK Consumer Group, which stated that subscription traps can be costly and wreak havoc on finances that are already under strain. In the European Union, consumers already have rights to clear subscription terms and cooling off periods. In the United States, regulators are taking enforcement action against systems that are designed to make cancelling difficult. And in Singapore, authorities have taken court action against businesses that enrol consumers into subscriptions without proper consent. The principle is clear. Joining should be easy, and leaving should be just as easy. This bill isn't just about fairness for consumers. It also creates a fairer playing field for businesses. Why should honest businesses in Morley and Midland, businesses who do the right thing, have to compete against online businesses that use nefarious means to trick consumers when competitors appear cheaper simply because they don't disclose the full cost upfront? This bill says to the honest people running businesses in my electorate and all around the country, we have your back. We will take action and we will make it fairer for everyone. A modern economy requires modern protections. Our marketplace has changed and it continues to change. Commerce is increasingly digital. Decisions are made quickly. And businesses design systems that shape how consumers behave. People in my electorate are being rushed into decisions online through countdowns, prompts and pressures to act quickly. They are often faced with confusing choices and add-ons during transactions that make it difficult to understand what they are agreeing to. For those of my generation and older who didn't grow up as digital natives, it's harder still. And around the world, governments and regulators are recognising this shift and the need to take action. In the United States, there is this action against these so-called dark patterns. The Federal Trade Commission in the US concluded that companies are using digital design to trick or manipulate consumers into buying products or giving up their privacy. In Europe, a directive aims to achieve a high level of consumer protection by curbing unfair business practices. And in the United Kingdom too, new laws reflect that same principle. This bill brings those protections into Australian law. These reforms set a clear standard. Businesses must not mislead through omission, manipulate through design, or trap consumers through complexity. Deputy Speaker, that standard is not radical. It is what Australians expect, and it is what other advanced economies are increasingly requiring. When markets are fair, people can trust them. When prices are clear, competition works. And when consumers are respected, the economy works better for everyone. In HAZLUP, people are doing the hard work, balancing budgets, making decisions, managing rising costs, and they deserve a system that is honest with them. This bill helps to deliver that. It reflects a growing international recognition that fairness must extend to the way choices are designed, not just the words on the page. It addresses real harm. It supports honest businesses, and it restores fairness to the marketplace. I will echo Choice in closing, which stated that the days of being mistreated by businesses nearly every time we transact online may finally be coming to an end. And I thank the Minister for his efforts and I commend the bill to the House.
The original question was that this bill be now read a second time. To this, the honourable member for Page has moved as an amendment that all words after that be omitted with the view to substituting other words. And the question is that this amendment be agreed to, and I call the member for Brisbane.
Now, this Labor government is serious about protecting Australians so they can keep more of what they earn. And we know Australian households are feeling the pinch when it comes to cost of living. Many families across my electorate in Brisbane are watching what they spend. They might not buy that extra coffee one week, but importantly, they're comparing prices before they put their money down. And that's why I was proud to join the Assistant Minister for Productivity, Competition, Charities and Treasury to announce that the Labor government is cracking down on unfair trading practices. Australians should be able to trust that their markets are fair, that their markets are transparent and not stacked against them. And we know that many businesses are doing the right thing. However, some businesses are not. They're playing tricky games, they're trying to deceive their customers, and that's all to drive up their own profits. Now, this bill will crack down on this sort of dodgy behaviour by banning unfair trading practices, cracking down on drip pricing and putting an end to subscription traps. We're putting a stop to business tactics that rely on confusion, on design tricks, needless friction or sheer consumer exhaustion. Deputy Speaker, the way Australians buy and subscribe really has changed significantly, particularly in the past 15 years or so. And today people make decisions about goods and services through a variety of pathways, browsing the aisles of a local store, searching online for the best deal, or entering subscription arrangements, many that renew automatically. Increasingly, the experience of choosing, purchasing and managing services spans multiple channels, reflecting a more complex but interconnected marketplace. Now, these changes are positive. They've given Australians more choice and convenience, but they've also created conditions in which certain business practices can pressure, confuse or trap consumers. Now, Australians are hard-working and fair-minded, and we expect businesses to be fair-minded too. And while we encourage businesses to compete and to innovate, that's a good thing. But when innovation is designed to deceive or trick consumers, governments must draw the line. In the lead up to the bill, the evidence was presented to the government that suggested that deception and trickery are not isolated incidents. In fact, more than half of reported consumer problems now occur from online purchases. 1 in 10 people say that online providers have manipulated their choices, while more than a quarter encountered unexpected charges added late in a transaction. Online, nothing is accidental. Where the button sits, what the screen suggests, and how hard it is to cancel, they can all nudge people into decision-making that they might not otherwise have made. This is all by design. As I said, nothing is accidental. Now, this bill is designed to address these issues that consumers have told the government that they are frustrated by. They're issues and challenges that people in my community come and see me about. Deputy Speaker, the bill modernises the Australian consumer law to reflect how Australians buy today, how they compare prices and how they subscribe. It protects consumers not only from outright deception, but also from subtle cumulative influences that erode informed decision-making and therefore genuine choice. Now, the bill does 3 things. First, a general prohibition on unfair trading practices. The bill introduces a principles-based test to address unfair trading practices. Now, these practices that don't fall neatly within existing prohibitions on misleading conduct that are unethical and unreasonable could fall within this principle. The bill sets out something fairly straightforward. It says businesses must not manipulate consumers or unreasonably distort the environment in which consumers make or are likely to make decisions in circumstances that cause or are likely to cause detriment. The test captures exploitative behaviour and biases that aim to overwhelm consumers with complexity or structures of choices in a way that leads people to decisions that they would not otherwise make. Think how many times you've been online and you've seen, sale ends in 5 minutes or only 3 items left, buy now. To provide practical guidance, the bill includes a non-exhaustive indicative list of examples of practices that may contravene the new prohibition. Now, these include impeding a consumer's ability to exercise legal rights or seek legal remedies, failing to disclose material information to a consumer, or maybe it's even just disclosing material information to a consumer in a way that is complex, ineffective, unclear, unintelligible, maybe it's ambiguous, but ultimately it may be overwhelming. And this could be something too like as simple as maybe a car dealer forgetting to tell a buyer that the car was involved in a flood. And other examples, creating an environment, including by using design elements in digital interfaces, and that these sorts of designs place unreasonable pressures on a consumer or that obstructs the consumer from making or fulfilling their decision. A great example would be a travel website with a timer that says, only 5 minutes to go, book now to get this price. The examples will help businesses understand where the line is drawn without restricting ordinary, legitimate commercial practices. Deputy Speaker, the second main element of the bill is addressing drip pricing. Now, we've heard a bit today in this chamber about what this means, but I think everyone can relate to what I'm about to say. Have you ever tried to book a hotel, a flight or a concert ticket, and the price you thought you were paying changes when you suddenly go to the checkout and click that final button? You take a closer look and you see that the company's added a booking fee here and there or a service charge on top of that. That's called price dripping, and that's called drip pricing, and we're cracking down on it. Australians should see the real price up front in order to make a proper informed purchase. And one example of from my electorate, a concert ticket promoted for $109.90 rose to $117 once a compulsory charge of 7+ service fee was added to the last stage of the process. By then, the consumer had already invested the time, the attention, and felt locked into completing the purchase. This bill does require businesses to disclose mandatory transaction-based charges at the same time they display the base price. That means no last-minute surprises, no artificially low headline prices that increase only after the consumer has invested the time and attention, and no business models that rely on consumers being reluctant to abandon a purchase late in the process. Now, just to be clear, Deputy Speaker, this bill doesn't prohibit transaction fees, it prohibits hiding them. It ensures that businesses doing the right thing are not disadvantaged by competitors who conceal the true cost until the final step. The third element of this reform is ending subscription traps. Everyone across this country, I'm sure, can relate to this. You sign up to the subscription, you decide you don't need it anymore, you jump on the website looking for the subscription cancellation button. Sometimes you can't find it, sometimes you can. Then you click that button, it takes you to another screen. Maybe it asks you if you want to keep your subscription at a cheaper rate. You might click no. It takes you to another screen and asks you to explain why you might be leaving the subscription, etc., etc. You click no, and then it asks you to email the company to cancel the subscription. And on it goes. This tactic is called shutdown subscription trap, and we are putting a stop to it too. Businesses use confusion, dark patterns, consumer fatigue to keep people paying, and they won't be able to keep doing that. Subscriptions are now a regular part of household budgeting. I'm sure we've all got them, but subscriptions provide access to news and fitness and entertainment software, many other services. And according to research from the Consumer Policy Research Centre, 3 in 4 Australians have had a negative experience when trying to cancel a subscription. Nearly half have spent more time than intended trying to exit a service. 1 in 3 have felt pressured to stay. 1 in 10 Australians have given up trying to cancel and just kept paying for a service they no longer wanted. Some people have been so frustrated by unwanted subscriptions they've chosen to cancel the credit card or the bank account just to get rid of the recurring subscription. These unwanted subscription costs cost Australian consumers an estimated $971 million a year. And this bill addresses these problems directly. Businesses must clearly disclose that a customer is entering a subscription, what it costs, how long it runs, how it renews, and how it can be ended. The bill also establishes reminder notices. We all can't keep track of what's going on in our lives generally, let alone a subscription that you might have signed up to 5 years ago. So consumers will get timely prompts when a trial ends or when a renewal is approaching. Cancellation must be easy to find and require only steps that are reasonably necessary. If you can sign up in seconds, you should be able to cancel just as easily. Many reputable businesses already meet this standard, but this bill makes it universal. Deputy Speaker, the bill is part of a broader agenda to strengthen competition, boost transparency and support consumers and businesses across the economy. We've legislated the biggest overhaul of Australia's merger laws in 50 years, ensuring major mergers are properly assessed and anti-competitive acquisitions can't slip through. We've boosted funding to the Australian Competition and Consumer Commission by more than $30 million to strengthen action on misleading pricing, particularly in supermarkets and other consumer-facing markets. We've outlawed unfair contract terms and for the first time empowered the regulators, the Australian Competition and Consumer Commission and the Australian Securities and Investment Commission, to seek penalties for breaches. We're strengthening the unit pricing code and cracking down on shrinkflation so consumers can see when products get smaller without getting cheaper. Under the former government, the Supermarket Food and Grocery Code was merely voluntary, without penalties for wrongdoing. Under Labor, the Food and Grocery Code is mandatory, backed by strong penalties that prevent supermarkets from using their market power to unfairly squeeze farmers and other suppliers. Deputy Speaker, we know penalties make a big difference to behaviour. That's why the government has increased maximum penalties under Competition and Consumer Act from $10 million to $50 million in 22 and last month up to $100 million. Stronger sanctions ensure that breaches of consumer law can't be dismissed as a mere cost of doing business. They change behaviour. They ensure that businesses of all sizes face meaningful consequences for conduct that undermines fairness. Additionally, through a reformed national competition policy supported by $900 million National Productivity Fund, the government is working with the states and the territories to remove commercial and industrial planning and zoning barriers that make it harder for new entrants to compete. We're progressing reforms to create a single national market for goods, streamlining standards, improving heavy vehicle productivity and improving occupational licensing so that workers can move more freely across jurisdictions. We're also supporting health and care professionals to work their full scope of practice. Together, these reforms really strengthen competition and dynamism in our markets. They boost productivity and contribute to a fairer marketplace. Speaker, this bill focuses on consumer protections, but unfair trading practices don't only affect individuals. Small businesses and franchises often face the same vulnerabilities when dealing with larger suppliers. The government will consult on extending unfair protections to small businesses, including those in franchising, and that work is underway. In presenting this bill, though, we reaffirm a basic principle. Markets work best when they're fair, when consumers are treated with respect rather than worn down, when innovation in business is used for the right purpose, when transparency is rewarded and hidden fees are not. The reforms in this bill, banning unfair trading practices, cracking down on drip pricing and cleaning up subscriptions, will help Australians make properly informed purchase decisions. It'll help them manage their household budgets, not to mention saving them time and frustration. They will also help businesses across our economies. This bill is about fairness, it's about doing the right thing, and I commend the bill to the House.
The original question was that this bill be now read a second time. To this, the honourable member for Page has moved as an amendment that all words after that be omitted, with a view to substituting other words. And the question is that this amendment be agreed to, and I call the Minister.
Thank you, Deputy Speaker. I thank members who have contributed to this debate. The members for Page, Melbourne, Kooyong, Fisher, Maribyrnong, Mallee, Holt, Moreton, Griffith, Whitlam, Sturt, Ford, Barton, Bennelong, Hasluck and Brisbane. The breadth of the contributions really reflects the passion that so many members feel about cracking down on unfair trading practices, subscription traps and drip pricing. And it reflects that energy, particularly on this side of the House, directed towards making the Australian economy more productive, more competitive, more dynamic. The Competition and Consumer Amendment Unfair Trading Practices Bill 2026 strengthens the Australian consumer law in three important ways: by banning unfair trading practices, by addressing subscription traps, and by strengthening drip pricing protections. Together, the bill ensures that consumers are treated fairly and that honest businesses, including small businesses, aren't disadvantaged by competitors who rely on tricks and complexity rather than value and service. Some in this debate have questioned whether these reforms are necessary, but the evidence before us is clear and consistent. Years of research, of consultation and enforcement experience show that there's gaps in the current law. Certain practices may not be clearly misleading and may fall short of the high bar of unconscionability, yet they still distort decision-making and cause real detriment to consumers. These are practices that quietly pressure, confuse or obstruct consumers, often through design, ensuring deception. For Australians, that harm is experienced in very practical ways. Time wasted navigating complex processes, fees revealed late in a transaction, subscriptions that are easy to sign up to but difficult to exit, and a growing sense that markets are structured to wear them down. Over time, that erodes trust, and when trust falls, competition and productivity fall as well. That assessment is not contested among those who see these markets up close. The Australian Competition and Consumer Commission supports this bill, informed by its enforcement expertise and its work across consumer-facing markets. On the day the bill was introduced, 17 consumer organisations welcomed it, including national consumer advocates, financial counsellors, legal services and community organisations. They were the Consumer Policy Research Centre, Consumer Action Law Centre, Choice, the Financial Rights Legal Centre, Mob Strong Debt Help, the Consumer Credit Legal Service, the Australian Communications Consumer Action Network, the Consumers Federation of Australia, Energy Consumers Australia, Financial Counselling Australia, Financial Counselling Victoria, the Justice and Equity Centre, National Seniors Australia, Way Forward, West Justice, AIMS Australia and the Western Australian Consumer Advocacy Network. The sheer breadth of support reflects a shared conclusion. These reforms respond to persistent, well-documented problems in everyday transactions. The bill responds in a careful, proportionate, balanced way. These prohibitions don't ban advertising. They don't ban fees, subscriptions or innovation. They do not tell businesses how to market their products. They simply ensure that key information isn't obscured, that cancellation isn't obstructed, and that competition takes place on its merits. As set out in the Decision Impact Statement, this package of reforms, covering the general prohibition on unfair trading practices, subscription protections and strengthened drip pricing rules, is expected to deliver net benefits to consumers and the economy by targeting conduct that causes the greatest harm, while keeping compliance costs proportionate and manageable for business. This bill is about drawing a clear line between fair competition and unfair manipulation. Most Australian businesses, especially many small businesses, already operate this way. For them, the changes will be modest. Good businesses shouldn't pay a price for doing the right thing. The Australian Competition and Consumer Commission will play an important role in implementation. It'll provide practical guidance so businesses understand their obligations clearly and early. The intention isn't to catch businesses out. It's to set clear expectations, supported by clear guidance, so firms can comply with confidence. That certainty benefits everyone, firms and consumers alike. These reforms sit within a broader competition and consumer agenda. Our government has delivered the most significant overhaul of Australia's merger laws in half a century. We're strengthening the unit pricing code and cracking down on shrinkflation so Australians can clearly see when product sizes fall and prices don't. We've increased funding for the Australian Competition and Consumer Commission to tackle misleading pricing and unfair practices. We've raised the maximum penalties under the Competition and Consumer Act from $10 million when we reached office to $100 million, or 3 times the benefit gained by the breach, or 30% of turnover. This ensures breaches can no longer be dismissed by businesses as a mere cost of doing business. Our government is scrapping non-compete clauses for workers earning under $183,000 to make it easier for people to move to a better job. We're revitalising national competition policy, backed by the $900 million National Productivity Fund, to break down commercial and industrial planning and zoning barriers, deliver more houses by removing barriers to the uptake of modern methods of construction, and build a more seamless national market for workers and goods. I thank stakeholders, including business, industry groups, consumer advocates and legal academics, for their engagement. Lastly, I want to thank again all those involved in the development of this bill, including officials from the Department of the Treasury, Office of Parliamentary Counsel and the Australian Competition and Consumer Commission. The expertise and care shown by officials across the Australian Public Service has ensured these reforms are robust and balanced. Australians shouldn't need a magnifying glass, a law degree and the patience of a saint to buy an everyday product or cancel a subscription. Markets work best when business success comes from offering a better deal, not designing a better trap. This bill helps ensure that in Australia, firms prosper by serving consumers, not by outsmarting them. I commend the bill to the House.
The original question was that this bill be now read a second time. To this, the honourable member for Page has moved as an amendment that all words after that be omitted with a view to substituting other words. The immediate question is that that amendment be agreed to. I will put the question. All those in favour? Aye. All those against? No. I think the noes have it. Division required. In accordance with Standing Order 133, the division is deferred until the first opportunity of the next sitting day. The debate on this item is therefore adjourned until that time. I call the clerk for the next item of business.
Government business. Order of the day number 4, Telecommunications Amendment Enhancing Consumer Safeguards Bill 2025. Resumption of debate on the second reading and on the amendment moved by the member for Lindsay.
The original question was that this bill now be read a second time, and to that the honourable member for Lindsay has moved as an amendment that all words after that be omitted with a view to substituting other words. And the question is that that amendment be agreed to, and I call the member for Ford.
Thank you, Deputy Speaker. I rise in support of the Telecommunications Amendment Enhancing Consumer Safeguard Bills 2025, and in doing so I very much acknowledge the work of the Minister for Communications, who is doing an incredible job in what is a very difficult and essential portfolio in an industry which is racked with problems. And which really I think has been allowed to get away with some unconscionable conduct, and so it is a credit to the minister that this bill forms a part of that general approach to fixing that essential service, and I very much think that she's really doing a fantastic job. And in fact, she's far more diplomatic than I would be when talking about some of these telcos. And she said it, and I'll use her words just in case I get a bit intemperate myself. She said that the 000 failures last year shook public confidence. Frankly, they exposed elements of a system that relied on a best efforts approach, and sadly, in some instances, those efforts were far from best. At a deeper level, she said, it exposed the discordance between how the industry is regulated and perhaps how it sees itself versus how the public expects it to operate. And I'm sure we all have constituents and suburbs in our electorates where the telcos are not operating as the public would expect them to operate. And so I think that this bill sits well within the Albanese government's approach to making sure that all Australians are connected, wherever they live. And it allowed me to reflect on a bill that sort of sits alongside this one, which was the Telecommunications Legislation Amendment, Universal Outdoor Mobile Obligation Bill. And which is dealing with telecommunications in regional and outback Australia, an area that I'm familiar with, an area where communications for me is in the year 2000 involved strapping a yellow rubber Garmin GPS to my motorbike so I could know where I was. And coming onto a property having grown up in town in Broken Hill, coming onto a property in my 20s, you can imagine that I was no bushman, and I very much relied on the technology, I think, to get me out of there alive. And it was very simple. It was a little green screen with an arrow that would point to the homestead or the tank or wherever we were going, but it connected to a satellite. And that communication device, which was familiar to people out in some of those places in the year 2000, while mobile phones were completely unfamiliar to people out there, it was things like that really provided that economic benefit that opened up those economic opportunities. In fact, just by the way, without digressing too far, it's amazing to see how telecommunications has come now, and the idea that stock can be mustered by having essentially wearing a collar that gives a sort of gentle vibration to steer them in the right direction. The future of communications is really quite amazing when it comes to what the potential for agriculture is. And so it was that people in the city had no idea what GPS is at the same time that we had no idea what a mobile phone was. But those methods of communication have come together and are vitally important now to our economy. But of course, it is not just an economic imperative or convenience that there are good communications. And I'm reminded of my mother's experience in the flood of 2010 in Brisbane, the first big flood. Something that unfortunately we've become all too familiar with. But in 2010, she lived in the suburb of Oxley, and her very modest house was flooded. And apart from the dislocation that, of course, that caused, the communication systems went down, and there was this moment of fear in my family not being able to get in touch with her. It was a fear which had spread through the whole community without being able to get in touch with family members, and it reminded a friend of mine who had escaped the Yugoslav war of the mid-90s. That being without those communications was exactly what it was like to be in a war zone. And so it is not just that there is that, as I say, that economic imperative, that convenience that we think it is, but also to give that human connection, which is ever more important as families and communities become diffuse. So it is that not only in the outback, not only in times of natural disaster, but it is really inconceivable that today, in well-established suburbs like Eagleby, where there's a retirement village that is constantly talking to me about the lack of service that they have on their mobile phones. A well-established suburb in my electorate called Cornubia, which has been there for as long as I've been alive. They can't get decent mobile phone service, let alone some of those newer areas like Homeview or Boronia Heights. I was out in Upper Coomera the other day trying to get connection on my phone to navigate through the maps. So there it was. I had better GPS services out there around between, out the back, literally out the back of Burke than I did have in Upper Coomera. And in some ways it is, I'm not sure whether it's more inexcusable that they haven't got the services in a well-established suburb, or is it more inexcusable that they haven't got the services in a new suburb, where it should have been obvious to them that these houses are going to move in, where it should have been easier for them to get hold of the land and get the approvals that they needed to set up the towers, the infrastructure in order to provide their service. And so it is that we are locally going to run a campaign to try and get the telcos to come to the party and to work collaboratively with them. So shortly we're going to be launching a survey to try and find out exactly where the black spots are, because it is typical also of the way that the telcos operate, that they have one set of data that shows that everything's fine, but actually doesn't reflect the experience of people on the ground. So we're going to do their job for them and find where these black spots are. We've got a pretty good idea as it is, but we want to see how widespread it is. And then we intend to work collaboratively with them. We're going to have a public meeting to really try and get some momentum behind this campaign, and then we're going to work collaboratively with them and with the authorities to try and get a solution, because ultimately that's what people want. They just want a solution. They don't want sort of blame to be sort of just thrown around, although there is plenty of blame which could be apportioned to these telcos. Someone said to me that perhaps they should only pay for the number of bars that they have of a service. So if there's one out of 5 bars, then they should only pay one fifth of their bill. Ultimately though, it is not about the blame, but there is a good bit of blame to go around. And the way that these telcos have just really thumbed their nose at the Australian public, the Australian consumers, is really, in some cases, unconscionable. The very well-respected Alan Fells pointed out that Optus, and I don't want to just single out Optus because it's a big list of telcos that have not lived up to their obligations. But Optus had 3 strikes there, two notable and tragic outages of the OOO network, but also the way they behaved, something that I referred to earlier. The member for Griffith has to sit through this again, but it is a story well worth telling, where the ACCC took Optus to court because they had been selling expensive phones and expensive plans to vulnerable people, obviously disabled people, people with severe learning difficulties. They sold these really effectively junk products because they hadn't even bothered to check whether Optus would actually cover them in the regions in which they lived. And it was only when really it was exposed that Optus ended up doing what it thought was the right thing, but it copped a $100 million penalty for that behaviour, which incidentally is only because this government has been properly resourcing ACCC, by the way, and giving it those enforcement powers that had been so lacking under the previous government. It had managed to take Optus to court and get that $100 million penalty, which hopefully deters behaviour not only of Optus, but deters behaviour of other providers as well. And ultimately, just as this debate sits within the broader government's economic objective, the government's broader economic objectives of keeping the cost of living down, if we can keep these services and level the playing field to improve competition and improve consumer safety, we're going to. That's one approach to lower the cost of living, and particularly with telcos, which are an essential service. But it's not just Optus. I feel like I should spread a little bit of it around. Exetel, a company that purports to be one of the fastest internet providers in the country, had dropped the ball, and effectively it was identified that there were 63 cases where it had allowed SIM swapping, which is where the scammer gets hold of somebody's mobile phone and then is able to control their phone number and get all their passwords and get all the codes in order to access their accounts. And those people lost over $412,000 because of the incompetence of Exetel. They copped a $700,000 fine. There's another company, to share it around a little bit, Circles Australia, which incidentally is a company I've only ever heard of because my son chooses to use them. They were fined $413,000 after they failed to verify the identity of 26 customers whose mobile services were abused by scammers that stole at least $45,000. And the telco's second such penalty. There is a long list of bad behaviour. Bad behaviour which has been really allowed to flourish.
If I might interrupt you, Member for Ford, if you would take your seat, please. It being 7:30, I propose the question that the House do now adjourn. And I call the member for Curtin.
Yesterday, the Treasurer handed down this government's annual budget, and I want to talk today about what it means for the people of Curtin and for Australia. Now, let me start with what I welcome. After 4 years of pushing for genuine tax reform, 4 years of being told it was political suicide to even raise the subject, we finally have action on capital gains tax and negative gearing. And I want to acknowledge every single constituent who wrote to me, attended one of the 3 community events where we discussed this, and who refused to let this issue be buried. The capital gains tax discount will move to an inflation-adjusted indexation model so that only real gains are taxed. Negative gearing will be limited to new homes from July 2027, with grandfather provisions for existing investors. Now, these are meaningful reforms that will help level the playing field for first home buyers who have been competing with tax-advantaged investors for too long. There are still some unintended consequences of this change that need to be addressed. We're facing a huge productivity challenge, and we need to ensure that changing the CGT discount doesn't reduce investment in new businesses and startups that are so vital to our productivity. I also welcome the reform to trust distributions, which will now attract a minimum tax rate of 30%. The number of discretionary trusts in this country has doubled in 20 years. This change won't affect primary production income, but it will reduce the incentive to create complicated structures to avoid tax. There's currently huge variability in how much tax our top earners pay, depending on how they structure their affairs. It isn't fair that trusts can pay significantly lower tax rates than working Australians. On housing more broadly, the $2 billion investment in enabling infrastructure to support 75,000 new homes is a step forward. The $59 million for community housing providers to address youth homelessness is something I specifically raised in this chamber, and I'm glad to see action here. On aged care, following my representations to the Minister, the government will now fund a wider range of personal care services, including showering, free of charge under the Support at Home program. That matters enormously to older Australians and their families in my electorate and across the country. I welcome the increased funding to be distributed from the Medical Research Future Fund. The research institutes in Curtin are world-class, and I look forward to them receiving some of this additional funding we fought for to continue their great work. But, Mr Speaker, I cannot stand here and pretend that this budget is not without some failings. The most glaring missed opportunity is gas taxation. So many constituents have written to me about this. We export vast quantities of liquefied natural gas, and the Australian people receive a fraction of what they deserve for these publicly owned resources. Less than half a day of proper taxes on gas exports could have funded $10 million for food pantries desperate to keep Australians fed. That's a choice that this government has made, and it's the wrong one. There's also no meaningful action on diesel fuel tax credits. Some of the most profitable mining companies in Australia continue to receive billions in rebates that incentivise burning fossil fuels. On climate and energy, I'm deeply concerned. Transitioning to renewables is not just good for the environment, it's our best long-term strategy for energy security. The sun and the wind do not travel through the Strait of Hormuz. Yet this budget takes its foot off the accelerator at precisely the moment we need to speed up. I also have concerns about the level of government spending, which is at its highest level in 40 years outside the pandemic, while our deficit remains high and growth slows. The budget's return to surplus relies on NDIS savings that I'll be scrutinising carefully. The NDIS changes are causing real anxiety for people who depend on the scheme, and I'll be pushing hard for certainty, transparency and genuine alternative supports. The $250 annual tax offset will be welcome news for working Australians, but the government could have indexed tax brackets instead. That would have delivered structural relief for working Australians and ensured the government can't just keep relying on bracket creep to fund spending. In summary, this is the most ambitious budget this government has delivered. That might be a low bar, and we shouldn't pretend otherwise. But there are genuine steps forward, particularly for younger generations, and many of these have been driven by the crossbench. But the missed opportunities are significant, and I will keep fighting for the longer-term reforms that we need to have a tax system and economy that's fit for the decades to come.
Call the member for Swan.
Thank you, Deputy Speaker. My Year 6 and Year 7 teacher, Mrs Wilson in Campbelda, taught me the importance of making a positive difference. I recognise that people that run for federal parliament and are elected into this place do that because they believe in a better Australia. And that is exactly what our mighty Treasurer delivered last night in last night's budget. This is a government that is not afraid of reform. As we saw from the announcements yesterday, we are delivering the biggest commitment to housing this country has seen in a generation. For too long, the Australian dream of owning your own home has moved further out of reach. With global uncertainty, conflict overseas, and frankly, our housing tax arrangements, the Albanese government has shown courage to create change during these uncertain times. Doing nothing was not an option. We are coming up with solving the housing challenge from every responsible angle. We are building more homes, we are making it better to rent, and we are backing first home buyers. And as announced last night, we are making the system fairer. And I'll start with housing supply. In my electorate of Swan alone, we are delivering 524 new social and affordable homes. And let me just put that in context. When the Coalition was in government, they built, over the 9 years across the country, 373 homes. Federally, Labor has committed to 55,000 affordable and social homes. For the homes that are being built in my electorate, 487 of them came from the Housing Australia Future Fund, a fund that the Coalition voted against. Despite the Coalition's best efforts to stop homes being built, this fund is now delivering for so many Australians. On Friday this week, I will get to turn sod on 50 new units in Victoria Park. 10 of those units will be reserved for older women over the age of 60 who are at risk of homelessness, and this is the fastest growing group of homelessness in Australia. This Housing Australia Future Fund is delivering on the ground in my electorate, real homes for real people who need them most. But we know we need more. That's why the Albanese Labor government is investing in $2 billion for a new local infrastructure fund. That's $2 billion to build the water, the power, the sewage and the roads. That unlocks 65,000 more homes across the country, with $500 million of that reserved for regional Australia. Because let's be honest, you can't build a home without connection to electricity and water. This government is making sure that our policy is backed by the funding needed to deliver the homes. Today I've seen news outlets raged over our tax reform changes. Now let me be clear. We are a government that listens. We're also a government that acts. On the weekend, maybe 2 weekends ago, there was a straw poll in my community in one of my local councils in the city of South Perth. They said that housing affordability was the #1 issue. This is also one of the most affluent parts of my electorate. They are wanting to make sure that we fix housing for this generation and the next. And we are a government that wants to see Australians get into their first home. And we're doing this by making the tax system fairer for the next generation of home buyers. Because for too long, too many Australians have been locked out of the housing market. Too many young people are working hard and doing everything right, and they still cannot see a path to home ownership. Too many families want nothing more than to get their foot in the door of their own home. So these changes, some will say that these changes don't go far enough, some will say that they will go too far. But the test is not what the commentary says, rather is to say whether the system was fairer than what it was. And under this government, it indeed is. More Australians deserve the chance to own their own homes, and this is what this government is determined to deliver. This is what a serious housing plan looks like. This is what intergenerational fairness looks like. This is what a Labor government looks like.
The question is the House to now adjourn. Give the call to the member for Wright.
I thank you, Mr Speaker. And without trucks, our great nation comes to a screeching halt. Truck Week 2026 is a national celebration of Australia's heavy vehicle industry. Truck Week is a national initiative that showcases the professionalism, contributions and everyday excellence of Australian heavy vehicle industry. It returns this year with a truly national focus, bringing together businesses, drivers, workshops, manufacturers, suppliers, communities and schools. A particular highlight is the continued support and leadership of the industry through events like the HVIA Truck Show X, delivered by Todd Hacking and his team at the Heavy Vehicle Industry of Australia. Truck Show X will be held on the 18th and 19th of May at Ridges in the Hunter Valley. It's events like this that showcase the very best of the sector: innovations, engineering excellence, safety advancements and the strength of calibration across the industry. From as far as Western Australia to the eastern seaboard, from Tassie to the Northern Territory, Truck Week is everywhere. At the heart of it, Truck Week is about recognising the people, the innovations that keep Australia moving every single day. Across 1 week, this week, workplaces and communities are coming together to host local events that highlight 3 key themes. First, people. The teams who build, drive, repair and manage our national truck fleet. Second, road safety. The commitment to safer roads, safer workplaces and shared responsibility across the entire industry. And third, innovation. The technology, ideas and solutions shaping the future of the heavy transport. It's fantastic to see more than 80 events already confirmed for the Truck Week across the country. That level of participation is a strong signal of just how engaged and proud the heavy vehicle industry is. from drivers and workshops through to manufacturers, suppliers and the broader community. It shows it's not just a campaign, but a genuine national movement and moment to recognise an industry that plays a vital role in keeping Australia moving every single day. Now, Mr Speaker, you will remember this morning you joined me over on the Senate where we met Kenny. Now, Kenny is not a person. Kenny is a Kenworth T410 truck, and it was here to promote Truck Week 2026 from one of their sponsors, the Healthy Heads in Trucks and Sheds. And from the outset, can I acknowledge the great work by Naomi and Ben and all the team at Healthy Heads in Trucks and Sheds do every day to support the health of employees in the transport and the logistics sector. They work to bring programs to life to make sure that the resources of Healthy Heads are accessible to organisations right around the country. Looking ahead, Truck Week also provides a timely lead into Road Safety Week next week as we celebrate the people, the technology behind our heavy vehicle industry. It's also an opportunity to reflect on the shared responsibilities we have to all other road users on the road. Absolutely. Truck Week highlights pride and progress in the industry, and Road Safety Week reminds us of all the importance and vigilance, care and safety for every road user. Together, they tell a connected story of an industry that's not only essential to the Australian economy, but deeply committed to safety and the community that it serves. Stay safe on the roads and make sure you keep on trucking.
The question is the House to now adjourn and give the call to the honourable member for Tangney.
Thank you, Mr Speaker. A few days ago on May 9, we celebrated World Migratory Bird Day. The theme was Every Bird Counts, and it highlighted the important role of community science for the conservation of migratory birds. In Tangney, we are very lucky to have the Friends of the Malouf Bird Sanctuary, led by volunteer Tom and Jenny, who are strong advocates for not only the migratory birds, but also for all 131 different species of birds who use Point Wayland. Work has now been started to rehabilitate and restore the foreshore at Point Wayland with an $850,000 investment from the Albanese government. It was an election commitment I made a little more than a year ago, and I'm proud that we are already getting started on this important work to improve our environment. The investment will include replanting trees and native vegetation along the Swan River. I was at the foreshore 2 weeks ago and saw work being done. You could smell the healthy soil with fresh compost and manure. And of course, we have the opportunity to see some of the birds who use Point Wayland. Cleaning up the river is a project that has been backed by $10 million from the federal government's Urban Rivers Catchments Program to restore the Canning River system. Last month, I checked out progress at Adenia Reserve in Riverton, also in Tangney. This site forms part of the Canning River tidal flat weed control and revegetation project. This is a critical intervention to restore the threatened coastal salt marshes ecological community. Some of the work happening included the removal of invasive species and targeted revegetation. This important work will improve our ecosystem and support biodiversity. Soil measures are one of the superheroes in our effort for a healthy planet. Salt measures are part of our blue carbon ecosystem and can help store carbon. The salt measures at Adenia Reserve is one of the last remaining examples of this habitat along the Canning River, and restoring this is of great importance. Mr. Speaker, the federal government also recently awarded $3.9 million grants to the regroup in Tangney to upgrade infrastructure at Canningvale Material Recovery Facility. New equipment will reduce contamination in paper and cardboard recycling stream to produce material that meet Australian standard and comply with the waste export regulations. Recycling has important impact on our environment, and our government recognizes this. Through the Recycling Modernisation Fund, the Albanese Labor government is contributing $29.1 million to 15 different recycling projects in Western Australia. Community volunteers are involved in many of the projects to safeguard our environment. I'm proud to have supported Murdoch Community Garden with a Stronger Community Program grant to establish a Miyawaki pocket forest at Murdoch University. The students, teachers, and community volunteers that make up the community garden hosted a planting day last week. Like other pocket forests, this one is expected to offer greater potential for carbon sequestration and greater biodiversity than traditional methods. The community garden is a safe and inclusive space for students at Murdoch and for the wider community. It is another example of how in Tangney we are engaging with nature and caring for nature. Thank you.
The question is the House to now adjourn and give the call to the Chief Opposition Whip.
Thank you, Speaker. Well, this time last night, the Treasurer delivered one of the most uninspiring speeches I have heard in this place. Now, I wondered why. I think maybe because the realisation was he was delivering the crystallisation of a broken promise. And of course, the Prime Minister was sitting there smiling happily, and he would, because he was seeing his successor fail on the national stage. And the person most satisfied with last night's speech, of course, was the Minister for Health, who's now been outed as the Prime Minister's hand-picked successor. Now, the problem is this. This Labor government ruled out before the last election that they would change capital gains tax and negative gearing, and we're supposed to believe in some fanciful way that things have changed so substantially in less than 12 months that they have now decided to break that promise. And then this morning on morning television, the Treasurer is on again, this time ruling out taxing the family home and ruling out inheritance taxes. Well, seriously, who would trust him now? This budget was a budget that crystallised Labor lies, higher taxes, lower living standards and fewer homes. There was a level of delusion in that speech last night that knew no bounds. You see, the Treasurer thinks he is Paul Keating. There were repeated and self-indulgent comparisons to Labor of yesteryear. But this is the thing. The Treasurer and this Prime Minister are not a patch on the Labor greats that they seek to emulate. The true historical comparison of this Labor budget is that it cements this Labor government's place as the highest taxing government Australia has ever had. Now, the big play in this budget was housing. Now, Labor's budget papers confirm exactly what the Coalition have been saying, that higher taxes will mean fewer homes. So on page 158 of the budget papers, it reveals that Labor's new housing taxes will lead to 35,000 fewer homes. Labor promised more homes, and instead all we got was more taxes. Now, the objective of all of this is to add 75,000 additional first home buyers. An admirable goal, although none of us can trust the forecasts that this government puts forward. That's 7,500 additional first home buyers per year. But to give that some context, under the current system without any change, we would expect that there would be about 1.2 million first home buyers purchasing a home in a business as usual scenario. So what we're seeing is a very small upside with a very high risk. This government, this Treasurer, are prepared to tip over a well-settled tax system on speculation of a 6% return. Now, as much as anything in these budget speeches, it's about what is not said. And the one thing that the Treasurer did not mention last night was migration. Not once. Now, why wouldn't he mention migration? I'll tell you why. Because migration has caused part of their housing crisis. You see, you cannot fix this housing crisis while ignoring population pressure. The budget confirms that net overseas migration is still forecast at 295,000 in 25-26 and 245,000 in 26-27. This is adding to the already 1.4 million people that Labor has added additionally over their time in office. And the other word that got a big run last night, the war, the conflict in the Middle East. Well, you know what, Speaker? The budgetary difficulties that this government finds itself in are a result of 4 years of poor economic management, not 4 months of a conflict in the Middle East. This Treasurer should be ashamed of what he has done to the Australian people, and it is only a coalition government that will protect Australians' way of life and restore their standard of living.
The question is the House to now adjourn. Give the call to the honourable member for Macon.
Thank you, Mr Speaker. Over the last quarter of a century, beginning with the September 11th Twin Towers attacks in New York, the world has gone from one crisis to another. Major conflicts in so many parts of the world, the global financial crisis of 2007 to 2009, the 2013 to 2017 ISIS years, the COVID pandemic between 2020 and 2023, the war in Ukraine, and now the attack on Iran have all caused disruption and uncertainty throughout the world. Living costs have risen everywhere, and there is a growing global humanitarian crisis that impacts every country, including Australia. Governments and political leaders are now frequently toppled, whilst political divisions grow wider. Meanwhile, the super wealthy accumulate even more of the world's money. It is in that context that the Albanese government's 26-27 budget was framed, and why it is a responsible budget for the times. No government could have managed the Australian economy better than what the Albanese government has done over the past 4 years. And whilst the critics will scramble to find flaws in the budget, they fail to articulate credible alternatives. Importantly, the 26-27 budget is not just a temporary fix to the economic stresses and financial pressures people face today, but provides long-term, enduring reforms for the Australian economy. All this has been achieved whilst the Albanese government delivers substantive long-term cost of living support and social justice reforms to communities throughout Australia, including, but not limited to, the $10.7 billion long-term fuel security investment, 137 bulk billing Medicare urgent care clinics to take the pressure off hospitals while saving out-of-pocket gap payments for patients, cutting student HECS debts by 20%, making free TAFE permanent, tax cuts for all working Australians, cutting the price of medicines, investing $47 billion into housing, securing Australian fuel supplies and increasing fuel reserves right now whilst cutting fuel excise by over 50% for 3 months, increasing defence spending, providing another $25 billion for public hospitals and $5.9 billion to list new medicines on the PBS. In my home state of South Australia, public hospitals will receive a total of $15.2 billion over 5 years, which is an additional $2 billion in funding. There have now been over 15,000 visits to the Para Hills Medicare Urgent Care Clinic in Macon since its opening on the 1st of October 2024. There are also now 16 Medicare bulk billing practices in the Macon electorate, an increase of 10 since Labor's bulk billing changes. That all equates to people receiving better health care with less out-of-pocket costs. Of course, some hard divisions had to be taken in the budget, and I accept that some people will be disappointed with some proposed changes. In particular, tightening the NDIS eligibility rules and benefits will impact NDIS recipients. However, the scheme is simply unsustainable under its current trajectory. Similarly, the reduction in private health insurance rebate for those over 65 years of age to around 24%, which brings it in line with the rebate for everyone else, will mean people over 65 years of age will pay on average $240 a year more for private health cover. The other notable tax changes are negative gearing, capital gains tax and discretionary trusts. The proposal is that from the 1st of July 2027, negative gearing for residential property investments will be limited to new builds, and the 50% capital gains tax discount for individuals, trusts and partnerships will be replaced with a cost-based indexation and a 30% minimum tax rate on capital gains. These changes are prospective. Properties held before the announcement will be exempt from the negative gearing changes. Additionally, investors who buy new builds will be able to choose either the 50% capital gains tax discount or indexation and the minimum tax when they sell their property. These changes commence on the 1st of July 2027. For discretionary trusts which have enabled a lower tax rate through income splitting, the government is introducing a 30% minimum tax from the 1st of July 2028. These changes are fair, reasonable and consistent with the Albanese government's drive to deliver intergenerational equity. And Mr Speaker, I expect to say a lot more about the budget in speeches in the coming days.
It being 8 p.m, the House stands adjourned until 9 a.m. tomorrow.